What's up, CMA final students? I really hope your exam preparations are going on in full swing since it's revision time. Here I am, Shivangi Agrawal, your law mentor, to assist you in the same. So, this video is a CMA final law marathon part 1 in 100% English, right? If I just take you through the features, it's going to be exam oriented according to the syllabus. It is detailed, yet it is going to be time bound and to the point. Extremely effective before exams. There is coverage of company law plus IBC in this part 1 marathon, and economic laws along with corporate governance will be covered or revised in part 2. Okay, so you'll have to wait for it to be uploaded. Of course, I've used the charts. So if you need the same, you can either note it down or you can purchase our set of 7 books in hard copy. And if these two options don't work for you, you also have the option to subscribe to the digital version of charts, which is only available on our Android app, Book My Video. Now, attempt has been made to cover even the small points. However, you have to understand that this video is only for revision purpose and not the replacement of main classes, which are very much needed to build the concepts, right? So if you're new to the subject or you're weak in this, please check our full course at bookmyvideo.in website. Now, what are you waiting for? Grab a notebook, plug in the earphones, and just begin. Happy revision, study really well, and make us all proud. Dream big, but don't wait to start big. You should always start small. So begin today, maybe just one chapter, and slowly and gradually it will all be done, right? So enjoy. Okay, so let's now revise the very first chapter. The first chapter that we are talking about, we all know that our entire syllabus is divided into sections. The very first section, that is Section A, Corporate Law, has 3 modules. The first module, that has Companies Act 2013, is further divided into 9 units. Basically, these chapters or units are not according to Companies Act classification. Here, the classification is different. But we are going to read it according to our syllabus. So we are revising the very first unit, that is company formation and conversion. Now, what are we reading in this particular chapter, ma'am? This is basically a mix of 3 chapters according to Companies Act, right? So first is preliminary, second is incorporation of companies, and third is companies incorporated outside India. So all these 3 chapters of Companies Act are basically comprised in this first unit of company formation and conversion. So here we get to know how a company is being incorporated, what are the different types of companies, how a company is being converted, some part of conversion to LLP and LLP to company also. Okay, now to begin with, when we talk about Companies Act, you all know how Companies Act has evolved, or what is the basics of Companies Act, what is it called, where is it applicable, because you have read this before, right? But still, considering the perspective that in examination you can be asked objective questions, you might be asked what was the first structured law on company, because we have different forms of business or different forms of doing business, simply different forms of organization in which we can do business. If I want to start a business, I can open a proprietorship, right? I can go for partnership, I can go for LLP, I can open a company, right? So given company, they're being governed by a certain law. So if I want to start a company, how am I going to incorporate it? Where am I going to register it? What are the things that I need to follow? If I don't follow, or if I do not comply with those laws, then there will be adequate punishment, and all of it that is given in the law relating to companies. So what was the first structured law? It was Companies Act 1913. 1913, right? Basically, we know more prominently about 2 acts. Companies Act 2013, which is prevalent as on date, and the previous one, that is Companies Act 1956, which has been repealed, and but it was there almost for 57 years. So that is insane and that is huge, right? But then as the time change, you need to change the laws also. The same laws which were prevalent in your family back 20 years back cannot be prevalent now, right? The students or the children out there will be reluctant to accept them, No, this doesn't happen nowadays. Gone are those days, right? So the law also needs to change. So came Companies Act 2013. It came with 29 chapters, 470 sections, 7 schedules, and a lot of rules. Now, the sections have been reduced because in Companies Act 1956, there were more sections and lesser number of rules. Here we have more number of rules because rules are easier to amend. So, government has kept a lot of power within themselves. Government enforces the law, executes the law, looks after the execution through its ministries. The ministry responsible for corporates is Ministry of Corporate Affairs, right? So MCA actually enforces or ensures that, okay, everyone is following company law or not. Through its ministry, that is through MCA, the rules are being drafted. Rules are being drafted like what, ma'am? Supposedly, you have been given in a section that if you want to register a company, you register it with 3 people, or you register it with 7 people, or you register it with 2 people, right? 1, 2, and 7 basically for OPC, private, and public as of date, what we have, right? Now, how do you do that? You submit certain documents to ROC. You submit the prescribed form. Now, they have not written the form number or they have not given the pro forma of the form in the act. Rather, it is written the prescribed form. So, when we go and see what has been prescribed, we go to the rules and check. So we get to know, okay, MCA has prescribed this particular form. Now, whenever MCA wants to change the form, they can easily change it. They do not need to pass another amendment act. Because if they want to bring in the changes in the act, they'll need to pass an amendment act, right? So a lot of rules are there that we already know, right? Okay. So we have certain authorities under the act. What are the authorities? We have a lot of authorities. We have the first thing that comes is Ministry of Corporate Affairs. In that, you have ROC, very important authority that we all know about. ROC is what? Registrar of Companies, which is responsible for facilitating incorporation or registration of companies and also responsible for maintaining their data. So all the records are being kept by that particular authority only. Then we have NCLT and NCLAT. They are judicial authorities for companies, right? Then we have SFIU. SFIU is what? Serious Fraud Investigation Office. So if the corporates tend to engage themselves in serious fraud, then the cases for investigation are being referred to this office, just like we have CBI, right? Then we have NFRA. NFRA is what? National Financial Reporting Authority. This is to oversee professionals. Oh my God, are they doing their work? Because companies are obligated to maintain books. The books are being audited by auditors, and are auditors doing their work correctly? That is being monitored by NFRA apart from their professional bodies, right? So we have these authorities also. Okay, there are more things as we go on. We'll get to know about official liquidators, what are regional directors and all, right? But these are basically the authorities that we're talking about, right? Now, we begin with the chapter. First thing is, what is company? Now, we all know the meaning of company. It is nothing but some people are coming together. So it is a voluntary association. Association voluntarily of people who have a common objective and they're going to do some business, right? Is it a natural person? No. It is an artificial person. We all know that, right? It is legally created. This company is being legally created, but it gets the status of being a person. Why being a person? Because it is paying tax. In income tax also, it is being recognized as a person, right? It is getting a lot of rights, but not exactly the rights which an individual gets, because individual is a natural person. So I can go ahead, you can go ahead and marry someone, right? But the company cannot go ahead and marry someone, right? Why? Because it is an artificial person. If we go by the definition or the term company has been defined under Section 2. Here comes Section 2, ma'am. Where is Section 1? Now, Companies Act Chapter 1 according to Companies Act classification is preliminary, in which you have only 2 sections. Section 1 is short title, extent and commencement, as well as applicability. What if the act is going to be called as, where the act will be applicable, and all of that. You have read this before. The second section is the definitions. So huge list of definitions is being given, which we are going to read right now. In that section, we have only section number 2 and section number 2 and a lot of clauses. So in section 2, clause 20, we have the definition of company, which states that company means a company incorporated under the act or previous company law. Now, what do you mean by previous company law, ma'am? Supposedly, today I want to form a company. I'll, of course, go ahead and look at Companies Act 2013 and I'll see how the company has to be registered. So now if I'm forming a company, my company will be a company incorporated under Companies Act 2013 only. But. Supposedly, I'm talking about any company, Reliance Industries, which was incorporated way before Companies Act 2013 came. So it got registered under the previous Companies Act, which was prevalent then. So now Companies Act 2013 won't apply to it. No, it will apply. How, ma'am? It is written at 2 places. One, it has been included in the definition of company. Okay, it has been included in the definition of company. That company does not only mean the companies which are incorporated under this act, but also under previous company law. Plus, it is also written in applicability part, right? So this is clear? Fine. So company is nothing. It is a body corporate. It is a legal person, and it has good amount of generous features, right? The first one being independent corporate existent. Now, when we go for a proprietorship business, the problem is that we are no different from our business. Anyone or any party looks at us, even law looks at us, even tax looks at us as one entity only. However, when we talk about this form of business organization, it has a tremendous feature of its independent existence. So its members are different and the company is different. It has a separate legal entity, which was also established in the famous case law of Salomon versus Salomon and Company Limited. Then it has limited liability. Now, when we are talking about limited liability, there can be 3 types of companies. One is the company limited by shares, the other is company limited by guarantee, and the last one is unlimited liability company. Now, in any case, we have to understand that the liability of the company will always be unlimited. However, there will be a limit on the liability of members of the company. So supposedly we 4 friends are trying to form a company, right? And we have formed a company. We have not formed an unlimited company because that's something which is really being formed. Why will anyone, we are forming a company to get and take this advantage of limited liability. So why will people actually go and form unlimited liability company? But that is an option which has been given. So if we go ahead and form a company limited by shares, what does it mean? I have agreed that, okay, I am going to pay to the company or I am going to invest in the company. However, you may think I'm going to invest in the company an amount of 1,000, right? So I'll have 100 shares of 10 each. That is how they have divided the entire share capital. You know the concept of shares, you know the concept of share capital. I'm not going to repeat it over here, right? So 100 shares at the rate of 10 each. So what am I going to? I'm going to contribute 1,000 amount. Now, on this, only 5 rupees has been given per share. That means I have contributed or I have given only 500 rupees, but I have to pay, or what is the amount which is unpaid? 500. So my liability is limited to the amount unpaid on shares held by me, that is 500 rupees. The company cannot ask for more money from me. If a company has taken a loan of 4 crores and they are unable to pay it, who cares? They cannot call for more money from me. Okay, they cannot call for more money from me. So this is the biggest advantage, no? If you're doing a business, okay, and if you have invested an amount of 10,000, the maximum that will happen is you'll lose that 10,000 if the business doesn't work out. But your personal assets will not be affected because no member is bound to contribute more than the nominal value of the shares which he holds in case the company is limited by shares, right? Okay. Next is perpetual succession. Now, in perpetual succession, there may be members who are coming, who are going. If we talk about the listed companies, Every fraction of seconds, there is a lot of sale, lot of buys, right? What is happening? The members keep on changing. Today, I'm a member of this particular company because I'm a shareholder, right? I'm a shareholder of this particular company. I sold my shares. I'm no more a shareholder. So, members are coming, they're going. It doesn't matter. The company goes on forever and ever and ever. So, somebody may die, somebody may become insolvent. It's not going to affect the corporate existence of the company. Okay. Eventually you will get to know more things, and we'll discuss on more serious issues also. Separate property as a separate owner. Now, since they are being recognized as a separate legal artificial person, they're also capable that they can have a property in their own name. So they can go ahead and buy a land, they can go ahead and get something patented, right? They can enter into any contract with in their own name. So they can own a property, they can transfer a property, they can just enjoy the property, right? So they become the owner. Ideally, if there are 4 friends who have contributed to the company, they have made investment in the company, all the assets should belong to them. No, it's not the case. They are still not the owners of the company. They can be said as joint owners of company's property, but it belongs to the company only. That property belongs to the company, and that property can be held liable for paying the debts of the company. Okay, so it belongs to the company only. Company is a separate person. Company has its own debts. Company has its own assets also. Yes, once the company dissolves, and if we have the assets left over, it will be given to the persons who have invested in the company, right? Okay, fine. Then we come transferability of shares. Because of this particular feature, the investors have a lot of liquidity. Lot of liquidity means, as an investor, if I have put in an amount of 2 lakh in the company, it's not that my amount is stuck till eternity. No, my dear. In private companies, though, the transferability of shares is a little restricted, right? The shares are not freely transferable. You need to seek certain permissions, and then you can transfer the shares of a private company. But if you're talking about the shares of a public company, they're freely transferable, and if they're listed, there's nothing else more convenient, right? So if you have invested in the shares of a listed company, you need funds immediately. You sell it in the open market and you have your funds, right? You have your cash. So it's highly liquid. Then we have common seal. What is common seal? Common seal is the official signature of a company. Now, earlier it was mandatory, but after Companies Amendment Act 2015, the common seal is not mandatory. So, ma'am, how a company officially signs a document? Because if it has common seal, then it can be used in the manner it is provided in the articles. But what if the company does not have common seal? Well, then all the documents, unless otherwise specified, is going to be authorized or is going to be signed by 2 directors. Now, if a company has company secretary, it will be 1 director and company secretary. Now we come to another concept called as corporate will, and thereafter its lifting. So, what do we mean by corporate will? Corporate veil is basically a kind of a curtain which does not let other people see who is behind the curtain. You've seen a puppet show, the puppets are dancing like this, but who is actually making them dance? We don't care. We only care for the puppets, right? But who is making the puppets dance has to be noticed or has to be checked when there is some problem. As long as the show is going good, it's all fine. But when there is a problem in the show, there is something which is offensive or something like that, then we need to see who is doing this. And then we need to punish that person. The same applies in the case of company. This wheel or corporate wheel is a wheel of incorporation. That is, when a company is incorporated, we have to understand that it is separate from its members. It is separate from the people who are running it. It is separate from the management. So no matter who is managing the company, who are the directors, who are the members, company is responsible for its acts. This is what wheel of incorporation or the corporate wheel concept establishes. Now, there are cases where we have to lift this curtain or remove this curtain and see who is doing this, because we have to punish that particular person, or we have to merge these two people, right? Now, ma'am, when does it happen? At a lot of places under Companies Act, the provision has been made such that, okay, if this filing is not done, the directors or the person responsible for filing shall be punished or shall be penalized. Why? Because ultimately company is an artificial person, and these defaults cannot be done by the company. It can be done by the person who was responsible to do it on behalf of the company. So that has to be punished. In this like manner, there has been a lot of cases in the past which went to the court, and the court gave the decision that no, in this case I want to lift the corporate wheel and I want to check who are the persons who are in control of the company, because they are no different from the company. Okay, so here it is all about disregarding the independent or corporate personality of the company. It's about understanding that, okay, these two people are the same. Fine. So I'm going to punish this person only. What are the cases, ma'am? Although there are associated case laws for these matters, but because you have read this before also, you don't need to, if you're very brilliant, I would suggest that, okay, you learn the case laws as I have dealt in the class. However, if that is not the case, you just learn the cases. Cases means all the points. You don't need to know the facts of these case laws. You only need to know the judgment. First thing for all cases. Now, the name of case law, if you can remember, good. If you cannot remember, it's completely okay. So the first thing is trading with enemy. Now, it is again, there is a case law and I need to explain, but in short, what we can understand is, although it's completely off the track, but for your understanding, let's take the example of India and Pakistan. Now, there are certain Pakistanis who have formed an Indian company. Right now, this company should be different from the people who have formed it. So it should be called as an Indian company only. Now, this company enters into a contract with another Indian company. Now, the government wants to identify that whether I'm trading with an enemy or not, because if the country is at war with another country, then they become our enemies and we're not supposed to trade with them. So to identify this, we need to see that, okay, this company is being controlled by Pakistanis, right? So ultimately that becomes an enemy if the country is at war with that particular country. So what happens? It's not allowed. So in this case, we don't simply see, okay, company is different, we don't care who the people are. No, we care. So we are lifting the corporate wheel in this case to take a decision. Okay. Next is concerning the matters of laws, of taxes, duties. So whenever the company is trying to evade taxes, okay, I'm forming other companies and I'll pass on my investment so that my tax burdens is reduced. No, for collection of taxes, government is going to lift the corporate wheel and consider you both same and club it and make that income taxable. Next is avoidance of welfare legislation. Welfare legislation like what? Like bonus. So if you earn a certain profit, you have to pay a certain bonus. Because you don't want to pay bonus to your employees, to your workers, you have shifted this profit to some other company. You have shifted this investment to some other company. Now, this is something which is not acceptable. So in this case, the corporate wheel was lifted and they clubbed it. They said, no, this is your income only. So you have this profit and you have to pay this much bonus. Next is to protect public policy. Very simple. Connors versus Connors Limited was the case. It is a very general case. So if you want to prevent anything which is contrary to public policy, you can lift the corporate wheel. Next is transfer of shares of company, which actually was sale of land. So there was a case called as SE's Information Technologies. What happened therein? That the sale of land was not permitted. So what they did instead, they transferred the shares. Transfer of shares means you get the control over the assets also. So this resulted in sale of land, which was prohibited. So it was held that, okay, we are going to lift the corporate wheel in such a case. We are not going to consider it like that. Next is formation of subsidiary to act as an agent. Although subsidiary is a different entity and the holding is a different entity. We'll learn about the concept of holding and subsidiary in a while, but they're different. However, if you have formed a subsidiary, maybe there is a going on concern, going on business, you have acquired it, you have registered it as a company, you have made it a subsidiary, or maybe your wholly owned subsidiary. Now, the company is not doing anything else, it is merely acting as your agent. You have formed this to just let that become your agent. So, in such a situation, you both are same. So corporate wheel was lifted in this particular case also, and it was held that, okay, this company has made its subsidiary, so it is also entitled to compensation. Now I'm not getting into the detail. Again, I would say you learn the judgment if you don't know the case law, and for all my students, of course, they'll be knowing the case laws, right? Next is what? Next is, in general, in Kasi criminal cases, the courts have pierced or they have lifted the corporate wheel. Whenever you're trying to avoid any legal obligations, the court can definitely lift the corporate wheel. Okay, ma'am. Now we come to nature of business organization in India. Now, definitely there are different types of business organization. Here we are talking about on the basis of government ownership. So how much amount government has invested in a particular venture, in a particular business, determines what it is going to be called as. Okay. So if the government actually or basically invests more amount, it is a public sector, which gives an impression that this belongs to government. Like we have railways, it belongs to government. We have postal services, it belongs to government. Right? So we have certain departments wherein it has been established by government. Then we have certain statutory corporations or statutory companies also, which are being set up and run by government. Like what, ma'am? Like RBI, like LIC. Are these companies? The answer is no. LIC is not a company under Companies Act. RBI is not a company under Companies Act. So, ma'am, how are they formed? We know that the entire, or you can say, India gets its power to make laws from the Constitution. So, Constitution has given the power to Parliament to make central laws. So Parliament passed an act called as Reserve Bank of India Act 1934, wherein in the act power was given to government to set up a corporation, set up an entity called as Reserve Bank of India. Using this power, Reserve Bank of India was set up. So it is not a company which has been a company incorporated under Companies Act 2013 or previous company law, but it is a statutory corporation, right? Then we have companies. Now there are general companies and there are special companies like government companies also, like we have ONGC. ONGC is a company which is registered under Companies Act, but it also has government stake. So government holds 51% or more shares in a company that is called as a government company, right? So government departments, statutory corporations, government companies, they are all a part of public sector. But then where government has invested from 26 to 50%, it is joint sector, because equal contribution, if not more, is also from the private sector. Right? Here the major contribution will be of government and hence it is called as public sector. Right? Okay, ma'am. Now we have different types of classification under Companies Act. Right? So we will read about the classification one by one. The first thing that we are reading over here is private company. Private company, section 2, clause 68. Okay. See, when we go on to read section 3, A company may be formed as a private company, a public company, or OPC. So no matter what we are talking about, if we are talking about government company, it will either be a private company or a public company. If we're talking about small company, it will be a private company only, right? If we're talking about Section 8 company, it will be either a private company or a public company. There can be no other company. We don't form a company, okay, I'm forming a Section 8 company. Yes, you might be forming a Section 8 company, but prima facie, it may be a private company with the license to carry out charitable objects. Hence, you are also a Section 8 company, but by nature, you're a private company. So it will either be a private or a public company only. A Section 8 company cannot be formed as OPC. So that is the restriction we all know. So we can form prima facie 3 types of companies only. The first one is a private company, Section 2, Clause 68. Now, a private company can be formed with minimum 2 members. That's given in section number 3. And if we go by the definition of private company, it means a company which has minimum paid up share capital as prescribed. If we go to the rules to check what has been prescribed, nothing has been prescribed. So right now we don't have any requirement of minimum paid up share capital, like you have to start a company with 50,000, with 1 lakh, with 5 lakhs, nothing like that. You can start the company with any amount you want to, okay? And which by its articles restricts transferability of shares, limits the number of members to 200, and prohibits invitation to public to subscribe for its securities. These are the 3 things which have to be written in the articles of every private company. Okay? It has to restrict the transfer of shares. The shares cannot be freely transferable. It has to limit the number of members to 200. So maximum number of members that can be there in a private company is 200. However, it has one exception. Firstly, if let's say a company has issued 199 shares to 199 different people. So it has 199 members and it has issued 199 shares. Now there is one more person who comes and says, I want to invest in your company. Then no problem. We can have maximum 200 members. So I can issue shares to you also, and you can also become our member. But he's newly married and he wants to invest in the joint name with his wife. So if he also becomes the member, there will be 2 persons. So will it become 201? The answer is no. Joint members are treated as single member only. So one thing is that. Secondly, when we are counting the limit of 200, we don't include the persons who are in employment and have been issued shares, or who have been issued shares when they were in employment and they have left the employment. They went to some other company, but they're still holding shares. We don't include them. Why, ma'am? Why? Because there is a notion which has to be broken, that, ma'am, private companies are small companies. No. There can be a lot of big companies also who don't want to go public. And there could be a government company also, which is a private company. So private company like Flipkart, they can be a private company, not a problem, but they'll have immense number of employees. And to encourage employees, to help them or to give them incentive that, okay, if you have bought the shares of this particular company, the company grows, your salary grows, your investment grows, everything is a win-win situation for you. So the employees will be encouraged. So for that purpose, a lot of times shares are being issued to employees when they are in employment. So if we count all of them in the number of members, then this limit will not do justice. So they are not included. Okay. So we have minimum number of members 2, maximum 200. These are the exception, past and present employees. Minimum capital, nothing prescribed in articles. They have restriction, they have prohibition, they have limitation. They have to add a suffix private limited at the end of their name. OPC and small company is a private company only. Small company can never be a public company, or a public company can never be a small company. That way you can say. Next, we come to section 2, clause 71, which is a public company. Now, public company definition is very simple because in its articles, there is no restriction, limitation, prohibition, and hence there is no exception also to that. Simple. Company, which is not a private company, is a public company and has minimum paid up share capital as prescribed. Ma'am, what is prescribed? Nothing is prescribed. Ma'am, how many minimum number of members are needed? 7. That is given in section 3. So 7 minimum number of members, maximum no limit at all. The only catch in the definition of public company is subsidiary of a public company is deemed to be a public company. Why? Why? Because public companies have the option to raise funds from general public. So, of course, government has to think about public interest in general. So these companies are obligated to be more transparent, to disclose a lot of more things, to be exposed to a lot of more compliances, whereas private companies are operating in their private space. If they have taken funds from a friend, it doesn't matter. At the most, that fund will not be repaid, right? So they are less concerned. Government is less concerned. So there are less regulations, there are less compliances on the same. Now what happens, there's a public company, it takes funds from all the public, it raises funds, issues securities, whatever funds it has taken. That funds are being invested in another company because it has purchased the shares of that company by making it a subsidiary. And that company is a private company, so that company is not required to disclose anything. Okay, so this public company discloses my investment is being made in this. No. This is not happening because here the funds are actually from public, or maybe there is a public company which has made investment or which has made its subsidiary. So this particular private company loses its exemption benefits. Now you'll be treated as a public company, so you have to disclose this, you have to follow this provision, you have to comply with this, you have to do this, you have to do that, and all the benefits or exemptions which were granted to a private company will be taken away from you. You can still be a private company by your name, by your character, but then you will not be allowed to take benefits of being a private company. That is the thing that you need to understand. Okay, so if I say the difference between private and public company, it is in the minimum number of members, it is in the maximum number of members. Directors, in private company you need just 2 directors and maximum can go up to 15, which can further be increased. In public company, minimum 3 directors, maximum 15. There is a prohibition to raise funds from public. In a private company, no such prohibition. In public company, transfer of shares restricted in a private company and freely transferable in a public company. Suffix is different because here you need to add limited in case of a public company, whereas here it was private limited. Right? Okay. Then we have one-person company. One-person company, section 2, clause 62. One-person company is basically for small budding entrepreneurs, right? Now, though this concept seems to be new for India, actually I wouldn't say it's new because in earlier Companies Act also there was a concept of one-man company, but one-person company has been introduced lately. But this is a concept which has been in the world in a lot of countries, and this has been adopted by India also. Now, what happens in this? There is one person. One person means what, ma'am? Can it be a company? The answer is no, it cannot be a company. Although company is permitted to be a member of another company, we all know that. Right? We all know that. Only firm is not allowed to be a member of any company. Why? Because it is not recognized as a legal person in the eyes of law. So it cannot be a member of any company except for Section 8 company. We'll read about it later. Right? Other than that, a company can be a member. But when we are talking about OPC, Here, the person has to be a natural person. He has to be an Indian citizen. He may be a resident in India. He may not be a resident in India. This is the basic requirement. Okay, ma'am. So that means a company cannot invest in OPC? Yes. So OPC can never be a subsidiary? Yes. And OPC can never be a holding also. Why? Because OPC is not allowed to invest in securities of a body corporate. OPC is being allowed because it is hybrid of sole proprietor and company that has been provided. A platform has been provided that, okay, you get this corporate existence and you do your business. Okay, so there is going to be just one and one member only. He's going to be the sole shareholder, and that has to be a natural person, Indian citizen, whether resident in India or not. It doesn't matter, my dear. It doesn't matter. This has been amended long back. Okay, now to keep in mind that we have a concept called as perpetual succession, that company has to go on and on and on, right? So to keep this in mind, there are very high chances that, okay, there was just one person, he may become incapable to enter into a contract, or he may die. So in such harsh or unusual situations, what should be done? Immediately there will be a halt, because usually in one person company, he is the sole member, he is the sole director also, because such type of companies, the minimum requirement of director is one only. However, they may have 15 directors. Maximum is still 15 directors. But there are cases that, okay, he is the sole member also, he is the director also, so he is the manager of the company. So in such situations of death or incapacity, there should be someone who takes charge and becomes the sole shareholder. So in OPC, the shareholder is going to nominate another person. He'll obtain his consent. Are you ready to become the nominee? He'll file the consent with ROC. He'll name that particular person in memorandum of association. And then that person is going to take charge in case of death or incapacity. Okay? Fine. Now, there are certain more things like what? You cannot incorporate more than one OPC. A sole shareholder. Who can be the nominee, by the way? The nominee also can be a natural person, Indian citizen, whether resident in India or not. Now, you're not allowed to incorporate more than one OPC. At one point of time, you cannot be a member of two OPCs, but you can be a member and a nominee of two OPCs. Okay. That means you are a member of one OPC and you are a nominee of another OPC. Supposedly, the OPC in which you are a nominee, that OPC loses its sole shareholder. The sole shareholder dies. So you eventually become the sole shareholder of that OPC, and you're already a sole shareholder of another OPC. So you will be given a span of 180 days to choose which OPC you want to continue with. Okay, you appoint another nominee and you leave that particular person will take charge. Okay, so at one point of time, you cannot be incorporating more than one OPC. And of course, the person you are choosing, the nominee you are choosing, he has to give you the consent. You have to file that consent along with the incorporation document. He may withdraw the consent. He might have given the consent, okay, I'll be your nominee, but now he doesn't want to. So he can withdraw and you can give another nominee's name. You might think that, okay, I don't like this nominee. You may remove him and you can give another nominee's name. The procedure is very simple. All you have to do is intimate the same to ROC and that is going to be done. There are various exemptions which are given to OPC. Various exemptions. You don't have to prepare cash flow statements, right? Your financials can be signed by just one director because you might be having just one director. You don't have to conduct annual general meeting. Who will you meet actually? Because there is just one member. Members meet has to be there. You cannot meet your own self, right? So you're exempted from holding annual general meetings. So we have there are least compliances in case of OPC. Okay. Now we move to another company called as holding company. Okay. Holding, subsidiary, associate, these are all the companies on the basis of control and their relative terms. One is related to another. I cannot say I'm a mother to everyone. So I cannot say I'm holding to everyone, but I can say I'm a private company. So private company, public company, it is a standalone concept. But when we are talking about holding subsidiary, if I say I'm a holding company, I will have a corresponding subsidiary and likewise, right? Vice versa. Okay, so first we will actually look at the definition of subsidiary company, and thereafter we'll see the definition of holding company. Subsidiary company, section 2, clause 87. Okay, now what does it say? There is one company which is controlling the composition of board of directors of this company. This becomes subsidiary, this becomes holding. There is this company which is holding more than half. That means 50.01% shares, 60%, 70, 80, 90, 100% shares of this company. That is, it exercises more than half of the voting power. Now, voting power is equivalent to shareholding as long as no DVR shares are issued. I hope you all know and remember the concept of differential voting rights. So, usually what do we say? One share is equal to one vote. So, if I have 50 shares, I have 50 votes. And if there are 100 shares issued, I have 50% votes. If I have 60 shares, I have 60% votes. So I have more than half of the voting power of that particular company. So I can take decisions of that particular company. So in a way, I am controlling that particular company. So that particular company is in my control. So that particular company is a subsidiary and I am the holding. If I'm able to compose the board of directors, that means I am deciding who is going to be on the board, and those board of directors are going to take the decisions. They are going to manage the company. So somehow that company is in my control. So I am the holding. Now, holding company and subsidiary company. One individual cannot be a holding. You have to keep that in mind. Okay. One thing that you have to understand over here is that controls more than half of voting power at own or with subsidiaries. Now, what do we mean by that? Supposedly, we have a company A Limited and it holds 60% shares in B Limited. So clearly we can establish a relationship over here. What is the relationship over here? A Limited is the holding and B Limited is the subsidiary. Now B Limited holds 40% shares in C Limited and A Limited holds 30% shares in C Limited. So can we see any relationship between A and C? Well, no. Can we see any relationship between B and C? The answer is again no. But we haven't read the concept of associate company yet. Okay, don't think that in mind. Now, listen to me very carefully. A Limited has only 30% control in C Limited. However, it controls B Limited and B Limited controls 40% in C Limited. So, if I can say that A Limited, your direct control is 30%, your indirect control is 40%. So together you have a control of more than, or you have a voting power of more than 70%. You have a voting power of more than 50% because you have a voting power of 70%. So A and C, you both also share a relationship of holding and subsidiary. Right now, there is one more restriction that the companies are not allowed to have more than 2 layers of subsidiaries. Ma'am, layering is what? One company, they can have 200 subsidiaries, not a problem. But if you are a company, you have a subsidiary. Now that subsidiary has another subsidiary. That another subsidiary has a subsidiary. A Limited holds 60% shares in B Limited. B Limited is layer 1 subsidiary. B Limited holds 70% shares in C Limited. C Limited is level 2 or layer 2 subsidiary. Now this particular company cannot have another subsidiary because in this manner you are taking the source and the origin, or you can say the usage and the source, too far to track things. Okay, fine. Now, what is holding company? Holding company means in relation to another company is a company of which such company is a subsidiary company. Very simple. Now, associate company is in between. In between means what? You have a significant influence on that company, but you don't have such voting power that you can make it your subsidiary. That means maybe a company is holding 25% shares in another company. Now it will be able to significantly influence the decision that company is taking because of its good amount of voting power, but it will not be called as a subsidiary. So if you have a significant influence which is more than equal to 20% of voting power, then that you call as associate. Joint venture is also included in the definition of associate company. Okay, fine, ma'am. Next is the definition of a small company, very popular among students for reason because we have seen a lot of amendments in the definition of small company. Now, what is a small company? Small companies are being given certain benefits because you're operating on a small scale. So basically the section defines that scale, that check yourself. If you do not exceed this limit and you are a private company, because a public company cannot be a small company. So if you're a private company and you're operating within the scale, then recognize yourself as a small company and then you'll be conferred to certain benefits. Okay, what is the scale that has been given? Now, prima facie, we have to know that a private company whose paid up capital does not exceed 4 crores and whose turnover does not exceed 40 crores is a small company, a private company. A Section 8 company cannot be a small company. A holding company cannot be a small company. So if you're a holding company and you're within this limit, you cannot be called as a small company. If you're a subsidiary, still you cannot be called as a small company. And if you're a company governed by special act like banking, insurance and all that, you're still not a small company. So this is the prima facie thing. But now the section does not say that. And you have to read the section only. You don't have to read this limit. I mean, you should know the limit. I'm teaching you the limit. But prima facie, you need to know the section. What is the section, ma'am? What does the section say? The section says a private company, or you can say a company other than a public company, paid up share capital of which does not exceed 50 lakhs or such higher sum as may be prescribed, government can prescribe up to 10 crores. So it shall not be more than 10 crores. This is how you're going to write the provision if it is being asked. And the turnover does not exceed 2 crores or such higher amount as may be prescribed, which shall not be more than 100 crores. That means government can use this power and prescribe up to 100 crores. Government has used this power and prescribed 40 crores. Government has used this power and prescribed 4 crores. Okay, fine. Next we come to Section 8 company. What is Section 8 company? Section 8 company is a company which has been formed for charitable purposes, right? Charitable purposes, it needs to obtain license because it is given a lot of benefits. It can be formed as a private company or a public company, but it does not uses the suffix private limited or limited at the end of its name. Now, the only thing is that because it is a company which is being formed for charitable objects, for promoting sports, for promoting education, and likewise, it might earn a few some surplus. Supposedly it made profit or it earns surplus, it cannot give it to the members. Oh my God, you have done so much of hard work. We are distributing it as dividend. No, you cannot do that. Whatever amount is surplus, whatever amount is earned, that has to be given back to the business. It has to be given back for promoting those charitable activities only. So, payment of dividend in such a company is completely prohibited. Okay, we'll read more about it when we talk about incorporation of Section 8 company. Next comes government company, although I've already told you this. Company in which at least 51%, so 51 or more, paid up share capital is held by the central government, state government, or jointly by both. Now, if it is held by central government, it is in the name of president. If it is held by state government, it is the governor of the state, jointly, of course, both. Includes the subsidiary of a government company. So, if we have ONGC, central government has invested in ONGC more than 51% or more, simply, let's put it that way. So, ONGC is a government company. Now, it holds 60% shares of another company in which government has not invested. But then this particular company being a subsidiary of a government company, not of some PFI or something like that, of a government company, then this is also going to be treated and known as a government company only. Foreign company is the concept which we'll be doing later, because we have a different topic over there. Then comes our dormant company. Dormant company means what? Supposedly there are four friends in a college, and they develop some IPR, intellectual property rights, and they think that, oh my god, we four have worked so hard on this particular project, and this is something that we have discovered. Now if we leave it like that, we'll not get the benefit because we are the first one to discover it. Let's get it patented. Now there is a dispute that in whose name it should be patented. So you decide that, okay, in future we are going to start with a business, let's form a company right away and we'll get it patented in the name of the company. So company is going to hold an IPR, intellectual property right? And thereafter, after completing our studies, we will continue the business in this way. So this company is being formed for future, or to hold some asset. It is not going to do any significant transaction. That means it is not going to purchase, it is not going to sell. All it will do is to pay ROC fees, right? And like things. So these are not significant accounting transaction, right? So in such a situation, what should be done? In such a situation, you may apply to ROC for obtaining the status of dormant company. Once you have been conferred as the status of dormant company, now ROC is also relaxed. They don't care. Okay, this company is not doing anything. We don't need to continuously monitor the things. And you are also relaxed with less compliances. Okay, so this is what should be done. Now, if you are an inactive company means what? You formed the company, you were doing business, but there has been no business in the last 2 financial years, or you have not done any significant accounting transaction in the last 2 financial years, or you have not been filing your financial statements and annual returns in the last 2 financial years. Such company is known as an inactive company, and that inactive company can also do the same and obtain the status of being a dormant company. Okay. Now, this I have already told you. We have something called as statutory companies, which are not companies which are incorporated under this act, but under any special act of parliament. And these are registered companies as explained in section 2, clause 20. Then we have limited by shares, limited by guarantee, and unlimited company. Again, something that I've already told you. If you're a company limited by guarantee, you must have undertaken an amount that, okay, I guarantee to pay an amount of 1 lakh if there is a deficit in the assets of the company. So throughout the lifetime of the company, I'll not pay any amount, but at the winding up, when the company is being closed, the assets are being sold to pay the liabilities, and the assets are insufficient to pay the liabilities, I will contribute maximum 1 lakh to those assets or to the winding up cost, right? So my amount or my liability is limited to this amount only, and unlimited, no limit on the liability of the members. Now we have listed companies. Listed company means what, ma'am? See, a company is not listed on a recognized stock exchange. Its securities are listed. So a company whose securities are being listed on a recognized stock exchange is called as a listed company. What is a recognized stock exchange? It is nothing but a platform for buying and selling of securities. So it is a platform which is being provided to public at large, that here you can buy and sell securities. Okay, ma'am. Now, we have to understand one thing that often students ask, can a private company be listed, ma'am? The answer is yes. A private company can also be listed, but it is not allowed to offer the shares, to offer its securities to general public. So if it is a listed company, if its securities are listed, that means they're available to public for trading. If they're buying and selling, how is it in line with the provisions? So you have to understand that stock exchange has different platforms. We have SME, we have main board, we have IGP, Innovators Growth Platform, right? So it is allowed by SEBI listing regulations that, okay, you can list your privately placed debt securities over there. They're not available for public, one thing. Now, if you're doing that listing, that is for a different reason what you're doing. You cannot be called as a listed company and be exposed to so many more compliances over here. You're being regulated by SEBI over there. That is okay. Right? So unnecessarily calling you a listed company over here and burdening you with a lot of other compliances is not justified. So what they did is, central government in consultation with SEBI, they prescribed this as this will not be considered as a listed company. So under Companies Act, this is not considered as a listed company. Likewise, we have public company. They have not issued their equity shares and got them listed. No, their equity shares are not listed. What is listed instead is maybe their privately placed debt securities or their privately placed preference shares. So that will also not be called as a listed company. Secondly, this is a public company which has listed its securities, but not in India, in some foreign jurisdiction, some other stock exchange outside India. So again, such a company will not be treated as a listed company. So these are the exceptions. Now, what is an unlisted company? Company which is not a listed company is an unlisted company. It is also called as closely held company. They are called as widely held companies. Then we have Nidhi companies. Nidhi companies are given in section 406. However, we are still reading the old definition here. I have tried to write the new one. Nidhi companies are what? They promote the habit of savings amongst its members. How? By doing cost cutting. How, ma'am? Supposedly you are earning something, you got an amount of 1,000, it is promoting you to deposit it. So whatever you have, you go and deposit it. Whenever you are in need of funds, you can take benefits. So it is a mutual benefit company. The members are being benefited, right, for mutual benefits. Now, because there were a lot of these type of companies which induced people that, okay, you deposit here, you can take whenever you want to, and there were a lot of frauds. What government did is, government said, if you want to become a Nidhi company, you have to make an application to us and we will declare you as a Nidhi company. Only then you will be called as a Nidhi company. So ideally, if they are declared in the official gazette, then they are a Nidhi company. Otherwise, they are not a Nidhi company. Then we have something called as Public Financial Institution, Section 2, Clause 72. What is a public financial institution? We have LIC, we have IDFCL, we have UTI, right? Unit Trust of India, then Infrastructure Development Finance Company Limited. Then we also have the institutions which were notified in Companies Act 1956 and any other institution which central government may notify. Now, central government is not going to pick up any financial institution and say that it is a public financial institution. No, because when we are saying PFI, it is giving an impression and it means that it belongs to the government. So it is a financial institution which government holds. So when we are saying any, or when we are notifying that this financial institution is PFI, we have to ensure that it should be either constituted under central or state act like LIC. LIC is constituted under Life Insurance Act 1956, right? So it is a central act under which LIC is constituted, or it should be that at least 51% of paid up capital is held by central government or state government or a combination of two. Okay. Now, joint venture. Joint venture is simple. There is an arrangement. We both are contributing. So we both have the right to the assets. There is something called as a corporate joint venture also, in which there are two entities and they form another company and they are joint. It is their joint venture. And there could be a non-corporate joint venture also, which simply means that these are two companies which are actually doing a business together. They have started a joint venture. Now, in such a situation, these two companies are called as associate companies. We have read in the definition of associate companies that it includes a joint venture, right? Okay, ma'am. Then we have something called as sectoral companies. Sectoral companies means what? Which fall in a particular sector, like a banking companies. They fall under the banking sector. So we have Axis Bank Limited. It is a company under Companies Act, and it is a banking company. It falls under the banking sector also. So it has to follow all the RBI guidelines, the master directions, RBI directives. It is being regulated by RBI. It is being governed by Banking Regulation Act, as well as it has to follow Companies Act 2013. Right? We have this banking company. It is a sectoral company only. It cannot commence business unless it has got the license from RBI. It has to use the word bank, as I told you, Axis Bank Limited. Likewise, we have insurance companies. Insurance companies also fall in the insurance sector. They cannot commence business unless they have IRDA license, right? And they also have to use the term insurance in the name of such a company, right? So sectoral companies, they are required to follow both the Companies Act as well as their sectoral law. We have NBFC also. Now NBFC is a lot like banks and a lot different like banks. NBFC is also a company which is registered under Companies Act. Non-banking financial companies. It is a financial company, so it provides finance. Basically, it is engaged in the business of loans and advances. However, it does not do that business of banking. That means if you want to open a savings bank account over here, you cannot do that, right? But it provides the loan, right? It could provide specifically loan for purchasing a bike or something like that, right? So this has a wider reach than banks. It goes through the rural areas and everywhere, right? So it works that way. Okay, fine, ma'am. So engaged in the business of loans and advances, acquisition of securities, leasing, hire, purchase, and all that. Now, before we actually go to the process of incorporation, we have to understand one more thing. And what is that one thing? Registration of large partnerships. So it is mandatory. We may think that, okay, ma'am, I want to choose partnership only. That's more convenient for me. And we are 60 people and we'll form partnership and we'll do our business. No, that's not even allowed. If you are forming a partnership of more than 50, up to 50 is fine, but of more than 50, you cannot do it unless you get yourself registered as a company. So large partnerships have to be registered, compulsorily registered under Companies Act. It is given in 464 section number. There are two exceptions. If you are HUF. So if you are a Hindu undivided family of maybe 60 people, then go ahead and do that business, not a problem. Or if your partnership is a professional partnership, that means you're being governed by some special act, like it could be CMA partnerships, it could be CA partnerships, right? CAs and practice are entering into a partnership, then that is allowed. Okay. Otherwise, if you contravene this, there will be absolutely your association will have no legal existence. It will have no legal existence. Okay. And the people will be personally liable. There will be no power by the member to sue, right? However, if there is a person who has paid money to the association, and if there is any third party or a member who has paid money to this particular association and that money has not been applied to an illegal person, they will be able to recover it. Otherwise, there won't be any liabilities, any existence, and likewise things. Okay. So I hope so far the things are clear. Now we come to incorporation part. Now, ideally, incorporation of a company or how do you start a business in a company essentially involves certain steps. First is promotion. Thereafter, you register the company, you get funds, and thereafter there is commencement of business. So that's how it works. Now, when I talk about promotion of company means doing the initial feasibility studies and all. Like if I want to start a business, that I'll see, fine, I'm forming a company, but if I'm setting up a factory, which will be a good place to, what other essential licenses which will be required, so I have to make applications for that. I have to incorporate a company, so I need to incorporate it as a public company or as a private company, so I need to gather people in that sense. I need to arrange for funds, right? Because this is my vision which is going to be materialized. So whoever has this vision and idea is known as the promoter of the company. Now, the promoter of the company is not the same during the entire lifetime. Why, ma'am? because maybe company is a perpetual succession, but the person is not a perpetual succession. Everyone has a shelf life. They're bound to retire, they're bound to die, है ना? So what will happen is there might come at a certain stage that these roles of arranging funds, of taking control, of being instrumental in things is shifted to somebody else, like the Ambani family, right? So the promoters also change eventually. Okay, and promoter is very important and being is recognized by SEBI, especially in case of listed companies. So a lot of responsibilities, a lot of compliances are being placed on the promoters also. Fine, ma'am. Now, supposedly we had a group of 4 friends and we're deciding to form a company. There are a lot of things that we need to discuss amongst our own selves, because once a company is formed, all the decisions will be taken in the manner Companies Act bounds them to do, right? But before that, we have entered into some pre-incorporation contracts on behalf of the company. So how will this take place, right? How are we going to decide the matters or decide certain issues? Because you have just taken an oral decision or come to a consensus or an agreement, oral agreement, right? That, okay, fine, we 4 are going to share this way, this is going to be your contribution, or whatever it is, right? Now, these terms, or you can say a kind of memorandum of understanding, is put down, and this is also known as promoters agreement. Now, promoters, what they're doing, all the 4 friends are deciding that, okay, let's prepare a memorandum of agreement. It's not something which is a memorandum of association. Memorandum of association is of a company which is mandatory, which has a validity. But this memorandum of agreement, or in general what you call as promoters agreement, this just mentions the issue with regard to the formation of the company or certain rights, liabilities. Okay, fine, once the company will be incorporated, this is how we are going to disclose the contracts, this is how we are going to disclose other things, whatever, it's their internal things that they are deciding. So this may be prepared. This is not something which is mandatory. So don't get yourself confused between memorandum of understanding or memorandum of agreement and memorandum of association. Memorandum of association is a much more important term when we are talking about the incorporation of company. Okay, fine. So here we begin the incorporation. One thing that I also want to let you remind over here is that the definition of promoter. This is the general meaning of promoter, which I already told you. But when we look at the definition of promoter given in Section 2, Clause 69, we will see that it is something else. And basically, it tells us how do you identify a promoter. So supposedly, you don't really know who is the promoter of this particular company, because who is taking control of this company? Supposedly a new company is being formed, and now we come to know, okay, this company, the promoter is Reliance Industries Limited. So we get a sense of confidence to invest in that company. It's being promoted by, so there will be involvement. So that is how promoters are important when the shareholders are taking a decision to invest. Okay, hence promoters are named in the prospectus. Whenever a company is making a public offer, it has to issue prospectus, and in that prospectus there will be the name of promoter, so you can easily identify, okay, this is the promoter. So promoter is somebody who is named in the prospectus or identified in the annual return that has to be filed under Section 92 every year by every company, right? Or promoter can be someone who has control over the affairs of the company. Maybe how he is the managing director, or he has kept with himself 57% share, so he has a good or majority shareholder, right? So anyhow he can have control. Or promoter is somebody on whose instructions or directions the board of directors are acting. So he's saying something and the board of directors are doing that only. So that particular person is in control. So that particular person is a promoter. So this is the definition of promoter, either of these. Okay. So there is a person who gets an idea and then decides to form a business organization, that is company. He does the preliminary steps necessary for incorporation, like gathering people, preparing documents, and deciding the name of the company and all of that, right? Now, during this process, it is necessary that you need to have a professional. Okay, without the signature of professional, you cannot incorporate a company. Now, this particular professional is going to guide you as to what documents are exactly needed, how do you prepare the documents, what things, whatever information is required from the client, the professional takes it. Professional could be CA, it could be CMA, it could be CS, it could be advocate, right? So we have a lot of people who may be instrumental in incorporating a company. Now, these people are not going to be treated as promoters, otherwise they'll be promoter of every company, right? So they are not promoters. So all these documents are prepared, the filing is done, and it's done. Now, before we go on to the detailed incorporation steps, here we have section number 3A. Now, we know about section 3. I have already told you this, that a company may be formed in 3 ways only. A company may be formed as a private company with 2 persons, as a public company with 7 persons, and as an OPC with just 1 member. So this is the requirement of forming a company. Now, is this the requirement only at the time of formation or throughout the life of the company? This is the minimum number of members that should be there, not just at the time of formation, but throughout the company's lifetime till it is actually dissolved, right? So, ma'am, what happens if a company is being formed with just 7 members as a public company? Minimum requirement is met. Now, one fine day, I shouldn't call it a fine day because in the next sentence, I'm going to say something really harsh. So one day, one of the members was driving through some highway and he met with an accident and died on spot. Now, how many members are there? Now the members left are only 6. So, ma'am, should the company be wound up? No. This is not going to happen. The company is a perpetual succession, but the minimum criteria is not now met. So, these remaining 6 members are being given a span of 6 months. Go and find another member. It may so happen that his shares are being transmitted to his legal heir and he joins as a member, no problem at all. Right? But supposedly that does not happen. So you have to find another member and you have to bring the minimum number of members back to 7 to continue with the company. Supposedly 6 months lapsed and you did not find the 7th member. So you're still doing business with those 6 members only. After 6 months, whoever is still the member, that means those 6 members, if you enter into any contract, now the company will not be liable, just you all will be personally liable. That is what the section is trying to tell us. Ma'am, supposedly out of those 7 members, 1 died and this 1 member was in US from past 1 year. So he did not know anything about the accident and the death. Only these 5 members knew. Now, when he comes back and he's being subjected to a lot of liability because of the contracts being entered beyond a span of 6 months, he is furious. He is like, why should I be held liable? I did not even know this. Is it correct? Yes, ma'am, he shouldn't be held liable. So what is over here? Every member, if at any time after incorporation of company, the number of members is reduced below 7 in case of public company or 2 in case of private company, then if business is carried after 6 months with reduced member, every member who knew this fact, who is cognizant of this fact, shall be severally liable for the debts of the company contracted during that time. During that time means after 6 months. Okay? Fine. So now we'll begin with the incorporation. When we start with the incorporation process and the document filing, the first 2 very important documents that you'll be needing is Memorandum of Association and Articles of Association. So first we'll know about this and thereafter we'll go then. So Memorandum of Association, Section 2, Clause 56 defines it, but the definition does not have anything. Memorandum means memorandum as originally framed or as altered from time to time, right? Everybody is altered from time to time. Do we change? No, we are the same, right? You still call me Shivangi ma'am from 10 years back, you still call me Shivangi ma'am, right? With the altered version, of course. So the memorandum, when it is being drafted at the time of incorporation, it is memorandum of association of the company. Maybe after some days, you change the name of the company, so the memorandum of association is altered. That is also memorandum of association. Fine. Now, what is it? It is the most fundamental document, basic charter, which tells us about the company. So it tells us company's constitution, how it has been constituted, with what name. Now, if you are a private company, the suffix will be private limited. If you're a public company, the suffix will be only limited, right? So the complete name of the company has to be written in the name clause. Next is situation clause. Now, it is not that you have to write the complete address of your registered office. No, it is only where the company is situated. So, the company is situated in the state of Uttar Pradesh. That is it. That is it. So, you only need to write the state in which it is registered. Object clause. Now, this is really important, and this defines the scope of the company where you can operate. If you are being told that, okay, the company is entitled to do this, it also means the company is not entitled to do anything beyond this. If you go beyond this, it will be ultra vires. That means beyond your powers. So that is going to turn every contract void. Liability clause. Liability clause. The liability of the members of the company is limited or unlimited, limited by shares or limited by guarantee, whatever it is, that has to be written. Thereafter comes capital clause. Capital clause means the authorized capital with which the company is registered and its division. 1,000 shares at the rate of 1,000 each or whatever it be. Succession clause is only and only in case of OPC. So when we come to it, we'll discuss more about it. Here you write just the name of nominee. And thereafter, many of you have heard and subscription clause. Well, it's exactly not a clause, but all the subscribers to the memorandum, all the subscribers means if you're forming a public company, you need 7 members. So all those 7 members, they are going to write their name, their address, their occupation, and they're going to sign it, and it will be countersigned by a witness. So that is what it is, subscribing to the memorandum. Okay, fine, ma'am. Then we come to the next type of document, which is articles of association. Again, the definition does not give us anything. What are articles? Articles are basically internal regulations of the company for own governance. Now, I hope you all know that Companies Act has 7 schedules. I should have written it in Roman. 7 schedules. Okay. Now, the very first schedule of Companies Act is all about tables. What tables, ma'am? Table A. Format. What format, ma'am? Format of MOA for a company limited by shares. The usual company. In India, maximum the companies which are being formed are company limited by shares only. Now, format of memorandum of association means what? You have it. You just fill the remaining part. Okay, object clause, I'm going to fill the name as this, situation as this. That is it. When we come to articles of association, articles are internal rules, internal regulations for any company. Now, it also has model articles. Model articles means what, ma'am? Like we have table F, the most popular one, for a company limited by shares. Table F. What is there in table F, ma'am? If you are forming a company limited by shares, You form your own articles because articles are mandatory and they are to be for every company. It is required at the time of registration. It is mandatory. So you have to prepare your articles of association. Now, when you're preparing your articles, you have to see whether I want these model articles, this table F to apply on me, or I don't want. I don't want this particular clause to apply on me, I'll strike it off. I can accept it as it is. I can frame, I can alter, I can do whatever I want to. Okay, but if I don't do anything, this is going to be applicable on me. That is how it works, right? Okay. Now, printed, signed, divided into paragraphs, numbered, witnessed in the same manner, must be prepared by every company, required at the time of registration, be altered later, can be altered later. Both memorandum and articles can be altered later. Section 13, Section 14, right? Now, there is something more called as entrenchment provision. Entrenchment means what? Entrenchment is making the change more difficult. What do we mean by that? See, one thing more that you have to understand over here is that whenever memorandum and articles are being framed and post incorporation or at the time of incorporation, they're being submitted to ROC, they become public documents. Okay, they become public documents, so anyone can read it. It is open to everyone. We'll also read a doctrine with respect to this, but it is open and anyone can read it. Now, the articles tell a lot of things. Supposedly, we have written a point in the articles that Shivangi is going to be the solicitor for life for the company. Now, what is this happening? You have to listen very carefully and understand this intent. Don't be confused at all. Now, this particular thing is being told by the company to its members. It is an internal discussion between the company and the members. It is not a contract between the company and me. I am an outsider. I am not a member, right? It's just that internally, like in a family, when we converse and we say, okay, let's do one thing, let's call this particular person only to garden or to take care of our garden. Now, this is what we're talking internally. Even if that particular person heard this conversation, he cannot come and sue us for not keeping him as a gardener. No, we were just discussing it internally. Or it was just a commitment internally. If at all we want to change this, you and me, we can change it always. We have not entered into a contract with you. You are an outsider. So whenever memorandum and articles, once they're registered, it is going to bind the company to its members on whatever points they have written. It's going to bind the members to its company, but it's not going to bind the company to outsider. Okay? So the outsider can never come and sue on any ground written in articles that you have written this, you should do this. No, I have written something in articles, I can go ahead and change it also with the permission or with the procedure followed in or written in Companies Act. Okay. So now, this is the background that you all have understood. Now this company is being formed and they said that, okay, we are going to add a clause in the articles of association that Shivangi is going to be the solicitor for life. I said, great. But this clause, adding this clause in your articles does not bind you to me. So any day you can come and change it. So I want somehow that you make this change more difficult. Because any day you are going to throw me out, you just simply need special resolution to alter your articles. What is special resolution? When the votes in favor are at least more than or equal to 3 times of votes against. So if there are 25 votes given against a particular thing, you need to have at least 75 votes in favor. And if there is this situation, 75 or more votes in favor, then SR is passed. So at any time you'll call your members, you'll pass SR and you'll change this clause. No, so I am not willing to do this or etc. etc. So what they did is they said, okay, fine, we'll add entrenchment. Entrenchment in that clause means supposedly they said and added that this clause can be changed only if 95% members agree to it. So now you need 95% consent. Earlier, you only needed special resolution, that is 3/4 majority, right? So this is adding entrenchment. Now, entrenchment at the time of formation of the company can be added without asking for anyone's consent, because whoever is consenting will only subscribe, right? But later on, if you want to add this entrenchment, then you need to ask. In private company, you need agreement by all the members. In public company, you need agreement through SR. Okay, fine, ma'am. So finally, we come to the process of formation of a company. We have a beautiful form, Spice Plus. Now, this particular form, I would say, is the great initiative of government. Why? Because it gives you the ease of doing business. If I want to start business, there is so much on my plate, right? I have to open a bank account. I have to obtain GST number. I need to get a PAN. I need to get a TAN, right? I need to get get my company incorporated. Then I also have some ESIC compliances. I have some Provident Fund compliances. Oh my God, there is so much. So every time I'm running to different departments, now this gives you a single window clearance. 11 services in a combination of central plus state governments. So some state governments were in like Maharashtra, Karnataka and West Bengal. So professional tax is mandatory. So you get that mandatory professional tax registration also. So if you want to start a business, it saves a lot of time and effort and cost. Okay. How does it work, ma'am? We have a form Spice Plus, which is ideally divided into two parts, Part A and Part B. Okay, Part A is just name reservation and Part B is the entire documentation and filing, and your company is incorporated, right? You get name reservation if you are proposing certain persons to become the directors, but there are nowhere directors elsewhere, then the DIN will also be required, director's identification number. So you get that also. You get TAN, PAN, SIN. That is something that you'll get undoubtedly. SIN is corporate identity number, the unique identification number for every company's. PAN you of course know, TAN you of course know, right? Apart from this, there is an accompanied form Agile Pro, which is an application for obtaining GST, EPFO, ESIC, professional tax, bank account, shops and establishment, right? Ma'am, how do they open a bank account? Well, to be very practical, they don't really open a bank account, but they let you choose which bank you want to open an account in, and that particular bank personnel calls you, coordinates, and then works for you. Okay, right? Fine, ma'am. So what we can do is, first we can just fill Part A and reserve our name keeping in mind the name restrictions given in section 4, right? What are the name restrictions which are given in section number 4? That our name should not be identical with an existing company. If I want a name like Reliance Education, I cannot get it. Why? Because it gives an impression that I belong to that particular group. So it cannot be identical to an existing company. It should not constitute an offense, and it should not be undesirable in accordance to central government. Okay, there are certain words which are being given. We don't have to read the rules in detail. Now, there should be no word which gives an impression that it belongs to the government, like board, Central Board of Secondary Education. So this gives an impression that it is a government entity. If I am incorporating a company and I'm using the name or the term board in the name of my company, so for using this, I need to obtain CG's permission. So approval of CG is required. So keeping all this in mind, we can suggest a name which will be approved by ROC if there are no defects, and it will be reserved for 20 days from approval. Now, initially we get an approval for 20 days. So 20 days, they'll set aside this name and keep it for us. If within that 20 days, we can make this Part B application. Okay, we'll read it on next page, right? If we can make this Part B application, great. our company will be incorporated. But if we are unable to make that application, then the name reserved will lapse and it can be taken by any other person. Now, if we think that, okay, 20 days are ending anytime soon and our documents are not yet ready, we can apply for extension by paying more fees, right? So our name reserved can be extended by another period of 20 days and again another period of 20 days. So 20 plus 20, it can be reserved, it can be extended, or see, initially 20, then again 20, then again 20, or 20 plus 40. So ultimately, in total, the name can be reserved up to 60 days in case you are forming a new company. If you're an already existing company and you want to change your name, then you can reserve that name by using a form run, and your name will be reserved for 60 days from approval. Okay. Now, sometimes it may so happen that you are using a word called as board in your name and you needed CG's approval for the same. What you did is you obtained a fake approval and you got this name reserved. Okay. Now, ROC, while checking this and reserving your name, they found out that this is fake. That means you have furnished incorrect particulars and you are trying to form a company. They will not reserve your name or whatever name they have reserved. They'll cancel it because your company is not yet formed. Okay, your name was reserved. If your name is not reserved, they'll simply reject it, right? But supposedly your name is reserved and it is later on found out that these were reserved by furnishing incorrect particulars. So they'll see whether the company has also been formed. No. The company has not been formed. The name reserved is going to be cancelled and the penalty of 1 lakh. But what if the company is also being formed? Now ROC will give you an opportunity of being heard and can pass any of the following orders. They can ask the company to change its name within 3 months or remove their name from the register, or maybe if they think that company has entered into a lot of contracts, have a lot of liabilities, assets, so they can also pass a petition for winding up, that this company be shut down, that this company, all the assets be sold and the liabilities be paid off. Okay, so this can be done. Okay, ma'am. Now, we have reserved the name or we haven't reserved the name and we have decided to fill part A plus part B together. There could be both situations, right? The next thing comes to prepare all the documents. Ma'am, what documents do we need to prepare? What documents do we need to prepare? See, the first thing is memorandum of association as well as articles of association. This is something that I have already discussed with you. It is going to be signed by all the subscribers to the memorandum. The next is declaration. Declaration by whom? Declaration by 2 people. First is the first directors and the second is advocate, CA, cost accountant, company secretary, whoever professional is involved in the formation of the company. Now, what declaration do they give? They declare that the requirements of Act have been complied with. Act, rules, whatever it is. The third is declaration again, declaration from the subscribers and the directors. What? Now, this is a declaration of no offense kind. So they say, I have never been found guilty in the promotion or formation of the company. I have never been found guilty of fraud in the past 5 years to any company under this Act. And all the documents that I am filing are true to the best of my knowledge and belief. So these are the 3 declarations that is being given by subscribers and first directors. Thereafter, the office address, if you do not have found a registered office yet, then you can give any correspondence address, and once the company is incorporated within 30 days according to section number 12, you must have a registered office, and at all times thereafter you must have a registered office. So you also have section 10A, wherein once you file and inform ROC about your registered office address in INC 22, thereafter only you can commence business if you're a company with share capital. Okay, so these are 3 connected sections. Now, Thereafter, particulars. Particulars of whom? Every subscriber, every director. So subscriber, their name, surname, residential address, nationality, proof of identity, everything. Right? For directors, you have DIN also. Right? Then the consent of directors, their other interest. All that has to be accompanied, all that has to be attached, annexed, and thereafter you submit this form to ROC. Whatever documents you have prepared over here, they have to be preserved till dissolution. Once the documents are being submitted to ROC, ROC is going to issue you a certificate of incorporation, wherein there will be mentioned the date, which is important because from that date, your company becomes a body corporate, your prospective company becomes a body corporate. Okay. And you will get a corporate identity number, which is going to be distinct for every company. Now, if later on it is found out that you have incorporated the company by furnishing wrong information, there you reserved the name by furnishing wrong information. Here you have incorporated the company by furnishing wrong information. So what is going to happen over here? When the form or when the documents were being screened, so yet the company is not formed, but they found out that okay, you have given incorrect information, so they will not register your company, and whoever is responsible will be subjected to or liable for the provision of fraud. Okay, so we have this universal section 447 under Companies Act, wherein you do any fraud, you're being liable for action under section 447. But what if the company is also incorporated and later on it is discovered that you have incorporated the company by furnishing incorrect information? See, you have part A, whatever information is required there, that is required only for name reservation. So if you furnish that incorrect information, you're being subjected to the first penalty that I told you. But part B, all the documents are for company incorporation. So here if you're furnishing incorrect information, then this particular penalty gets attracted. So promoters, first directors, subscribers, they're all liable for fraud, and there will be additional orders may be passed if an application is made to tribunal, like closing the company and all. Okay, fine. Now we have certain points with respect to one-person company. If you're forming a private company, if you're forming a public company, the things go the same way. But if you're forming an OPC, we need to have certain additional points in mind. What are they? First, you need to have a nominee. So your memorandum of association will have an additional clause called a succession clause, wherein you'll write the name of the nominee, but you cannot write anyone's name. Oh, I like her, let me write her name. No, you cannot. You have to go and take consent, written consent. That written consent has to be filed with ROC so that ROC knows that the other person has accepted to be the nominee. Okay. So this filing has to be done along with the incorporation document. Right? Now, this particular nominee will become the sole member in the event of subscriber's death or incapacity. Yes? So, till the time the subscriber does not die or become incapable, this is nominee, this is sole person. Nominee after a certain period of time thinks that no, this company is not performing so well. I don't want to be the nominee, otherwise I'll be exposed to so many responsibilities. I don't want to. She can withdraw. She or he can withdraw the consent. In such a situation, there is vacuum or vacancy in the position of nominee. So this sole member will find another nominee, obtain his consent, file the same with ROC. Okay. Now, there could be another situation that the sole member thinks that no, I don't like this particular nominee. Earlier, I thought he's very competent, but now I feel that he'll not be able to pull it off. So they want to change the nominee. They can again inform the company and do the filing. Give the notice to company. The company is going to intimate it to ROC. Right? So nominee can withdraw his consent and the sole person can change the nominee also. That is not the problem. And every time you're changing the name of the nominee, although you are also changing memorandum of association, but this is not deemed to be alteration of the memorandum. Okay, ma'am. What is this? Ah, what is this happening? Okay, clear so far. Now, minor can't become the member of OPC. What am I doing? Minor can't become the member of OPC. OPC, this I've already told you. Two persons are not allowed. This also is something that I've already told you, right? Now, if you read anything with respect to voluntary or compulsory conversion of OPC, that is an old law and that does not exist anywhere now. Okay, fine, ma'am. Next section comes commencement of business section 10A. So if you are a company which has been incorporated after Companies Amendment Act 2019, that is after 2nd November 2018, from when the amendment was effective, and you are a company with share capital, then you need to do these two things. What I need to do, if you have not furnished your registered office address to the ROC at the time of incorporation, you must file INC 22. Okay, and thereafter you can commence business, and you must also file INC 20A within 180 days of incorporation. Now, what is INC 20A, ma'am? It is a declaration by whom? Declaration by the director. Ma'am, what is he declaring? He's declaring that we had these 7 subscribers who agreed to buy 100 shares each of this particular company. So eventually they have to pay a certain sum. They only agreed. Once the company is incorporated, they will pay the amount, the company will issue the shares, and it will begin, right? So whatever they agreed, have they paid that amount? So declaration that yes, the amount has been paid, and this has to be verified by a company secretary, chartered accountant, or a cost accountant in practice. See, cost accountants also have a lot of scope when it comes to MCA. Okay, now I hope this is clear. So they make a declaration and thereafter they can commence business. Supposedly they started business without filing declaration, they will be exposed to penalty. And ROC, if they believe that you are not doing any business, no declaration has been filed, so they will ROC will come, they will inspect, and they will see. If they find that you are not doing any business, they'll remove your name from the register of companies. Okay, now we come to section number 12, registered office of the company. First, every company from 30th day of incorporation and at all times thereafter must have a registered office. It's not 15th day, it is 30th day, my dear. Okay. Secondly, you have to do the filing INC 22, I already told you. Thirdly, labeling of the company. What is labeling of the company? Every company has to paint or affix its name outside every office, registered office, branch office, whatever it is. So they have to paint and affix its name, right? You have to write in proper legible characters. What you are going to write? Simply the name and address. Address of what? Address of registered office. Name and address of registered office outside every office. Okay. If there is some local language which is prevalent, then you have to write in that local language also. Okay, and in your business letters, bill heads, letter papers, the name of address of registered office, and the sin along with phone number, website, email, that all has to be printed in all business letterheads. Fine. If you change the name of the company, then you have to print the old name also till 2 years. Okay, and if ROC has reasonable cause to believe, this is I have already told you, they will do the physical verification, and upon verification, if default is found, registrar is going to remove the name of the company from register, right? Okay, now the next thing is alteration of memorandum. Alteration of memorandum means what, ma'am? We are altering, memorandum means we are altering any of the clauses of memorandum: name, situation, object, capital, right? Now, liability. The first one, or in general, you should understand the memorandum can also be altered by passing SR. Articles can also be altered by passing SR. That's the rule in general. Now, firstly, we talk about name clause. So we want to alter, that means we want to change the name of a company. Can we do that? Yes, we can do that if there is no default in filing annual returns or repayment of deposits. Okay. How do we do that? We call the general meeting, we pass special resolution, thereafter we make an application to central government. So we need approval of central government for changing our name. Once we get that approval, the SR approval of CG, we file it with ROC, and ROC is going to register our new name and issue us a new certificate of incorporation. So that was name change. Alteration to name clause. Secondly, alteration to situation clause. Now you have to understand that in situation clause, what are we writing? We are just writing the state. We are not writing anything else. So only changing the state comes under this particular point, alteration of memorandum, right? So now, just a second. If you want to alter, okay, let me tell you. If you want to alter the state, that means you are shifting your registered office from one state to another state. Then for this, you need approval of central government. You need approval of central government. Now, central government, when you make an application to central government for approving this, central government will satisfy itself. Okay, what will it satisfy? That the creditors have been paid off. There's sufficient provision which you have made for the creditors. You have got the consent of the creditors. And after ensuring all this, what happens is government gives you an approval. Now you get this approval, you again have shareholders resolution, that is SR. SR plus CG's approval, you file this with ROC of both the states, the old state and the new state. The new state ROC is going to issue you a fresh certificate of incorporation. Okay, because now you're being shifted to that state. Okay, so that is how it works. Then comes your change in object clause. I'll come to all these later. But first of all, when I'm talking about alteration of memorandum, let's strictly discuss alteration of memorandum only. So next is alteration in object clause. Now what is happening over here? Object clause. No problem at all, ma'am. We just pass SR and we can change the objects of the company. But there is only one case wherein there is more requirement. More requirement like what, ma'am? The company has unutilized money raised from prospectus. That means company issued a prospectus, raised an amount of 1 crore, has utilized 50 lakhs so far, and now it wants to change the objects. That means the people who have given you money for a particular object, you're using their money, but you're changing the object. So you need to ask them. Ma'am, we are asking them, we are passing SR. But you need to be more conscious. More conscious means what? The SR will be passed through postal ballot, because not everyone can come to your general meeting and attend and give a vote. So it has to be postal ballot so that we can have in large participation of the members, at least who want to object, at least who want to dissent. They can, and they will be given an exit opportunity. They can exit from this particular investment at a rate as decided by SEBI. Okay. So in accordance to SEBI regulations. Another thing has to be done. What is that? That resolution is going to be published in the newspaper, vernacular and English, so that everyone gets to know, okay, this is happening. It will also be placed on the website, because we don't want people to feel cheated. The ones who are not very active, the ones who are not very aware, we want them to know this. Okay. So that is how you can change the object clause. Right now, when we talk about the capital clause, the alteration is given in the chapter of share capital. So we read about this later, liability and capital. So that is something that we are not supposed to read over here. Now, whatever alteration we are doing, the special resolution has to be filed with ROC within 30 days. And once it is filed, once it is registered with ROC, then only it will have effect. then only it will have effect. Okay, so this was about alteration. But now we have something else. What something else, ma'am? We have section 16. Section 16 tells us that change your name. Compulsory change of name. You change your name. Why should we change our name? Because government is directing us to change our name. Why is government directing us to change our name? Because we have got our name identical with an existing company. Why did IROC do this mistake? See, now this really happens because there is an automated system, and ROC, the portal is going to detect that no, your name is identical. So they'll not even approve the name. But let's say, for example, it is approved, and later on it is discovered by government. Government will direct us, change your name within 3 months. And we have to change our name. Once we change our name, within 15 days, we have to inform ROC that, okay, we got the CG order, we have changed our name, and ROC is going to issue us a new certificate of incorporation. Fine. There is one more thing. There is a registered trademark of usually the proprietors. See, if I am a proprietor, I have a registered trademark in the name of Book My Video, and somebody goes and forms a company in Book My Video Limited. Now, I'll have an objection because I've already developed a trade name over here. So I will make an application within 3 years of that company's incorporation to central government that she asks this company to change the name. I already have a registered trademark in this name. CG will give a direction, and that particular company has to change the name in the same manner. Okay. Now, situation clause, alteration you have already discussed. But apart from that, what thing you should know is that if there is a company and wants to change its registered office within the same city, they just need board resolution. If they want to change their office from one city to another, but they're still in the same ROC, then you need basically regional directors. Okay, let's forget regional director right now. You need SR. Here you already need board resolution. Here you need special resolution. Thereafter, when you want to change your office from one ROC to another ROC, but within the same state. Within the same state, how can this happen? One state has just one ROC. Well, you all know that there are 2 states in India which have actually 2 ROC. One is Maharashtra and one is Tamil Nadu. So if you are changing from one ROC to another, but still you are in the same state, you need the permission of regional director. And if you're changing from one state to another state, you need the permission of CG, as I already told you. Although this has also been delegated to RD, but this is what you have to remember for your exam. Shall not confuse you. Okay. Now we come to the next part, articles alteration. So alteration of articles. Alteration of articles basically mean converting. Alteration in general of articles of any clause can happen by simply passing special resolution. So there's nothing that we need to tell you. Once special resolution is passed, it has to be filed with ROC, and it has to be filed within 15 days, right? So once you file it, once the articles or altered articles are registered, then it will be valid as if they were originally contained in the articles. Now, there are 2 things that you need to understand. If you're converting a private company into public company, we alter the articles. Why, ma'am? Because a private company has that restriction, limitation, prohibition. And if you're going to be a public company, then you need to remove that. And if a public company is being converted into private company, then you need to add that restriction, limitation, prohibition, everything, right? So in both the cases, articles are being altered and conversion is taking place. Now you have to understand over here one thing, that this alteration from private to public company is simple, is fine. You pass SR and you submit the altered copy plus SR to ROC and it's done. But when you are altering for this particular purpose, you are converting public company into private company, you also need approval of CG. Okay. So copy of order of approval of CG also has to be filed with registrar. Okay, fine. This is something that I've already told you. Now we come to the doctrines part. Doctrines part means what, ma'am? Doctrines of ultra vires. First of all, doctrines of ultra vires is what beyond the powers of, right? So you have a limit, or you have a scope, or you have a purview within which you have to operate. the company, its management, you cannot do something which is beyond the memorandum, right? You can do something which is beyond your articles, because then all articles can be altered by shareholders. So shareholders have the power. So if you do something beyond the articles, maybe it can be ratified by the shareholders, it can be later on accepted by the shareholders. But you cannot do something which is beyond the memorandum. You cannot do something which is beyond the act. Okay, fine. So if you do that, what is going to happen? That particular transaction is going to be treated as void. Ultra wires by the company cannot be ratified even if all the members subsequently agree to it. You have to understand that. Okay, shareholders might even decide that, okay, I can change the object also. So currently the company is not allowed to do this, but I'll alter the object and I'll accept it retrospectively. No, you cannot do that. This was the existing memorandum. This defined the power, what a company can do and what a company can't do at that particular point of time. So you cannot change it later. Okay, so you cannot ratify it, you cannot accept it at a later point of time. The second one is doctrine of constructive notice. What this particular doctrine means: if you are an outsider, first thing, according to section 399 of Companies Act 2013, as I already told you, once the documents like MOA and AOA are registered, they become the public documents and they're freely available. So any person who is coming to deal with the company is presumed to have read those memorandum and articles. You cannot later on come and plead that, oh, I didn't know this was the company's policy. Oh, I didn't know the company is not allowed to deal in cement. Yes, it is beyond, and that becomes void. You cannot later on go and plead and pretend and pretext that, no, I should be paid the compensation. This is wrong on my part. You should have read what the company is allowed to do and what the company is not allowed to do. So you are deemed to have a constructive notice. You are constructive means what? Deemed notice, basically. Deemed notice, right? So the third parties are deemed to have notice of the same. They're presumed to know about MOA and AOA. And lastly, we have doctrine of indoor management. Doctrine of indoor management is absolutely opposite. It works actually in favor of outsiders. Doctrine of constructive works in favor of company, but here it works in the favor of outsiders. Supposedly I'm outsider, I'm coming to deal with the company or enter into a contract with the company. I know that the company has to pass SR and thereafter they can do this. I asked the company, have you passed SR? They said yes. Fine, I entered into the contract. Now, am I at fault? Am I supposed to inquire that, yes, whether you did this or not? No, I'm not supposed to inquire into internal affairs of the company, right? Doctrine of constructive notice, let's discuss this only, because doctrine of indoor management is actually the opposite of doctrine of constructive notice, right? Just a second. So here we are entitled to assume that whatever directors are doing or whatever the company officers are doing, they're doing it validly. We don't need to inquire whether you are doing it in the correct manner or not. We can straight away go and plead to the court. I didn't know that this was not passed. This SR was not passed, or this was the flaw inside. Right? Now, supposedly I knew the flaw. Then will the court accept it? Oh my God, it's okay, ma'am. We understand that you're not supposed to inquire, but you knew this. You knew this problem, still you entered into a contract. So that's your mistake as well. So if I had the knowledge of irregularity, I will not be able to take advantage of this doctrine of indoor management first. If I was negligent, that means with little inquiry, I am getting that suspicion, but I'm not checking onto it. Like, this happens a lot in day-to-day no, I shouldn't say, but Gen Z relationships. I would say that if there is somebody who is operating, who is just looking at a phone, and the partner or whatever girlfriend, boyfriend you call, they drop into the room and they are saying, oh, you're trying to hide. Or if your parents drop into the room and you're trying to hide your mobile, the parents will get suspect. oh my, he or she is doing something wrong, right? And despite the suspicion, they were negligent. It's okay. It's okay. And later on, they discover something. So you cannot, you should not actually blame the other person only. You also were negligent in this, right? So you should have made effort to find out what problem he or she is dealing into, or what is that is going on in his or her life, right? So if you are negligent, then also you cannot take advantage of this. And lastly, forgery. Forgery is complete nullity. Supposedly, the company has entered into a contract, but there are forged signature of the director. This can never, we can never say that the company should be liable for this contract. No, because this forgery is complete nullity and it can never be made valid. Okay. Fine. Now we come to Section 8 company. Section 8 company are the companies which are formed not for profit. Not for profit. So they are being formed for charitable purposes, like for promoting sports, for promoting education, for promoting religion, for protection of environment, for restoration, or like things, right? So whatever they are getting, the donations, whatever surplus they are making, they are going to apply their income in promoting that object only and cannot pay dividend to its members. One thing. Now, because government gives a lot of grants, you get a lot of donations, you get a lot of exemption benefits, you need to obtain license from the government. If you are a newly if you're newly incorporating a company, that means you're forming a Section 8 company. Well, you have Spice Plus that includes your application for license also. Now you don't need to make a separate application for license. That includes, right? All you have to do is you have to file these additional documents, that is estimated annual and income and expenditure for next 3 years for the license part. So you file this in the same manner and you get license plus the certificate of incorporation from ROC. Once you are incorporated, you enjoy the benefits of being a private company or a public company, whatever you are, without adding the words private limited or limited at the end of your name, but still you are a limited company only. The special part over here is that a firm can be a member of such Section 8 company. But a weak part is that whenever you are changing, you are altering your memorandum or you are altering your articles, you cannot alter it unless you get CG's approval. Now, if CG has given you a license, CG can revoke your license also. When can they revoke it? They can revoke it if you contravene the requirements of Section 8. They can revoke it if you contravene the condition on which license was issued to you. So maybe there are some additional conditions which CG has imposed that, okay, we are giving you a license, but you have to follow this. You did not follow it. If you do that fraudulent conduct, if you are conducting in a manner violative of your objects, you were supposed to promote sports, but you're doing some sports business, you're selling, you are uplifting some, so it is violative, or you are doing it against public interest. Maybe here some public interest is being harmed. Your license can be revoked. Of course, if your license is revoked, you will be getting an opportunity of being heard, and once the license is revoked, a copy will be given to ROC. Now what happens? License is being revoked, so now you become either a private limited company or you become a public limited company, and you add that suffix. You just add limited or you add private limited, whatever the case be. More than that, apart from that, I would say CG may also pass additional orders like winding up of the company or amalgamation of the company. Because it is a Section 8 company, you cannot take the funds out in your pocket. So it may be wound up, right? Whatever extra fund is there, whatever sale proceeds are there, you have a rehabilitation insolvency fund, it will be transmitted to that, right? Or it may provide for amalgamation of this particular company into some other company having similar objects, another Section 8 company having similar objects, right? Okay, ma'am. Now, if there is an existing private company and now it wants to convert itself into a Section 8 company, what you can do is you must remember INC 12. INC 12 is the application for obtaining license for an existing company. Okay. And of course, if you want to obtain license, what you have to do is you have to give your 3 years estimated income and expenditure, and you get the license. No problem at all. So if Section 8 company wants to convert itself into any other company, they have a Rule 21, pass SR at general meeting, file application in INC 18 along with SR to regional director for approval, and thereafter a copy to ROC also. If any other company wants to convert itself into a Section 8 company, then this has to be satisfied. You need to obtain license, and thereafter you can do that. Right? So I hope this is clear. Okay. Now, if you want to convert any other company, right? How we are going to do it? By altering memorandum and articles. I've already told you private to public and public to private how it is going to be done. Otherwise, you alter the memorandum, alter the articles, you file this application to ROC. ROC is going to issue you a new certificate of incorporation, and your old liabilities, existing contracts, existing obligations, everything is going to remain the same. There is going to be no change in these. Now we are going to talk about conversion of LLPs into company and company into LLP, right? How does that happen? First, conversion of LLP into company. See, you are converting your LLP into a company. You will also have an option. You can always incorporate a new company. There is no problem at all. So shut this down and incorporate a new company. But when you're converting, you have to keep in mind that when you're converting LLP into company, all the partners of LLP will become the members of company. There cannot be extra people out there, right? Basic requirements. You need approval from all the partners, right? You will have a newspaper advertisement. You will have an NOC from ROC. Which ROC? Where the LLP is registered. Okay. So these are the basics that must be done. These are the basics that must be done. Okay. Now, there is one more requirement, basically, that LLP must have at least 7 partners, and thereafter you can convert it into a company. That means, ma'am, if an LLP has just 2 partners, it cannot be converted into a company. Earlier, there was this requirement that you need to have at least 7 partners. Now, there is no such requirement. So if there is LLP will not be with 1 partner, so there will be at least 2 partners. So now LLP with 2 partners can also be converted into a company. So please, if you read this, don't be confused. Fine. Okay, ma'am. Where is the process given, ma'am? It is not given under LLP Act. We have a section 366 of Companies Act 2013, which actually tells us that partnerships can convert it into company, or LLP can also convert into company. So first of all, the partners approval we have, the partners decide the name, they can reserve a name, right? And when they meet, they authorize a particular partner that, okay, you are supposed to prepare all the documents and you are supposed to register these documents. Fine. What extra things they need to have? Approval, advertisement, NOC is fine, name approval is fine. Thereafter, the most important thing is filing form URC1 with attachments. You get DSC, you get DIN, all of that. Now you need to file URC1. Okay. Now URC1 means what? It means simply the details. What details? The members' details. That means the partners who are existing partners who are going to be the prospective members. Names, address, occupation, how much shares are they going to take up, right? Shares allotted for cash, for consideration other than cash, who is going to become the first directors, his DIN, his details, right? Names, address, everything. If you are an LLP or if you're a partnership firm, you must be having a deed of partnership, so that NOC or written consent from the creditors, right? Consent of all the partners, right? So all that, copy of newspaper advertisement. So all this has to be filed in URC1. Now we come to conversion of company into LLP. Now this is being given according to LLP Act. Fine. What is it, ma'am? Now we have a company. So company will have a board. So first of all, a board meeting shall take place. They shall ask the members. The members shall agree, right? So you have to take consent. First, you hold a board meeting. You authorize the director, right? Thereafter, you have the consent of shareholders, right? So, board resolution, written consent of shareholders, then you file the form for name availability, then you file the necessary docs for incorporation of LLP. What is that, ma'am? What is that? The basic details. Here, the form is E Form 18. Okay. What are the details? Statement of shareholders' consent, statement of assets and liabilities, list of creditors and their consent, the director's details, right? All of that. Now, one more thing that you have to understand over here is that about LLP agreement. Because you're converting your company into LLP agreement, if you remember the provisions of LLP, you must also remember that when we incorporate LLP, we don't need LLP agreement. LLP agreement can be filed later on after incorporation also within a span of 30 days, but it is advisable to avoid any dispute. It must be filed at the time of incorporation, right? So it is not necessary to have LLP agreement at the time of incorporation. The same goes here also. In LLP agreement, you usually have the name of LLP, profit sharing ratio, rights, duties, what business are we going to do, who's going to be the designated partner, and everything. Right? So you have that. It is one of the basic documents, but that can be done later on also. Okay. So what do we file over here? We file E Form 18. Right? Okay. I hope this is clear so far. Now let's revise all about foreign companies. Where's it coming from? See, ideally, it is a part of our very first chapter, company formation and conversion. But if we look at it technically, it is the provisions are contained in chapter 22 of Companies Act, right? So chapter 22, which essentially or originally has section number 379 to 393A, those are the provisions which relate to foreign companies, or which are made applicable for foreign companies. But prima facie, at the very first place, we need to understand what is foreign company. So we have some companies which are incorporated in India under Companies Act or previous company law. They are all Indian companies, right? Or they are just company under Companies Act. However, there are certain companies which maybe are incorporated outside India. So how are we concerned about the companies which are not incorporated under Indian laws? How can Indian laws be applicable on those type of companies? Yes, of course, they won't be applicable. Now, these companies which are incorporated outside India, if they are not concerned with India, if they are doing business outside India only, we are not concerned of them unless they come here. But, if such companies come here, they open another Indian company, and through that Indian subsidiary, they are doing business. That Indian subsidiary is an Indian company, so all the laws will be applicable. Again, the concept of foreign company does not step in. The concept of foreign company steps in when we have a company incorporated outside India, which comes to India through physical opening of office or through electronic mode and conducts business activity in India. Not by opening another company, but just maybe by establishing a place of business, by opening some branch office or whatever. So company incorporated outside India, it has a place of business in India. This place of business could be direct, it could be through agent, it could be physical, it could be through electronic mode, and is conducting business activity in India. So such foreign company, such company which is incorporated outside India, which has a place of business in India and does business activity in India, that will be known as foreign company. This branch of that company incorporated outside India will be known as foreign company. So this here we are referring to that foreign company, its Indian operations, and here we are concerned of making Indian laws applicable on such a branch, because it is doing business with Indian people. They are all involved, Indian stakeholders are involved. So of course government is concerned and steps in and makes a beautiful chapter 22, which is made applicable to foreign companies. Now, It could have a place of business in India electronically also. So for that, we have a rule too. And we have to remember some keywords for electronic mode. Keywords like there could be B2B transactions, there could be B2C transactions, there could be telemedicine, telemarketing, cloud computing, right? It could be digital supply, there could be acceptance of deposits, a lot of things. It could be whether by email or by any social media, the server is India or outside India, we're not concerned, right? So, all of that you have to keep in mind when we look at the definition of foreign company. So, the definition of foreign company is contained in Section 2, Clause 42. Now we have two types of entities or three types of entities. One is the companies which are incorporated in India. On that, entire Companies Act is applicable. Second is companies incorporated outside India. They're not doing any business in India. And the third is the companies incorporated outside India which are doing business in India. So they are foreign companies, right? Now, this chapter 22 is applicable on foreign companies. So all the provisions like that is start from section 379 to 393A, everything is applicable on foreign companies. However, sections starting from 387 to 391, these are the sections which actually relate to prospectus and all. They are also applicable on companies which are incorporated outside India. They're not doing any business activity in India. Ma'am, how can we make our Indian laws applicable on some entity which is incorporated outside India and is not even concerned in doing business in India? But if that company comes and raises fund by showing prospectus over here, then the provisions with respect to prospectus will be applicable. Okay, so these are the provisions with respect to prospectus which are applicable on all companies incorporated outside India, and the other provisions are applicable on all foreign companies. Okay. Now, this was section 379. 379 has another part of deemed Indian company. Now, let's say, for example, we have a company incorporated outside India. It has established a place of business in India and does business activity in India. So now on, we are going to refer it as a foreign company. So this foreign company, 50% shares of that foreign company or more, 50% of paid up capital of such foreign company is held by either Indian citizens or Indian company or a combination of them. In such a case, it is a foreign company. So obviously entire chapter 22 will be applicable. Moreover, there will be some additional prescribed provisions which will also be applicable on this company as if it was an Indian company. Okay, as if it were an Indian company with respect to its Indian business operations only, right? So this is something that you have to remember. And when we are talking about paid up capital over here, we have to keep in mind we're talking about preference plus equity. So specifically, you have to remember this for this particular point. Moving to the next section, section 380. Section 380. Now, whenever this company incorporated outside India establishes a place of business in India, that means it is opening a branch office. Once it has opened whatever place of business or electronically it has established a place of business in India, within 30 days, you will furnish FC1 along with these following documents to ROC New Delhi. Now, what are the documents? The very first thing, just like we have memorandum of association for our Indian companies, likewise, you must be having some instrument which constitutes or which defines the constitution of the company. So, whatever that charter document, whatever that fundamental document you have, that you have to furnish. Supposedly it is in some other language, so translate it into English and certified translated copy should be furnished. Second, the address, registered address of your principal office that you have in your own country. Third, your directors, your secretary and their particulars, their prescribed details. Fourth, what is going to be the person and their address in India. That means you have to find some resident in India who is going to be your authorized representative, who is going to accept documents on your behalf. 5. Whatever your address of principal place of business over here is, whatever principal place of business you have opened, the address of that. In past, it may so happen that you have opened a place of business and you have shut it down. So whatever past place of businesses were there, that also you will be giving the detail. And thereafter, you will also give a declaration. What type of declaration? that my director, secretary, and the authorized representative that I have hired in India, they're not convicted. That means they have not been found guilty of any fraud in the formation of company, or they have not been debarred from formation of the company. So they are genuine people. All of the things are allowed, right? So you will give a declaration like that also, and other prescribed information. If there is any change in such type of information, then there is another form for alteration, FC2. So within 30 days you will furnish that particular form for alteration, and you will give it to registrar for registration. Section 381. Just like Indian companies have to maintain a lot of accounts, they have to prepare financial statements for every financial year. In the same manner, what foreign companies have to do? See, foreign company, that means you are a company and you have established a place of business in India. So what you have to do is you also have to prepare financial statements of your Indian business that you're doing. And you have to prepare it for every financial year. Ma'am, the financial year of such foreign company and that Indian company, is it the same? That means they also have the same financial year, 1st April to 31st March? No, it may be different, right? Subject to necessary approval. So you may have a different financial year, right? Now, according to your financial year, you will prepare, of course, whatever financial year is permitted, they will prepare according to their own financial year only. However, it has to be according to Schedule 3 with prescribed annexures and all of that. And within 6 months of your close of financial year, you will submit it to a registrar. It may also grant you extension. That is, this information is not so important for you, for your exam perspective. However, what you have to remember and what you have to keep in mind is that supposedly the financial year is the same. So 1st April to 31st March is the same financial year that such foreign companies also following. That means 1st April to 31st March, and thereafter you get 6 months to do that. That means you are somewhere submitting your financial statements maybe in August or maybe in September. You're doing it. So every year in September you are going to do it, or I should say every calendar year you are doing it, right? Fine. But it may so happen sometimes that your financial year is say of 18 months. So what happens is, it may so happen that in 2 years there is no financial statement which is coming. So Indian people will be concerned. So for that reason, you get this type of confusion, financial year and calendar year. Now students get confused that, ma'am, what we have to do? Every foreign company will prepare its financial statement for financial year only, but they have to deliver it to registrar and ensure that every calendar year they are delivering one financial statements. Okay. Now, display of name of foreign company, section 382. So what you have to display, just like Indian companies also, if you look at section number 12, you should remember that every company has to put a board outside every office that, okay, fine, this is the name of the company, this is the registered office of the company, and like things, right? Outside every office, you have to put a board. Likewise, if there is a foreign company, so outside every place of business, they are going to put a board. Outside every place of business that you have in India, on that board, name, country of incorporation, and the fact that the liability of such a company is limited. That has to be displayed. And that has to be displayed in 2 languages. One, English in proper legible characters, and second, in local language. You will print these 3 things on all the letterheads, bills, and notices also, but that you have to print only in simple English language, not in the local language. That is not required. Okay. Then comes your service of documents, that is section number 383. Now, if ROC wants to send a notice to this foreign company, how can they send it? Well, this foreign company has provided them with the address of principal place of business in India. They have also provided the details of authorized representative who is the resident in India. So if ROC, or as of that any matter, if any notice or document has to be delivered on foreign company, they will serve it and send it by hand delivery, post, or electronic media to person resident in India, whoever is authorized, at the address which is furnished by such foreign company. And if you follow this process, The foreign company cannot deny, oh my God, notice was not received by me. I did not get the notice. Well, it was sufficiently given to your authorized representative, and if they have received it, it is deemed that you have also received it. So it has been served on you. That is going to be deemed, right? Now, when we talk about the chapter of company incorporated outside India, in our syllabus, only this many sections are covered. However, you have another section that you should keep in mind, that is section number 376, which actually relates to the chapter of winding up. Now, what happens? There is a company incorporated outside India. It has opened a branch. Now, that company incorporated outside India dissolves. Let's say, for example, it closes its operations and is shut down according to the laws of their own country. So, what will happen? This will also get dissolved. The answer is no. According to Companies Act, the provisions of winding up, the Indian business, this particular thing, is going to be wound up as an unregistered company. So in the chapter of winding up, we have the provisions that how an unregistered company is going to wind up, because this is not registered under Companies Act. This is an unregistered company only, right? This is an unregistered thing, right? So just like unregistered companies are wound up, this is also going to wound up like that only. So this is a small section. We don't have to read the entire thing. Body corporate incorporated outside India. That means a company which is incorporated outside India, which is carrying on business in India. It ceases to carry on business in India. So now it is not going to do business in India. Now, even if that original body corporate has ceased to exist, that means it has dissolved according to the laws of its own country. Yet, this particular Indian business or Indian operations, it is going to be wound up as an unregistered company according to the laws of Companies Act 2013. This is the only thing that you have to keep in mind. Remember the section number, because often in your examination, a short note or some part is being asked on this particular topic of winding up as unregistered company, right? Let's now revise the chapter of investment and loans. Now, this is basically divided into two parts, I would say, because we have two sections, section number 186 and 187, which talks about the loans and investments by company and all that. They are basically covered under the chapter of board meetings according to Companies Act classification, and it's too early for us to combine with this particular chapter. So basically, here we are revising chapter 5 of Companies Act 2013, which is deposits, right? So because after we read about board's power, which is given in section 179, thereafter companies get the borrowing powers. You read about making investments and all that in section 186, 187. So that we'll revise later along with that particular chapter. But right now we are discussing over here acceptance of deposits, its renewal, default, remedies, and all of that, which is covered in chapter 5 of Companies Act 2013, which contains section 73 to section number 76A, right? Okay. So the very first thing, ma'am, what do we mean by deposit, right? So deposit is what? Received of money by company. So company is receiving certain money. How company is receiving certain money? Company could receive certain money, or company could receive money in ample of ways, by way of deposit or loan or any other form. That means in whatever form you call it a deposit, you call it a loan, company is receiving money, that receipt of money is called as deposit. Is it that simple? No, the answer is not. We go to a bank and we want to take a bank loan. We receive money from the bank in the way of a loan. Is it deposit? The answer is no. Why is it not deposit? Because the purpose of this particular chapter, the intent of this particular chapter has to be understood. The purpose of deposits is basically to cater to the short-term needs, right? A company is running, it has to put in certain amount of money, and it will be blocked for a span of only 7 months, and thereafter your money will be released, or you're expecting money flow from somewhere. But for a span of 7 months, supposedly you need certain money. Now what do? You have some short-term credit facilities also, but then maybe they are not available, right? And maybe if you want to take money from your own members who have already invested in you, who know about the company, they're very happy and satisfied, you can take money from them also. But what do you give them in exchange? Are you going to issue them some securities? Now, again, issuance of securities is a long, tedious process. We have read about issue of shares, public offer, private placement, issue of debentures, and all of that, right? Before. Now, all of this takes time, all of this has regulations. Now, this is a short term need which is of the company and that has to be catered. So, you go to the member and ask them, are you ready to give me money for 7 months? After 7 months, I'll repay it to you. They said, fine, you take it. Now, the problem is this particular receipt of money, what do we call it? We don't call it share, we don't call it debentures, we don't call it bank loan, right? We cannot call it any of it. So how it is going to be regulated by Companies Act? Supposedly, company defaults in repayment of deposit as promised. What will happen? There is no penalty which has been stated. There are no rules which have been made. So for this leftover category of receipt of money, actually deposit provisions have been introduced. It helps regulate this particular sector also. Right. So because companies were what? They were taking deposits, but they were also incurring defaults. So for that reason, this particular chapter is there. So it clearly says that deposit means receipt of money in the form of loan or in the form of deposit, or you call it any, you give it any name. It doesn't matter. It will be called as deposit, but there are certain prescribed categories of receipt of money which will not be treated as deposits. What are the prescribed categories by CG in consultation with RBI? Ma'am, what are those receipts and are we supposed to learn it? The answer is you're not supposed to learn it. They are given in Rule 21C, and here we have also given it for reference, just for your knowledge, just for reading. You're not supposed to learn it. On these particular receipts of money, no question should be asked in examination, as it is not incorporated in the syllabus completely, right? Okay, so if you receive, like if you're taking a loan from bank, it is not a deposit. If you're taking loan from PFI, it is not a deposit. If you're receiving some amount from government, it is not a deposit, because all these sectors somewhere have their specific regulations and are being regulated, they're being managed, they're allowed, right? Apart from that, if you're receiving deposits. Now, can you receive deposit? The answer is yes, you can receive deposit, and any company can receive deposit, whether it's a private company or a public company. Private company, you can receive deposits only from your members. And public company, can you receive deposits from general public also? The answer is yes, provided you satisfy certain conditions and become an eligible company. So eligible public company, we have now three category of companies. We have private company, we have eligible public companies, and non-eligible public companies. All these three can accept deposits from members. However, only eligible public company can accept deposits from public. How? There should be some procedure which has been specified. There should be some conditions which have been imposed. The answer is yes. All of it that we are going to read in this particular chapter. So we begin with section number 73. We begin with section number 73. I also have this. If you want to take a screenshot, you can definitely take a screenshot. Now, these are the points that I have written as you should write in examination, because often a direct question is asked in examination, like, how can a company accept deposits from its members? Right? So if this type of question, or you frame any language, the content of section 73 is being asked, how will you write it? The first thing, any company, no company can accept deposits from public. Ma'am, you said eligible company can. Yes, except as provided under this chapter. So first general rule, that any company is not allowed to accept deposits, to invite deposits, to renew those deposits from general public, except as provided under this chapter. In this chapter, we have these provisions contained in section number 76. So according to section number 76, if you follow that, you can accept deposits from public. Apart from that, no company can accept deposits from public. Ma'am, if we talk about banking companies, if we talk about NBFCs, it is their ordinary course of business, and they are bound to accept deposits from public in day-to-day business. So that is an exception. So banking company, NBFC, HFC, or any other company which CG may specify after consulting RBI those companies will be exempted from this particular clause. Now, if any company wants to accept deposits from members, what is the procedure that they follow? First thing is passing of ordinary resolution, right? It is, I think it is somewhere written SR, so that is the incorrect thing. You have to rectify it. Other than that, the first thing is passing of ordinary resolution. Now, after ordinary resolution is passed, that means you have taken shareholders' permission. What is next is preparing of circular. Preparing of circular, ma'am, what type of circular? Circular containing the details. Details like what is the financial position of the company, credit rating, if any, the total number of depositors, right? If there are previous deposits, what amount is due in that previous deposits, and other particulars as may be prescribed, right? So this is a circular which is being prepared. First, the circular is filed with ROC. And once it is filed with ROC, within 30 days, you issue the circular to member also. That means if I take you through law language, we read it like that. We file the circular with ROC within 30 days before the date of issue of circular. So here you are issuing circular within the span of 30 days. Within the span of 30 days. That means once you file it within 30 days, you have to issue it. You can understand like this or like this, right? But you write it like this, you get more marks. Okay. Fine. After that, next is, let me take you from here also. So company, whether you're public or private, you may accept deposits from its members by complying with such rules as prescribed by CG. Procedure steps are as under: call general meeting and pass OR, prepare circular. The circular will contain these details. Then you have to also, you have to file the circular with ROC. You have to issue the circular to members, and thereafter what you do. Let's read the other points also. You have to prepare a DRR. Now, what is a DRR? Deposit Repayment Reserve Account. You go to a scheduled bank, you open a separate account like an escrow account, a temporary account which is going to serve the purpose, and then shut it down. So that is an account which has been created. Now, what you're doing is you have to repay the deposits for which you're creating a reserve. That means setting aside certain sum of money. Ma'am, what sum of money? When you stand at the beginning of the financial year, you assess before 30th April that what are the deposits which will mature in this year. Supposedly it comes out to be 1 lakh. So 20% of 1 lakh comes out to be 20,000. So at least 20,000 sum I will set aside and shift it to DRR. That means I'll transfer it to that particular account, and that I will use only for repayment. Okay. Then there comes certification of no default. Now, if there is a company which has never incurred any default in repayment of deposits, you will certify that, okay, there has never been any default in repayment of deposits. But supposedly there is a company which has in past done some default. That means the deposits were due on 5th September 2020. But or let's say 2010, but 2010 will again be too early. 2015, let's keep it like that. Okay. So the deposits were due on or September end 2015, but the company did not pay it. Company paid it 1 year later. That means in 2016, September 2016, the company paid it. Now, the date 30th September 2016, you rectified the default, you made the default. Now from there, for 5 years you're disqualified, you cannot accept deposits. And once those 5 years have lapsed, you can always provide a certificate that yes, the company defaulted in these provisions, but the company made good the default and 5 years have elapsed since then. So you have to give either of the certificate that there has been no default or there has been a default, but the default has been remedied and 5 years have elapsed. Okay, so this is the certificate that has to be provided. Then you will also provide security. See, our deposits can be secured or they can be unsecured also. You cannot say they are partially secured. Partially secured means unsecured only. And whenever they are partially or unsecured, you have to state this fact on every circular, every advertisement, everything, that these are unsecured deposits, right? And if they're secured deposits, you will provide adequate security by creating a charge on the assets of the company. Okay. Fine. So this is clear, this is clear, this is clear, this is clear. When you accept the deposits, you issue the depository receipts within 21 days of receipt of money. You transfer to DRR. You also file return of deposits DPT3 before 30th June with ROC. And there is one more thing: execution of deposit trust deed to appoint trustee. What is that, ma'am? We will read about deposit trustee, and in that, of course, you have to enter into a deed with them, and that has to be done before issuing a circular, right? Within 7 days. So that I'll do that later. Once the deposits have been accepted, they have to be repaid. Their interest has to be repaid in whatever time that has been promised. Supposedly, you fail to do so, the depositor can make an application to NCLT, and NCLT is going to pass an order for payment of damages, for payment of deposits, for immediate, forthwith, whatever it is. Okay? So, this was about section number 73. Now we move further, right? Section number 76. It tells us only an eligible public company can accept deposits from public. So, what is an eligible public company? A public company whose either net worth is 100 crores or more, or turnover is 500 crores or more. So, you satisfy any one condition and you obtain the consent of your members and file the same with ROC. Ma'am, how do we obtain the consent of our members? Through SR. Through SR. Okay. So you're a public company, you satisfy any of the criteria and you pass SR and file it with ROC, you become an eligible public company, or you become a public company eligible to accept deposits from public. But there is one more thing. So obviously, when you're revising, or when you will get to know about section 180 later, but right now you have to understand that section 180 is about power of board to borrow. There is a company has given certain powers to the board of directors, right? The board of directors can borrow up to a certain amount, and if they are borrowing up to this amount only, they do not need special resolution. So this much borrowing is within that limit. So here also it is said that if you're borrowing or if you're accepting deposits within the limit which has been specified in section number 180, which you're going to read later, right? So if you're accepting deposits, accepting of deposits means what? You're borrowing money from your members or you're borrowing money from general public, but you're not giving them any securities. You're just issuing receipts to them, which are deposit receipts, that we have taken the sum of money and will return it at a particular date, right? So if you're accepting deposits within this limit, then you don't need to pass SR. OR is going to be sufficient. Okay. What is the procedure, ma'am? The procedure is exactly the same as we read for acceptance of deposits from members. That means we need to prepare circular, we need to file circular with ROC, we need to issue circular, certificate of no default, all of that, right? There is one additional thing, or you can say simply two additional things that you need to keep in mind. One is that you need to obtain credit rating credit rating from credit rating agencies. What is credit rating, ma'am? Everything has been rated just for us to know how it is or how it is performing, right? If we go to buy a car, we have safety standards, we have safety ratings. So if it is 5-star, we get to know, okay, this car is safe for us. Likewise, if you're making an investment, we also want to know, is it safe for us? How do we know that? By looking at the rating. And how is it being rated? The credit rating agencies evaluate the parameters and thereafter they rate a particular so at the time of acceptance of deposits, you need to obtain this credit rating, and every year thereafter you need to obtain the credit rating, because maybe during the year you have done so many defaults, your credit rating, your credit worthiness has actually declined, so people might not be willing to continue, right? So every year this has to be done. Point number one. Secondly, the circular that you prepare, it is not issued to members. Here it is being issued to general public. So it is prepared in the form of an advertisement. There are more detailed provisions to that, but you don't have to get into that. Okay. Fine. Now, you create a charge if the assets are secured within 30 days of acceptance, and the charge is going to be created on tangible assets of the company only, maybe on movable assets or immovable assets. Fine. Okay, ma'am. Now, there is a register of deposits which has to be maintained. And in that register of deposits, what will be the contents which will be there? First of all, the details of the depositor, ma'am. What details? The name, the PAN, address, right? Then there are more things. More things like what, ma'am? Like the nominee details, right? The deposit receipt number, what is the amount that has been accepted, the date and amount of deposit, when are you going to repay, that means date of repayment, what is the interest which is going to be carried, for what duration the deposit is going to be there, right? Then other instructions for TDS, if you have provided security, if they are secured assets, what is the security that he's been provided. And then there is something also called as deposit insurance. What is deposit insurance? Deposit insurance, again, if the company fails to repay, we have got it insured, so the insurance company will pay. So to what extent have we the deposit insurance? So all those details, everything is going to be there in the register of deposits. Now this register has to be preserved for a period of 8 years from the last entry. So whenever you make the last entry, you preserve it for 8 years. The entries are going to be made within 7 days. It is going to be kept at the registered office, right, and authenticated by director or secretary of the company. Fine. Okay, ma'am. Now, some more conditions with respect to deposits. First of all, we talk about the tenure of deposits. What is the tenure of deposits, ma'am? See, you cannot accept deposits for a period of 5 years or for a period of 1 month. No. For a period of 6 to 36 months is what we have in general. More than 36 months, you cannot accept deposits, you cannot renew it, you cannot do it. It's very simple. Whether it's secured, whether it's unsecured, it doesn't matter, it cannot be done. But for certain short-term needs, if you want to meet out your short-term needs, then if your deposit amount does not exceed 10% of paid up capital plus free reserves plus securities premium, then you can accept deposits for less than 6 months also, but not for less than 3 months. That means they can be repayable in 4 months, 5 months, 3.5, whatever it is. So in that tenure, if you justify this, this is something which is allowed. Then we come to the limit on deposits. There are broadly 1, 2, 3, 4 and 5. 5 limits that you should remember from examination perspective. First, if you are a public company could be an eligible company, it could be a non-eligible company. So if it is a non-eligible company, it can accept deposits only from its members up to 35% of paid up capital plus free reserves plus securities premium. Fine. Okay, ma'am. If it is an eligible company, it can accept deposits from members also and from general public also. So from members up to 10%, from general public up to 25%. If it is a private company, then up to 100% is allowed. Up to 100% is allowed. Okay. So these are broadly the 3 things that you should remember. And of course, for government company also, if eligible government company is there, then there is no bifurcation. Eligible government company, you can accept 35% from members or 35% from general public. It does not matter. Okay? It does not matter. Clear? Fine. Now, your rate of interest, your rate of brokerage, everything is not supposed to exceed the maximum rate which RBI has specified for NBFC. RBI regulates non-banking financial companies. Now they have specified, okay, this is the maximum rate, because what happens, sometimes the companies make the offer so lucrative that people will fall for it and they might become prey to it, right? So in such a situation, there has been put a maximum limit that this can be the maximum rate of interest that you can provide in this particular case. Okay. Now, the deposits can be accepted in joint name, but it cannot exceed 3. So, maximum in the name of 3. Fine. Not exceeding 3. Now we come to the deposit trustee. Deposit trustee. Who can be the deposit trustee? We still have few sections left. We have to discuss about section 74, 75, 76, 76A. So we have all these sections left. But before that, we will actually talk about deposit trustee. So first of all, who is a deposit trustee? Deposit trustee could be any person. Could be any person, but he should not be disqualified. That means he should not be a depositor in the company himself. He should not be a director, KMP, or employee of company, of its holding company, of subsidiary, of associate. Okay. He should not be indebted to company, its subsidiary, its holding, its associate, or subsidiary of holding. Ma'am, do we need to learn this? Undoubtedly, you have to learn this. A lot of times this question has been asked in past in examination, that who can become a deposit trustee or who can't become a deposit trustee. So you need to learn this, and it's very simple, trust me, it's not very complicated. As you see, a lot of places disqualifications are. Then he should not have a material pecuniary relationship with the company. No, material pecuniary relationship has not been defined. Pecuniary relationship means what? Monetary relationship. Material means something which really can affect your decisions, or which can actually make you biased, or which can take away your independence, right? So this has not been specified that this much percentage or this is going to be. So it's in general, and no question will be asked on this particular point. Next, who has actually given guarantee of the deposits? Wow. He is the person who has given guarantee of the deposits, and he is going to speak on behalf of depositor. No. He will always suppress them, right? So he cannot be, or he cannot be the relative of these people. Okay. So these persons are not allowed to become deposit trustee. Apart from that, there could be any person. Person means he need not be an individual only. There can be other person also. So they can become a deposit trustee. How do you become a deposit trustee? Your consent is being obtained. Just you are a professional, you are rendering services, you can become a deposit trustee. We enter into a written agreement with you, and that written agreement is what? Deposit trust deed in DPT2. Now, as I told you, it is being executed at least 7 days before you issue the circular to members, or before you give the circular in the form of advertisement, in case of eligible public company, in case of public offer. Okay, so 7 days prior. And once he is appointed, can he be removed? The answer is yes, he can be removed. But he can be removed only with the consent of all the directors present at a board meeting. And in case the company is required to appoint independent director also, then in such a case, that board meeting must have one independent director. Okay. So all directors present plus one independent director must give his consent. This removal is possible only in such a case. Okay, ma'am. Now, once this deposit trustee is being appointed, what does he do? What are his duties? There is Rule 8. What does Rule 8 say? First, whatever assets or whatever security you are getting, see, he has to basically protect the interest of depositors. He has to protect the interest of depositors. In doing so, he has to first ensure, okay, the deposit amount is 1 crore. What is the security that they have got? Maybe they have got a security of 50 lakhs plus there is an insurance cover of 50 lakhs. So if we combine the insurance, if we combine the security, is it sufficient to cover the principal amount plus the interest amount? Is it sufficient to cover that? Ma'am, of course, then only we call them secure deposits. No, it may so happen that later on this security's value is declining. So the deposit trustee will be concerned, and he has to ensure that at all times there should be sufficient security. He has to ensure that whatever circular you are issuing or advertisement you are giving should have all the information which is consistent with the trust deed. There is no contravention, there is no or there is all the times harmony between the provisions, right? There should be no breach of conditions. Whatever the company has promised, is it doing the same? right? If there is breach of conditions, then you take necessary steps to coordinate with the company. If supposedly the interest is not paid, or there is a delay, or there is a reduction in the rate of interest, what was promised, what has been given, so you take reasonable steps to procure a remedy, right? Whenever necessary, call the meeting of depositors, okay, and try to resolve all the grievances, whatever is necessary. Apart from that, when do you call the meeting of depositors? When at least 1/10 of the depositors give you or a requisition in writing. So there are, let's say, 100 depositors, 100 depositors which have given 1 rupee each, or let's say 100 crores. So 1 crore each, or whatever it be, right? So we have to understand that 1/10 of the depositors in value, that means any number of depositors holding at least 10 crores, because 100 crores if we are talking about the deposits, so at least 10 crores, if they give a requisition in writing, then the deposit trustee will call the meeting, and he will also call the meeting whenever there is any default, right? So that is something that I already told you. Now, section number 74, although has become obsolete, but still we'll quickly decide that. Now, this is the time when there were deposits pre-hand. And now the deposits, Companies Act 2013 came and put a restriction that, okay, you cannot accept deposits for more than 36 months. So if there is any unpaid deposit as at the time of commencement of the act, or it becomes due thereafter, within 3 months, first of all, you'll prepare a statement and give it to ROC, that these are the deposits that we have as on date, and these are the repayment dates, and etc etc. And then you have to repay them within 3 years of commencement. Supposedly your due date falls after 1 year only, you repay it, but supposedly the act has commenced and 3 years have elapsed and still your due date is far ahead. No. This is the maximum tenure, maximum transition phase that you have been given. So within 3 years, you have to repay it. Supposedly you cannot, your funds are blocked. Make an application to tribunal. The tribunal is going to consider your financial position and grant you extension if that is possible. Okay. Thereafter, we have the penalty damages for fraud, section number 75, which talks about liability under section 447. We have section number 76A, which talks about the penalty or the contravention, which of course you will do it. And thereafter, this is something that I've already done. Thereafter, we have debt instruments. What are debt instruments? What are debt instruments? See, if I talk about the debentures definition, according to Companies Act classification, it has been defined in section 2 clause 30, which says debenture includes bonds also, and it includes any instrument which evidences a debt. It could be secured, it could be unsecured. It includes stock also, debenture stock, just like we have common stock, equity stock, like we have debenture stock. So it includes that. It is an inclusive definition which has been given. Now we have different types of debentures. You could be asked in examination, elaborate all the types of debentures, one, or you could be asked in a question specifically that what are the debentures, or what could be the debentures on the basis of interest rate. So you have fixed, you have floating, you have also zero coupon. So you can write like that, or you can be specifically asked any objective type of question within this, right? Okay, so first, redeemable debentures. What are redeemable debentures? When you get a debenture certificate, there is a specific date of redemption which has been written, and the company is obliged to pay you back the amount, the principal amount, on that particular date, on or before that date, right? Now, irredeemable, they do not have any date of redemption. That means when will it be repaid, ma'am? When the company will wind up, right? So when the company winds up, at that particular time, it will be repaid. Okay, it will be repaid at the time of liquidation. Or it may so happen in rare cases that you reduce the company chooses to reduce the liability, and at that particular point of time they repay it. Otherwise, they're like perpetual, going on and on and on and on, right? Then we have convertible and non-convertible. Now, in convertible, you have to understand, convertible means your debt is going to be converted into equity after a certain period of time. Right? It could be fully convertible, it could be partly convertible. Fully means, ma'am, the entire debt is going to be converted into equity. Partly convertible means what? There will be some convertible portion and some non-convertible portion. Non-convertible portion will go ahead and be redeemed according to the terms of issue. It will be repaid, and convertible portion will be changed into equity according to the conversion rate. Now, everything is pre-decided. So at the time of issue of debentures, you know whether your debentures are convertible, they are non-convertible, they're partly convertible, they're fully convertible. Is it mandatory conversion, or do I have the option to convert? Optionally convertible means what? The option is given to the investor. You want to convert it into shares, you can. You don't want to convert, you don't convert. And non-convertible, where at all you don't get the option, they're not fully, partly, nothing converted. For issued for a tenure of 10 years, for 10 years they will be remaining as debentures only, and after expiry of 10 years they will be redeemed according to the terms of issue. Okay. Then we have secured and unsecured debentures, which I've already told you. Just one more thing I want to add over here. Secured debentures, which are secured by some assets. So by creating a charge on certain asset of the property, you get it secured. Unsecured. Why will anyone take unsecured debentures? Just like I have told you about deposits, like we have unsecured debentures also. See, unsecured debentures, usually you get high rate of interest. Of course, risk is involved, so people might be willing to take that. But more than that, you invest in that according to the on the basis of credibility of the person, because they are naked debentures. Their unsecured debentures are also called as naked debentures. It's just the credibility of the issuer. Oh, he is asking for money, he'll not take my money and go away, right? No problem. Even if he's not providing the security, I'm getting a good return, so I can definitely go ahead and invest in that, right? Now there are SEBI guidelines that if you're making a public issue of debentures where the maturity period is more than 18 months, it has to be secured only. It cannot be unsecured. Debenture trustee has to be appointed in that case, right? Then we come according to the rate of interest. Fixed rate debentures, that means you have 10% debentures throughout the tenure, you'll get a rate of interest of 10% only. Floating rate, which is changing according to the market conditions, and it's based on some benchmark rate, maybe RBI rate plus 4%. So that is the rate of interest you're getting on your debentures. If the benchmark rate is reducing, your rate of interest is also reducing. So it is dependent upon the market conditions. And then we have zero coupon debentures. What are zero coupon debentures? They do not have any interest rate. They do not have any interest rate. So, ma'am, why will anyone again invest in zero coupon debentures? Because usually you get them at a discount. They're also called as discounted bonds. Why? You get them at 80 rupees and they'll be redeemed at 100. So you take it and they'll be redeemed at 100, so that the interest which you have foregone actually is compensated by the price difference or by the discount that they're offering, right? So usually this happens. There could also be a chance of getting some shares at discount. That means you could get a warranty like that. Okay, so that's it. Let's now revise the chapter of dividend, right? This particular chapter, if we look at the Companies Act classifications, it is chapter number 8, which contains section 123 to 127. Now, basically, first we have to understand what is the meaning of dividend, because if we go by the definition of dividend states that dividend includes interim dividend, so you won't find the real meaning. But when we look at the meaning, supposedly I am an investor and I purchase a share of 100 rupees. I would definitely want this to grow. I would definitely want my investment to grow. If I've invested 100 rupees, maybe today I am buying the share at 100. Tomorrow, if I want to sell it, it is being sold at 120. That means 20 by rupees 20. This investment has appreciated, right? This is basically nothing but a capital appreciation or increase in the value of shares, right? Now, how does it increase? Because the company is growing, the company is making more profits, there is more demand for the shares of that particular company and all of it, right? So that is the growth that you get in the value of shares. There is something more to it. Wherever a company is earning profits, it has a choice to make. It can either retain those profits, and if it has good reinvestment opportunities, and invest it or ploy it back to the business and make more profits, and likewise or distribute it to the shareholders. Now, that part which is retained by the company of the profits, it is retained earnings. However, that portion of profits which is not retained in the business but is distributed to the shareholders, the dividend is distributed in proportion to the amount paid up on shares held by them, right? This is something that you already know. Now, if distributed, that is known as dividend. Now, a lot of times this might be a real attraction for the investors. Oh, this company pays dividend. I want to invest in this particular company, right? So, the before we go further, I want to actually take you through this topic. This topic means what, ma'am? Financial parameters of declaring dividend. Listen to me very carefully. There are many companies which pay a large chunk of dividend, a large chunk of their profit as dividend. They are called as good payout companies. So, whatever you are investing, you will soon get the payout also. And some companies which are very conservative in terms of dividend, they retain the profit as reserves and they're plowing it back, or whatever they're doing, they're called as bad payout companies. It doesn't mean that the company is bad, it just means that the payout is bad. Okay, it may be doing wonders by retaining, and maybe there is immense share growth or whatever, but it is a bad payout company. So that is something that you have to keep in mind from objective question perspective. Now, before we go on to check out the provisions, because any company can declare dividend except for section 8 company, that company is prohibited to declare dividend, so such a company cannot declare dividend. Apart from that, any company can declare dividend. How do you declare dividend? How do you pay it? What if you declare and don't pay? What if you do this? What if you do that? So there are a lot of provisions which we read over these sections. However, there is one in general thing, that if there is any company, why do you think the company will declare dividend, or why do you think the company will not declare dividend? So there are certain financial parameters or grounds or factors which need to be considered, which you need to see that, okay, if I want to declare dividend, I have to check my profitability. If the company is not making profits, because you all know that dividend can be declared from current year profits also and from past year profits also. It has to be declared from profits only, because it is an appropriation of profit, it is distributing profits. It is not an expense that it has to be a charged and it can be booked even in case of loss. No. So maybe current year profits or past year profits or whatever be, you are declaring dividend out of that only, you are paying dividend out of your profits only. But supposedly earlier you were making very good profits and that's why you were declaring dividend, but in the past 2 years the company has been declining, the profitability has been declining. If you continue to pay out the same dividend, well, don't you think the company might come in trouble? So, first thing that you must consider is the profitability. Second thing, what is the cash component that you have? Because if you have limited cash, you need cash. Dividend cannot be paid in kind, and dividend is not something which is like bonus shares. That means there is no outflow of cash involved, and you're only capitalizing the profits and issuing equity shares. So, bonus is not, dividend is not like bonus. Here you need proper cash. If you want to give away 2 crore of your profits to the investors, you need to have 2 crore cash. So what is your cash availability? Right? What is the cash flow? And is there any some future requirement of the fund? Maybe you have 2 crore cash and you have paid the entire 2 crore cash. Now what will you do? If you have immediate some outflow, cash outflow or fund requirement, then what will you do? How will you manage it? So these are the financial parameters which must be considered. Okay. Apart from that, operation of any other law. What does it mean, ma'am? Maybe you have been restricted that you cannot pay dividend because there is some law which has come into picture, right? There is some law which is prohibiting you to do that. So because of any law, you're not allowed to give away dividend as of now, maybe. So you cannot give dividend. So you have to not just see Companies Act, but you have to see all other laws also. It could be simply a court order also. Okay, or it could be some maybe under IBC or under any other law you have been prohibited. No, you cannot declare dividend right now, so you cannot. You have to consider the losses which have been incurred, and it is advisable that if you have continuous losses, the board should not declare dividend. Next is restrictions and agreements with lenders or covenants. Covenants means conditions. Now it might happen that you go to a bank and you take a bank loan. The bank tells you that unless you pay 50% of the principal amount, you are not supposed to give dividends, because of genuine reasons, of course. So, in such a situation, there is a restriction which has been imposed on the company by the lender that you cannot pay dividend. So, you cannot pay dividend. You have to consider that factor also. Unavailability or uncertainty of earnings of the company. We are not very sure about the financial results of the company, that what it will be, because if you are a salaried employee, you know that okay, on 5th of the next month my salary will be credited, or whatever the date is, right? But if you are a businessman, then you have to assess everything. What am I expecting? What are the financial results which I'm expecting, right? Because there might be sales, there might be no sales, there might be a lot of sales, right? So what is it happening? We have to assess that. Availability of opportunities for reinvestment. Now, if I have, or if the company has generated a profit of 5 crores and all of it is available in cash, now the company thinks, what will I do of this 5 crore? They don't have any plan. The way their business is going on, they're fine with it. Even if they decide that, okay, let's put this 5 crore more into production, they don't have the customers to sell it. So whatever pace it is fine. They don't have any other growth opportunity in mind. They don't have any reinvestment. So they don't know where to use these surplus funds. So distribute it as dividend. On the contrary, if you have immense opportunities available, you should rethink and try to invest in those opportunities, right? And lastly, any cash outflow. Now, dividend distribution policy we'll do later. We'll come back. Right? So company, you earn profit, you have a choice whether you can retain it or distribute it to shareholders. If you distribute it to shareholders, you can give it away as dividend, or there can be just capitalization of profits, and it is being said to the shareholders that okay, you hold one share, you get one more share of the company free of cost. You don't need to pay anything. You don't need to buy this share, you're getting it free of cost, right? How they're using it? They're using the profits to give bonus shares, right? They don't need to give any cash, but it's less like you're getting a bonus share. Fine. So that is being covered in the chapter of share capital, section 73. Here we are talking about dividend. Dividend basically are of two types, final and interim, which we read in this chapter. But before that, you also need to have a conceptual clarity on equity and preference dividend. Preference dividend is what? The dividend which is fixed, paid to the preference shareholders in priority over the equity shareholders. So supposedly the company makes a profit of 2 crores. First of all, it will give dividend to preference shareholders, and whatever is left will be used for paying dividend of equity shareholders if it is declared. Preference shareholders is obviously given every year because the rate is fixed. Ma'am, is it given even in case of losses? The answer is no. It is at the discretion of the company. Because it is appropriation of profit, so they cannot make it a charge, right? Now, one more thing. Supposedly, ma'am, there is heavy loss in a particular financial year, and the board of directors of the company decides that we don't want to pay preference dividend this particular year to preference shareholders. What will happen? It depends how the preference shares are being issued. Are they cumulative? Are they non-cumulative? If they are cumulative, then the preference dividend gets accumulated and it is going to be paid next year. If it is non-cumulative, then it's waived off, right? So they have to let it go. Right? Equity dividend is not fixed. Now we come to the main two dividends which we read about in this particular chapter, which is final dividend and interim dividend. Of course, we're talking about equity. Now, final dividend and interim dividend, what it is all about. Interim dividend is declared by the board between two annual general meetings. What is annual general meeting? The annual meet of the shareholders, right? So they meet once annually. That is known as annual general meeting. Now, supposedly, I'm talking about a financial year 24-25, which begins from 1st April 24 and ends on 31st March 25, right? Then the next financial year begins 1st April 2025, and then maybe here 25th September 2025 is AGM of 24-25. Now listen to me very carefully, because these are dates I'm taking a bit of time to explain. Final dividend and interim dividend. Now, final dividend for financial year 24-25 will be declared only on 25th September 2025. That is the date of AGM. However, when we are talking about interim dividend for financial year 24-25, it can be declared during this financial year or after the end of financial year till AGM is declared. Okay. Yes, ma'am. Now, usually or practically, what happens is once the financials are prepared, here, somewhere here, that means maybe 25th July. 25th July, the board decides that, okay, I know that in the last financial year we have made good profits and we don't need to wait till annual general meeting to declare dividends. We have the power to give away an interim dividend. So we declare interim dividend of 10% and we are going to give it to the shareholders. You can do that. The board of directors have the power to declare interim dividend. Clear? Okay, ma'am. Now, interim dividend can be declared in this period or in this period, right? The only difference between interim dividend and final dividend is that it is being declared by the board. However, final dividend is being declared by the shareholders, and the sources are different. Sources are different. So these are the two differences that you have to keep in mind. Otherwise, by going by the definition of Section 2, Clause 35, dividend includes interim dividend. So if an interim dividend is declared, it has to be paid within 30 days. So the same provisions goes for dividend also and interim dividend also. Final dividend is declared at an annual general meeting, but again, it is proposed by board. It is declared by shareholders by passing ordinary resolution, as it is a matter of ordinary business at annual general meeting, right? Okay, ma'am. Equity shareholders will not get any dividend if there is a default of Section 73 or 74, which is the chapter of deposits. You already very well know that. Now, once the dividend is declared, whether it is interim or it is final, it has to be transferred to a separate bank account in a scheduled bank within 5 days. Okay, when it is declared, from the date of declaration within 30 days, it has to be paid also. So you declare it within 5 days, you keep it aside, and from the date of declaration, that is from the date of passing of board resolution or ordinary resolution, whatever the case be, you have to pay it also. How do we pay it? Ma'am, in cash, not in kind. Dividend cannot be paid in kind. In cash means it could be bank, it could be a warrant, it could be a check. So electronic transfer, warrant, check. To whom do we pay it? We pay it to the registered shareholder or his banker or his order, maybe. He has ordered it, give my dividend to this, so fine, we'll give it to them. So only to that particular person. Fine? Now the point to understand. I told you, interim dividend and final dividend, the sources are different. We're not here to discuss about the accounting. Although in class, I usually tell you that also just to have good clarity, but this is revision. Now, listen to me very carefully. Interim dividend is declared by the board during any financial year or any time from closure of financial year till annual general meeting. The point to remember is the sources. Whatever profits have been earned in this financial year can be used for payment for interim dividend. Yes, ma'am. Whatever profits are there in P&L account can also be used for payment of interim dividend. Whatever profits have been earned over here till preceding quarter, supposedly you are declaring declaration of interim dividend. So if you're declaring it on 25th July here, from 1st April till 30th June, also the company might have earned certain profits. So these profits can be used, and the balance which lies in P&L account, this can also be used for payment of interim dividend. Now for all other chapters or for all other things, P&L account and general reserve is the same thing, but not for this chapter. General reserve is something, or the profits that has been transferred to reserves. However, P&L balance is the profit which has not been distributed yet. It remains undistributed. So that can easily be used. But if you want to use the amount which has been transferred to reserves, then you need to comply with certain additional conditions. And that is something which is not available for payment of dividend or payment of interim dividend. Okay. Fine. So interim dividend, you use these three sources. Now, supposedly, in this quarter, from 1st April to 30th June, there is a loss. In such a situation, you declare interim dividend using these profits. Fine, you can. But then there is a restriction which has been put. What is that restriction? The interim dividend that you declare should not be a rate higher than average rate of preceding 3 financial years. So in last 3 financial years, whatever dividend has been declared, you sum total divided by 3, there comes the average. Not more than that rate can be given as interim dividend. Fine. Now we come to the final dividend. Now final dividend, again the sources are going to be different. We are reading section number 123. So dividend has to be paid after providing for depreciation out of the profits of that particular year. So if you are declaring dividend for financial year 24-25, whatever profit has been earned after providing for depreciation, whatever you have been left with, you can give away dividend, not a problem. Out of past year profits also you can give. Out of past year profits have been divided into two categories. One is that remains undistributed, that is P&L account. So you provide depreciation and give away profit, not a problem. Give away dividend, not a problem. But the profits of past years which have been transferred to reserves. Supposedly, you want to give away a dividend of 2 crore when you have a profit of 2 crore. You give it, no problem. But supposedly, you want to give away dividend of 2 crore when you have a profit of just 1 crore left. Now, in this is a situation of inadequate profits. So supposedly a company has inadequate profits, they need to check whether I have some profit of past years undistributed lying in P&L account. They don't even have this. So they will see, do I have reserves? Yes, I have reserves. So can I use those reserves to pay dividend? Well, then you have to comply with these 4 conditions. Then you can use it and pay dividend. Condition number 1. The rate of dividend should not exceed average of last 3 financial years. So again, you sum, just like over here, you sum total, you take out the average, and the rate of dividend should not exceed that. Secondly, whatever amount you are drawing, what amount you're drawing in this particular case, you need 1 CR from the reserve. So this 1 CR should not exceed paid up capital plus reserves 1/10. Supposedly the paid up capital is 1 CR plus reserves is 1 CR. So sum total 2 crores. 1/10 of 2 crores, whatever amount comes, that is the maximum amount that you can withdraw for paying dividends. Thirdly, whatever amount you withdraw, you'll first utilize it for setting off losses, and thereafter whatever balance is remaining, that you can use for payment of dividend. And lastly, Your balance of reserves. Supposedly there was a reserve balance of 1 CR and you have withdrawn 50 lakhs. So what is the remaining? It's only 50 lakhs. Now this 50 lakhs should not be fall below 15% of paid up capital. So supposedly 15% of 1 crores. It comes out to be 15 lakhs. So here it is not satisfying. Your balance of reserves, whatever reserves is left over, should be at least 15% of paid up capital. Should be at least 15% of paid up capital. Now, some students say, ma'am, if it is not 15% of paid up capital before that, you cannot withdraw. No, you cannot withdraw. Okay. So these 4 conditions have to be satisfied with, and then only you can use this. There is another source of dividend, which is money provided by government. Ma'am, why will government provide us the money? Maybe there is a company in which government has made investment and government wants general public also to make investment. So government took a guarantee, right? And they said that I will provide you dividend if this company fails to do so. So on the basis of government's guarantee, there are many people who have invested, right? This may be a situation. So in such a case, the government provides money for payment of dividend, and that can be used as payment of dividend, not a problem, right? Okay, ma'am. Now, Section 124, when the dividend is declared, it has to be transferred within 5 days to separate bank account, and from declaration, it has to be paid within 30 days. Now, if it is paid, very good. If it is not paid, consequences of Section 127 are attracted. Apart from that, supposedly there was a person who could not be traced and dividend was not paid to him. So will we keep it back? The company cannot keep it back. You will transfer it to a special account and scheduled bank, which is known as UDA, unpaid dividend account, right? If you don't transfer it, you'll be liable to interest at the rate of 12% per annum. Now, when you transfer it within 90 days, you'll prepare a statement. Okay, these are the last known shareholders who have not taken this particular amount of dividend, their contact details, whatever it is, and you'll put it on the website of the company. Any person who has not taken their dividend, they can apply to the company and take it. If it is taken, paid, great. If it still remains unpaid for 7 consecutive years, it will be transferred to IEPF. Ma'am, can we take it from IEPF? If I don't take my dividend for 7 years from the company and now it is shifted or it is given to IEPF, you can still claim it. You can still claim your money and IEPF will give it to you. Okay. Now, what is IEPF? Investor Education and Protection Fund, covered under Section 125. It is being managed and constituted by central government. There is a chairperson, CEO, and 7 maximum members, right? So they meet and they take decision. They have ample of employees, officers, resources. Everything is being provided by central government to them. They also maintain accounts. Their accounts are audited. Everything is done in this manner. Now, this is a fund. So this is a pool of money. From where do we get money in this particular fund and how do we use that particular fund? So from where do you get money? This unpaid dividend account. Somebody who has not taken their dividend, it comes over here. Government also gives grants or donation. This amount is being invested and whatever income is being generated from that investment, that is also used. There is application money. A company got a lot of applications. Now they allotted the shares and they want to refund certain applications, right? But the people are not to be found. So what do we do? The amount should be kept by the company? No, it should be transferred to IEPF. Likewise, if your deposits have matured, if your debentures have matured, if there is interest, if your preference shares have redeemed, but there is nobody who is claiming it, so you'll transfer it to IEPF, right? How do we utilize this? If the people were not claiming, they can anytime go to IEPF and claim. So unclaimed money, it can be refunded from that particular fund. Apart from that, it is going to be used for promoting investors' education, for educating them, right? For distribution of disgorged amount. There is somebody who has taken undue advantage, right? And that has to be distributed, right? Now, reimbursement of legal expenses. A lot of legal cases keep on happening. So to do that. Now, section number 127. If dividend is declared, it has to be paid within 30 days. If it is not paid, the company has to pay a simple interest at the rate of 18% per annum. Plus, the director is also liable or attracted to imprisonment and fine. But now listen, there is a company, and the company had to pay dividend. The company tried to pay dividend to a shareholder whose bank accounts were available with the company, but the money was bounced because of incorrect bank details. The company informed the shareholder that, see, we are unable to remit dividend to you according to your instructions. You please respond and provide us with another bank account. The shareholder did not reply. Is it company's fault? The answer is no. Should the company be liable to interest? The answer is no. Should its directors be liable for imprisonment or fine? The answer is no. So there are these cases or exceptions where there is no offense under this section and the people involved over here will not be liable. How, ma'am? By operation of law. Supposedly there is FEMA in play and FEMA restricts you to pay dividend to your foreign investor. You cannot. Shareholders' direction cannot be complied with. Shareholder gave you an instruction that pay my dividend in this particular bank account only, and that is not you informed the shareholder that your instruction cannot be complied with, so you're not at fault. There is a dispute regarding right to receive dividend. Why? Because there was a transfer deed received by the company. Now we don't know whether to pay dividend to Mr. A or Mr. B. The shares have not been transferred yet. There is a confusion, there's a clarity, there is no clarity, there's a dispute. Dividend lawfully adjusted against the dues. The company has to take 500 rupees from Mr. A as a call money, which is due, and company has to pay 100 rupees to Mr. A as dividend. So they adjusted it. Now they are only going to take 400 from Mr. A. Fine. Non-payment not due to default of the company. So the company is not at fault in any case. So in such situation, these penalty or these liabilities will not be attracted. Okay. Dividend once declared cannot be revoked. And fine, this is the time limit. That's something you already know. Now we come to the last part, dividend distribution policy. SEBI loaded regulations. There was an amendment in 2016 and it came up with 43A dividend distribution policy. Now, what is it all about? The top 1,000 listed entities based on market cap. You all know market cap. So based on that, top 1,000 listed entities, it is mandatory for these entities to prepare a dividend distribution policy. Why, ma'am? Because a lot of investors actually have this opinion that from past 3 years, this company is paying dividends, so I should invest in this company, and this year also the company will pay dividend. But to make an informed choice, an informed decision, we actually must know that on what grounds this company is giving dividend. So what is their dividend distribution policy? So top 1,000 listed entities, you have to formulate and disclose an annual report plus website your dividend distribution policy. What is going to be in your dividend distribution policy? First, in which circumstances can we expect a dividend, or in which circumstances can we not expect dividend? We can be said that if this happens, the dividend will not be given. So we will be mentally prepared. Okay, the shareholders, the investors will be informed. They can accordingly sell their shares. They can accordingly buy and take decisions. Financial parameters which we consider while declaring dividend. I have told you the general financial parameters which should be considered by every company. Now here, in the dividend distribution policy, listed entity has to specify that which parameters are we going to consider, which internal or external factors are we going to consider for declaration of dividend. If at all we don't declare dividend and we retain this earnings, how are we going to utilize this earning? Okay, and supposedly there might be many times that, okay, these are the financial parameters which we thought, but this is something which has happened, and based on this, we are taking a decision of not giving away dividend. So if there is a change in some parameter, or if you wish to have an additional parameter, then again you should disclose it along with the reason in annual report and on website. Apart from the top 1,000 listed entities, if any other listed entity wants to prepare dividend distribution policy voluntarily, they definitely can. There's no problem in that. Okay. Let's now revise the chapter of Accounts and Audit. Now, this is basically Unit 4 of our company law module, and it comprises of three things, I would say. Chapter 9, according to Companies Act, which is Accounts of Companies, and contains section number 128 to 138. Thereafter, Chapter 10 of Companies Act, which is Audit and Auditors, and contains section number 139 to 148. And thereafter, you have something called as CARO 2020, which ideally is a part of auditors reporting only. Okay, so we have to read about all these three in this particular unit of Accounts and Audit. So first we'll begin with Accounts of Companies, right? Chapter 9 according to Companies Act. Now we are talking about accounts of companies, right? So what are accounts? Every company is supposed to maintain certain accounts. What are accounts? Books of accounts. What are books of accounts? Now, books of accounts primarily has been defined in section 2 clause 13, which actually means that the records, which records, ma'am? Records of sale, purchase. So whatever company is purchasing, whatever company is selling, the company's assets, liabilities, the money it's spending, the money it's receiving. So cash receipts, expenditure, sale, purchase, asset, liability, the record of everything is actually books of accounts, right? Now, not just this books of accounts, but we have something called as books and papers also, which is the supporting documents or the vouchers, the deeds. So all of that is covered in books and vouchers, basically, you can say, right? So books and paper contains all that voucher. Now, books of accounts plus books and paper. That means the record with respect to sale, purchase, asset, liability, receipt, expenditure, everything, plus its supporting documents, the deeds, the vouchers, contracts, everything. They have to be prepared for the entire financial year. Here comes in question, ma'am, what do we mean by financial year? Financial year basically means year ending on 31st March, or rather, I should say, period ending on 31st March of every year. Right? So, this is financial year. However, when a company is newly incorporated, and if it is incorporated on or after 1st January, then the financial year does not end on the coming 31st March 2000, whatever it is, on the coming 31st March, rather it ends on the 31st March of next year. So ideally what becomes is, supposedly there is a company which has been incorporated on 1st January 2024. So the financial year will not be like from 1st January to 31st March. No. It will be like starting from 1st January to 31st March 2025. 31st March of following year. Moreover, there is another catch. What is that catch? That, ma'am, if there is a company which has a subsidiary, which has an associate, and for some reason the consolidation is required. Now, in India, we follow this particular law and we have this particular financial year, but maybe if there's a foreign subsidiary, associate, or holding, whatever it be, and they follow a different financial year, now their accounts, their books cannot be consolidated. So, there will be a problem. So, in such a situation, companies over here can make an application to central government and ask to follow a different financial year. Central government may permit the same. So, for such type of companies, the financial year may differ, right? Coming back to basics, every company is supposed to prepare the books of accounts plus books and papers, and in certain cases, items of cost. So that we read about it later, that which companies are also required to prepare items of cost. It is not relevant in case of all the companies, just manufacturing entities which come under a prescribed threshold, they have to prepare and maintain cost records also. Okay. So every company has to do this, and this has to be done according to accrual and double entry system. So no single entry recording. Okay, that I have received this much money, so I'll just write cash received 10,000. No, this cannot work. Cash received 10,000 against a particular creditor, whatever. It has to be the dual effect, and it has to be accrual. No cash basis is allowed. Okay, so this is basically about maintenance of books all year round. Now, when the year ends, You know what the financial year is now? When the year ends, you also have to prepare financial statements. Financial statements are basically covered under section 129, and we are still reading section 128 from where the chapter begins. But I'll still tell you what are financial statements: balance sheet, P&L account, or in case of section 8 company, it's like income and expenditure account, um, receipts, expenditure, right? Receipts, payment, income, expenditure, cash flow statement, statement of changes in equity, explanatory note, and there is one more thing which you must remember about about financial statements is that the financial statements of one person company, small company, dormant company may not include CFS, cash flow statement. So such type of companies are allowed. They are not supposed to prepare CFS. So cash flow statement is exempted for that part, right? Okay. So this has to be prepared at the year end. Okay, this is given in section number 129. Coming back to our very first section, section number 128, you prepare the books of accounts. Where do you maintain this books of accounts? Okay, let me first take you through certain pre-basics, I would say, before we actually go to the main section, section number 128. So every company maintains this for the entire year, which may also be inspected according to the provisions, and prepares financial statement at year end, which is approved by the board, given to auditor. His audit report is obtained, which is circulated to the members, and at annual general meeting, the members adopted by passing ordinary resolution, which is filed with ROC. Now, section 128, every company, you must prepare books of accounts for every financial year on accrual and double entry basis by complying with accounting standards as given in section 123, which must give true and fair view. It is not just for the sake of preparing books that you're preparing. No, the books should actually present a true and fair picture of the company. So what is the position of the company? That should actually come out, right? Now these books can be maintained in physical form, or it may also be maintained in electronic form. Considering the evolving technology, we would say that gone are the days when actually the books were maintained in physical form. So now in every place you'll find it in electronic mode only. Some people use tally, which is very conventional and traditional now, I would say, but then still it is in use by a lot of offices. We have a lot of ERP softwares, we have QuickBooks, right? So we have a lot of accounting softwares, but the software, whichever you're using, should have audit trail feature. Now, there are certain things which must be followed. Rule 3 of Companies Accounts Rules 2014 actually tells us that, okay, fine, if a company wants to prepare books in electronic mode, they can. They want to prepare the books, keep its books, relevant papers, they can. But then they have to follow certain conditions. That conditions are being laid down in Rule 3. What are the conditions? First, it should be accessible in India. Accessible in India, of course, it is an Indian company, it is registered in India, so it should definitely be accessible in India no matter where your operations are, right? It should be completely retained in the original format. Often it happens that, okay, fine, this is the information which has been prepared by a particular official, but when we are trying to record it in the electronic form, we have altered its format, and now if there's some error and we want to trace it back, we cannot, right? So it should be retained in the original format in which it was created, or in which it was sent or received, or whatever it be. The information that you receive from the branches also should be kept unaltered. Okay, so that again accountability may be established, right? It should be in legible, proper form. There should be proper storage, there should be proper retrieval, and you should also be able to take the printout of the same, because everywhere you cannot carry your systems and make decisions. A lot of places you need management information system reports, that is MIS reports. You need to take a lot of decisions, right? So you need printout also. Fine. So it should be capable of being printed. Okay. And then backup should be taken. What is one more thing that you should keep in mind over here is that you might be using a service provider, Indian service provider, outside service provider, whatever it be. you have to provide certain information to ROC on annual basis. The name of your service provider, if you are maintaining your books in electronic form, IP address of the service provider, location of the service provider. Now, if the service provider or you're maintaining it on cloud, then whatever address is provided by the service provider, that address you will give. Okay, so this has to be intimated every year on annual basis to ROC. Okay, the books of accounts that you prepare have to be preserved for a period of 8 years, and there might be longer period if the investigation is ordered. Okay. Now comes your place of maintenance. Where do you maintain it? You don't have to confuse this particular provision with Section 88. Section 88 is something that you have read before, which talks about the register of members and where register of members can be kept. Here we are talking about the books of accounts. Now, books of accounts are basically the concern point for directors. Shareholders are nowhere concerned about it. I mean, I don't know what's happening with the Reliance Industries Limited, and I'm not concerned about it, right? And they'll not even let me see their books of accounts and all that, right? So basically, books of accounts, papers, they're all kept at the registered office, but they may be kept at any other place as the board may decide. They might feel that, okay, no, most of the times we are here only, let's keep it over here only, it will be easier, it will be more convenient, there's more space, there's more facility. Fine, go ahead and keep it, but it is important that you inform ROC that where your books are kept, right? So books of accounts at the registered office of the company, it may be kept at any other place as the board may decide. Wherever you keep it, within 7 days, give a notice in writing in AOC 5 to ROC and inform ROC that, okay, this is the place where we are keeping our books of accounts. Now, there could be a situation that a company has a lot of branches and the records relating to branch, it's convenient to keep it at the branch only. Go ahead and keep it, not a problem, right? But periodical returns must be sent to the registered office or to the place where main books of accounts are prepared. Okay. Now, as I told you, shareholders are not concerned with the books and hence they do not have any power of inspection. The books of accounts of a company can be inspected by the director. If director does not have much knowledge about the books, then it may be inspected by his agent. He may appoint an agent and it may be inspected by his agent. Because ultimately, according to section 128(6), the managing director, whole-time director who is in charge of finance, CFO, or there could be any other person who is charged by the board, they are responsible for maintenance of proper books of accounts. So in a company, if the books of accounts are not maintained and we have a CFO, the CFO is going to be responsible. We have a whole-time director who is in charge of finance, he's going to be responsible. If we don't have, managing director is going to be responsible, or any person who has been entrusted with the responsibility of doing so will be responsible. So they are the ones who are going to be responsible, and hence they have this responsibility. Okay, I will be penalized if they don't maintain proper books of accounts. So I must constantly check whether books of accounts are being maintained in a proper manner or not. So they want to check it, they want to inspect it. Go ahead and do that inspection. You are allowed to do that. So whatever books are being kept at the registered place or any other place, maybe we have summarized returns of the branch, or maybe there is any information which is outside India, and you want to check that whether it has been incorporated, what has been done, how has it been dealt. So all that can be inspected by the directors or his agent during business hours. With respect to outside financial information, director has to give a request and thereafter it is being produced within 15 days. It cannot be produced instantly. That is a but obvious thing, right? And this can be done by the director himself only. However, all others can be done by director, his agent during business hours. Now, there's one more thing which you should keep in mind. The officers have to provide complete assistance to the directors who are inspecting. That is completely fine. But if there is a company ABC Limited, it has a subsidiary PQR Limited. Now a director wants to inspect the books of the subsidiary. He cannot do so unless he's authorized by a board resolution. So he will go to his own board of directors, he will seek permission, a board resolution will be passed, and then he can do that. Okay. So a director has the power of inspection of books of accounts of his own company only. Fine. Okay. Financial statements, I've already told you what they are. Now, every company has to prepare financial statements, and they have to be prepared according to the format which is given in Schedule 3. We all know that Companies Act has total 7 schedules, out of which Schedule number 3 is the format which is being given for the companies to prepare the financial statements, right? Now, when we talk about the format, we have insurance companies, we have banking companies, we have electricity companies who do not follow this format. Why don't they follow this format? Because they have a specific governing act wherein the formats have been given. So they follow those formats only, right? So this is not applicable to these type of companies. Whatever financial statements you're preparing, they have to be giving a true and fair view and according to the accounting standards. If there is deviation from the accounting standards, then why is there a deviation? You need to disclose certain things. What is the deviation? Why is there a deviation? And what is going to be the effect of this deviation? So this has to be disclosed. Now we have something more called as consolidated financial statements. Now, when consolidated financial statements have to be prepared and by whom? If there is any company which has one or more subsidiary or associate, then it has to prepare its own financial statements plus a consolidated financial statements. Consolidated means the combination of its financial statement plus its subsidiary. So the turnover has to be merged. Okay, I make a turnover of 5 crores, my subsidiary is making a turnover of 2 crores. So consolidatedly, our turnover is of 7 crores. So that's how you consolidate the financial statements. And as I told you before also, that the financial statements are laid to the members for their adoption. So the consolidated financial statements shall also be laid before the members at the annual general meeting. Let me first tell you this. Financial statements plus consolidated financial statements plus AOC1. Ma'am, what is this form AOC1? You must remember this form number also. Now, this AOC1 form is about the salient features of financial statements of subsidiary. The financial highlights, or whatever you can say, salient features of the financial statement. So this is also given separately. Okay, this is clearly written. So this will be prepared. It will be laid at an annual general meeting and filed with ROC. If you do not comply, then non-compliance attracts penalty. Now, there is certain exception or exemption, you can say, which is being given to certain kind of companies which are not required to prepare consolidated financial statements. Ma'am, what are those kind of companies? Supposedly, we have a company A Limited. It holds 70% shares in B Limited. B Limited holds 100% shares in C Limited. Okay. C Limited, B Limited, you both have a relationship of holding subsidiary. So when I talk about B Limited is a company which has one subsidiary, and hence it must prepare its standalone financial statements plus its consolidated financial statements and lay at the annual general meeting, right? Yes or no? This is what we have read so far. But. Now we are going to read about the exception. What is the exception? That if you are a wholly owned subsidiary or partially owned subsidiary of another company, B Limited, are you a subsidiary of another company? The answer is yes. You are a partially owned subsidiary of A Limited, right? And all your members, there has been no member which has objected that, okay, fine, don't prepare. You don't want to prepare CFS, it's fine, don't prepare it. So nobody has objected that, oh, you have to prepare CFS. Condition number 1, you are a subsidiary. Yes, you are. Condition number 2, members don't object. Members don't object. Fine. Condition number 3, you're not listed. You're an unlisted company. Fine. Condition number 4, your holding prepares CFS. Prepares CFS. So if these 4 conditions are met, you are exempted from preparing CFS. So A Limited, which is the ultimate holding company, or there could be an intermediate holding company also, they actually prepare CFS according to accounting standards. So in such a case, B Limited, you are exempted. Right? Okay. So contravention penalty, I'm not discussing in detail. Then moving to the next section, section number 134. We also have section number 133 in our syllabus, but it's actually concerned about the accounting standards, which I've already told you. So we have Institute of Chartered Accountants of India, we have NFRA, we have central government. These are the 3 bodies which play a role in prescribing accounting standards. Okay. Now, section number 134, financial statements, signing or authentication, and board's report. So board's report, we'll read about it a little later, but right now we're talking about the signing or authentication of financial statements. The financial statements, CFS, they're approved by the board. Of course, they're prepared by the finance team or the accounting team. They come to the board, they say, okay, fine, this is what we have prepared. Now the board is going to sign it. How does the board sign it? If the chairman is authorized by the board, it is signed by chairperson and CEO, CFO, and CS if appointed. If it is not authorized by the board, then 2 directors, out of which 1 shall be MD, and CEO, CFO, and CS if appointed. So this is how signing is being done. In case of 1-person company, we might have just 1 director, so it is signed by just 1 director. Okay. Now, after it is being approved by the board and signed in this manner, it is given to the auditor for audit. Okay. Now, when the auditor actually audits, he gives a report on different matters, general report on internal controls, CARO report, everything is being given. And this particular set means what, ma'am? We have a set that is signed copy of financial statements, notes, auditors' reports, and we also have something called as board's report. Okay, this entire set, CFS, everything is circulated. How is it circulated? The members actually have a right to get this before general meeting, according to section 136, because if at annual general meeting the entire set somehow goes up to 200-300 pages, and if you ask the members, okay, come on, read this 200-300 pages and tell whether you adopt it or you don't adopt it, right? So it will be very difficult for them to make a decision. So these the entire set, audit report, all the annexures of the audit report, that is annexure on report on internal financial control and everything, this is being sent by every company to the members, to debenture trustee, and every other person who is entitled to receive the notice of general meeting. So it is sent to everyone. Okay. It is sent at least 21 days before annual general meeting. So ideally it is sent with the notice only, if not much before. Because the notice also has to be sent at least 21 days before. We have 21 clear days, right? So it is usually sent with the notice only, although here they don't exactly write the clear days, but it has to be sent 21 days prior. Now, you sent it and the members will read it, they will be prepared, and they'll come and vote, right? Sometimes it may so happen that the financial statements are not ready and we cannot send it so much prior hand, so they have to obtain the consent from the members to send it a little later. Okay, the consent is being asked properly. Okay, we are going to send it itna days after, whatever it is, right? Consent is obtained from whom? If the company has share capital, you will take consent from members holding at least 95% of paid up capital. If they agree that, okay, fine, you can circulate us these documents for lesser than 21 days, it's fine. You can send for a lesser period than 21 days. If the company is not having share capital, you will take consent from the members holding 95% of voting power. You take the consent in writing. Okay. So this is how you will be sending. Now there is something more. In case of a listed company. Now listed company, it becomes even more difficult. Why? Because there are a huge number of people who are associated with the company, and there is a lot of documents which are being, because you have to comply with a lot of SEBI regulations and everything. So the set is also very huge. Now what should be done in such a manner? So listed company, do this, or better. Make your financial statements available for inspection at the registered office 21 days before annual general meeting, and send a statement which is AOC 3. Okay, statement containing salient features of the entire documents in AOC 3 to every member, to every trustee, to everyone, unless they ask for full statements. If they ask for full statements, that particular shareholder can be provided with the full statement. Otherwise, do this and it's going to be sufficient compliance. Yes, apart from that, a listed company also has to place the financial statements on its website. The financial statements of subsidiary also has to be placed on the website. Now, the financial statements of subsidiary must be audited. But supposedly, audit is not mandatory in that particular country. Why will they get it audited? So, place unaudited financial statements only, not a problem. If they are in some Chinese, Japanese language, you have to translate in English and then you'll place it. Okay, fine. How do you circulate this, ma'am? How do you circulate this to all the members? Well, you circulate it the way you want to. In case of listed company and in case of public company with net worth more than 1 crore and turnover more than 10 crore, there is a manner of circulation which has been given. Although, again, I would say this has become irrelevant, because gone are the days when we used to have our shareholding in physical form. Now we have the shareholding in demat form only, right? Especially of such companies, it is not even permitted to have shareholding in physical form, but still, because the provision exists, so we are reading it. So listed company or such companies, you have to see if your shares are in electronic form, you will send the documents by electronic mode only. Now you will see all the notices that you receive of the companies, all the financial statements or set which is being circulated, you will all receive it via email only as a PDF attachment. This is how you get it. This is the ground level or practical reality, what we are seeing, right? But the provision says that if the shares are not in demat, then ask the members if they consent to receive it electronically, send them in electronic mode. If they don't give consent, then you have to dispatch physical copies to them. Okay. Section number 130 and 131, very small sections. They basically talk about reopening of what, ma'am? Reopening of accounts. A lot of times it may so happen that, okay, companies have fabricated, they have window dressed their accounts, and there is some fraud which exists, but somehow they have wrapped up the accounts and they've moved on. But when income tax authority looks at it, they find that, okay, my God, there seems to be a lot of tax evasion, and we cannot vouch that it is correct. So we must reopen the accounts. They all must be restated. This totaling must be done. This is how it should be done. And then it should be audited. And thereafter, what we can do is we can rely on this. So in such a situation, central government, SEBI, or income tax authority, or statutory regulatory body like maybe IRDA, or any person concerned, he can make an application to tribunal. NCLT, when receives such application, he sends a notice to these authorities that what is your take. Supposedly CG has given them an application, so NCLT is going to give a notice to SEBI, income tax authority, other person concerned, whatever it is, right? After seeking their representations, NCLT will pass an order. NCLT comes to the conclusion that, okay, the accounts were made fraudulently, or the affairs are being mismanaged in such a manner that there is a high doubt about reliability of these financial statements. There's a huge doubt that, oh my God, these financial statements are not reliable. We cannot rely on that. And hence they must be restated. They must be re-prepared, you can say. right? So he will pass, NCLT will pass an order for reopening of books. Now, we have already read before that we have to preserve the books of accounts for a maximum period of 8 years. So, can NCLT ask us that reopen your books of past 10 years? No, they cannot. So, for maximum 8 earlier years only, they can reopen. Whatever accounts are revised, they are going to be considered to be final. Okay, first we move to section number 131. Section 131 talks about voluntary revision of financial statements of board's report, which is done by the board of directors themselves. Now, they have to prepare board's report according to section 134. They have to prepare financial statements according to section 129, which must comply with the accounting standards and everything, right? And your board's report also has been given a certain format that, okay, you have to prepare it this, you have to report this, you have to give this also, and everything is being done. Now, supposedly this happens that the financial statements are not in compliance with section 129, or the board's report is not in compliance with section 134. The board comes to know this. They make an application to NCLT that, see, this is the mistake that we have done and we want to restate this. Can we do so? So NCLT is again going to make an application to CG, Income Tax Authority, seek their representations and pass an order. Okay, fine, you can go ahead and revise it. See, the company will revise it. Revision can be done only once, and revision can be done only once for a particular financial year, and revision can be done only for past 3 financial years, not before that. Okay, and revision can be done only in these two conditions. You cannot say that, okay, I have misstated a certain figure and I want to revise the entire financial statements. No, you cannot do that. Okay, fine. Now we come back to the board's report. Board's report, my dear, is a huge topic, and often it is being asked also. I don't know why, but the entire section 134, which contains a huge list of what should be included, what should not be included, is being asked, and hence you must actually know this and try to remember as many points as you can. So I have shortened those points. See, board's report has to be prepared by whom? By the board of directors. They basically contains the financial summary or the highlights. Okay, the company performed in such a manner, and the board is being entrusted with a lot of responsibilities like you have to meet, you have to check the related party transactions, you have to comment on why auditor found or why auditor has given a qualification remark, right? So director is being entrusted with a lot of responsibility, with a lot of duties under the entire Companies Act, and here those directors or that particular board of directors is actually preparing a report. Okay, what we did the entire year. So the web address, the number of meetings of by board, how many times we met. There is a director's responsibility statement which actually has a lot in detail to be written. And how did you prepare your annual accounts? What are the accounting standards that you followed? You prepared the accounts on the basis of going concern. What is the accounting, or you took proper care for maintenance of accounting records, right? Internal financial controls that you followed, right? You have maintained proper systems for compliance of laws and all that. So all that part is included in the director's responsibility statement. Thereafter, the details of fraud reported by CAC. When we talk about the fraud which is being reported by the auditor, we have two types of fraud. One is of lesser quantum, which has to be only told to the board. Okay, fine, we tell it to you and you report it in your board's report. The second is of huge quantum, which actually has to be reported to central government. So here we are talking about the fraud which was reported by the auditor to the board of directors, what action they took, and they have to incorporate it in their board's report, right? Okay, so about nomination and remuneration committee, about your explanation, as I already told you, then particulars of loans or contracts with related parties, whatever amount you have transferred to the reserves, right? Section 186, LGSI, what is that you are recommending by way of dividend, right? Then we have something called as conservation of energy, technology, CSR, section 135. There are other prescribed matters like financial summary, the changes in KMP, changes in nature of business, changes in subsidiary, provisions with respect to deposits, right? Then Sexual Harassment Act compliance, cost records, if applicable, of course, then any court or tribunal's order, etc., etc. You can learn as much as you can. There is an abridged report for OPC and small company. So it contains lesser information which needs to be attached to the financial statements. Fine. Okay. This is something that we have already done. Now coming to section number 137. Section number 137 talks about filing of certain documents with the ROC. What are those documents? Your financial statements, of course. And they have to be filed with ROC. So annual general meeting took place. In annual general meeting, the financial statements, CFS, auditors reports, boards report, all the annexures, they are going to be placed before the members, and members adopt it by passing ordinary resolution. Once they adopt it, you have to file the same with ROC within 30 days of annual general meeting. This is the general provision or the general rule that we have, right? Now, supposedly annual general meeting was held, but all these were not adopted. For whatever reason, members suggested some changes and hence the meeting was adjourned. So what you'll do is you will file it with ROC within 30 days of annual general meeting. Now ROC takes in record as provisional records. Okay, once your meeting is finalized, once these documents are adopted by the members, again you will do the filing and then ROC will register it as final documents. But what happens if AGM is not held? Are we not supposed to file our financial statements with ROC? Then also you have to file the financial statements with ROC. Ma'am, how do we do that? Well, whatever financial statements were prepared, you will file with ROC and you will also furnish the reasons that why AGM could not be held. Okay, why AGM could not be held. Fine. Okay. So this has to be remembered, otherwise there is a penalty. Then we have a section called as CSR, although when we talk about the syllabus of CMA final, CSR is basically covered in the chapter of corporate governance. Main content we find over there only. However, the governing provisions originates from Companies Act section 135. So here we talk about lesser content. Firstly, which companies are required to do CSR, right? So applicability of CSR, the company which meets any of these three criteria. That means if your net worth is 500 crores or more, or your turnover is 1000 crores or more, or your net profit is 5 crores or more. So in such a case, you are subjected to CSR provision. So you will calculate what is the CSR expenditure that you have to do, how you'll calculate this. 2% of average net profit of 3 immediately preceding years. So 3 immediately preceding years, supposedly the average net profit comes out to be 6 crores. So 2% of 6 crores will be your CSR expenditure which you have to incur. Now, if this expenditure is within 50 lakhs, it does not exceed 50 lakhs, it is 50 lakhs or lesser, then the board can do it. The board can take decisions and they can incur CSR expenditure. If it exceeds 50 lakhs, then you need a separate committee called as a CSR committee. Now, this CSR committee will consist of 3 or more directors, out of which at least one shall be independent director. Okay, so you'll prepare that CSR committee, and CSR committee will actually recommend that, okay, we should do this because you give preference to your local area. CSR is what? Corporate social responsibility. So corporates have a social responsibility to deliver. So they are contributing something towards the society, right? So whatever you're contributing to this towards the society, it can be implemented by itself, or it could be a third party implementation. There are process and everything that we read in corporate governance chapter. Here we have to remember one thing, that there is something called as ongoing project also. What is ongoing project? Ongoing project is like if you are doing CSR expenditure, it may so happen that let's do something good, let's do something meaningful, and it's going to take a span of 2 years, but I have to incur 1 crore in this financial year only. So what do I do? So for that reason, supposedly you're building a school and it's going to take 2 years. This year you have spent 50 lakhs out of 1 crore, which was the minimum CSR expenditure, and you have spent only 50 lakhs. So what you do is the remaining 50 lakhs you transfer within 30 days of end of financial year to unspent account in a scheduled bank, and you can utilize it thereafter within 3 years, right? So that's something that you must remember. And the last section for the chapter of accounts of companies is internal audit, where just one question is being asked every single time, and that is which companies are required to appoint internal auditor. Firstly, internal auditor could be an individual, it could be a partnership firm, it could be a body corporate. Okay, fine, ma'am. Now, internal auditor can be an employee, or it may not be an employee of the company. It can be chartered accountant, it can be cost accountant, or it can be any other professional which may be decided by the board, right? So the scope of audit is being told by the company, and the internal auditor does the same. Now, which companies are required to appoint internal auditor? Every listed company. If you are an unlisted public company having any of these, paid up share capital of 50 crores or more, turnover of 200 crores or more, outstanding loans or borrowings of 100 crores or more, or outstanding deposits of 25 crores or more, right? 25, 50, 100, 200. So into 2, into 2, into 2. That's how you can learn it, right? Outstanding deposits at any point, loans or borrowings at any point, and these two of course are the balance sheet date. Private company, if you're having your loans or borrowings 100 crores or more at any point in financial year, or turnover of 200 crores or more in the financial year, fine. So such type of companies are required to appoint internal auditor. Okay, the next topic now, audit and auditors. That part is covered in chapter number 10, sections 139 to 148. Now, as I've already told you this, that audit is something which is mandatory for every company. We're talking about stat audit. We're not talking about internal audit, right? So we have a statutory auditor. Sometimes we also have cost auditor, wherein cost audit is compulsory, right? Then we have some other special types of audit also. Now, we begin with section number 139, but actually before that, some background. Some background is very well given in this particular chart, and we'll go through that. Where a company is incorporated, it has to appoint auditors according to section 139. Now, who can be an auditor? An auditor can be an individual also, an individual, or it could be a firm also. It cannot be a body corporate. So auditor can never be a body corporate. The only exception is LLP, right? LLP, even being a body corporate, can be appointed as an auditor. If you are talking about a firm, the majority of the partners should be CA, and only a CA can actually sign the audit report. So we need to have a CA in practice who can be the auditor basically, right? But then the struggle doesn't actually end over here. It is mandatory for every company to appoint auditor according to section 139. But whoever you choose to be the auditor, that particular auditor has to, one, give his written consent that, okay, I agree to be the auditor. Second, we need to obtain a certificate from him. What is the certificate that we need to obtain from him? There are going to be 4 things. Or I would say rather 5 things also you can say that has to be written in that certificate. Number 1, that you are eligible for appointment. You're not disqualified according to section 141. So we have a section 141, basically subsection 3, which actually talks about a huge list of disqualifications, that these are the persons who cannot become the auditor of a company, which we'll discuss later, right? So you are eligible for appointment, you're not disqualified. Your appointment is according to the term provided under the act. What is the term? We will talk about the rotation of auditors a little later, which talks that, okay, an auditor can be appointed for one term of 5 years, an individual. And if we talk about the firm, for maximum 2 terms of 5 years. So that is, so whatever term is being provided, your appointment is within that term. Secondly, it is within the limits which have been laid down. So it is not like, okay, you are somebody who has immense capacity, okay, so you do 1,000 audits. No, a person has a capacity, and if we do not restrict, the quality of the audit will be compromised. So a restriction has been placed by the act that, okay, one particular person can do maximum these many audits. So you have to have that audits within the ceiling limit, right? There might be some disciplinary proceedings going against you, during which you're suspended to take audit assignments. So you cannot, if you're not suspended, you have to correctly disclose about the proceedings which are going on against, right? So all this has to be given in the certificate, and thereafter you can appoint such particular person as the auditor. Once you appoint them, you will inform the auditors, and you will also file the notice of appointment with ROC, that is ADT 1, within 15 days of appointment. Of course, once an auditor is supposedly appointed for 5 years, during those 5 years he may be removed also, and he may also himself resign, subject to the provisions which are being given under the act. Okay, so now we come to the part of appointment, how an auditor is being appointed. We have, my dear, two types of companies. One is a government company and one is non-government company. Why are we classifying it this way? Because we have to read the provisions of appointment of auditors separately for these two types of companies. Because when we talk about government companies, the power to appoint the auditor and its governing authority, everything lies with CAG, that is Comptroller and Auditor General. Okay, so first we'll talk about the non-government company. Non-government company, we talk about the appointment of first auditors and the appointment of subsequent auditors. Ma'am, why is it different? Because when the company is being incorporated, supposedly a new company is incorporated on 4th April 2024, right? Now, I told you that auditor is being appointed at annual general meeting. This is something that you already know. It is a matter of ordinary business. Every year at annual general meeting, we look at this and we see about the appointment of auditors, appointment of directors. They are matter of ordinary business, and we appoint them at annual general meeting. Whoever is qualified, whoever fulfills the criteria, whoever gives his consent and certificate and all that, right? Fine. But if we wait till annual general meeting, don't you think it will not serve the purpose? Because the entire financial year is gone. The financial statements have been prepared. Who will do the audit? Because the financial statements, once prepared and approved, are given to the auditor, but the company doesn't have the auditor because it will wait till annual general meeting to appoint the auditors. The first auditor, you cannot wait till AGM for appointment. So the first auditor has to be appointed pre-hand only. But yes, the second auditor or any subsequent auditor can be appointed at annual general meeting. That is not the problem, right? So when we look at the first auditor, it has to be appointed by the board. It has to be appointed by the board, and he is going to hold office till the conclusion of first annual general meeting. So he's appointed from, at whatever date he's appointed, from that particular date till conclusion of first annual general meeting, and thereafter from conclusion of first AGM till conclusion of sixth AGM, and likewise for every next 5 years, second or subsequent auditors are being appointed. Now here I introduce another concept, which is the concept of audit committee. Fine. Because we have a rule 3, companies audit and auditors rules 2014, wherein we talk about the detailed procedure with respect to the audit committee. What is audit committee? First of all, we have a section 177 under Companies Act 2013, which talks about audit committee. Audit committee is nothing but it is a group of that company's directors which are dedicated to the cause of audit. So they are the ones who have good qualification and experience in the field of audit, in the field of finance, and they can actually identify, okay, this auditor can be appropriate for the company, right? So they can think about which should be appointed and how the auditor is doing the work and all perspective related to audit and everything, right? So they only recommend. Their decision is not final. They are the ones who look after this thing. They come up with a lot of recommendations to the board, and the board thereafter decides the same. But in most of the cases, board agrees with the recommendation. Sometimes it may so happen that the board disagrees with the recommendation of audit committee. In such a situation, supposedly audit committee has recommended a name that Mr. A should be appointed as the auditor, and the board says, no, no, we don't like Mr. A. Then why are they not liking? So they refer back the recommendation to audit committee. Audit committee what thinks, okay, fine, if they don't like it, we'll find some other name. Or they are so determined, adamant that they say, no, 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 Mr. A is the perfect choice. So they decide not to reconsider what board is saying. So they will again give, no, we stick at our own recommendation. Now it is the board's choice. Board may agree, board may disagree, right? Because you referred back and the audit committee is still intact, right? So now it's your choice. You may agree, you may disagree. So if you disagree, then you have to report the same in the board's report also. Okay. And if you agree, then there's no problem. Okay. So this is how the whole process actually works. Now, let me take you through the appointment. Audit committee is not required to be appointed or to be constituted by every company, right? Because if it is a small company, who has to be the auditor? There are not many functions of audit committee that can be done by the board itself. But if the company is huge, like it's a listed company, then you need to specifically have audit committee. You need to specifically have nomination and remuneration committee, stakeholders relationship committee, and likewise a lot of committees, CSR committee. So you have different committees which actually work on their core areas, right? But otherwise it's not needed. So in certain companies you need audit committee, in certain companies you don't need audit committee. Company which is required to constitute audit committee, in that case audit committee will recommend a name to the board, and board is going to appoint. If board appoints, great. If board doesn't appoint, then the members will call EGM, because annual general meeting happens only once in a financial year. EGM, extraordinary general meeting, that is meeting other than AGM is EGM. So they'll call EGM within 90 days and they will appoint the auditor. Now, supposedly there is no requirement of audit committee, then the board directly will appoint the auditor within 30 days of registration. Okay. If they appoint, great. If they don't appoint, the members appoint. So this is how the first auditors are appointed. If we talk about the subsequent auditors, then subsequent auditors again. If there is audit committee will recommend to board. Board will recommend to members. Because now the appointment of auditors is going to be done by the members by passing ordinary resolution at annual general meeting, right? So they recommend to members and they're appointed by members at ordinary general meeting. If there is no audit committee, the board recommends a name to members and they're appointed. Who can be appointed at annual general meeting? Well, the first auditor which was appointed by the board, he may be reappointed, or there might be someone else who is appointed. So both the situations may exist. He may also be reappointed if he is not disqualified, if someone else is not being appointed and there is no resolution passed of his non-appointment. Clear? Okay. Coming to the government company. Government company, if we are talking about the first auditor, now the difference between government and non-government company is that in case of non-government company, the auditors are being appointed for a tenure of 5 years. However, when we talk about the government companies, the auditor is being appointed for a tenure of 1 year only. So he'll be appointed and he'll be appointed till the conclusion of annual general meeting. That's it. His role ends. So the first auditor is appointed by CAG within 60 days. If they do it, great. If they don't it, by board within next 30 days. If they do it, great. If they don't, by members within next 60 days to hold office till the conclusion of annual general meeting. Okay, ma'am. Subsequent auditors, they are appointed by CAG within 180 days from commencement of financial year. From commencement of financial year to hold office till the conclusion of AGM. When does the AGM conclude? 30th September, let's say. And if we begin the financial year 180 days, again 30th September. So somehow you have the auditor every time, right? Okay. So that's how it works. Next, coming to rotation of auditors, section 139(2). Now, let's eliminate one-person company. Let's eliminate small companies. We have listed companies and we have certain companies which are prescribed. Prescribed like what? Unlisted company, unlisted public company which has a paid-up capital of 10 crores or more. Unlisted public companies which has a paid-up capital of 10 crores or more. Private limited companies which have a paid-up capital of 50 crores or more. You might see at some places this to be 20, that has been long amended, right? So it's 50 only. Or the companies with public borrowings or public deposits of 50 crores or more. So these type of companies plus the listed company, rotation is applicable on you. That means you cannot have one single auditor for life. You need to rotate your auditors. That means you need to change your auditors. Simple. Ma'am, what is the limit? I have already told you. If you appoint an individual as auditor, you can appoint him for maximum one term of 5 consecutive years. So once his term ends, there is going to be a cooling period of 5 years during which he cannot be appointed. After those 5 years end, again he can be reappointed. That's how it works. And if you appoint a firm as an auditor, you can appoint the firm for maximum 2 terms of 5 consecutive years. Again, there will be a cooling period of 5 years, right? Now, during this cooling period, there are certain things that you should remember. During this cooling period, you cannot appoint another audit firm with a common partner. So you appointed this particular audit firm where Mr. A was a partner. Their tenure of 10 years has expired. Now you appoint this particular firm again where Mr. A is also a partner. You cannot do that. So during cooling period, such a firm cannot be appointed. Such a firm cannot be appointed, right? This particular, I'm not revising, this is something which has become redundant or obsolete, right? Members may resolve to provide for internal rotation. Supposedly there are 5 CAs in a firm. So members may say that, okay, for these 5 years, every year a new CA will be doing the audit and will be the signing partner. So this may so happen. Okay, fine. How this rotation take place? Again, if you have audit committee will recommend the name to board and board of directors will propose the name to members and members will actually appoint it considering the fact and everything, right? Okay. Now, casual vacancy. What is casual vacancy? Casual vacancy is a situation where we don't have an auditor before his term has actually ended. So if we appoint an auditor for a tenure of 5 years, we know that after 5 years, we have to appoint another auditor. But what if he dies, or what if he becomes incapable, or what if some disqualification is attracted, or he resigns, any such thing happens that results in the casual vacancy in the office of auditor. Now, this has to be filled by the board within 30 days. Simple. In case of a non-government company. But supposedly, the auditor resigned. Usually when the auditor resigns, there are very high chances that they were somewhere, the management was not so cooperative. So in such a situation, there is additional compliance which is being given over here. What is that? The auditor resigns, no problem. You fill the vacancy within 30 days, but the same is going to be approved by members by holding a general meeting in the next 3 months. However, if you're a government company, the government company casual vacancy shall be filled within 30 days by CAG. If it is filled, great. If it is not filled, then the board is going to fill it within next 30 days, right? Here we come to one of the most important provisions of this particular chapter. So section 139 basically ends. Section 140 talks about removal of auditor, which we'll read a little later. Removal, resignation, and all that notice. So we straight away come to section number 141. 141 basically says that who can be an auditor? Only a chartered accountant can be the auditor. Firm can also be auditor, where majority of the partners are practicing CAs, and only signing partner can be CA. So I've already told you all that, right? Now we come to section 141.3, disqualifications of the auditor. First, body corporate cannot be the auditor. I've already told you that. Secondly, officer or employee of the company. He can be an internal auditor. He cannot be the statutory auditor. Thirdly, a person who is a partner or who is in the employment of an officer or employee of the company. So there is a company, it has an employee, he cannot be the auditor. Now, employee has a partner, he can also not be the auditor. Employee has an employee, he can also not be the auditor. Right? So you get it? Next. Person who his relative or his partner. Now, there is Mr. A who himself holds security of the company, he cannot be the partner. There is Mr. A who is proposed to be appointed as the auditor, but Mrs. A holds security. Then again, Mr. A cannot be the auditor. Mr. A is being proposed to be the auditor, but he is a partner in a firm and his partner holds security in the company. Then again, Mr. A cannot be appointed as the auditor. So that's how you have to understand. Of course, in the revision class, we cannot go into in-depth details, right? But a person who his relative or partner holds security of company, holding, subsidiary, associate, or subsidiary of holding. But the relative is allowed to hold securities up to 1 lakh. In fact, even if this limit exceeds, supposedly the wife of Mrs. A is holding securities in the company of 1 lakh, she buys some additional securities. There will be a time span of 60 days during which you can take a corrective action, and during that 60 days the person will not be disqualified, right? So you can decide, you can sell off those securities, or you can whatever you want to decide, and we're talking about the face value, we're not talking about the market value. Fine. Next, they are indebted to company, subsidiary, holding, associate, or subsidiary of holding cash, okay, in excess of 5 lakh, in excess of 5 lakh, right? Third, if that particular person or any of these have given guarantee or security of third person to them in excess of 1 lakh, in excess of 1 lakh, right? So the person will not be qualified. Next, any person who has a business relationship with what? Business relationship with company, subsidiary, holding, associate, subsidiary of holding, or subsidiary of associate. So there are so many companies which are being given. So if you have a business relationship with any of these, you cannot do that. Now, business relationship does not mean the commercial transactions that you are undertaking in the name of professional services. Like if I am a chartered accountant and I am rendering some auditing services or some other services and I'm taking fees, so I'm having a business relationship with the company, that means I'm disqualified to be the auditor? No. The commercial transactions or the professional services that you're rendering, that does not mean you have a business relationship. Likewise, there are a lot of commercial transactions which I take place. Supposedly, I am an auditor of an airlines and I want to travel somewhere. I buy a ticket of that particular, so I am a customer. Right. I am just like a customer in the ordinary course of business. That is not a business relationship that I have with the company. Okay. So that will not be covered. Next, if there is a person whose relative is a director. So I am Mr. A and Mrs. A is a director in the company. I cannot be the auditor, right? So whose relative is a director or is a KMP, basically. Any person who is in employment elsewhere, in full-time employment, you cannot be. And there is a limit of 20 companies, excluding OPC, excluding dormant companies, excluding private companies which have a paid-up share capital of less than 100 crores, right? So those you exclude. Otherwise, there is an upper ceiling of 20 companies. You cannot exceed that limit of 20 companies. Fine. or who has been convicted for fraud for a period of 10 years. Or basically, you can say who has been convicted for fraud and 10 years have not elapsed. So, if you have been ever found guilty of fraud, then you cannot become the auditor of the company unless that conviction has end, and from that date of conviction 10 years have elapsed, right? Okay. And lastly, who renders services under section 144. 144 is what it is, that the auditor is not allowed to render certain services like accounting and all that. We'll read about it later. Okay. Next comes removal of auditor before his term. Section number 140. If you want to remove the auditor, you're not satisfied with the service of the auditor, how can you remove the auditor? Call a board meeting, pass board resolution. Within 30 days, you'll make an application to central government. So you need to obtain the approval of central government, which actually has been delegated to RD. So you make an application to regional director online and you obtain approval. Thereafter, you will call your members and pass pass SR at general meeting. Auditor will be given a reasonable opportunity of being heard, and then in this manner auditor may be removed. So auditor cannot be removed so easily. Secondly, resignation by auditor. If the auditor is not satisfied and auditor wants to resign, then you can resign and file the statement indicating reasons within 30 days in ADT 3, and you will give this to the company, you'll give this to ROC, and you'll also give to CAG if you are the auditor of a government company. Okay. We also have something called as special notice for not appointing retiring auditor. Usually what happens, there is an auditor which is going to retire, and unless rotation is applicable, he will be reappointed, right? That's how it works, right? Now, there might be a situation where the members don't want this particular auditor to continue. So what they'll do is, eligible members, as we read in section 115, to send special notice. That is, if you're holding at least 1% voting power or 5 lakh paid up share capital, at least 14 days before annual general meeting, you will send that we don't want this retiring auditor to be reappointed, or we want someone else to be appointed. Okay. This you are sending to the company. Company sends a copy of this to retiring auditor. He gets an opportunity to make a representation. And this representation will be circulated amongst the members and will be read out at the meeting, right? Okay. But if the auditor is trying to abuse this right and saying defamatory things about the director and all that, trying to defame the company, then the aggrieved person may make an application to tribunal and say that stop this right of auditor. His statement need not be circulated or read out at the meeting. So tribunal will give accordingly directions, right? Otherwise, he'll be entitled to this representation, and accordingly, the members will hear the auditor and they will take their decisions. Okay. Apart from that, we also have the power being conferred to tribunal to change the auditor. So if there is any person concerned, he can make an application to tribunal. Our tribunal can itself also, if satisfied that no, this auditor is doing some fraud in the company, they're not rendering their professional services correctly, then it can change the auditors. Right? Such auditor will also be liable for an action under section 447. Okay. Now, auditor, if you are being appointed, your remuneration will be fixed in general meeting only. But if you're a first auditor, then your remuneration will be fixed by the board, because you're being appointed by the board only, right? You will be paid remuneration, plus over and above you will also be paid to the expenses that you incur, or any facility which is being incurred to you, or which is being extended to you. Fine. Then we come to section number 143. What is section 143? Here we talk about the powers of auditors. So auditor has certain rights and he also has certain duties. He has right to check the books. So if there is an auditor and he comes and says that, okay, give me this, provide me this particular book, and you say, no, We are not going to provide you that. Oh my God, he has all the power, he has all the right to access those books and at all times. Okay, wherever they are kept, it doesn't matter. If he needs any information, if he needs any explanation, you are bound to provide the same to him, as he has the right to information, explanation, right? And he has the right as well as a duty to make certain inquiries. Certain inquiries like what? If the company has provided any loan, whether you have taken security against it or not, there could be a lot of book entries. The transactions have not actually taken place, but they are just book entries for manipulation. So, whether the transactions are just book entries or they're actually taking place, right? Are they not harmful for the interest of the company, right? So, sometimes company make a lot of investments. Supposedly I've made an investment and I'm selling that investment at a loss. Now this should not happen. If this is happening in case of investment companies, it is completely allowed because that is their role, right? But otherwise that has to be checked, that has to be inquired by the auditor, right? The loans and advances, if you have made a loan, have they been shown as deposits? Sometimes it may so happen that the director has gone for a Europe trip and it has been written traveling expenses, so where the personal expenses have been charged to revenue, right? And many a times it may so happen that shares have been allotted for cash, so whether you have actually received the cash or not, so how you are recording all that. So it is the right as well as the duty of the auditor to make certain inquiries. He also has the right to receive remuneration. He has the right of lien to retain certain papers till his remuneration is being paid off. He has the right to receive notice. He has the right to access the records of subsidiaries also, as long as consolidation is concerned and all that, right? Then he has a lot of duties duty to give audit report on the financial statements which have been examined by him, right? Duty to make report on internal financial controls, right? Duty to express his opinion in true and fair view, right? Or give his opinion, right? Then there is an auditor's report which also must state a lot of matters which we have dealt in before, with respect to compliance with accounting standards, right? Disqualification of directors, then branch office, right? If you have consolidated, and whether the report of the branch was sent to you and how have you dealt in with it, right? So there are a lot of things, other things also, which as an auditor you must incorporate with the audit report. Moreover, it is the duty of every auditor that you must comply with the auditing standards, right? Central government has prescribed the standards and it's his duty to follow the standards, duty to make inquiries, duty to make report, duty to exercise reasonable skill and care, right? Okay, I will first take over here also duty reporting of fraud by auditor, although this is something that I've already explained you before. If the fraud is less than 1 crore, within 2 days, you report it to the board or audit committee and they disclose in board's report. If the fraud is 1 crore or more, then within 2 days, you report it to the board and ask for their reply. They reply within 45 days, great. After they reply, within 15 days of reply, you give your report, reply of the board, as well as comments on your comment on their reply to central government. If they do not reply or they do not give satisfactory reply, whatever it is, then within 15 days of expiry of 45 days, you will give your report, you will give the details that we sent it to the board but they did not reply. You'll give this to CG. So reporting of fraud is also covered in section 143 only, which has to be done, and all the provisions which apply to a normal auditor, they also apply to in case of branch auditor, in case of cost auditor, and likewise, right? Okay, then we have something called as audit of government companies. slightly different. We all know that we talk about government companies, they are owned or controlled by central government, state government, or a combination of them, right? So, this particular audit report will also include some directions by CAG. Okay. Now, CAG has some additional right because CAG appoints the auditor, auditor does the audit, he makes a report to CAG only, right? So, auditor submits a copy of audit report to CAG. Now, within 60 days from receipt of that audit report, CAG has some additional rights. What they can do is they may order supplementary audit. Supplementary audit means some additional information or some additional investigation on a particular matter, on a certain thing, right? He may also comment upon audit report. Fine, this particular comment is being added by CAG. They can do that, and they can also supplement such audit report, additional, right? So add on something, right? So that can also be done by CAG, right? It is placed. Acha, there is something called as a test audit also, and which may also be done by CAG. Then we have branch audit, section 143, subsection 8. Company's auditor can go ahead and do that branch audit, or the person who is qualified to be appointed as a statutory auditor, any person may be appointed as a branch auditor also. So just like we have section 139, these people can be the auditor, statutory auditor of a company, they can also be the branch auditor. So you can either tell the statutory auditor that you have to do branch audit also, or you can appoint somebody else as a branch auditor. Fine. If there is a foreign branch, then again the audit can be done by the company's auditor, by the accountant, or any person who's qualified over there to audit. Okay. Fine. They'll have the same rights, same duties, everything. The branch auditor is going to prepare a report, send it to the statutory auditor, and statutory auditor is going to deal with it. And he will also give in his report how he has dealt with it. Right? Okay. We have section 144, which talks that auditor is not supposed to do certain services. What services? The auditor cannot go and carry out accounting and bookkeeping services, internal audit, investment advisory, actuarial services, investment banking, management services, outsourced financial services, design and implementation of financial system, and others as may be prescribed. Okay, fine. So we have small sections like section number 145, which talks about signing of audit reports. So it is the duty of the auditor to sign the audit report, to certify everything, right? If he has qualified the report, or if he has given any adverse remark, whatever it is, right? That is all going to be open for inspection. Secondly, we have section 146, which actually gives auditor a right to attend the general meeting. So he's entitled to get a notice also, and he's entitled to attend the general meeting also. So all the notices, everything is going to be forwarded to the auditor, which I've told you already. We have section 147, which actually talks about the penalty on company if they contravene the provisions. Then we have penalty on the officers if they contravene the provisions, and we also have penalty on auditor if they contravene the provisions wherever they are required to comply with, right? So we have those penalties, and thereafter we have section 148, which talks about the cost audit. Now, we don't have to read in detail which companies are required to prepare cost records and all that, but central government has actually prescribed certain companies which are manufacturing entities or are producing certain goods or services that you have to maintain cost records, right? And once you maintain cost records, you have to get apart from that, then certain companies which meet a certain threshold or the criteria, they have to get cost audit also done. We have some regulated sector, we have non-regulated sector, about which you have read before, and now we don't have it in our course, so we are not supposed to read it, right? So cost auditor, who can be the cost auditor? Only a cost accountant can be the cost auditor. Cost accountant in practice is appointed by the board of directors. His remuneration is also fixed by the board of directors. It is ratified by the shareholders. Now he has to prepare a report in CRA 3, submit it to the board, and board within 30 days will furnish to CG with an explanation. CG may ask for additional information. That's it, right? Now after this we have Caro. Okay, now we have to revise Caro. It is not there in the charts. I'll revise it from the main book. First of all, Caro, it is basically divided into 4 paragraphs. So what is it? It is something which is additional reporting requirement for the statutory auditor, right? So if you're doing the audit of a company, of any type of company, you have to prepare this additional report. You report on the financial statements, you report on internal financial controls, right? You report on so many matters. Likewise, this is an additional reporting format which has certain clauses. On these clauses you have to check and you have to report on the same. This has been decided by CG in consultation with NFRA. Earlier we had Caro 2016, now we have Caro 2020, which is divided into 4 paras, and para 3 has basically 21 clauses, right? And we have to read about all these 21 clauses. What you will learn from examination perspective, that I've already highlighted in pink, and for the ones who want to know, they can of course note it down. Now there is one more thing, although this is not something which is very much important technically, but it is very much important from examination perspective. Why? Because you need to know about the non-applicability. Most of the times whenever a question about Caro is asked, it is asked on which companies Caro is not applicable. So if you're a statutory auditor of a banking company, then you don't have to prepare this Caro 2020 report as an annexure to your main report. You don't have to add this report to your audit report. Okay. So what are the exemption? Banking, insurance, Section 8, OPC, small company, and private company, which meets 4 conditions, right? I repeat, banking, insurance, Section 8 company, that is companies with charitable objects. OPC, you all know, small company, the current limit is 4 crores and 40 crores. So paid up capital not to exceed 4 crore and turnover not to exceed 40 crores, and you should not be a subsidiary, you should not be a holding, you should not be a Section 8 company, you should not be governed by special act, and you should be a private company. So you fulfill the criteria of being a small company. And lastly, private company, which meets 4 conditions. What are the 4 conditions? You should not be a holding or subsidiary of any public company. Second, your paid up capital plus reserves should actually I should say not exceed 1 crore. So it can be 1 crore or lesser than 1 crore. Then your borrowings at any point of time in financial year should not exceed 1 crore, and your revenue should not exceed 10 crores. So if you fulfill these criteria, then such private companies are also not required to report on Caro. See, private companies or any company as of that matter does not prepare any report. It is the auditor which is being mandated to do that, right? So if you're auditing such a private company, you have to always check that, okay, I am the auditor of a private company, on this Caro is applicable or not. Fine. So that is what you have to see. Now, what are the matters which are included in Caro? First clause, property, plant and equipment. Now, there are 2 types of properties basically when we are talking about the fixed assets, tangible and intangible assets. Every company is required to maintain proper records. Records means the quantitative details as well as the situation. That means simply that, okay, at this particular point or at this particular branch, there are so many desktops, or whatever it be, right? So quantitative details and situation, whether the company is maintaining that or not. Secondly, whether the management is physically verifying it or not, that it is just on paper. Physically, they don't know where are the assets gone, right? So physically, they should verify, and if there is material discrepancy which is being noticed, then that has been dealt in the books of accounts or not, right? Secondly comes your inventory. Again, inventory has to be physically verified at time and again, right? So whether it is being verified by the management at reasonable interval or not. Secondly, if it will be verified, then there might be material discrepancy which may be noticed. Material discrepancy of 10% of more, if it has been noticed, how has it been dealt in the books of accounts? And there is one more point. Whether working capital limits, if the company has been sanctioned some working capital limit and it is in excess of 5 crores, that has to be reported. Next is LGSI. Company is giving loan, guarantee or security or investment or loan to directors, right? So investment or loan to directors, you have to comply with section 185 and 186. Now, if you're giving loan, guarantee or security, firstly, auditor will see that this loan, guarantee or security should not be harmful for company's interest, should not be prejudicial to company's interest. Secondly, if you have given loan, then there should be a proper repayment schedule, that okay, on this particular date the principal repayment will come back, or on this particular date interest will come, right? So these are the dates of interest, quarterly interest, monthly interest, whatever it is. So there should be a proper repayment schedule, and the receipts should be regular according to that repayment schedule, right? So that is also something which is very important. So auditor will check that. And auditor will also check something, that if you have given a loan to somebody and that person is not repaying your loan and the amount has been overdue for more than 90 days, what are you doing? What steps have you taken for that recovery? Because you can extend the credit period. Okay, fine, you are unable to pay the installment today, pay it after a week. That is fine. But 90 days overdue, that is not fine, right? So that has to be done. This I have already done. Then comes your deposits. Deposits is what? We have read about the chapter of deposits. So whenever the company is accepting deposits, it has to comply with the sections of Companies Act 73 to 76A, plus it has to comply with RBI directives, right? So whether it has complied with it or not. Next is cost records. For the companies which are required to maintain cost records, are they maintaining it or not in the manner provided, right? So you have to check that compliance. Next is statutory dues. Income tax, direct tax, indirect tax, income tax, GST, right? And provident fund, employee state insurance. So whatever are the statutory dues which you are obligated to, which you are mandated to, and which has a deadline and a due date, whether the company is regular in paying that or not. If the company is not regular, then you have to report the details, right? And what are the areas which are outstanding? And there is one more thing, if it has been overdue for more than 6 months, then that also has to be reported, right? Then the transactions which are not recorded in the books, you found any transaction which has not been reported, which has not been recorded, right? So that has to be reported over here. Repayment of loan. Now, this particular loan, we are talking about the company has taken loan from bank or from financial institution. Then we have to check whether the company has defaulted in the loan. If yes, what is the amount? What is the period? Right? That loan was company has given loan. Here the company has taken loan. Next is utilization of IPO and FPO. So whenever a public company can raise funds from private placement also and from public offer also. Private company can raise funds only from private placement. Whenever you're doing it from private placement, you have to ensure that you comply with the section 42 and 62 for the issue of shares, right? But when you're doing public offer, then what has to be ensured is that whatever money you are raising, you're raising it for a purpose. You should utilize it for the same purpose. It should not be that, okay, I have raised money for some religious event, spiritual event, and then I'm running a DJ night, and no, that cannot be done, right? So that has to be reported. And if there is any default, then what is the subsequent rectification that has been taken place? That adequate amount should be brought back and it should be invested and like that. Next is reporting of fraud, which we have read about in section 143 subsection 12. When we read about the duties of auditor, auditor is also obligated to report fraud to central government. See, if the fraud is less than 1 CR, it has to be reported to board or audit committee. If it is exceeding 1 CR or it is at 1 CR, more than equal to 1 CR, then you have to report it to central government. So whatever fraud you have discovered, you have to report it here in Caro also. If you're doing the audit of Nidhi company, you have to ensure 3 things. First, there should not be any default. If there is default, report that. Secondly, net own funds to deposit should be the ratio of 1:20. And thirdly, Nidhi company should maintain 10% unencumbered term deposit. Next is related party transaction. You see whether the company has done any related party transaction. Yes. Then whether it has complied with section 188 or not. Next is internal audit system. Now, not all companies have to go for internal audit system, but if you have an internal audit system and there is an internal auditor which has made a report, that report is to be considered by the statutory auditor. Okay. Next is non-cash transactions. Non-cash transactions means what? See, we have a section 192 which deals with the restrictions on non-cash transactions with the directors. So if the company has entering into any non-cash transaction with directors, it has to check that whether there is a compliance of section 192 or not. Next is for NBFC or housing finance companies. For them, it is mandatory that they need to register themselves under section 45IA with RBI. So if they register themselves, it's great. So the first thing you should do is ask for their registration certificate, because otherwise they're not even allowed to carry out those activities, right? So whether registration has been obtained or not. Next is cash losses. If the company has incurred any cash losses in the financial year or immediately preceding financial year, that has to be reported. If there was another auditor who has resigned, there could be many reasons of resignation, but if he has raised any concerns or objections, whether they have been considered by you or not. You also report on the financial position of the company, right? That whether the company will be able to meet out its liability at least for 1 year or not, right? Then you have CSR compliance with respect to unspent account, right? Whether it has been transferred adequately and properly or not. And lastly, there are points which have adverse remarks or they have been qualifications. So that is going to be indicated separately, that okay, paragraph numbers of the Carver report, these contain the qualifications or adverse remarks, right? So that's it. Okay. Revision of the complete chapter of directors, appointment and qualification of directors, containing section number 149 to 172. So we have a lot of sections along with the relevant rules, and we are going to revise the same now. Let's begin. First thing is, what do you mean by directors? See, directors are someone who are appointed to the board of the directors of the company. Directors do not have any power individually, they have collectively power, right? They have collective power, which is, you can say, the board of directors or the directors or the board. These all three terms are synonymously used, and they have the power. Why do we need directors? Because company is an artificial person and company cannot run on its own, so we need someone to direct the company. All the company directions cannot, decisions, actions, directions, they cannot be done by the shareholders who are the investors of the company. Simple reason being because they are in huge number and everyone cannot be interfering in the management of the company. That's why we need directors to manage the company. So Companies Act has divided the whole powers of company into two authorities. One is the board of directors and other is shareholders. So at times we need permission from shareholders, and the day-to-day management is being handled by the board of directors. Section 149 mandates that every company must have board of directors. Section 149 tells us that minimum number of directors and maximum number of directors, what are they? Minimum number of directors you need 1, 2 and 3. 1, 2 and 3. 1 for OPC, 2 for private and 3 for public. And maximum number of directors for all types of companies is 15. This 15 can be increased. That means a company may have even 20 directors provided it passes a special resolution in this regard. So by passing SR, the maximum number of directors can be increased by any company, right? This particular requirement does not apply to Section 8 company as well as government company, not applicable to government and Section 8 company, right? That means if a Section 8 company wants to have 20 directors, it can have without even passing special resolution, So minimum 1, 2 and 3, maximum 15, which can be increased. Now, that was the first proviso. This was the first proviso. It can be increased by passing SR. Second proviso to Section 149(1). So we are talking about one subsection and its second proviso, which is very important. That's why you must learn this second proviso to Section 149(1). Now, what does it mean and what does it talk about? It talks about woman director. Every company needs a woman director, ma'am? No. If it is a private company, there are 2 directors just, out of which one should be woman. This will be harsh on the directors, harsh on the companies. So this is not the requirement which has been imposed by the Act. What has been imposed is that certain set of companies need at least one woman director. You are such a huge company, you have so many board of directors, out of which at least one director can be a woman director. So this is the mandatory requirement which is imposed on listed company, and listed company means listed public company only pursuant to the definition pursuant to amendment in section 2 clause 52 definition of listed company which I'm not discussing here again right now. And if it is other type of public company, then it has to satisfy either of the two criteria. Paid up capital more than or equal to 100 crores or turnover more than or equal to 300 crores. Fine. So if it's a listed company, one woman director must. If it is an unlisted public company, if you come under these two categories, any of these two categories, then you must have one woman director. Fine, ma'am. Now, if it is a new company, newly incorporated company, and it's paid up capital, the turnover will not be, you will not be able to get to know turnover within 6 months of incorporation undoubtedly, but yes, the paid up capital and the listed criteria it may meet. So the whole intention is that the company pre-hand knows that I have this requirement of woman director, and so it has to appoint woman director within 6 months of incorporation. Otherwise, we don't have any specific clarification or law given as to if the threshold increases by when woman director should be appointed, right? All the directors are being appointed in general meeting, and so this woman director will also be appointed. If we look at the financials, and if we find the financials, yes, it is crossing the threshold, thereafter this will be appointed. But what if it is a listed company and a woman director was appointed for a tenure of 5 years, but before that only the woman director died? This gives rise to intermittent vacancy, because if it is not filled, it has to be filled, because if the woman director has died, there is no woman director and it is non-compliance of law, so it must be filled. Who has the power to fill it? The board has been conferred the power to fill it. By when? Immediate next board meeting or 3 months, whichever is later. So intermittent vacancy has to be filled within this particular time limit. Okay, within this particular time limit. Now, section 149(3), resident director. This is for all types of companies. Even if you are a private company, you are a public company, or a one-person company, you need at least a resident director. Who is a resident director? Someone who stays in India. For how long? For more than or equal to 182 days in previous financial year. More than or equal to, that means if a person stays for even 182 days, he will be called as a resident. He will be called as a resident. So a director who is also a resident of India is known as resident director, and every company must have at least one resident director. Fine. Every company must have at least one resident director. Now, basically, if you try to recall, there are two types of directors. One are executive directors and one are non-executive directors. Executive directors were in the whole time employment of the company. Non-executive directors were not in the employment of the company, that is independent director or part-time director. And executive directors, we have example managing director, whole-time director, right? Ma'am, women director have to be appointed as executive or non-executive. It can be appointed either ways. It's not a requirement that they have to be appointed as executive only. No, even if an independent director on the board of a company is a woman, it is sufficient compliance for second proviso of section 149(1). Okay. Likewise, ma'am, the resident director, has it to be executive only? No. Again, no such requirement has been given. So it can be executive, it can be non-executive, that does not matter. But every company must have at least one resident director. Okay, I hope that is clear. Fine, ma'am. So we know the requirement of directors. Now, how do we appoint directors? See, section 149 is not over yet. It has a huge part of independent director, which we will do a little later. Why? Because I teach you in that manner only in the regular class as well, right? So we will revise it also in the same manner. Now we are talking about the appointment of directors, how the directors are going to be appointed. See, the directors are to be appointed by members, by shareholders in general meeting. That is what section 152 tells us, right? However, in certain cases it can be appointed by the board of directors also, it can be appointed by NCLT also, and it can be appointed otherwise also. So we will discuss how can we appoint the directors. Section 152 gives us three things. How first directors are going to be appointed, the requirements of being a director, and the rotation of directors. So it has three concepts involved in it. Fine, ma'am. Who can become a director? An individual. A company cannot become a director. An individual who is holding in, who is not disqualified, who has given his consent, right? And who has furnished MBB1, right? So such a person can be appointed as the director of the company. Fine. Supposedly I fulfill all this criteria. What are the methods? How can I be appointed as a director in the company? The appointment of first directors is given in section 152. The appointment of subsequent directors is given in section 160. And the appointment of retiring directors is given in again section 152. So that's how the appointment is spread over different sections. Okay, ma'am. So every director who has to be appointed to the board of the company must have DIN. What is DIN? It is an identification number which defines who you are, right? So anyone who wants to become a director in a company must have DIN, director's identification number. Without DIN, you cannot be appointed as a director in the company. So you must have DIN. How do you get it? There are two sources of obtaining DIN, DIR 3 and Spice Plus. We'll read about this later. Okay, fine, ma'am. So you obtain DIN, you give this DIN, and you give a declaration that you're not disqualified, DIR 8. You give your consent, DIR 12, to the company. The company in turns file form DIR 12 for your appointment within 30 days of appointment, right? Section 170 mandates the requirement of filing return, DIR 12, for appointment and wherever there is change in the appointment or change in the directorship or KMP. Okay, fine, ma'am. So anyone who is an individual, anyone who has DIN, anyone who is not disqualified, anyone who gives the consent can be appointed as the director in general meeting by the shareholders unless otherwise provided in the act. So something else can also be provided in the act. In that case, that will apply, but otherwise this is going to be the appointment. However, for the first directors, we cannot wait till general meeting because we are in a hurry. We need directors immediately when the incorporation happens, right? Because we cannot, for one day also, who will manage the company? To call general meeting, who will call the general meeting? So we need directors as and when the incorporation takes place, and that's why the first directors of the company, the appointment cannot be deferred. We need immediate appointment of the same. So what is given? According to section number 152, the names should be mentioned in the articles of association. So the articles of association are going to clearly specify that these will be the first directors of the company. Supposedly the articles of association don't specify. They will specify the manner. How will they be appointed? Supposedly they don't even specify that. So we will check whether table F can be applied or not. If we have specifically striked out table F that it shall not apply, then it shall not apply. Otherwise, it will be applicable if our articles are silent. What is table F? Table F is the model articles of association for a company limited by shares. So if our articles give the name, Mr. X and Y will be the first directors, they will be. If it has given the manner, they will be elected in such a manner, elect in that manner. If first 2 points are not applicable, table F will apply. What does table F tell us? Table F tell us that it will be decided by the subscribers. It will be decided by the subscribers, whoever has subscribed to the memorandum. Supposedly, no name is given in articles. We don't say provide the manner, and we say that the table F shall not apply. In that case, the individual subscribers become the first directors of the company. See, the subscribers may be individual, they may not be individual. A company can become the member of another company, right? So maybe on the memorandum of association of that company, a company has signed, right? A company's common seal is affixed or their representatives have signed. Quite possible. A company cannot become the director for another company. Only individuals can become the director, because again company will be an artificial person. So all the individual subscribers become the first directors of the company. Okay, fine, ma'am. First directors are going to hold office till the ensuing general meeting, and after that they can be reappointed or they may leave. If they want to be appointed again, they have to give their candidature. Because for appointment in general meeting, how appointment at general meeting is going to happen? When you give your candidature under section 160, your name is proposed, and general meeting, the shareholders pass OR and appoint you as a director. So now that is going to happen. That is going to happen. Fine, ma'am. And after that, you can be appointed as rotational director or non-rotational director in case you are a director of a public company. If you are a director of a private company, you can be permanent directors also, that's not a problem. But if we are talking about the directorship of public companies, then you can be appointed either as rotational director or as non-rotational director. Fine, ma'am. Now, before I move to this particular part, DIR 2, that is the consent part, it is not required in case of not-for-profit organizations, that is not-for-profit companies, as well as for government companies. So they have this exemption from filing DIR 2. Okay. Now, if we are talking about a public company, from the total number of directors, minus your independent directors. Supposedly, a company has total 14 directors and 5 are independent directors, 9 are left. Out of this 9, 2 by 3, 2/3 of 9, that is equal to 6, will be rotational directors. And out of the 6, 1 by 3, that is equal to 2, will be retiring. Will retire at every annual general meeting. Right? So, whatever is your total number of directors in a public company, its 2/3 have to be, at least its 2/3 have to be rotational director, whose office is going to be determined by rotation, right? Out of this 2/3, 1/3 is going to retire at every annual general meeting, right? So here in this case, as on our example, 2 directors will retire at every annual general meeting. How they will retire? The person who has been in the office for the longest will retire first. Supposedly 2 people have been appointed on the same day, they will mutually decide who is going to retire in this general meeting. If they cannot decide, then some lots will be drawn. And they will decide. Okay, they will decide. Fine. Supposedly, they have to retire at general meeting. That means they will go. They can come back also, but the chances are they will go also. Right, so they can go, they can come back. Supposedly the directors did not call general meeting. Can they continue? They cannot. If AGM is not held, they will have to vacate the office on the last day AGM ought to have been held. If AGM is held, then the 2 directors, that is 1/3 of the rotational directors, will retire. They can be reappointed, or in their place someone else can be appointed, or the company may resolve that they don't want to fill the vacancy. Either of the 3 will happen. Either of the three will happen. Supposedly none of the resolution is passed, then the AGM will be adjourned. It will not be conclusion of AGM. AGM will be adjourned. When AGM is adjourned and the vacancy is not even filled at the adjourned AGM, it amounts to automatic reappointment of the retiring director. That means he will be automatically reappointed. But there are certain cases of exception where he will not be treated as reappointed. Supposedly Mr. X is retiring and Mr. X has clearly said that I don't want to be reappointed. So he has expressed his unwillingness in writing that he doesn't want to be reappointed. We cannot reappoint him. We cannot reappoint him. Supposedly he is disqualified. He has become of unsound mind. How can we appoint him? Specifically in the act is written that we need OR or SR for his appointment. We cannot appoint him. There is contravention of section 162. When Mr. X was appointed, his appointment was only void. That means he was appointed through a single resolution, wherein appointment was needed by a separate resolution. 2 appointments were made by a single resolution. So it amounted to contravention of section 162. Now since your appointment itself was void, you cannot be reappointed. And we tried for your reappointment. So we proposed a resolution in front of the members to reappoint you, but this resolution was lost. That means our members do not want you to be reappointed. So no automatic reappointment will apply to you. Okay, fine ma'am. Now there is one more point over here. What does it tell us? See, some public companies may say that no, we want a transparent vision in our company, and we want all our directors to retire at every AGM. So all the directors retire, someone who's good comes back and the others leave the company. Companies Act tells if you have such strict provisions, way more stricter than what law says, great, follow them. So if your articles say that all the directors are going to retire at annual general meeting, so be it, right? But if they don't say it, then this is something that you are going to follow. This is something that you are going to follow, right? So section 152(6) tells us about rotation, and section 152(7) tells us how the vacancy will be filled pursuant to this retirement of rotational directors. Ma'am, what if they don't follow? If they don't follow these provisions, we have a section 159, which gives us the penalty, Section 159 tells us that if you contravene section 152, this penalty will be attracted. So the penalty is not given in section 152, rather it's given in section 159. The rotation part does not apply to unlisted government company or its subsidiary. Fine. Okay, ma'am. Section 160. Section 160. What is it? It is a section for new candidates. That means, see, who will be the first directors? They will either be the subscribers or they will be someone who is known to the board. Supposedly, I am incorporating a company and I know an efficient person. I will take his consent and I'll write his name as the first director. So I know that person knows me. That's why he could be the director. But section 160 gives a chance to anyone. If you want to be the director, you can propose your candidature. So anyone can propose candidature. Just to screen out or just to have those serious applications, there is a deposit. A refundable deposit of 1 lakh. It's not refundable in all cases, but it's refundable in these 2 cases. So what you have to do is, if I am a member and I want to become a director of my company, or if I am not a member, or if I know someone, I can propose his candidature also. So we propose someone's candidature. How do we propose candidature? We give it to the company. We say that we want this particular person to be appointed as a director in the upcoming general meeting. What you have to do is, you have to give a 14 days notice to the company. That means whenever company is going to hold its general meeting, 14 days prior to that, you must give that notice. plus 1 lakh rupee deposit. Now this deposit will be refunded if the person is elected as a director, or even if he is not elected but his votes are 25%, more than 25% of the total votes which have been cast, it shows that he was a serious and eligible candidate. So in this case also the refund is made. Fine. So you serve this notice to the registered office of the company. What does company do? Company sends this notice of candidature at least 7 days before general meeting to all the members. It can be done by sending individual notices or a public advertisement in 2 newspapers, English and vernacular. And it also has to be placed at the website of the company. Fine. So all the members receive this notice that someone has been proposed to be a director. At the annual general meeting, simply by passing ordinary resolution, they can appoint the director, or if the resolution is not passed, the person will not be appointed. The section does not apply to a private company, because in private company not everyone gets the power that they can nominate themselves. No. It does not even apply to a 100% government company, wholly owned subsidiary of such 100% government company, and Section 8 company where election is happening by ballot system. Right? Okay, fine, ma'am. In certain cases, you don't need deposit. Why? Or in what cases? In case of independent director. If independent director is proposing his own candidature, independent directors are someone who are anyway highly knowledgeable, highly professional, highly qualified people. You cannot doubt and you cannot say this is not a serious application. Of course, it's damn serious. So they don't need deposits. Moreover, if a person is recommended by board or NRC, probably they are the people who have much knowledge, and if they are recommending someone, he is a deserving candidate only, right? So in this case, you don't need a 1 lakh deposit. Now, supposedly, someone who has retired, a person was appointed as a rotational director in a public company and he retires according to section 152(6). Now, he wants to be reappointed. The question is, do we need to send the notice and 1 lakh deposit under section 160 for his appointment? Answer is no. Section 160 does not apply for the case of reappointment of retiring director. It clearly says that a person who is not a retiring director in terms of section 152 shall also be eligible to be appointed as the director if he gives a notice plus 1 lakh deposit to the company at the registered office, etc., etc. So that's how the process begins. Fine. Okay, ma'am. Now, we know that individuals who are holding DIN and who are not disqualified can be appointed as the director. So, the next question comes out is, what is DIN? DIN, Director's Identification Number. How do you obtain DIN? How do you get DIN? DIN can be obtained in 2 ways. See, the provisions of DIN are covered in section 153 to section 159. 159 is that last penalty part. Any individual who wants to be appointed as a director, you cannot be appointed unless you have DIN. How do you obtain DIN? You can file an application in DIR 3 with these attachments. There is also an option that Spice Plus. Supposedly, I am forming a new company and I have never been a director of any company. So what choice I have is in Spice Plus only I can fill my details and it is going to work as an integrated form and will also provide me DIN apart from incorporation of the company. Right, so this is also a method of obtaining DIN. Otherwise, the general form and the regular form that we have for DIN is DIR 3. Now, just like you can obtain PAN as and when you need, you cannot obtain DIN as and when you need. For DIN, what is required is that you must be a director of some company. Ma'am, how can we become the director without DIN? You must be proposed to be a director of some company, and only then you can obtain for DIN. That means government needs to know that where do you want to be appointed as a director, and then only they will give you DIN. Why? Because in attachments there is a need for board resolution. So the company which is proposing you to be appointed as a director will give a resolution, and then only you can submit this application. Once your application is submitted, central government examines your application. Central government examines your application. Just a second. Central government, if they find that your application is not defective, then what are they going to do? They are going to allot you the DIN. But if they find that yes, your application is defective, then they are going to intimate you via mail or via website, and you have to rectify the defect within 15 days. So you get a chance to rectify the defect within 15 days. Supposedly the defect is rectified, then again you can be allotted DIN, and if you do not rectify the DIN, then it has to be rejected, right? So the application will be rejected. Now whatever DIN you have obtained is going to stay with you for your life, no matter in which company you become a director. You become a director in XYZ, PQR, X Limited, Y Limited, doesn't matter. One DIN for all the companies and one DIN for your life. It's not going to change. It's never going to change. Fine. Okay, ma'am. Only one DIN is allowed for every individual. Just like you cannot have a duplicate PAN, you cannot have a duplicate Aadhaar, likewise you also cannot have a duplicate DIN. Okay. So first thing, you make an application for DIN in DIR 3. Second thing, central government allots you the DIN when they find the application is in order. Third thing, you're prohibited to obtain more than one DIN. Okay, whatever DIN you obtain, supposedly, if now you want to become the director of any company, you cannot become without DIN. But for the directors who were already directors, before these rules came into picture, before this concept of DIN came, they were already directors. Now they are also being given a time limit that they have 1 month from the receipt of DIN. They have to inform central government. Okay, they have to inform the companies, and the company in turn will inform the ROC. So existing director has to intimate DIN to the company and the company to ROC. That is section 156 and 157. Okay, fine. This is clear. Now, any director, if you have DIN, wherever you are quoting that you are the director of ABC Limited or whatever like that, you must state your DIN. Your name is not sufficient. To identify you, we need that DIN. Just like we quote membership number wherever we are doing that, right? CS membership number, CMA membership number, CA membership number, we quote that, right? That is important. So likewise, directors also have to quote their DIN. Okay, fine, ma'am. Now tell me, ma'am, something that can we surrender our DIN once we have obtained the DIN? Can we surrender the DIN? The answer is no. You cannot surrender the DIN just like that. Supposedly, I have worked as a director in a company, I have done enough fraud, and now I simply surrender my DIN and I go away, and now I take another DIN and I become the director of some other company. So whatever frauds I'm doing, I'm never traceable. Can I do that? The answer is no. The answer is no. But supposedly I have unused DIN. Unused DIN. That means, ma'am, how can that be the case? I was being proposed to be appointed as a director in some company, and that's why I made an application in DIR 3 to obtain DIN. I obtained DIN, but in this company, OR was not passed for my appointment, and so I could not be appointed. And thereafter, I have not been appointed in any company as a director, but I have DIN. I know that I'm not going to use this DIN, so I want to surrender this DIN. Can I? Yes, you can. If you have unused DIN, you can surrender that DIN to the government, and the government is going to deactivate your DIN, right? Otherwise we don't get this power. Then what happens, ma'am? RD or central government can cancel or deactivate our DIN. When? If we have duplicate DIN, If our DIN is being obtained in some wrongful manner, that means we have given some misinformation and we have got DIN, or we have got DIN with the intention to deceive someone. In both cases, our DIN can be cancelled. If we die, if we turn out to be of unsound mind, if we turn out to be insolvent, if we surrender our DIN, or if we fail to do KYC. If we fail to do KYC, that can also lead to deactivation of DIN. What is KYC? What is KYC? We have a rule 12, where earlier you had to read a lot about KYC, not now. What is KYC? Know your customer, right? So know your director. Basically, it is an annual e-verification. Whenever you become a director of some company, every individual who holds DIN, no matter you are a director or you're not a director, you are holding DIN, you have to file this form DIR 3 KYC. And every financial year, there has to be a simple verification DIR 3 KYC web through that, right? So all your records are available. It is an online facility. You just approve the same. Why? Because the government records cannot be updated. We're talking about directors. We're talking about the corporate world. The records cannot be old, right? So they have to be updated from time to time, and the responsibility is being conferred on the person holding DIN. If you have DIN, it's your duty to do that. If you don't go for annual e-verification, your DIN will be deactivated. Fine. Okay, ma'am. We also have another rule, Rule 12, which talks about the changes in DIN. So whenever there is any change, not in DIN exactly, in our details, maybe my address has changed. So it is my duty that I intimate the company within 15 days. Moreover, I file DIR 6. I attach the proof of change. It is verified, that is the DSC of CA, CS, CMA is attached. I submit the form for verification. Central government incorporates all the changes and informs ROC also. Ma'am, why this is happening? Why don't we directly file the form to ROC? See, you are doing an online filing only. So you are filing this DIR 6 also on MCA website, but it goes to the central government and not to the ROC. Why? Supposedly, I am a director in a company of Kolkata, Mumbai, Delhi, Karnataka. So I am a director of 4 companies in 4 different states. To which ROC it will go? So the DIN cell intimates it to the concerned ROCs. Fine, ma'am. Number of directorships. What do you mean by this? Supposedly, I am an eligible person, I have DIN, and I want to become a director in 50 companies. Can I? Why not? 50 companies. If you have that caliber, why not? Well, this is not like eating a donut eating competition or a puchka eating competition or something like that. It is becoming a director in companies, which requires time, effort, energy, efficiency, everything. And the government itself has given a very generous limit of 20, out of which 10 can be public companies. So if you are a director in 20 companies, you should know that you are highly efficient, like Rajnikant or something, right? You cannot be holding 20 directorships in active companies just like that, right? So we have a limit. What is the limit? Maximum number of directorships in all companies, 20. So I can be a director in maximum 20 companies. But this does not include Section 8 or dormant company, but includes alternate directorship, out of which maximum 10 public company directorships I can hold, right? So if I am a director in 20 companies, and I have 9 public companies and 11 private companies, this is something which is allowed. But 11 public companies and 9 private companies, it is something which is not allowed. Now, when I am computing which is the public company directorship, I have to make sure that I include this also. What is it, ma'am? Private company. Private company which is either a holding to some public company or it is a subsidiary to some public company. This is going to be treated as public company. This is going to be treated as public company for the purpose of, for the section 165 for computing this limit. Okay. Now, supposedly before commencement, there was a person who was a director in 50 companies and there was nothing rule like this. There was no provision like this. When this provision came into picture, he has been given a time period of 1 year that you choose in which companies you want to stay as a director, and the rest of the companies you have to leave. So you resign in the rest of the companies and you intimate your choices to ROC. Okay, fine, ma'am. But after commencement of act, this is going to be the maximum number of directorships. Now, some companies, they do it that if you want to be the director of my company, you cannot hold more than 10 directorships. Ma'am, can the companies do so? Yes. By passing SR, you can have strict provisions in this regard. So you can reduce the maximum number of directorships. You cannot increase it. You can reduce the maximum number of directorships. Fine. So that was section number 165. Section 164, this talks about the disqualification. See, this section is divided into 3 parts. Part number 1, that is section 164(1), which talks about 9 grounds of disqualification. If any of the ground of disqualification is attracted to the person, he is disqualified to be appointed in any company as a director. Okay, ma'am. And supposedly, after his appointment, some ground of disqualification is attracted to him, then he has to vacate office according to section 167 of the Act. So we have 2 different sections. One is for disqualification and other is for vacation, but they go hand in hand undoubtedly. Okay, fine, ma'am. Section 164(2) also talks about 2 grounds of disqualification, but these disqualifications are attracted to the individual because the company in which they are holding directorship has done some default. These disqualifications are attracted to an individual. These disqualifications are attracted to a director. If you are not a director of any company, there is no point of this particular subsection. And section 164(3) talks about additional grounds of disqualification. That is, a private company has been given the power that you can provide additional grounds of disqualification also. Okay, ma'am. Let's read them one by one. First of all, the 9 grounds of disqualification that have been given in section number 164(1). First is unsound mind. It doesn't matter whether I consider myself of unsound mind or not. It is that I have to be declared by the court. Undischarged insolvent. The court has declared you as insolvent, but you have not been discharged yet. So in that period, you are undischarged insolvent. Third, if you have applied for insolvency, but you have not been declared by the court as insolvent or not solvent, whatever. That means your application is not disposed of yet. You have applied. So during that tenure also, disqualification is attracted to you. Next, if you have been convicted by court, that means you have been found guilty by the court. See, you have done some offense. The offense is moral turpitude or otherwise. You have been found guilty by the court. The court has given you a sentence of imprisonment. The imprisonment is 6 months or more. Imprisonment is 6 months or more, then you are disqualified for 5 years. Okay. See, if your imprisonment is less than 6 months, you're not disqualified even for a single day. If your imprisonment is 6 months or more, you're disqualified for 5 years. But supposedly the imprisonment is 7 years or more. 7 years or more. Then you are disqualified for life. You can never be appointed as a director in any company. Any company, any time in the future, you cannot be appointed. Fine. Whatever disqualification we are checking is of course at the time of appointment of director. So whenever you want to appoint, you check whether the person is of unsound mind, discharged, insolvent, is his application pending, has this disqualification attracted to him. For 5 years he will be disqualified. 5 years from the date of, not court's order, but from the date of expiry of his sentence. So when he has completed his tenure of imprisonment of 1 year, 6 months, 2 years, whatever it is, after that 5 years he has been disqualified. After that 5 years he will be disqualified. Next, court's order. If the court has given you an order that you are disqualified, you are disqualified, simple. Unpaid call till 6 months. Now this is for shareholders. See, a director may be a shareholder, he may not be a shareholder. It's not imperative that he has to be a shareholder only. If he is a shareholder or if a shareholder wants to become a director, then he has to check this disqualification also. I am a shareholder of the company. The share price of the price of one share is equal to rupee 10. Out of which 6 I have paid to the company, 4 is unpaid. The company calls for this rupee 4 and I fail to repay it. I fail to pay it. Now imagine appointing someone like me as a director who cannot pay her own call money. You think I have the capability to collect other people's call money, to be responsible for the compliances? No, this shows my responsibility, how irresponsible I am. Right? But this irresponsibility cannot be checked at the immediate moment, right? So we have been given a time period of 6 months. 6 months, right? So during the 6 months, if I pay, the disqualification is not attracted to me. The disqualification gets attracted to me when the tenure of, or when the period of 6 months has elapsed from the last day fixed for payment. Okay, then I am disqualified, and this particular disqualification attracts only for company in which call money has not been paid. In which call money has not been paid, and not in other companies. So in other companies I am qualified to become a director. Only in this company I cannot become a director. But supposedly you are already a director. So I vacate the directorship according to section 167 and I cannot be reappointed. Reappointed till when? Till I pay this call. Offense under section 188. Related party transactions offense. So if I have been found guilty for this offense, I cannot be appointed. Till when? Preceding 5 years. So we check for preceding 5 years. If preceding 5 years this offense is existing, I cannot be appointed. If in preceding 5 years this offense is not existing, I can be appointed. He has not been allotted DIN. Without DIN, you cannot be a director. And if your directorship limit is exceeding 20, you cannot be a director undoubtedly. So on all these 9 grounds, you are disqualified. You cannot be appointed as a director. You cannot be appointed as a director. Fine, ma'am. Then we come to section 164(2). From examination point of view, this is very important, but although it's very small one. Supposedly, I'm a director in some company, and that company fails to file its financial statements or annual return for a continuous period of 3 years. Or it does not pay its deposits, debentures or dividend. They remain unpaid for 1 year or more. Either of the two situations gets attracted, the company becomes a defaulting company. And if I am the director of the defaulting company, I become disqualified. That means if I want to be appointed in some other company, I cannot be appointed. I cannot be appointed. And ma'am, you have to vacate office also from this company? No. This is the catch over here. Not from this company. Not from this company. See, vacation has 8 grounds. If a director is disqualified under any of the ground of section 164(1), he vacates the office. If you are disqualified under section 164(2), then also you vacate the office, but not from the defaulting company. That means if a person is a director in 4 companies, A Limited, B Limited, C Limited, D Limited, and A Limited has not filed its financial statements, the directors of A Limited are disqualified. They cannot be appointed in any other company. And whoever is the director of A Limited is also a director of B, C, D, you have to vacate office, but in A Limited you will continue the office, right? Because you are responsible for all this. Okay, fine, ma'am. Now, supposedly there is a new director who joins, and before he could actually analyze what's happening in the company, this default gets attracted. And when the default gets attracted, all the directors of the defaulting company, they become disqualified. So Mr. X cannot be appointed in any other company. Oh, very unfair, right? So this disqualification does not apply for 6 months from the date of appointment. So a new director gets the benefit, he gets the time to, he can rectify the defaults, whatever is going on in the company. So he gets a benefit of 6 months. Okay, fine. Clear? For this, you also have to give a declaration, the IR 8, that I have told you a number of times. Now, vacation. Grounds of vacation, section 167. First 2 grounds I have already told you. Third is, if the director is absent in all board meetings during 12 months, see, not in the financial year, not in the calendar year, we check for any 12 months, any 12 consecutive months. So, the director skips the first board meeting, from there we check for a tenure of 12 months. If he does not attend any board meeting, doesn't matter how many board meetings are held during that particular time, if he does not attend any board meeting, he has to vacate the office. He vacates the office, can he come back? Why not? Because this is not a ground of disqualification. So when we want to reappoint him, when we want to appoint him again, we check the grounds of disqualification. We don't check the grounds of vacation. So again, he can start. These 2 grounds both relate to one section, section 184. What is section 184? It talks about interested contracts. A director may be interested in some contract. If he is interested, he must disclose it pre-hand to the board of the directors. So he has to disclose it. Moreover, if he is interested, he will stay away from that particular contract. He will not participate in that board meeting. He will not vote, etc., etc. So there are 2 requirements on part of the director that he has to do. So if you fail to disclose your interest, or if you participate in that meeting of interested contract, both are an offence under section 184. And if you contravene these 2, you have to vacate office of director. You have to vacate office of director. Okay, ma'am. Next is, if you are disqualified by court. If you are disqualified by court, it is included in this. So you vacate office. If you have done an offence, imprisonment 6 months or more, disqualified, included in this, vacate office. Why? Given separately. Because in such situation, the vacation of office is postponed till disposal of appeal. See, whenever anyone passes a court order against us, we get a time period. What time period? We get certain time period to file an appeal. This is our right. So if court has said that you have done an offence and you are being sentenced to imprisonment for 1 year, this is my fundamental right, I can appeal. And when I appeal, will this disqualification be attracted to me? Do I need to vacate office? What is going to happen? So I have made a beautiful chart for that. Let's discuss this. Order of court. So we have a court order and the court order finds us guilty. I have two choices. I can either file an appeal or I don't file an appeal. If I don't file an appeal, I get a chance to file an appeal within 30 days. If I don't file an appeal, on the 31st day, I vacate. If I file the appeal within 30 days, then I will not vacate office till this appeal is disposed of. See, if the court has declared me as guilty, I am disqualified. I cannot be appointed in any other company, but the directorship that I am holding is going to be delayed if I file the appeal. So I don't have to vacate immediately. I will vacate when the appeal gives its order. Okay, so next court order I receive, I'm not guilty, I don't vacate. And if I am guilty, I again get a chance to file an appeal within 7 days. If I file the appeal within 7 days, if I don't file the appeal within 7 days, I vacate on the expiry of 7th day. But if I file the appeal, again I will not vacate the office till this appeal is disposed of. And after this, I don't have a chance for further appeal. So if I'm guilty, I have to vacate. If I'm not guilty, I'll not vacate. Okay. So that's why these 2 points are given separately. Then, if I'm removed in pursuance of the provisions of the Act, Section 169 gives the power to shareholders that they can, by passing ordinary resolution, remove the director. So, if a director is going to be removed, he has to vacate the office undoubtedly. And moreover, if he is appointed by virtue of holding office, if he is the CEO of a subsidiary company, and he has been appointed as MD because he is the CEO. If he ceases to be CEO, he will cease to be MD also. Simple. There can be a situation that all the directors have vacated the office. Now, the company again cannot run on its own. So, we need the directors. Where will we go? We will go to the promoters. The promoters will appoint the directors. In their absence, we will go to the central government, and central government will appoint the directors. They will hold office till the general meeting, and in general meeting, we will the regular directors can be appointed, or these directors can only be regularized, right? Just like a private company has the power to provide additional grounds of disqualification, it also has the power to provide additional grounds of vacation also. Okay, fine, ma'am. Now, Section 161, a very important section. Even from examination point of view, it is divided into 4 parts and you have to remember all 4 subsections. Section 161(1), additional directors. 161(2), alternate directors. 161(3), nominee directors, and 161(4), casual vacancy. 161(1), additional directors. Who are additional directors? Anyone. See, if you appoint first directors, if you appoint the directors in general meeting, if you appoint additional, alternate, casual vacancy, whatever type of director you appoint, if you appoint nominee director, if it is appointed by NCLT, whatever it be, one thing is must, or the basic requirements are must. Such person must have DIN, such person must give consent, such person must not be disqualified, and these are basic requirements. Okay, so even when you are appointing someone as additional director, you have to ensure these things. General rule given in Section 152 is that the directors will be appointed by the shareholders in general meeting. This is an exception to that. So Section 161 here, the appointment is not happening by the shareholders in general meeting. It's happening by the board of directors, right? So the board of directors are appointing here. For additional director, the board of directors can appoint by passing BR, provided they have an authorization in AOA. If AOA is silent, table F can also authorize. Okay, ma'am. So, if the board has authorization, they can appoint someone as additional director by passing board resolution. Now, this additional director is going to hold office till AGM only. Supposedly AGM is not held, last date on which AGM should have been held. Okay. Supposedly Mr. X, he was proposed in the general meeting and he could not be appointed because his resolution was lost. Now he approached the board of directors and they appointed him as additional director. This is something which is not allowed. Someone who has been rejected by the members cannot be appointed by the board. So a person other than someone who failed to be appointed at general meeting can be appointed as additional director. Alternate director. Alternate director. If a director goes out of India for 3 months or more, right, the board has the power. From where do they get the power? They get the power from either articles of association or through ordinary resolution in general meeting. So if they have this power, they can fill the vacancy of that director by appointing someone else. How? Simply by passing ordinary resolution. Now, he is a replacement. Although you have to understand that alternate director is not a proxy of the original director. He is not the agent of the original director. He is having a separate terms of employment with the company. But it is just that he is appointed to fill that vacancy. So if the original director returns, he vacates. If the term of original director expires, he vacates. So he cannot hold office beyond that particular period. Moreover, a person who is going to be appointed as an alternate director has to be someone who is not already a director of the company. And one person cannot hold alternate directorship for more than 1%. Right? Alternate director is not an agent of the original director. It has its own duties and own liabilities. Okay, ma'am. Section 161(3), nominee director. See, okay, before that, one more point for alternate director. Supposedly, alternate director is a retiring director. He is a rotational director. And he has to retire at annual general meeting. So he retires. At annual general meeting, there was no ordinary resolution which was passed for his reappointment or appointing someone else or resolving not to fill the vacancy. So AGM was adjourned. At adjourned AGM also none such resolution was passed. So it leads to automatic reappointment of retiring director. Now this retiring director is out of India and we have in its place an alternate director. So who will be reappointed? Alternate director or original director out of India? Original director out of India. So the reappointment is not automatic. Reappointment does not happen for alternate director. It happens for original director. Okay, ma'am. Now, nominee director. Nominee director. For alternate directors, you have to remember all those basic points, that it does not matter whether the original director is going to out of India for whatever purpose. So the purpose is not important. When he comes back, he has to vacate. Right. So all these minute points also we have to remember. And now fine, nominee director. Nominee director, section 161(3). See, the board, if he gets the board gets a nomination, that means supposedly the company has taken loan from a financial institution and they have an agreement that we are going to give you loan only if you allow one person who we are going to nominate to be a part of your board of directors. So financial institution is nominating a person and the board has to appoint that person as a nominee director on their board. Likewise, it can be nominated by central government if they have a shareholding, of course, in a government company. So that is the situation. And it can also be in pursuance of some law. So if the law states or mandates, that is also going to be nominated. So whenever financial institution or other institution or government, they nominate a person by virtue of their shareholding, by virtue of law, or by virtue of an agreement, the board, by passing board resolution, appoints such person as a nominee director, subject to articles. Clear? Fine, ma'am. Then we have casual vacancy. Casual vacancy is not like intermittent vacancy. The director who has been appointed by the shareholders in general meeting, it is for the director appointed in general meeting and not for the director appointed by board or any other manner. It is for the director appointed in general meeting only. Supposedly his office ends otherwise than in normal course. He was appointed for a tenure of 5 years, but before 5 years only, after the expiry of 2 years, he dies. This is a casual vacancy. This is not intermittent vacancy. Why? Because in intermittent vacancy, it is imperative. It must be filled. Otherwise, it will lead to non-compliance of law. Here, a director has died. It is not non-compliance of law, right? So, it may be filled by the board. It may not be filled by the board. Okay. So, this is known as casual vacancy. If board has power through articles, it can fill this vacancy. How? By passing a resolution at board meeting. Now, it is a casual vacancy. For 2 years he worked and for remaining 3 years he could not work. So his vacancy is for 3 years only. This is casual vacancy. So whoever fills this position is going to hold office only up to the date which director in whose place he is appointed would have held had he not vacated. That means this particular date. So anyone who is filling the vacancy, casual vacancy, is not going to hold office beyond this tenure, beyond this date. Beyond this date, he cannot hold office. He cannot hold office beyond this particular date. Is that okay? Is that fine? Okay. Now, there is one more requirement in case of casual vacancy, because he is going to hold office for a very long tenure. Say for 3 years, 4 years, 5 years, it could be anything, right? For the remaining tenure, it also needs approval from members. So, although board has the power to appoint anyone wherever casual vacancy arises just by passing board resolution, they have to seek subsequent approval from the members also by passing OR in whichever next general meeting comes. Okay? Clear? Fine, ma'am. Now, section 162. Appointment of directors to be voted individually. This section applies not to a private company. It does not apply to a private company. What does this section tells us? It tells us that appointment of a director, 2 or more directors, appointment of 2 directors or more directors cannot happen by a single resolution. I cannot say that I propose to appoint or resolve that Mr. X and Y be hereby appointed. The members are being deprived of the freedom of choice over here, because either they have to appoint X and Y both or they have to reject X and Y both, which is not allowed. So for every appointment of director, we must have a separate resolution. Appoint X, yes, no. Appoint Y, yes, no. Appoint X and Y, yes, no. Doesn't work. So separate resolution is something which is allowed for appointment of 2 or more directors. However, single resolution may also work. When ma'am? When can it work? When a prior resolution is passed. That means before this single resolution, another resolution is passed which tells us, resolve that appointment of X and Y is going to take place by single resolution, whether you approve or you disapprove. So you are taking prior permission from the members for proposing single resolution, and when you obtain this prior permission, it's not going to be OR, it's not going to be SR, it's going to be a resolution with no vote against it. That means there shouldn't be any objection raised to the passing of single resolution. Before single resolution, there has to be another resolution which has to be passed. Okay, fine, ma'am. Supposedly, you did not meet these conditions, you did not meet this requirement, and without meeting these requirements, single resolution was passed. Without taking this permission, single resolution was passed. Then all the appointments will be void. And this section 152(7) deemed reappointment shall not apply. We discussed this as an exception. When the retiring director automatically reappoints in adjourned AGM, there is an exception. This is an exception. I told you before only that section 162 does not apply to a private company. It does not apply to a 100% government company and wholly owned subsidiary of such 100% government company. Wholly owned subsidiary of such 100% government company. Okay, ma'am. Section 163. Proportional representation. What is proportional representation? See, if there is being given the power in article, some companies may choose to appoint their directors by proportional representation. Normally what happens, a person is proposed, OR is passed. If we get simple majority, he is appointed as a director. But in PR, we have a special voting method. This is by majority, simple majority. The minority shareholders might have to say that we cannot propose someone, our proportion is not being represented, etc., etc. So we have differential voting methods. What are the three voting methods which are recognized by this section? Single transferable vote, cumulative voting, or otherwise. So you have to remember these three names. The procedures are explained in the regular classes. Now, if your articles permit you, the company may resolve to appoint the directors by proportional representation, right? If you choose PR, then at least 2/3 of your directors are going to be appointed by PR, which cannot be removed by using section 169. Okay, this is an overriding section. So if you choose PR, all other things get stagnant. No rotation, nothing. Okay. The appointment is like the elections. It happens for 5 years, again election will happen. So likewise, here the appointment is happening for 3 years, again after 3 years, again PR. Again after 3 years, again PR. Right? The same people can be appointed, that's not a problem. Okay? Now, this section is again not applicable to 100% government company or wholly owned subsidiary of such government company. The directors who are appointed by using this particular section of proportional representation cannot be removed using section 169. They cannot be removed using section 169. Clear? Okay. Next we have section 168, the resignation of directors, a very simple section. Before we go on to resignation, let me discuss with you, what do the directors do? What are their duties? The directors have to act in accordance with the Companies Act. They have to act in accordance with the articles of the company. They must act in good faith. They should not be negligent towards the company. They should have due diligence. Their interest and the company's interest should be common. They should not ever have a conflict of interest. They should never attempt to have any undue advantage of any situation or gain anything which make secret profit or anything like that, right? And more importantly, prohibited to assign office. This is the most important duty which is covered under section 166 of the Act. Prohibited to assign office. You cannot transfer your office of directorship to anyone else. If you do, or if you do not follow or diligently perform any of the duties of the director, then you can be attracted to a fine starting from 1 lakh to 5 lakh. right? So all the duties of the directors must be efficiently discharged by the directors who are appointed to the board of the company. Okay, fine. Now, resignation by director. Director may resign. Director cannot be stopped by anyone else. If it wants to leave the company, he or she may leave the company. What they have to do is they just have to give a notice in writing to the company, right? The company, it is company's duty to further inform ROC that their director has resigned. So there is a form DIR 12. Within 30 days of receiving that resignation, you have to inform ROC. Whenever a director is giving resignation to the company, the resignation is going to be effective from the date when the company receives the resignation or the date you have specified in the notice, whichever is later. So from that date, your resignation will be treated to be effective. Okay, fine. And when the board comes to know about the resignation, they have two duties. They have to intimate ROC, plus they have to also include it in their board's report. Board's report, as and when it will be made. Now, there is an optional requirement given in section 168 which tells that a director who is resigning may also inform ROC. Although it is not this duty of the director who is resigning to inform ROC, it is the duty of the company to inform ROC. But you may also voluntarily inform ROC within 30 days of giving resignation in DIR 11. In DIR 11. Okay, fine, ma'am. Now here also there may be a possible situation that all the directors have resigned. So again we will go to the promoters. The promoters will fill the position of directors, and if it cannot be filled, then the central government is going to take charge, right? Central government will appoint the directors. Next is section 169, which talks about the removal of directors. What happens? Supposedly the board wants to remove any of the director. It cannot. The power to remove director is with the members. How can they do it? By just passing ordinary resolution. Now, removal before expiry of their term, because when their term has expired, they automatically leave and vacate the company. Before the expiry of their term, the members have the power that they can remove the directors, right? But for removing the directors, you must send special notice to the company. And to send special notice, you must be eligible. How do we come to know whether we are eligible to send special notice or not? Section 115, right? So it tells us that the members who are holding at least 1% of voting power or 5 lakh paid up capital in value is eligible member. So if you have the eligibility to send a special notice, send a special notice. This is just a name, nothing very special about it. It's just that this notice has to be sent 14 days before general meeting to the company. General meeting, any meeting, AGM or EGM. This special notice can contain two things. One, remove, we propose, or the intention, we intend to propose for the removal of Mr. X as a director. Point number one. Or it may say, we intend to propose to remove Mr. X as a director and appoint Mr. Y in his place. So there are two situations. One is you just want removal, and the second is you want replacement. So when you want replacement, you suggest a name also. And when you want removal, it's just removal, right? So there can be two probable situations. So you give this special notice to the company. Now what does the company do? The company sends a copy of this notice to the concerned director. for whose removal the notice has been received. This concerned director gives a written representation to the company, what he has to say to its members. Right? This written representation is being requested by the company to be forwarded to the members. But what happens sometimes? The directors, the concerned director tries to misuse this power. He has been given an opportunity that he can convey his message to the members. But instead of using this opportunity, he is misusing the power and writing all the bad things that he can about the company, about its directors, about its management, etc., etc. Now, when the written representation reaches to the company reads it, they get disturbed and they feel that how can we let this be circulated to our members? So to seek a solution, they may move to tribunal. So they make an application and they say that we understand that the director has a right to make a representation, but such type of representations that he is making cannot be circulated. So the tribunal might order that there is no need for circulation of this written representation or reading it out at the meeting, right? So in such case, this written representation may not be circulated. Otherwise, it will be circulated. Fine. So eligible member sends special notice to the company forwards the copy to director gives written representation to the company sends written representation plus notice 7 days before general meeting to the members. Quite possible there is time constraint or any other thing and the meeting and the notice as well as the representation could not be sent, so it will be read out at the meeting. That's not a problem. And quite possible it is sent. Whatever the case be, general meeting is held. By passing OR, the director can be removed. Now, when he is removed before the expiry of his terms, it again leads to vacancy which has been created. Right? Ideally, this is a case of casual vacancy, but supposedly we got the special notice of replacement and Mr. Y's name was also proposed. So, by passing OR, Mr. Y can be appointed. Supposedly, he was not appointed or no name was proposed. Then it will amount to casual vacancy which can be filled by the board by using section 161(4). Okay. So, we are removing directors just by passing OR. There are certain type of directors which cannot be removed by OR. What type of directors? Director who has been appointed by the tribunal, the director who has been appointed by proportional representation, the nominee director, and. See, independent director, he is appointed for 5 years by passing OR. He can be removed by OR. He is appointed again for 5 years, that means for his second term by passing SR. He can be removed also only by passing SR. He can be removed also only by passing SR. So, independent director in second term removal requires SR. Clear? Okay. Now, broadly we have completed the chapter and we are left with two important topics, independent director and SSD. Before that, section 170. What is 170? It tells about the maintenance of register. So, every company has to maintain a register of directors as well as KMP. This is going to be maintained at the registered office, which shall also be open for inspection by the members according to section 171. They can inspect this. It will also be available in every annual general meeting where members can come and see it. They can take extracts. It is company's duty to provide extracts, within 30 days. If you fail to do so, an application can be made to ROC, and ROC will order you immediate provision of the same, right? So that is something. Section 171 talks about inspection. Section 170 talks about maintenance of register. Apart from maintenance of register, Section 170 also talks about DIR 12. That whenever you appoint a director or whenever there is a change in director or KMP, file DIR 12 within 30 days. Within 30 days. Section 170 as well as 171, they both are not applicable to government companies. They both are not applicable to government companies. Section 172, this talks about punishment. So if the punishment, if you contravene section 149 to 171 and there is no specific punishment provided in that particular section, example, non-maintenance of register, non-appointment of a woman director, all this is, no specific punishment is given in that respective section. So you follow the punishment of leftover section, that is section 172, which states that minimum penalty 50,000, 500 per day continuing default, and maximum penalty 3 lakh and 1 lakh. 3 lakh for company, 1 lakh for officer in default. Okay, 3 lakh for company and 1 lakh for officer in default. Clear? Now we move to independent directors. Independent directors. Who are independent directors? Someone who is a highly experienced, highly knowledgeable person and who is not connected with the company. So when he comes to the company, he brings high level of expertise, and since he is not connected with the company, he will bring an unbiased opinion. We don't need independent directors in all types of companies. They are needed in certain limited companies. Listed company, if it's listed, we don't need to check any threshold. Listed companies straight away have to have 1/3 of their directors to be independent. If it's not listed, we have to check 3 criteria. 10, 100 and 50. Paid up capital more than equal to 10 crores, turnover more than equal to 100 crores, or loans, debentures, deposits more than not more than equal to more than 50 crores. If either of these 3 criteria is satisfied, then you have to appoint 2 independent directors, at least 2 independent directors. Okay. So every listed company, at least 1/3 independent directors, and unlisted public company, if you meet the threshold, at least 2 independent directors. Whatever independent directors you are appointing have to be subject to the requirement of audit committee, NRC, any other law. That means if audit committee says you need 4 directors, independent directors, and this section says 2, appoint 4. Okay. Supposedly, the company is an unlisted public company and has crossed the turnover of 100 crores. So 150 crores is the turnover, you appoint independent director. Next year, the turnover comes down below 100 crore. Again below 100 crore, again below 100 crore. So if for constant 3 years you fail to meet that threshold, then there is no requirement for appointment of independent director. There is no requirement for appointment of independent director. Just like the vacancy in the office of woman director is filled immediate next board meeting or 3 months, whichever is later, like that here also the intermittent vacancy which is created in the office of independent director has to be filled up immediate next board meeting or 3 months, whichever is later. To appoint anyone as independent director, what is needed is the person should be an individual. He should not be disqualified. He should have given in. He should have given consent. He should meet the criteria of independence given under section 149(6). Apart from all that, and his name should be included in the data bank. What is this? What is this? We will read it a little later. Okay, so all these requirements, if they are fulfilled, then his name can be proposed, and when his name is proposed, he is appointed in the general meeting by passing ordinary resolution. Okay, ma'am. To be an independent director, independent director comes under the category of non-executive director. So you cannot be MD or whole-time director or nominee director. You cannot be these three. And if you are not these three, then if you meet the criteria of independence, you can be appointed as independent director. So not MD, not WTD, not nominee director, and satisfying all conditions below can be appointed as independent director. Point number 1. He should be the person of integrity, experience and expertise. Not in our opinion, but in the opinion of board. If it is a government company, in the opinion of respective ministry. He should not be the promoter of company holding subsidiary associate. This you can call as CHSA, this you can call as cash, this you can call as group, however you may learn it. Not related to PD, that is promoter director of cash, PD of cash. Someone should not have a pecuniary relationship, that is a monetary relationship with cash or with PD of cash during preceding year or 2 preceding years, during financial year or preceding 2 years. Now this has an exception. It is quite relaxed that if your pecuniary relationship does not exceed 10% of total income, it's okay, you may have it. Still you will satisfy the criteria of independence. Right, still you will satisfy the criteria of independence, integrity, experience and expertise, not related to PD of cash and not a promoter, not having a pecuniary relationship. So these are the first 3 clauses, easy ones. Then comes D, which is for the relatives. So your relative should not be holding security in cash, that is CHSA. Your relative should not be holding security in CHSA. There is a limit that if it holds security up to 50 lakh or 2% of paid up capital, it is allowed. Your relative should not be indebted to CHSA or PD of CHSA. If it is indebted in amount of less than equal to 50 lakhs, it is allowed. Your relative should not give guarantee to CHSA or promoter of CHSA or director of H. If it gives a guarantee for an amount less than 50 lakhs, it's okay. It's okay. You can write for an amount of 50 lakhs or more. Right? It's okay. Your relative should not have a pecuniary relationship with CHSA. For an amount 2% or more of turnover or total income. Pecuniary relationship, again monetary relationship. We have done a detailed discussion on all these points, right? So now I think you are well in a situation that you can quickly recall this, and this is learnt by you, right? Okay, so clause D was for relatives, 4 points. Not holding security, 50 lakh, 2% paid up capital, not indebted in excess of 50 lakhs, not guarantee for 50 lakhs or more, no pecuniary relationship, 2% or more of turnover or total income, right? So these are the 4 points for relative. Now, you or your relative should not have been a KMP or employee in CHSA preceding 3 financial years. However, relative may have been an employee. You or your relative should not have been employee, proprietor or partner in audit firm of CHSA, CS firm of CHSA, cost auditor firm of CHSA, or such a legal firm which is getting 10 or more% of its total income from CHSA, right, in preceding 3 financial years. You with your relative should not hold more than 2% of the voting power of company. You with your relative, you or your relative should not be a director or executive of such NPO which is getting 25% or more of its receipts from CHSA, or the director or promoter of the company, or holds 2% or more voting power. Who possesses other qualification as prescribed? What are the other qualification prescribed? You can be an expert in finance, you can be an expert in law, management, sales, marketing, administration, research, any other discipline, etc., etc. Fine. Now, every person who is going to be appointed as an independent director must give a declaration that yes, he has fulfilled the criteria of independence. So whenever you are appointed as independent director, in the first board meeting that you participate, in the board meeting of every financial year, and wherever there is a change in circumstance, you have to give a declaration. It is your duty. We have a code, Schedule 4, code for independent directors, how independent directors must react to the situations, how they should behave. You must follow that. You must follow that. What will you get? Because you cannot get salary, you are not an employee. You would get profit related commission. Even if there is no profit in the company, then also you will get commission. Then also you will get some amount. You will get sitting fees. Right, you will get reimbursement of expenses. Okay, but you will not be entitled to stock option. That is one thing that you need to remember. You will be appointed for 5 years. For 5 years. You may be appointed for a shorter term also, but you cannot be appointed for more than 2 consecutive terms. And any term shorter than 5 years will also be treated as 1 term only. So here you can be appointed for 5 years by passing OR, again for 5 years by passing SR, and then you need to have a cooling period. Then you need to have a cooling period for 3 years. Cooling period for 3 years. Again you can be appointed for 5 years. Okay, during the second term, if the company's shareholder want the independent director to be removed, they have to pass SR for removal. OR will not suffice. OR will not suffice. Okay. Now, whoever is the independent director or any non-executive director, he cannot be held liable for everything that's happening in the company. He will be liable only for those acts where he has given his consent, he had knowledge, or he had not acted diligently. Only for those cases he will be responsible. Only for those cases he will be responsible. Independent directors don't retire by rotation. Don't retire by rotation. Now, as I told you about data bank, right? What is data bank? Section 150. Section 150 basically tells us about data bank, that central government, see, every company, it is mandatory for listed companies and the companies which are meeting this criteria, it is mandatory for them to appoint independent directors. From where will they get these independent directors? For which central government has maintained a data bank. Now this data bank has been maintained by the notified institute of government. What is the notified institute of government? Indian Institute of Corporate Affairs has been notified by central government. So any company who wants independent director, they can go to that data bank, they can select a person, they have to perform their own due diligence, and if he meets all the criteria of independence of your company, etc., etc., you may appoint such a person as independent director. Fine. Okay, ma'am. Now we have a rule 6. If I want to be the independent director, or I have been the independent director, I have to comply with this rule 6. What does it tell us? What does it tell me? that I cannot be an independent director unless my name is included in the data bank which is maintained by this institute. How do I include my name, ma'am? I have to make an application to the institute along with the relevant fees, and my name will be included. Okay. That means before this rule came into picture, there were many independent directors. They also have to include their name. Yes. They have been given a time period of 13 months within which they can apply to the institute for inclusion of their name along with the fees. The name can be included for 1 year, 5 year, or for lifetime. And after this rule, anyone who wants to be appointed as an independent director, that means some companies proposing you to be appointed as independent director, you must before your appointment include your name in the data bank. And supposedly I'm not being appointed by anyone as independent director yet. I find this as a career opportunity and I want to include my name voluntarily. I don't even have DIN. I'm not a director of anyone. Can I? Yes, you can. So voluntarily also you can apply for your name as an inclusion in the data bank. Now, when you apply for your name as an inclusion in data bank, within 2 years you have to pass a test, online proficiency self-assessment test, OPSAT. With 50% passing criteria, there is no limit on the number of attempts. So within 2 years you have to pass it. You have n number of times. So within 2 years you can appear for the test n number of times and you can pass this test. You have to. If you don't pass it, your name will be removed from this particular data bank. If you pass it, great. Supposedly you enrolled your name for 5 years only. The tenure expires. Within 30 days, you can renew it. If you don't renew it, your name will be removed. Fine. Now, what has to be, what else is there in this rule which needs to be remembered is the exemption. What exemption, ma'am? Now, some very proficient people are not required to appear for their test. They will apply to the institute for inclusion of their name and this step is excluded. They don't have to appear for their test. Who, ma'am? Someone who has 3 years of experience as a director or KMP in listed public company, unlisted public company with paid up capital to 10 crores or more, in any body corporate which is listed either in India or in such a country which is a member of FATF or IOSCO. Any body corporate which is incorporated outside India but having paid up capital more than equal to $2 million US. Any other statutory corporation. Or if you have 3 years experience in the pay scale of director or above in the Ministry of Corporate Affairs, Ministry of Heavy Industries, Ministry of Public Enterprises, Ministry of Commerce, etc. Right? Or if you have been in the pay scale of Chief Manager or above in SEBI, IRDA, RBI, PFRDA. So all these are excluded from appearing for test. Moreover, if you are an advocate in practice, if you are a CA in practice, if you are a CS in practice, if you are a CMA in practice and you've been practice for 10 years, at least 10 years, then also you are exempted from the test. Okay. Fine. And this is probably the last section that we have to discuss, that we have to revise. We've covered all the sections. SSD, Small Shareholders Director. Who are SSD? SSD. The directors who are elected by the small shareholders. Who are small shareholders? Small shareholders are the shareholders who have less than or equal to 20,000 face value of shares of the company. So they are considered as small shareholders. Now this section applies to listed company and it is discretionary. It's not mandatory. So if a listed company wants, it may suo motu, that means on its own or on receipt of a notice by the eligible small shareholders, it can have one SSD who is elected as who is elected by small shareholders. Who is eligible to send notice? 1000 small shareholders or 1/10 of small shareholders, whichever is lower. Right. So they will send a notice to the company that we are proposing the appointment of this person as SSD, and this is his DIN, this is his consent, and he has given a declaration that he is not disqualified. Right. So along with these details, they send a notice to listed company, and listed company may have one director elected by SSH. Now this is not a normal election which is happening by all the shareholders. So it's not an ordinary resolution in general meeting. It is the election by small shareholders only. So they meet. Only their meeting happens, and in their meeting, by majority votes, such a person is elected who is going to be non-rotational, who is going to be independent. So he also has to meet the criteria of independence, section 149(6), and he also has to give a declaration in that regard. Okay, and he is going to be non-rotational. He has a fixed term for 3 years. Can he be reappointed after 3 years? No. Then 3 years will be cooling. Again, then he can be appointed after 3 years. During this cooling period, he cannot be appointed or be associated in the company in any manner. In any manner. Okay. Fine. If small shareholders director, someone who is appointed as SSD, is disqualified under section 164 or grounds of vacation are attracted to him, or he fails to meet the criteria of independence, he has to vacate. He has to vacate the office. One person can be SSD in maximum 2 companies, but the 2 companies should not be competing business, should not be in the competing business, okay, or their business should not be in conflict with each other, okay, and no reappointment allowed. That is something that I've already told you. SSD can be removed under section 169. This is something which is allowed. SSD can be removed under section 169, right? So I think we have revised everything. Okay. Okay, now we are going to revise appointment and remuneration of managerial personnel. If we look at our syllabus, we have a chapter of board of directors and KMP, in which this chapter is also incorporated, right? But all these chapters of company law, we are actually reading according to Companies Act classification to have a quick and to have a better understanding of all the sections. So this particular chapter, appointment and remuneration of managerial personnel, is chapter number 13 of Companies Act and contains prima facie section number 196 to 205. Right, so this is what we have to read. It is also important that we read certain part of Schedule 5 of Companies Act. Schedule 5 is basically divided into 2 parts, Part 1 and Part 2. Part 1 deals with appointment and Part 2 deals with remuneration. So Part 1 has certain conditions which are important and relevant for you to learn in examination. However, Part 2, the remuneration part, you don't have to read from examination perspective. No need to learn that, right? Okay, so here we begin. First of all, when we talk about this particular chapter, appointment and remuneration of managerial personnel. So first we need to understand that what is managerial personnel, or who are managerial personnel. There is a difference between key managerial personnel and managerial personnel. When we are talking about managerial personnel, basically we are talking about 3 people. What are the 3 people? Managing director, WTD, that is whole-time director, and manager. Who are these people? First of all, when we talk about managing director, it is given in or defined in section 2 clause 54, which states that first of all, if you're a director, Secondly, you are entrusted with substantial powers of management. Now, what are substantial powers? Supposedly, there is a resolution which has been passed and it's written, okay, all the necessary acts in this regard is to be done by Mr. X, a director, and he's also, he will be responsible and he will be entitled to draw a negotiable instrument or endorse a check in this regard, whatever, right? Or he is going to sign all the share certificates. Such type of things are being written. Does it mean that Mr. X has been given substantial powers of management by passing a resolution? No, because these are administrative routine matters. You're fixing common seal. Well, any director can be delegated this particular thing, right? It is the work of board of directors. It can be delegated to anyone just by passing a board resolution. Anyone can sign a check if it has been authorized to do that, right? Anyone can draw a negotiable instrument or sign a share certificate or register the transfer of shares. So these are routine administrative matters, and if somebody has a power to do these administrative routine matters, he is not having substantial powers, right? So if a director is entrusted with substantial powers, how does he get the substantial powers? By a resolution board, resolution by members, or an agreement, or through articles, right? So he can get those substantial powers by any of these, through any of these medium, and thereafter he's going to be called as a managing director. He may not be specifically appointed as such, but he's going to be called as, right? Then comes whole-time director. Now, whole-time director, again, the first requirement is you have to be a director, and secondly, you have to be in whole-time employment of the director. They're also called as executive directors. And a lot of companies, we have seen that these whole-time directors or these executive directors have been further they're classified into their field of area, like director finance. So they are nothing but executive directors who are handling the field of finance, right? So such type names are also being given. The third one is manager. Manager defined in section 2, clause 53. Now, what is manager? Now, manager is not a director. He may be a director also, but he is simply an individual. Now, what is he doing? He has whole or substantially whole power of affairs of the company. Okay. So, ma'am, what is the difference between manager and MD? See, technically or legally, they are the same. That is why there is a provision that you cannot have MD and manager at the same time, because managing director, he's being called as managing director. So prima facie requirement is that he has to be a director. Here, if you're a manager, then you need not be a director. So if you don't want to become a director, yet want to have a substantial, or you want to have you want to manage whole of the affairs of the company, then you can work under board of directors and be appointed as manager. Okay, and you're doing the same thing just as managing director. What he does, you are also going to do the same thing, right? If we talk further, manager need not be a director. So when we are talking about appointment of manager, all those things which are required to be followed by a director need not be followed over here, right? Ma'am, if managing director and manager are the same, we have hardly heard any company have a manager. We have heard a lot of companies having MD. So basically, I have told this before also in the class, that manager is a very underrated and a very common term which is used in every organization at every level or hierarchy, I would say. So I have this manager, this manager, this manager, product manager, sales manager, such manager, right? So the concept which is given in Companies Act, and if you say that, okay, this particular person is a manager in the company, they'll not take you seriously, because they'll not understand what a manager can be, how much power a manager can hold, right? If we are talking about the manager which is defined over here, right? So that's why most of the companies appoint managing director and not manager. Okay. Now, If we combine all these three people, they're known as managerial personnel. However, you have to ensure that either there will be MD plus WTD or there will be manager plus WTD, right? We cannot have manager plus MD. This is not allowed under section 196, right? So we will have this combination or we might have this combination. In most of the cases, we have this combination, right? Okay. Now, if you want to appoint these people, we have to understand that since these are prima facie directors, all the provisions relevant to directors will be applicable on these. Plus, there are additional conditions which are given in section 196, read with schedule 5 for their appointment. Okay. If you're talking about manager, then you just have to follow these and not follow the directors if manager is not the director. Okay, ma'am. So we start with section number 196. Now, section 196 states that you can appoint MD, WTD or manager for a term of 5 years only, for a term of maximum 5 years. Thereafter, you may reappoint him, but you cannot at once appoint that particular person for a tenure of 10 years. Now, ma'am, it is better to appoint any person for a longer tenure so that the flow of operations or flow of actions is not hindered, right? So that is why there is a provision for reappointment. That means supposedly he has been appointed for a tenure of 5 years and his appointment ends at end of 2025. So when 2024 ends, that is earlier than 1 year or within 1 year before expiry of his term, he can be reappointed. So somewhere maybe in mid 2025, you can reappoint that particular person for another term of 5 years so that the flow is not hindered. Right? But you cannot reappoint him. Like today, I have made an appointment of Mr. X as MD for 5 years, and tomorrow I have reappointed him for another 5 years. No. When only 1 year is remaining, then you can reappoint him because most of the scenario is clear. Okay. Secondly, any person who has attained the age of 21 can be appointed. If there is anyone who is below the age of 21, he cannot be appointed as MD, WTD or manager. Moreover, anyone who has attained the age of 70 years, that means he has become of 70 years, he cannot be appointed as these person. But there is an exception. If you attain the age of 70 years, you may be a person who has immense knowledge and experience and you can bring a lot to the table. So we want to appoint you. So you can seek the permission of your members by passing special resolution and you can appoint that person. Now, ma'am, here you have written and CG approved. That means somehow we need the approval of CG also if we are appointing somebody who is more than 70 years of age. Yes, but this we will get once we reach schedule 5 conditions. Then you will understand this better. Okay, fine. Now, there is something more. Okay, what is that? You cannot be appointed if you're an undischarged insolvent. So you have been declared as insolvent, you cannot be appointed. If you have been declared as insolvent, but till now you have not been discharged, you cannot be appointed as MD, WTD or manager. Right? If at any time in the past you have made a composition with with your creditors, making composition or suspending payment means what? Like supposedly you had to make a payment of 10 rupees to your creditors, but you have asked them that okay, I'll pay 50 paise in a rupee. That means you are ready to pay only 5 rupees, right? So if you're such a person who's making composition with your creditors, then my dear, you are not permitted to do this, right? To be appointed as such. Next, if you have been convicted means found guilty. So if at any time you have done an offense for which you have got a punishment as imprisonment for more than 6 months, up to 6 months, it's completely fine. More than 6 months, you're not allowed. Okay. So all these conditions are given in section 196. If you follow all these conditions, then you can be appointed. Otherwise, you cannot be appointed. Well, there are more conditions. But first have a proper idea and then we'll move to the more conditions which are written. Okay. Now, this is the condition which has to be followed. How do you appoint? That is the process of appointment. You call a board meeting, pass board resolution, and thereafter this has to be approved by members in general meeting. Right? Simple, normal, ordinary resolution is required. However, if you're appointing somebody who is more than 70, who has attained the age of 70, then you will be needing SR over here. Otherwise, you need simple OR. Now, if you get the approval, great. You will check whether the person is complying with the conditions stated in part 1 of schedule 5 or not. What are the conditions? The conditions we'll be reading now, right? If the conditions are met, then you don't need any further approval. What happens? Board resolution, then members approval, and that's it. If you comply with all the conditions stated in section 196 and stated in schedule 5 part 1. Right? So no need of further CG's approval. However, if the conditions are not met, then you will be needing CG's approval. Okay. If you don't get members' approval, then you cannot even proceed further. You cannot make this appointment any more. Right? But the prior acts done by the director, managing director, whole-time director, is going to be valid. Once you make the appointment, within 60 days of appointment, you have to file MR1 and file it with ROC. Okay, fine. Now, these are the conditions of appointment in part 1 of schedule 5. What are the conditions, ma'am? What are the conditions? First, if the person has been imprisoned for 1 day, 2 day, 5 day, 10 days, 6 months, 1 year, whatever tenure, or you have been fined for more than 1000, up to 1000 is fine, more than 1000, under any of these 16 stated acts, you don't have to learn the name of all the acts. Okay, so if you have been imprisoned or fined exceeding 1000 for an offense under these acts, then you cannot be appointed unless you obtain CG's approval. Next, if you have ever been detained means what? Detained means taking somebody into custody for some inquiry, right? So if you have been detained under Conservation of Foreign Exchange and Prevention of Smuggling Activities Act for any period, then you cannot be appointed unless you take CG's approval. Third, if you have not attained the age of 70 years, if you have attained the age of 70 years or not completed the age of 21 years, if any such person has to be appointed, you need CG's approval. Okay, you need CG's approval. So this brings me back over here. This is not allowed under section 196. So there is no chance that you can appoint somebody who is lesser than 21 years as MD, WTD. No. But if somebody has attained the age of 70 years, he can be appointed provided you pass SR and you seek CG's approval. Okay. And lastly, he must be the resident of India. Fine. If he is not a resident of India, then you need CG's approval. Okay, fine. So I hope this is clear, and the procedure of appointment is also clear. You have to remember form MR1, right? Okay. There are certain subsections which are not applicable to government, company and all that. I'm not discussing that right now. Now we move to the next part, which is managerial remuneration. Okay. Now we are talking about managerial remuneration of a public company, of course. So we have section 197. Section 197, what does it state? It states the overall managerial remuneration and thereafter its subparts also. First of all, we take the case that the company has adequate profits, or let me tell you practically what happens whenever we are appointing a managing director. We enter into a contract of service or contract of employment with them, and that clearly says that, okay, monthly you'll be given this much amount. But when we go to Companies Act, we have a criteria, we have certain limits to be checked. Would the limits state that 11% of net profits is what maximum remuneration you can give. Supposedly the company earned a profit of certain amount, and when we checked that what is the 11%, we have paid extra. It may so happen that we have paid extra to our managing director or manager, right? What do we do now? Because we just entered into a contract of service and decided a number, and that particular person agreed to that number, but now the company could not do that much profits, right? So what happens practically is, we have fixed a number, great, we usually know that what profits the companies are earning, and what is, and based on that only it is very low, right? But if in a rare case it exceeds, then there is also the provision for recovery of such excess remuneration which has been paid. Okay. Now, if the company has adequate profits, that means company wants to pay a remuneration of 20 lakhs and it has that much, no problem at all, right? So the maximum remuneration that it can pay is 11% of net profits. How are net profits going to be calculated? That we will see in section 198 after we read this particular section. Okay. If we want to pay more than this, then we need authorization in general meeting by the members. There is further classification to this. There can be two situations. The company has some MD, WTD or manager. The company does not have any MD, WTD or manager, and there are all part-time or non-executive directors that we have, right? So if the company has managing director, WTD or manager, it may have 0 MD, WTD or manager, it may have 1, or it may have more than 1. So if it has 0, there will be no remuneration paid to them. If there is just 1 MD or WTD or manager, 5%. If there are more than 1, then it's going to be 10%. 10% to all of them. Now to other directors, if there is no MD or manager, that means they have to do more work, so they will be paid 3%. But if there exists MD, WTD or manager, then maximum they'll be paid as 1%. So these are the limits, that these are the percentage that you must remember. If you want to pay more than 5% to your solo MD that you have, then you need to seek approval from two people. One, your members by passing SR. And secondly, if you have taken loan from bank, or if you have debentures and you're not paying money to them, then you need to seek their approval also, because you're not paying money to them, but you're paying so much extra to your directors. They may be very well deserving, they may be doing a lot of work, you may be soon going to be out in losses or whatever it is, right? You may justify the situation, but then you need to seek approval. Clear? Okay. If the company does not have adequate profits, then we have Schedule 5, Part 2, which is divided into two sections, and thereafter we have certain items, we have to comply certain conditions. But basically what is there is, we have to calculate the company's effective capital, and based on that capital we have to check what is the maximum remuneration which may be paid in case the company has inadequate profits. Again, SR has to be passed if that limit exceeds, but all these things you don't have to learn, and more details you don't have to learn from your examination perspective, right? This is something that you must learn and remember. Okay, then there is something more to section number 197. First of all, remuneration. See, what is going to be the mode of remuneration? I already told you, you may pay remuneration as monthly or as percentage of profits, or partly by both, a combination of both, right? Apart from that, a director may also be paid sitting fee. Section 197(5). What is sitting fees? Sitting fees is the amount that you pay to the directors for attending meetings. What meetings? Board meetings or committee meetings. The sitting fee cannot exceed 1 lakh per meeting. Okay. Moreover, if you are paying sitting fees of 50,000 to one male director, you cannot pay less than 50,000 to the female director. So you cannot pay lesser sitting fee to independent and women directors. Okay, there has to be pay parity, right? Okay, ma'am. Now, remuneration for other services. See, there are a lot of cases. Supposedly, there is a director who is also who also has expert legal knowledge, and he is giving some legal consultancy services. So he is rendering those services in professional nature. So can he charge for that services? Of course he can, over and above the remuneration which he's getting in the capacity as a director. Okay, fine. Then we have a provision called as excess of remuneration. So if excess remuneration has been paid, then it is going to be refunded to the company within two or lesser period, whatever is allowed. And recovery can be waived if approval of bank or PFI and SR is passed. Now. This is something that I've already told you, right? Okay. So I hope this is clear, right? Okay, refund of excess. Let me explain this once again. See, if there is a director who has received excess remuneration, because later on when we calculated the remuneration, we got to know that okay, this is the maximum limit. 11% of net profit comes out to be 10 lakh. However, we have paid 12 lakh to our directors. So 2 lakh is the excess remuneration which has been paid to them, right? So in such a cases, it has to be refunded to the company, and till the time it's not refunded, the director is going to hold it in trust of the company, right? That means on behalf of the company. We have something called as remuneration of independent director also. Independent director is not entitled, or you can say is eligible for sitting fees, for profit related commission, for reimbursement of expenses, but is not entitled to stock option. Okay. Now we have some disclosures by the listed company. We have some part relating to contravention and all that, right, which I'm not discussing. Then we move to section number 198, which talks about calculation of profits. So we have to basically understand four things. There is a profit which has been calculated, but it has to be according to section 198. So section 198 says that if in your profit the bounties or subsidies which have been received by the government have not been added, then add that. If in your profit you have added the profit that you have earned by selling your immovable property, deduct that, right? So profit that you have got on sale of forfeited shares, profit that you have got on sale of your shares, right, or immovable property, right, or you have simply got some revaluation profit, deduct all that. Fine. Then if there are certain expenses which are allowed, and then there are certain expenses which are not allowed, so they have to be added back. So what are the allowed expenses? Director's remuneration, the usual working charges, right? Bonus that has to be payable, right? Some portion of tax, right? Interest on debentures, interest on unsecured loans, repair expenses, depreciation, right? Bad debts, all of that are allowed expenses. What are not allowed is income tax, some portion, right? I have explained you that in detail, right? The compensation, right, compensation which you have paid voluntarily, then revaluation loss, right, or any loss of capital nature, that is not going to be included, right? Then we have section 199. See, supposedly there were financial statements which were fraudulent, or there was fraud in the company, non-compliance, and the financial statements have been restated, and after they have been restated, we got to know that okay, the profits were overstated and we have only this much profit. That means the payment or the remuneration has been paid in excess. Now what do? We have to recover that remuneration, so that remuneration can be recovered. Then we have section number 200, which talks that government, central government, has the power to fix limit with regard to remuneration. Okay, now central government or company. We have Companies Act which says certain limits, but now we're talking about an internal limit which is being set by the company, right? So central government can also fix in certain cases, and central government looks that okay, fine, what is the financial performance in the last 3 years of this particular company, right? And what is their remuneration policy, how many securities the directors hold. They look at a lot of things, right? Likewise, the company also looks at the financial position. They look at the professional qualification of the particular person. They look at the remuneration which they are drawing, right? All of the matters, etc., etc. So based on all the factors which they consider, they have the power that they can fix a certain remuneration within the limits which are given in the act. So if act says you can pay up to 11%, they may say that okay, we are going to pay up to 5% only, so they can fix this particular percentage. That is not a problem, right? Okay. Then we have section 202, which talks about compensation for loss of office. Now we are talking about loss of office of MD, WTD or manager only, and no other independent, non-executive directors or anyone else. You appoint these people for a tenure of 5 years, but supposedly they have served only 2 years, and thereafter you find some more better deserving candidate and you ask them or you remove them, right? And then you appoint somebody else. So there is a loss of office for them for a tenure of 3 years. For that, they will be given compensation. Compensation, maximum compensation that can be given to them is lower of unexpired tenure or 3 years. That means if they have served a period of 4 years, their unexpired tenure is only 1 year, they will get this compensation for 1 year only. But supposedly they have served a term of only 1 year and 4 years are remaining, then in that case they will be getting a compensation for 3 years, because lower of unexpired tenure or 3 years. Ma'am, at what rate will they get the compensation? At the remuneration which they have actually earned, right, during the preceding 3 years or shorter period of office, right? So this is the maximum compensation that can be given to them. Now in certain cases they will not be given any compensation. What are the cases? First one, there is a case of merger. The director resigns from the old company and joins the new company. Where is loss of office? Director resigns voluntarily, company is not at fault or company is not responsible. There is some disqualification which is attracted to this particular director or managerial personnel. So how is the company responsible? Of course, he has to vacate according to section 167, right? So vacation of office, any ground gets attracted, right? Then company is being wound up according or by virtue of directors fraud or negligence. So if director is negligent and that's why the company is being wound up and now you need the compensation also, no, you'll not get that, right? Director guilty of fraud or breach, director will not be getting any compensation. And lastly, if director is responsible for his own termination in any case, okay. And then we have certain one more thing. What is that? If the director has disassociated or ceased to hold that particular office, and thereafter within 12 months the company goes into liquidation, the company goes into winding up, the company is unable to pay to its shareholders, that means the company is falling short of money, the assets are insufficient to pay all the capital, then in that case there will be no compensation. Okay, fine. Then we have a section called as section 203. What is section 203? Appointment of key managerial personnel. So here you have to understand what is key managerial personnel. MD, WTD, manager, CEO, CFO, CS, they're all key managerial personnel. Now, all the companies are not required to appoint KMP. All the listed companies plus public companies with paid up capital of 10 crores or more, they are required to appoint any one of these and CFO and CS. However, if you're a private company with paid up capital of 10 crores or more, you have to appoint a CS only. Okay, which is mandatory. Other than that, you can appoint anyone voluntarily. That's not a problem. How do you appoint it? By passing resolution at board meeting. The casual vacancy has to be filled within 6 months at board meeting only. Okay, fine. There are certain small points. Thereafter, we have secretarial audit. What is secretarial audit? Again, not mandatory for all types of companies. We have listed companies, public company with paid up capital 50 crores or more, public company with turnover 250 crores or more, or any company with loans 100 crore or more. They have to get their secretarial audit done. See, in company, Statutory audit is mandatory for all the companies. Then we have read something called as cost audit, which is again not mandatory for all companies, but of a certain category of companies. And then we are seeing over here secretarial audit. So statutory audit is done by a chartered accountant, cost audit is done by a cost accountant, and secretarial audit is done by a company secretary, because they have more knowledge about the compliances, right? That is what they do all the time, right? So compliances, checking the compliances, they do secretarial audit, prepare a report on MR3 and give it to the board, right? If they have qualified the report, or if they have added any such clause, then it is going to be the duty of board to also give explanation on the same. Okay, fine. Now, wait. We have section 205, which talks about functions of company secretary, which is not much relevant, but yes, company secretary is required to convene the meetings, is required to ensure all the compliances, ensure that all the standards are being followed, discharge all the duties which are entrusted by it to it by the board, right? So I hope this is all clear and good. Okay. Hi everyone. Let's now revise the chapter Meeting of Board and its powers. So this is a huge chapter containing a lot of sections and very important from your examination perspective. It commences with section number 173. But before we start section 173, let's have a basic understanding of how board takes its decisions. Now, why do board need to take any decisions? Because company is an artificial person and company cannot take decisions on its own. Hence, the decision making powers are being distributed over a board of directors as well as the shareholders, right? Whenever board has to take any decision, that means any issue comes up in front of all the directors, collectively known as board, they have to resolve the decision. They have to resolve the problem. So a resolution is passed. What is resolution? Majority or you can say voting happens, right? That is, all the directors have to give their assent or dissent, whether they agree that this should be done or they disagree. If majority of the directors who are present and voting agree, then we consider that board resolution is passed. However, if they don't agree, we consider that the board resolution was put forward but it is lost. So the decisions of board of directors are taken by a board resolution. Now sometimes section 186, section 203, you also have unanimous board resolution. There is a difference between board resolution and unanimous board resolution, that is UBR. This is that whoever is present at the board meeting, so all the directors present, they cannot refrain from voting, they cannot abstain from voting, they have to vote and they have to vote in favor. So even all the directors present vote in favor, then a UBR is passed. So UBR is not required at all times, it's required in 2 sections in Companies Act, and in fact it's required under a rule also, but that is not something that we are going to consider right now. Now, how this board resolution will be passed? Undoubtedly, ma'am, all the directors should come together, then the issue will be told to them and then they will resolve the issue. That's how things happen. There is another way of passing board resolution, which is by circulation. That means the decision of board can be taken either at the board meeting or by passing the resolution by circulation. Now this board meeting may be virtual, it may be physical. It may be virtual, it may be physical. Earlier we had this provision that some matters cannot be dealt in at a virtual board meeting, but now there is no such restriction and all the matters can even be dealt at virtual board meeting or the board meeting that's being conducted through video conferencing, right? So this is the general thing. Now, one thing which is imperative from this discussion, which we come to know,
is that we must meet, that the board of directors must meet in order to take decisions. And since their meeting is mandatory, they must meet. Companies Act has put in some mandatory requirements about board meeting. Starting from section 173(1), we come to know about the minimum number of board meetings which every company must conduct. See, board meeting is, the matters can take place, or directors can vote directly from their place also through circulation, resolution by circulation, but that is something which is not allowed for every matter. There are certain matters for which it is clearly specified that you must meet to take decisions. Okay, you have read section 161. In section 161, there are 4 parts. Section 161(1), additional director. Section 161(2), alternate director. Section 161(3), nominee director, and 161(4), casual vacancy. Now, out of these 4, only 161(4) says that resolution at board meeting. That means this is a section which clearly specifies that the resolution has to be passed at board meeting only, and the resolution cannot be passed through circulation. So a lot of times matters are being specifically reserved for board meeting. So for all the other 3 cases, you may have a resolution by circulation, but not for this one. Right? So there are restrictions which have been imposed. Moreover, we have a section 179. Which says that certain powers are exercisable by the board only at the board meeting. Okay, so although decisions can be taken through circulation also, but still it is imperative that the board meet, so that all the directors are aware about what is happening in the country, and moreover to take the decisions which are being specifically reserved for board meeting. Okay, now what is the requirement? First board meeting has to be held within 30 days of incorporation, and thereafter every company is going to have a minimum 4 board meetings in every calendar year. In every calendar year. The gap between 2 board meetings is not going to be more than 120 days. So maximum gap 120 days. This is the general rule that we have for all types of companies. However, there are certain exemptions. Now, before I go on to exemptions, you have to understand that even if the meeting is adjourned, that also has to happen within the time limit specified. That means if you call a board meeting, it is adjourned and held after 4 months, the gap between 2 board meetings should not exceed 120 days. So this applies to adjourned meeting also. Now, for section 8 company, we have the requirement minimum 1 meeting in every 6 months. I hope you understand and remember the difference that I have told you in classes. 6 months and half year. So that's a difference, and you must understand and remember that. So section 8 company, 1 board meeting in 6 months. OPC, small or dormant company, 1 meeting in half year. Minimum gap should be 90 days. Minimum gap. Here maximum gap was specified, here minimum gap. Now, private company which is startup, again the same thing as of OPC, small company, and dormant company. OPC with 1 director only, the section does not apply. See, meeting, introspecting, all this does not happen when you're talking about company. When you have to take the decisions of company and you are the only one to take decisions, why you will call a board meeting and meet with your own self? Obviously no, right? So you will not meet. Then comes your section 173(2), which talks about video conferencing. That means a board meeting may also happen through video conferencing. I'm not telling you over a telephonic call or a teleconversation. No, it has to be AV, audio, visual, both. So it may so happen. That means a director, if he is unable to attend the board meeting physically, he can also attend the board meeting virtually. So we have a whole procedure which is being listed when the meeting is happening virtually, or when the directors are participating virtually. So what is the procedure that's going to be followed? What are the requirements that are going to be followed? What is needed? So section 173(2) read with rule 3 and 4. So that's how we are going to read it. I mentioned this before that earlier there was rule 4 which prescribed certain matters which could be dealt only at a physical board meeting, but now those matters have been removed. That has been omitted. So now we don't have any matter which is specifically reserved for a physical board meeting. Okay, fine ma'am. So a director can attend in person or can attend through video conferencing only. The only requirement is that whenever a company is going for a virtual meet, it has to ensure that whatever setup it is establishing, it is capable of recognizing the people and recording the director's presence and storing everything along with date and time. Moreover, the chairperson and this company secretary who are responsible for convening a board meeting, they have to make necessary arrangements to avoid any type of failure and should take reasonable care for these. See, whenever a board meeting is happening virtually, it's a welcome move. Undoubtedly, it's a welcome move by the government. But there are issues with respect to confidentiality, security, and other like matters, right? If we are in a closed, compact conference room and a board meeting is taking place, we are sure that no one else who is not entitled or authorized is listening to us. But if we are sitting here out in open and everyone is participating through different places, there might be some insecure surroundings. There might be, right? So this raises a doubt on the confidential matters of any company. However, duty has been imposed on the director as well as the company. That director also has to ensure that you are not around anyone, and the company also has to ensure that the director is sitting alone and only authorized access is being given to the in the board meeting. Right? Fine. So what has to be taken care of? Security and integrity, availability of equipment. All the proceedings will be recorded and thereafter minutes will be prepared. You have to safely keep the records for future. You have to ensure authorized attendance only, as I just mentioned. However, if a person is disabled and request for an attendant, then that person will be allowed one, and ensure proper audio visual. Okay, so these are the requirements which must be fulfilled, and then only you can go for VC. What is the procedure? And one more thing, is AV mandatory? If a director is unable to attend a board meeting, he requests the company to provide for audio visual facility and the company ignores and rejects the plea. Is it valid? I would say no. It is mandatory that you provide audio visual or video conferencing facility to the directors if they want that. Okay, for this we also have a case law, Achintya Kumar. Now, what is the procedure? Because normal board meetings, people come, we count, we see things, right? We see things, we hear things, we are in a closed compact room. How the things are going to happen over video conferencing, that is also the procedure which has been laid down. What is the procedure? The first requirement. Well, if you want to call someone for your birthday, for your anniversary, for anything, you must give an invitation, right? Or even if it's not a very formal invitation, you must at least notify. If I want to call you for a class, I will at least have to notify when that's going to happen, where it's going to happen, at what time, place, all these details, right? Likewise, when company wants to call its directors, either physically or virtually, it's their choice. They have to at least inform the directors. How do they inform the directors? By sending notice. What is to be included in the notice? That we will read in section 173(3) later on. In the same section we have the provision of notice also, but right now I am concerned about one particular part in the content of notice, that is an option of VC. So when a director receives the notice of board meeting from the company informing when board meeting is going to take place, He's also given an option that the meeting may be, you can participate in the meeting through video conferencing, and this is the information with respect to that, right? So this is the disclosure that's given in the notice. I have received the notice, so I will attend the meeting. But this is something which is not very common, although it's becoming common. But I have to intimate the company that I am going to attend through VC, so that company can make adequate arrangements. If I don't intimate anything, it is deemed that I am going to attend in person. Fine. So I informed the company made adequate arrangements keeping all this in mind. And I attend the meeting through video conferencing in the mode as has been specified by the company. What happens is that at the board meeting, the chairman is going to ensure quorum. The next question arises, what do you mean by quorum? Quorum is the minimum number of directors which are required to constitute a meeting. Only then the meeting can proceed. The question is, ma'am, do the quorum need to be physically present or it can be virtually present? See, it may be a situation that all the directors are virtually present. It may be a situation that some are physically present and some are participating through VC. Never mind. The directors who are physically present as well as the directors who are virtually present, they both are counted for the purpose of quorum. So we count the physical directors. If they're present, it's a physical board meeting, right? And that we don't need to compute further, right? So that is how the case is. Once quorum is there, the meeting begins. Then happens the roll call. Roll call is like an attendance. You must have seen a lot of CBI inquiries or police inquiries in movies and web series. What happens? They ask or they interrogate, and the first thing that they ask the accused is that, tell your name. Although I know the name, but still I ask them to tell the name for the record. Right, same thing is happening here also. The directors are being asked to tell their name, the place from their attending the meeting, the fact that they have received the agenda, and the confirmation that no one else is around. So they have to give this for the record. Although the chairman clearly knows that particular director, but still a roll call happens for the record. Then what will happen? Of course, the meeting has started, there will be people discussing and then there will be voting. So when the people are discussing, there might be these directors also who want to participate and contribute to the discussion. So whenever they contribute, they will identify themselves, and if their voice gets disturbed by any means of disturbance, they will repeat it. Okay. And then voting happens, voting again, roll call, voting. That's how it happens. The chairman at the end announces the summary, and everyone, if they have any objection, they can raise it. After that, the minutes are drafted. That is the true and fair correct summary is being recorded or is being put in writing. Once it is written, it is circulated to all the directors who attended the board meeting. Okay. So they have the chance, they have the option of raising or of commenting on the accuracy within 7 days. If they don't comment on the accuracy, or if they don't have anything to say, it is deemed approval, and if they have anything to say, accordingly they raise that objection. After that, it is going to be entered in the minutes book. The minutes book is prepared under section 118 and is open for inspection under section 119, right, and is signed by the chairperson. Clear? Fine, ma'am. Then we have section 173(3), which talks about the notice of board meeting. See, what are you concerned in the notice? You have to inform the directors. What do you have to inform? Date, place, time, venue, option of VC, and agenda. What are we going to discuss in the meeting? Right? And when we have to inform? That means if the meeting is commencing at 1 p.m, I cannot call at 12 and say the meeting starts in 1 hour at this particular place. Right? A lot of cities where the traffic is huge or commuting takes time, they will not even be able to reach, even if they are willing to and they leave immediately. Then also they might not be able to reach, right? So there has to be a sufficient time given to the directors to prepare themselves for the meeting, to make themselves available for the meeting. So ideally 7 days time is required. So company gives 7 days notice to all its directors. To all its directors. No particular form of notice, 7 days notice in writing to every director, either by hand delivery or by post, which has a proof, or by electronic means at his address which is registered with the company. At his address which is registered with the company. If you don't give notice, then 25,000 fine on officer in default. Fine. Now I said one particular point with a lot of emphasis, that is agenda. What is it? Agenda is the matter which we are going to discuss. Now, Companies Act does not make it mandatory to give agenda along with the notice. However, as a part of good secretarial practice, it must be sent, and if we talk about the practical world, it is always sent, because the directors must know what are we actually going to discuss. However, this may so happen that 3 agendas are specified and the chairman wants to take up another matter which is required, and a board meeting is already in existence, so they can take up that matter, right? Simple reason being because the agenda is not mandatory under law. Fine, ma'am. Now, a lot of times this also happens that we don't have time. We don't have time to wait for 7 days to discuss a particular matter, and that's why we want the directors to come together at a shorter notice. So this is also something which is permitted for urgent matters, but there is a requirement. What is the requirement? That one independent director must be present in such a meeting which has been called at a shorter notice. Now, this may so happen that that no independent director is available or no independent director attends that meeting. So there is another solution. What is the another solution? It is supposedly a shorter notice is given, meeting called, no ID attends it, no independent director attends it. So circulate the decision to all the directors, and if at least one independent director ratifies it, then it's going to be valid. Ma'am, what about the companies in which we don't have independent directors? This is not the requirement, so you can call the meeting at a shorter notice. Simple. Okay. So this restriction has been placed on those type of companies only which have independent director. Okay. Sometimes students have this confusion that, ma'am, can board meeting be held on a holiday? Yes. Can it be held outside business hours? Yes. Can it be held outside the city or registered office? Yes. It can be even held outside India. Okay. So board meetings, that is something which is very well possible. Okay, fine. Now, Section 173(4) is only about the penalty that I've already told you. Moving on to the next part, Section 174, that is quorum of a board meeting. Quorum is the minimum number of members which are required to constitute or to validly conduct a board meeting. 1/3 of total strength or 2, whichever is higher. Although articles may specify an even larger or higher quorum, articles don't have the power to specify a lower quorum as it will be non-compliance of law, but it can specify a higher quorum. So articles may say that in my company the quorum will be 5 directors. So irrespective of what section 174 says, you have to have at least 5 directors to constitute to conduct a board meeting. Fine. Okay, fine, ma'am. Now, what if the quorum is not present? What is going to happen? The meeting will be adjourned. If quorum is not present, the meeting will be adjourned according to what articles say. If the articles don't say anything, it will be adjourned to same day, same place, same time next week. Supposedly at the adjourned meeting also quorum is not present, the meeting will be cancelled. In general meetings, we have read the opposite. What we have read in general meetings is that if in the adjourned meeting also quorum is not present, the members who are present shall be deemed to be the quorum. This is not the case in case of board meetings. Fine. So in board meetings and general meetings, this particular provision is different. Fine. Okay. Now one more thing that you have to understand, that what is interested directors? Who are interested directors? We have a section 184, in which we talk about the disclosure of interest and like things. See, there might be a situation that I am a director and the company is entering into a contract with my father. So I would definitely want that this contract should take place because I'm interested. Somehow I have an interest, and therefore my discussion, any contribution to the discussion, any contribution to the voting cannot be unbiased. Or even if I am so competent to be unbiased, others might not believe it, right? They will still have the feeling that I will give a biased opinion only. So Companies Act prevents such a situation and tells the directors who are interested to not be a part of such meetings, to refrain yourself from participating in such meeting and voting in such meeting in which you are interested in any contract. Okay, fine, ma'am. Now, supposedly there are 9 directors, and out of which 2 directors are interested. So 1/3 of 9 comes out to be 3 or 2, whichever is higher. So out of these 7 remaining directors, you can have at least 3 directors who are present and they will constitute the quorum. That's not a problem, because interested directors, since they cannot participate in the meeting, they are also not a part of quorum. Fine. But let's imagine a situation. There are 9 directors and out of which 7 directors are interested. So if I calculate 1/3 of 9, it will be 3. We don't even have 3 directors who are not interested, because 7 directors are interested. We just have 2 non-interested directors. So in such a situation, there will never be a quorum. So for this situation, it has been specified that if the interested directors at any time is more than or equal to 2/3 of the total strength, then higher of number of disinterested directors or 2 directors shall be the quorum. Okay, it shall be the quorum. Now, one relaxation in private companies, because in private companies you will be interested in almost all the contracts and you are only the member, you are only the director. So if you are interested, you are allowed to vote. It's just that you have to give proper disclosure. So this does not apply to a private company. Now, for section 8 companies, quorum is different. 25% of total strength or 8 directors, whichever is lower. However, in no case it shall be less than 2. Okay. Now let's imagine a situation, ma'am, my articles say that you need 5 directors to be the quorum and I have only 3 directors. So how? Because my 3 other directors have died. So how can I get 5 directors? How can I conduct a board meeting? In such a situation, you can call a board meeting even with lesser number than the quorum to increase the directors or to call general meeting. So for these 2 purposes, even if there is no quorum, the directors may act. Okay. Section 175. Passing of resolution by circulation. One thing that I have already told you, that resolution by circulation is not allowed in all cases. For the cases where it has been specifically mentioned that you have to deal with this item at board meeting only, then board meeting is needed. We are reading about the notice, we are reading about the quorum, all for the board meeting, not for passing resolution by circulation. So here we don't have any such requirement. What is the process then, ma'am? You draft a resolution, attach necessary papers which help the directors to take a decision, and send it to all the directors by hand delivery, post or email at their address. If you get approval by majority, then in the subsequent board meeting you will note it and include it in the minutes that such a resolution was passed. Okay. Sometimes it may so happen that I have received this draft resolution, and I sincerely feel that this is a matter which should be taken up at the board meeting because it needs a lot of discussions. So if 1/3 of directors require that the resolution should be passed at board meeting, then chairperson shall decline this particular thing and they will call a board meeting and the matter is going to be decided at the board meeting. Clear? The matter is going to be decided at the board meeting. Then comes your section 176, a very small section which just talks about the defects, or you can say validity. See, a lot of times it may so happen that we appointed a director, his appointment was defective, or some disqualification gets attracted to him, or he has to vacate some office, some grounds of vacation has been attracted to him, but he doesn't know. The company is not aware. In such a situation, he continues to act as a director even during that period of disqualification for say 6 months, 7 months. Now during this tenure, he has passed a lot of resolutions, he has taken a lot of decisions, he has entered into a lot of transactions with other parties, third parties. Once we come to know that his appointment was defective, that means he was not a director, proper director, and that means all the acts that he has done as a director are not proper. That means we have to reverse all the acts. The answer is no. Section 176 gives us a clarity that if the director appointment was invalid by reason of defect, disqualification or termination, then whatever acts are done by the company till whatever acts are done by the director till company becomes aware of it, they shall be deemed to be valid. Okay. So after his appointment has been noticed by the company to be defective, thereafter all the acts will be invalid, but before that the acts will be valid. Okay. Before that the acts will not be considered to be invalid. Just a second. I try hard not to waste your time because I understand you are into such heavy professional studies, and at this particular time, if at this particular point, if I am asking you to devote 1 hour with me, then I have to understand the importance of that 1 hour, and I cannot be like only half an hour to be productive and half an hour some chit chat or this example or that joke. So I refrain from cracking a lot of jokes when I'm into serious studies. Of course, for the flow, for keeping the classes entertaining, you know that we need stories, we need jokes, we need situations every now and then, so that has to happen. But of course, when I'm doing this continuous revision, I don't want to waste your time, and that's why I am trying to be as quick as I can. If you still want that the flow should increase somehow, you can increase the speed, but I wouldn't a lot suggest you that. For the topics wherein you are very confident, you may skip this revision, you may increase the speed, but for the topics you are not very confident, then this is going to help you only, right? So you can revise along with me. I'm trying to cover all the aspects of all the complete section. I'm not leaving anything for you. Now, section 177, audit committee. See, 177 has two aspects, audit committee as well as vigil mechanism, and section 178 has NRC and SRC. First, we'll talk about section 177, audit committee, or as of that matter, any committees that we're talking of. What are these committees? They're nothing but a group of directors of the same company. So they are dedicatedly being appointed to the cause of something. When I'm talking about audit committee, they have been some directors who have expert knowledge in finance or who understand finance, who understand the financial statements and all, who understand how audit is being conducted, what is the importance of audit and like things, they are being included in this committee. What do? They see that which auditor should come, so they can give recommendation with respect to auditor, his remuneration. They can see how audit is being performed. They can see other internal controls of the company. They also have to approve some related party transactions, right? So they investigate into certain matters. So not just audit, but overall control of the company. So they have certain powers and they have some certain functions that they need to discharge. So they are going to oversee all those things. Okay. Ma'am, do we need audit committee in all types of companies? The answer is no. See, as the company grows and expands, then you need specific expertise areas. Otherwise, one person can handle it all. One person can handle audit also, he can handle the employees also, he can handle the operations also. So even if you have 2 directors, they can handle everything. But as company grows, you need different dedicated team to handle things. So the companies which are required to appoint independent directors, the same companies are also required to constitute audit committee. Okay, that means listed public companies or public companies which have paid up capital of more than equal to 10 crores, turnover more than equal to 100 crores, loans more than 50 crores. So these companies are required to constitute audit committee, which is mandatory. JV, that is joint venture, wholly owned subsidiary, dormant, not applicable to them. So they are not required to constitute. Now, we need to understand what is going to be the composition of audit committee, what are the powers that they have been given, what are the functions that they need to discharge or they need to perform, any disclosure and punishment for not doing it. The punishment is not given over here, it is given under section 178. So we don't have any punishment which has been specified in section 177. For contravention of section 177 also, the punishment is stated in 178 only. Okay, now composition. Minimum 3 directors, of which majority shall be independent and with the ability to read and with the ability to read and understand financial statement. They have to be financially literate, not just literate. Okay. What do? They recommend auditors' remuneration. One important point to note over here that they recommend. They cannot impose their decisions on the board. It is board's discretion only whether they want to appoint or nominate the auditors. Appointment of auditors is a matter of ordinary business which is being dealt at the general meeting of the company, but board nominates the name of the director, nominates the name of auditor. This name is being suggested by the audit committee. When an expert is giving you a recommendation, you must follow it. Although it is your life, your decision, you might not follow it. But when you reject that expert's recommendation, you must have a strong backing reason for that. The same goes for the board. Board, if you are rejecting, if you are not accepting the recommendation of audit committee, you must disclose the reasons in the board's report why not, along with the composition of audit committee. Fine. So they recommend, then they review auditor's performance, how the auditor is performing, so that we can give a feedback, no, this auditor is not correct, we should not reappoint this auditor, or this is performing brilliantly, what is happening, right? Then examining the auditor's report. If auditor has given any qualification in his report, then you are going to discuss it with the auditor, why this particular qualification has been given. If it is a clean report, no problem at all. Right, but then you will see on what aspects auditor has examined, on what aspects auditor has not examined, what are the things that are happening in the company. So it also acts as a bridge between the management as well as the auditor. Then scrutiny of loans, assets, internal control, monitor use of public funds, additional things, and approval of related party transactions. So section 177 out here is read with section 188. Is read with section 188. One by one we'll do it. Now, to discharge all the functions, you also have been given certain powers. You can call for comments of auditors, you can review financial statements, you can discuss issue with the auditors, you can investigate and oversee vigil mechanism. We'll do this later after we do this. Fine. Now, what is related party transaction? What is related party transaction? For this, you need to understand what is a related party. Section 2, clause 76 defines related party. Company, the director of company, relative of director. KMP is relative. Any firm in which they are a partner. Any private company in which they are member or director, any public company in which director or manager is the director and holds more than 2% of paid up share capital of the company along with its relatives. Then any body corporate according to whom you are acting, or the body corporate who is acting on according to you. Then we have holding subsidiary, associate, investing company, subsidiary of holding, any other as may be prescribed. So all these are related parties. All these are related parties. Company enters into a contract with the related party. Company is buying some goods from related party. Now this is a contract which is specified in section 188. I'll repeat. Section 188 has 7 specified transactions if entered into with related party needs approval. Approval from audit committee, approval from board, and if ceiling limit exceeds, then approval from members also. So audit committee approval, board's approval, as well as members approval if ceiling limit exceeds. Members approval is needed only if ceiling limit exceeds, right? That means you need audit committee's approval also. So audit committee will grant the approval. Fine, ma'am. Audit committee has an option to give omnibus approval also. What is omnibus approval? It is one-time approval. See, if the transaction is not covered under section 188, of course you don't need to give any approval, you can only give recommendation. If the transaction is covered under section 188, then you need approval. But even within that, if the amount is less than 1 crore and you don't take approval from audit committee, then audit committee can ratify it within 3 months, and if not, it is going to be voidable at the option of audit committee. But if the amount is more than 1 crore and the transaction is specified under section 188, then either you can take approval transaction wise or you can take prior approval for maximum 1 year. Okay. For this, audit committee is going to check how repetitive the transaction is and how justified the transaction is. So based on that, they will give prior approval for the whole year. That okay, this is the maximum value, that during the whole year, maximum up to 1 crore you can enter into transaction, or maximum up to 10 crores. Per value transaction is not going to exceed 1 crore. You have to make these disclosures. These transactions are not permitted, and I'm going to review from time to time. Okay, so this, by imposing such conditions, audit committee can grant omnibus approval for related party transactions which need approval under section 188. Clear? If you contravene this, penalty is there. This is the penalty which is given under section 178. Clear? Now, audit committee is also required to oversee vigil mechanism. What do we mean by vigil mechanism? Vigil mechanism is set up for the benefit of employees, for the benefit of directors, so they can report their concerns, their grievances directly. A lot of times it happens that employees are being caught in the web of manager or the exact upper hierarchy. They don't have the access to move to higher authorities. They don't have any access to complain. They don't have any medium to complain, right? Even if they go to their own manager for complaining about him only, he's not going to listen. So for such purposes, for the companies, if your company is a listed company, if your company has accepted public deposits, or if your company has borrowings more than 50 crores, then in these situations it is mandatory for the company to establish vigil mechanism. Okay, now vigil mechanism is just a system where you can register your complaints, where you can have access to people who will listen and resolve your problems. For the companies which have audit committee oversees the vigil mechanism. In many companies, it may so happen that you don't have audit committee, but because you have accepted some public deposits, you are required to establish a vigil mechanism, and therefore you do it. So in such a situation, the board is going to nominate a person to oversee vigil mechanism. It also happens a lot of times that people take undue advantage of this system and they file unnecessary or frivolous complaints. So in such a situation, action will be taken against that employee also. I'm sorry. Clear? Fine. So this was about section 177. Now we move to section 178, NRC and SRC. Who is required to establish NRC and for what reason? NRC is again being established by those companies who are required to have independent director or who are required to constitute audit committee. So the same companies are also required to constitute NRC. What is NRC meant for? NRC is going to identify persons who should be appointed as director, who are deserving ones, who are required in the senior management, who should be removed. Formulate the criteria. In fact, even develop the criteria for evaluation of the performance of board, that he is a director who is performing really well, or he is in the senior management, he can be promoted as a board of directors. So this is the criteria that I have developed for evaluation of performance, like who attends at least 7 board meetings. So this is the criteria that they have maybe set up. Now this can be evaluated by them only, or it can be evaluated by some external agency also, or by the board also, right? So all this is the function of NRC. The composition of NRC is slightly different than audit committee. Here you need 3 directors, only non-executive directors, 3 or more, at least 3 non-executive directors, of whom half shall be independent directors, Now, whoever is the chairperson of the company can become the member of NRC, but he will not be the chairperson of NRC. He is the chairperson of company, he is an executive director, he can still be the member of NRC, but he will not be the chairperson of NRC. Clear? Okay. Then we have Stakeholders Relationship Committee. Ideally, when we talk about stakeholders, we include everyone, be it government, be it our suppliers, be it our employees, be it our vendors, all of them. But here, stakeholders mean the persons who have invested into the company. They are the security holders, they are shareholders, they are deposit holders as well, they are debenture holders, they are any other security holders. So collectively, if this number exceeds 1000, then comes the requirement of SRC, that is Stakeholders Relationship Committee. What are they going to do? Vigil mechanism for the reporting of complaints by employees. This is also for reporting of complaints or grievances or problems of stakeholders. Some might not have received the dividend, some has the issue with respect to share warrantor, etc., etc. There can be ample of things, right? So they can file their grievances. Stakeholders Relationship Committee, a group of dedicated directors who are going to oversee that all the problems are being resolved or not. So the basic idea is to protect the interest of all security holders, okay? Not just your equity shareholders, but all the shareholders, right? Now, sometimes it may so happen that I'm genuinely trying to resolve a problem, but the other person is not listening at all or is in some other angle. So, if you have tried to resolve the problem in good faith and you are unable to do that, then it will not be deemed to be contravention of the same. Okay, so no contravention if inability to resolve the problem in good faith. You have the penalty. What is the penalty? 5 lakh and 1 lakh. Section 177 plus section 178. So if you contravene any of the provisions of these sections, then this is the penalty. Penalty on company 5 lakh and penalty on officer in default 1 lakh. Right? Now, Section 179, powers of board, or I can say powers exercisable only at a board meeting. See, first thing that you need to understand for this section is that what board of directors can do. Anything that a company can do, its board can. What company can do? Company has to comply with Companies Act. The board also has to comply with Companies Act. Company has to act within the purview of its memorandum of association. So will the board. So you have to understand that anything that a company is permitted to do, its board can do. But there are some powers or there are some acts which only shareholders can do. Like altering the articles of association. A company is permitted to alter its articles even after it has been drafted, but this power has been specifically reserved for the shareholders. So such a thing cannot be done by the board of directors. So all the acts which a company can do within Act, MOA, AOA or any regulation which the shareholders have imposed in general meeting. So within these powers, board can do all the acts which company can do, but board cannot do the things which are specifically reserved for the shareholders. Now, so board has ample of powers. Out of these ample of powers, there are certain things which have to be dealt at board meeting only. These powers cannot be exercised or these matters cannot be dealt through resolution by circulation. Okay. So BR in BM is needed. That is board resolution and board meeting is needed for transacting these items. That means whenever you want to call money on shares. See, I have given you a mnemonic of learning this. I hope you remember that and you have learned this well. Calls on shares, buyback, issue of securities, approval of merger, diversify business, approval of financial statements, political contribution, takeover, appointment of KMP, internal statutory auditor, removal of KMP. And then you have big powers. Borrowing money, investment and giving loan guarantee security. These two are covered in section 186 and this is covered in section 180. So section 180, company can borrow, company can give loan, company can invest, company can give guarantee, company can give security. Company can do this. It is not such that these things are not permitted. These matters can be dealt only at a board meeting. However, these three big powers, BIG, big powers can be delegated. You call a board meeting, you pass a board resolution, resolved that the power to borrow money has been delegated to managing director of the company. He is now empowered to borrow money on behalf of the company. The maximum amount that he can borrow is this, etc., etc. So by imposing all those conditions, you can delegate the power to a managing director, manager, commercial, the principal officer of the company or branch, right? He can be a director also. So I hope that's clear. Now, board of directors has all the powers which company has, subject to act, memorandum, articles and regulations. Now, there are around 13 matters which require board resolution at board meeting. Only then they can be discussed or they can be dealt with. How, out of these 13 matters, there are 3 matters which can be delegated, right? Now, we come to section 180, borrowing. This is the major thing that is given in this section. Section 179 tells us that the company can borrow, but to borrow it has to hold a board meeting. However, it may also be delegated to someone, but whatever power is delegated, it has to be within the limit which is given in section 180. What does section 180 tells us? Section 180 restricts the general and vast power that has been given to the board. The board can borrow. The board can borrow money. Section 180 tells, hold on, you can borrow only up to this amount. If you want to borrow more than this, you need to go to the members and take special resolution. You need to pass SR and take their approval. Moreover, you also need SR for these things. So in these 4 cases, SR is needed by the board of directors. Case number 1. Company wants to sell its undertaking. What is undertaking? Undertaking is a separate unit. How do we identify whether a particular venture is an undertaking or not? If that particular venture is giving you or is worth 20% of net worth, more than 20% of net worth, or it's generating more than 20% of income, then it's an undertaking. So if you want to sell off that undertaking, the board cannot take decision on its own. It has to go to the shareholders and get SR passed. If the company wants to sell only substantial amount of undertaking, not the whole undertaking, but a substantial amount of undertaking. What is substantial amount of undertaking? 20% of that undertaking. So if you want to sell that, then also you need SR. Clear? Sometimes on merger, you have received some amount. Company has received some amount. Now you want to use this amount for some purpose. It's not your money, it's the money of shareholders. You need to take their permission and then only you can use this amount. Supposedly, company has given some loan to a director. Now, can company give loan to a director? Yes, subject to section 185. Subject to section 185. Supposedly, company has given loan to a director and now the director is unable to repay. The director comes to the company and says, I need 1 more year. The board says, okay, fine, take it. Today is your day, tomorrow our day will come. No. The board does not have the power to give extension to the director. For this, you need SR. And lastly, if the amount of borrowing exceeds a particular limit, what is the limit that has been given? Borrowed plus proposed exceeds paid up capital, free reserves, securities premium. If this exceeds, then SR is needed. If it does not exceed, then SR is not needed. That means if your total borrowings are less than equal to paid up capital, free reserves or securities premium, then you don't need SR. If it exceeds that particular amount, then you need SR. In this section, in this particular point, we have a concept called as temporary loans. Temporary loans, what are they? Temporary loans, like you have any short term loans, they are not going to be part of that borrowing. For example, if there are short term loans 50 lakhs, and then you have long term loans again 50 lakhs, and the company proposes to borrow further 50 lakhs. So how will I compute this limit? I will say that my existing borrowings is 50 lakhs and my proposed borrowing is 50 lakhs. So 1 crore is the total borrowings. Now if this amount exceeds this, then I need SR. So I will also calculate paid up capital plus premium plus free reserves, and I'll see which one is higher. If my borrowings is less than or within that limit, then I don't need SR, otherwise I need SR. Okay. Section 180 does not apply to a private company. So in private company, the board can borrow any amount that they want to. They don't need to get any special resolution. So for private companies, you can borrow any amount that you want to. There is no restriction or there is no limit which has been imposed. Fine. Section 181. Contribution to bona fide or charitable funds. This is a very small section. Company wants to contribute to these funds, you can. If you want to contribute up to this particular percent, it is within board's limit, and if it exceeds more than 5%, then you need OR, and then you can contribute. Then comes your section 182, which is political contribution. Again, a lot of students have this problem that, ma'am, why political contribution is so liberal that any amount, you can contribute any amount. So I have told you the logic behind this, right? See, any company other than government and a company which has been in existence for less than 3 years, they can contribute, they can give any amount they want to a political party. It's just that cash contribution is not allowed. They have to either contribute through check, draft, ECS or instrument. So they can. They just have to disclose in P&L account. Okay, fine. Contribution to National Defence Fund. This is an overriding section. It overrides everything. It says that if company wants to contribute to NDF, National Defence Fund, or any other approved fund for defence, go ahead. Even if your articles restrict you, then also you can. There will be no contravention, absolutely no. Okay, fine, ma'am. If you contravene this, there is a penalty. This reminds me, if you contravene section 179, section 180, section 181, that is powers of board, then you have restriction on powers of board, and even if you have charitable contributions. These three sections that we read before, they don't have any penalty which has been specified. That means, ma'am, we have been given that we have to discuss this matter at board meeting only. But supposedly we don't discuss this matter at board meeting and we pass a board resolution by circulation. What is the penalty? You have the penalty which is not specified for the section. So you go to a specific section of penalty, which is section 450, general section of penalty. So for all the sections where a specific penalty has not been specified under Companies Act, we have a general section, section 450. Now, disclosure of interest by director. A director has to give disclosure of interest. For this, again, we come back to a related party. For the students who have not done very thorough study, might not understand that what is the connection between related party and section 184, ma'am. Section 188 is for related party, section 184 is not for related party, but you have to understand that there may be situations when both the section applies. Why? Because we have interest in our related parties. No matter how much we say that we are interested in our neighbors or this or that or this or that, no, we are interested in our family, our relatives, our people. Right? If my mother is being appointed as one of the employees of a particular company, I'll be interested in that contract. If some XYZ person is being appointed, I'll not be interested. So my interest is somehow connected with related party, though it may not always happen so. Now, if I am a director, I have to check in which companies I have the holding, in which firm I am a partner, where body corporate, where association I'm interested. And I have to give all these details in the first board meeting in which I'm participating as a director. I've been appointed as a director. In the first board meeting that I participate, I have to give this disclosure. Thereafter, every year in the first board meeting, I'll give disclosure. And if there is any change in my interest, then after the change in interest, the first board meeting that happens, there also I'll give disclosure. So I have to give disclosures in this manner. The form specified is MBP 1. I give the disclosure. The company maintains a register MBP 4 for recording these things. Okay, fine. There is another subsection, section 184(2), which is more important for examination point of view, that deals with specific disclosure. Specific disclosure. Now, this is when the company enters into a contract or arrangement with body corporated firm and the director of the company is interested in such body corporator firm. Now, this interest has been specified. Section 184 interest has not been specified, so you have to give disclosure in all respect. But here, you have to give disclosure only when you hold more than 2% of paid up capital, or your promoter or manager of CEO and partner or owner of the firm in case of firm. So you have to, if above situation arises, then this director must disclose his interest in the board meeting in which first time the contract is discussed, and he shall not participate in it. Supposedly there is contravention of the same, the contract becomes voidable, such director has to vacate office and there will be a fine of 1 lakh on interested director. On interested director. Okay. Again, it does not apply to private company, because in private company, the directors who are interested, they can vote. After giving the disclosure, they can vote. Fine. Moving on to our next section, section 185, that is loans to directors. See, the first thing, company is prohibited to give loan, guarantee or security to the directors of the company, the directors of holding company, the relative of such director, partner of such director, and a firm in which such director or relative is a partner. So you cannot give loan, guarantee or security to your director, to your directors of holding company, and to other concerns in which the directors are related. This is the logic, this is the section which it says, but then it has exceptions. See, section 185 deals with such a situations when there is loan, guarantee or security to the directors or its concerned entities. If the director is not related to any entity, this case does not fall under section 185, because section 185 deals with loans to directors, etc. So we are talking about loans, giving loans to director directly or giving loans to the entities in which such director, in which director is interested. So one is that prohibition, you cannot give to these people. Second is that you are permitted to give to certain people in which director is interested if you pass SR. If you pass SR. Okay, ma'am? Permitted to give loan to or guarantee or security to private company in which director is a director or member, body corporate whose board acts according to us, and body corporate in which we hold more than equal to 25% of voting power. So you can give to such entities in which director is interested. Loan can be given to such body corporates in which the director is interested if Explanatory statement is given to the members and SR is being passed. Clear? Now, it's not applicable to private company if no body corporate has invested in that private company and the borrowings are within this limit and there is no default. It is also not applicable to government company if they have obtained the necessary approval from their respective ministry and no default of filing. Moreover, it is not applicable if loan is made to MD or WTD as employee. They are executive directors, right? That means they are employees of the company. So just like advance salary can be given to other employees, it can be given to these directors also. So fine. There might be some scheme which has been released by the company, and in pursuance of that scheme you can take loan. So you can take loan, not a problem. There might be a situation when you give loan in ordinary course of business like NBFC or banking company. It is their business to give loan. So just like they give loan to other customers, they have given loan to director also. But obviously when you give loan to your internal employees, to your internal directors, you give loan at some reduced rate. In any situation, your rate should not be less than the government security yield. If you will give loan to your wholly owned subsidiary, if you give guarantee to your wholly owned subsidiary, guarantee or security to your wholly owned subsidiary. So these are the exceptional cases where it is permitted, right? Where it is permitted. Moving on to next section. Loans, investments, etc. by a company, a very small section, section 186, or rather I would say it has two perspectives. Sorry, 186 is not a small section. It has two perspectives. One is putting a restriction on layering of investment companies, and the second is LGSI limit. First thing you need to understand for this section is what do you mean by investment companies, and since you have to understand about investment company, I'm going to take you over here. Investment company is what? Whose principal business is investing. How do you identify whether a company is investment company or not? See, if I want to check, I open a balance sheet of any company. If that's a factory, it will have a lot of assets as plant and machinery. So I come to know, okay, a lot of manufacturing is taking place in this company. Likewise, if I open the balance sheet of an investing company, I will see a lot of assets as investments only. So more than 50% shall be them. Or if I check the P&L account, I will see more than 50% of its income is coming from that investment sources only. Right? So that's how I identify whether a company is an investment company or not. Although we can talk about any type of company, there is a restriction on number of layers of subsidiaries. But this section 186 talks about investment companies only. It restricts the number of layers of subsidiaries to maximum 2. It does not mean that a company cannot have more than 2 subsidiaries. Undoubtedly, it can have hundreds of subsidiaries, but it cannot have more than 2 layers of subsidiaries, which means a company has a subsidiary, this company has another subsidiary, and this company has another subsidiary. So layer 1, layer 2 and layer 3. So layer 3 is not permitted. Fine. There are exceptions. What are the exceptions? Banking company, NBFC with net worth more than 500 crore, government company, insurance company. These are the exceptions. One more thing, that wholly owned subsidiary is not counted as a separate layer, that is merged with that company only. And we have a company, this company acquires a foreign company. It becomes a subsidiary. Now this foreign company already has 5 subsidiaries, 5 layers of subsidiaries, I would say. 1, 2, 3, 4, 5. And this is something which is permitted in that country. So this foreign company is not doing anything unlawful. It is a lawful act. And now you want to acquire, you want to make this foreign company as your subsidiary. An Indian company wants to make this foreign company as their subsidiary. You can. So if Indian company is a foreign company, if the investing company is a foreign company with permitted more layers as per foreign law, it is allowed. Now we have other provisions of section 186. This is LGSI. Loan to any person or body corporate, guarantee with respect to the loan, security with respect to the loan, or investment in body corporate. This is shortly known as LGSI. For this, you need unanimous board resolution. So for giving loans to anyone, for giving guarantee, for giving security, or for investing in any body corporate, you need UBR. More than that, apart from UBR, if the ceiling limit exceeds, you also need approval from members. You also need approval from members. So what are the cases? UBR is must in all cases. If LGSI made plus proposed does not exceed the limit which has been specified. What is the limit? This is the limit. Higher of 60% of paid up capital plus free reserves plus securities premium, or 100% of free reserves plus securities premium. So you check this limit, you compute this limit. If your LGSI which is already there plus proposed exceeds this amount, you need SR. If it does not exceed this amount, no SR is required. Okay. Now, if it does not exceed the limit, no SR needed, you just need UBR. Plus you need PFI approval if there is default in repayment. If there is no default in repayment, no problem. Fine. But if your LGSI exceeds this limit, you need UBR. You also need SR. As well as you also need PFI approval. Ma'am, even if there is no default, yes. If it exceeds limit, you need PFI approval also. Fine. Apart from this, whatever loan you are giving, at least this has to be the rate. The minimum rate is going to be at least yield of government security closest to the tenure. Right, when we compute this 60% of paid up share capital, we have to take capital as both preference plus equity, as well as we deduct call scenarios which have not been received, because we are computing paid up capital. So whatever has been received, that only is taken. There has to be no subsisting default with respect to deposits. If there is, you cannot go for LGSI. Disclosure has to be fully made in the financial statements. Okay, full disclosure in financial statements. Apart from this, there is a register for LGSI which is being maintained, MBP2. This register is also going to be open for inspection by the members, and there is contravention. If the company contravenes these provisions, minimum fine 25,000, maximum 5 lakhs. So your fine can range between this. On the company and officer in default, imprisonment less than equal to 2 years, and again fine between that. Fine. Section 187, a very small section. Whatever investments you are holding, whatever assets you are holding, whatever securities you are holding, it has to be in your own name and in your own possession. Simple. That is the general rule. So company, if it is holding any investment, it has to be in company's name only. However, there are certain exceptions. Sometimes it is important that you have, for compliance of law, you have to hold it in your nominee's name, hold shares. Sometimes you give it to the bank for collection of dividends. Sometimes you have to transfer it to the bank for facilitating sale. Sometimes you transfer it, rather give it as a pledge for obtaining loans. Sometimes when your shares are in demat form, you're not the registered owner. Your depository is the registered owner and you're just the beneficial owner. So in these situations, investments might not be in your own name. For this, you have to prepare a register in MBP3, which is going to be kept at the registered office, preserved permanently, and is going to be open for inspection. Section 188. Again, we have a punishment also for this. 5 lakh and 50,000. Okay. Section 188, related party transactions. Now, see, whatever transaction is happening between the company and its related party, Not all the transactions are covered under section 188. First of all, if they are at arm's length price in the ordinary course of business, they are not covered. Secondly, if they are not at arm's length price in ordinary course, then we have to check whether they are covered under the specified 7 transactions. What are the specified 7 transactions? Sale, purchase or supply of goods or material, disposing of property, leasing of property, availing or rendering of services, then with or without agent, that is clause E. Then appointment of OPP, office or place of profit, underwriting of securities. So these are the 7 specified transactions. If the company enters into a contract or arrangement with related party, the transaction which is specified under section 188, you need BR. If it exceeds the limit, you also need OR. Simple. For BR, notice of board meeting will be sent with agenda explaining everything. At board meeting, resolution will be passed. The interested director is abstained from participating and voting. Next thing is we have to check whether it exceeds the limit or not. If it exceeds the limit, then notice of general meeting will be sent along with the explanatory statement, and the ordinary resolution will be passed. Related member will not vote. If it does not exceed, no OR is required. No OR is required. Right? Transactions between 100% subsidiary and holding, no OR is required. Whatever transaction is being entered with the related party will be adequately disclosed in board's report. The next question arises in our mind that, ma'am, what is the limit? What is the limit? If it exceeds limit, we need OR. But what is the limit? The limit, sale, purchase of goods, material with or without agent, more than equal to 10% of turnover, OR. Property more than equal to 10% of net worth. Leasing more than equal to 10% of turnover. Services more than equal to 10% of turnover. 2,50,000 per month and 1% of net worth exceeds that. Now, if the contract needed approval from board or approval from members, but that necessary approval was not acquired and the transaction took place, the contract was entered into, what happens in that case? Does the contract become void? The answer is no, it becomes voidable. First of all, it can be ratified within 3 months. Even if it is not ratified, it becomes voidable at the option of the board or the members, whatever the case be. Right? If there is any director who is involved, he is going to indemnify the company for the loss. Okay. You have the penalty. In case of listed company, 25 lakh. In case of unlisted or others, 5 lakhs. Right. Now we have very small sections remaining. Section 189, the register. So for section 184, for section 188, you have to maintain the register, MBP 4. The register is going to be preserved permanently, kept in the custody of company secretary. When we give disclosure under section MBP 1, that details are going to be included in the register. Register will be kept at the registered office. It is going to be open for inspection, produced at every general meeting, and there is a penalty for non-maintenance, that is 25,000. Then comes section 190, which talks about the contracts of employment with MD or WTD. See, whenever a company is appointing MD or WTD, it enters into a contract of employment. If there is no contract of employment, then we'll at least have a memorandum of understanding where the terms are being boiled down to writing, right? Whatever it is, it has to be kept at the registered office of the company, and which is going to be open for inspection for members. This is not for private companies. So only in public companies this is going to be an open thing for members, right? Again, there is a penalty, fine less than equal to 25,000 and 5,000 respectively for company and officer in default. Section 191 is somehow related to 202. Because here we compensate for the loss of office. Section 202 gives compensation only to MD, WTD and manager. However, this section gives compensation to all the directors. In case of sale of undertaking, sale of shares, takeover, there is any loss of office to the directors, then they can get compensation which is not going to exceed the compensation given under section 202. So within that limit, the compensation can be given. Compensation can be given undoubtedly to the executive directors as well as non-executive directors. So when I'm talking about executive directors, there are some restrictions. Since they are involved directly in repayment of deposits, repayment of debentures, repayment of bank loan, taxes, then payment of employee dues, or dividend to preference shares or redemption of preference shares, if there is any default in all these, they will not be entitled to get compensation. The non-executive directors will still be entitled, but they will not be entitled, right? Moreover, an additional point to note over here is with respect to the quorum. Usually, see, one more important thing. When we are talking about section 191, we give compensation to all the directors by passing ordinary resolution. So when we are passing ordinary resolution, it may so happen that the meeting was adjourned, and at the adjourned meeting also the quorum was not there. So deemed quorum and the resolutions were passed. This shall not be passed. No deemed approval in case of this section. Okay, penalty 1 lakh. Then we come to section 192. Restrictions on non-cash transactions, that is a kind of barter system. Again, this is not going to happen unless OR is passed. So if you want to enter into any transaction with a director which is non-cash, you have to take prior approval by OR, and the value shall be determined by the registered valuer. If it is not so obtained, if the approval is not so obtained, the transaction will be voidable at the option of the company. Okay. Lastly, we have section 193, that is contract by one person company. It is absolutely nothing. One person company is entering into a contract with the sole member who is the director also. So what disclosures you will give, what board meeting you will hold, what permissions you will take, nothing required. You just have to enter it in the minutes book, and you have to inform the ROC within 15 days about the transaction into, because he is a related party, right? So that's how things will take place. That's it with this particular chapter.
Okay, let's now revise the chapter of inspection, inquiry, and investigation. According to Companies Act classification, it is chapter 14 of Companies Act, and consists of sections from 206 to 229. But then we don't have to read all the sections, because there are very small sections also which are not in our syllabus. So let's begin. But before we actually begin revising the entire chapter, we have to first understand the meaning of three terms: inspection, inquiry, and investigation. Although these terms have nowhere been defined in Companies Act, but if we look at the general dictionary meaning, we get to know about inspection. And if we even try to analyze our surroundings and the circumstances, then we will understand what is exactly inspection is. We have food inspectors who come and just ensure that there is no adulteration, everything is in order, right? We have so many inspectors who come and just do that site inspection before granting you a particular registration like GST and everything, right? So inspection, my dear, is done to check something, to look at something carefully, that okay, everything is correct, everything is legal. So inspection is not negative. Inspection at times is mandatory in all cases, even if you have not done something negative. So inspection is a matter of routine thing, and it is not negative. However, when we are talking about the term inquiry, or when we are talking about investigation, these are negative terms. Why? It is always going to be negative. Why? Because inquiry is like asking people that okay, this has happened, there is some plane crash which has happened, now this is something bad which has happened, now there's going to be an official process of inquiry against the pilot, maybe, right? So this has happened, now there is so something bad has already happened, this is negative. Unless you get a clean report, oh my god, there's an inquiry going on against that particular person. So this is the thought process that we have. And investigation, it further goes on. further detailed thing, right? There is some crime, there is some problem, there is something which has happened. Now you're in detail examining the same, right? So that is investigation. So investigation is a very detailed thing. Inspection and inquiry are not so detailed, but inspection is something which is routine, and inquiry is something which is something bad has happened, right? So in this particular chapter, how do you differentiate between the two? Inspection is going to take place when simply ROC wants more information and they're not clear of the view and they just want to ensure that everything is in order. Inquiry takes place when they suspect that there might be a fraud, right? Investigation shall take place on the basis of these reports. So, on the basis of inquiry or on the basis of inspection, if we discover that there are certain things, then investigation may take place. Or in general, we have other grounds also. So, this is how they are interconnected. And now we will straight away focus on the section. So, section number 206, the very first one. What is it all about? This section talks about inspection, it also talks about inquiry. So there is company has filed certain documents, company keeps on filing documents with ROC, needless to say. ROC also receives a lot of information from other sources, like from interconnected companies or like things, right? So company filed the document with ROC, or there is some information which has been received by ROC, and when ROC looks at that information, tries to scrutinize the same, they're not satisfied with the information. So what they'll do is they'll send a written notice and ask for more information or explanation. Okay, so they send the written notice to the company. Now it is the duty of company, its present and past officers to send info. Ma'am, why past officers? Why will past officers now be involved in all that? See, there could be such a situation that the information that ROC is seeking relates to a past period when there were some other people as directors, or it was in control of some other management. So they will be knowing that information, so they have to reply. It is their duty to reply. Okay, so they have to basically reply within the time frame given. Reasonable time. What is reasonable time? Reasonable time is specified in the notice. It could be said that, okay, ROC is seeking such and such information from you and you have to reply within a span of 15 days. So you have to reply within a span of 15 days, right? It may be not sufficient for you might think that, okay, I need to arrange this particular information and I need more time. So you have asked for extension and they have granted you an extension of again 10 days. So now you have a span of 25 days. So you have to reply within the time or within extended time. Or there may be situation you didn't reply. Now you didn't reply gives rise that why? Now I need to inspect. Now I need to look at things more carefully, right? Okay, so if you reply and the reply is satisfactory, great. If you reply, but your reply is inadequate or unsatisfactory, or you don't reply at all, then ROC is going to record the reasons why it is going for inspection. It will give a written order to company that produce your books of accounts at prescribed place, time for inspection. Okay. How inspection will be carried out, that is given in section number 207. So who is carrying out inspection? It is ROC. Central government may also at times order inspection and they also may appoint inspector. So inspection can be done by ROC or the inspector appointed by central government according to section 207. So section 207 has the entire process of inspection, and thereafter we make a report. We can leave this right now because we'll read the respective sections. Okay, now if I come straight away to section 207, you have already got the order of inspection. Inspection can be done by registrar or inspector. They'll call the books and so the process will happen. But before we actually read that process in detail, we have something called as inquiries. I've already told you the difference and everything. Now, any person may make a representation or may provide some information to ROC, or on the basis of available information with ROC is satisfied that this company is carrying on business in a fraudulent manner or doing some unlawful business, and we need to inquire about this, right? We need to inquire about this. or there is some non-compliance of provisions, or they're not addressing the grievances of their stakeholders. So in all of these cases, registrar is going to tell the company that this is the allegation that we have found against you, and this is, like I told you, there is a plane crash, the pilot is going to go under an inquiry that you are responsible for the crash, you did not manage it properly, whatever things needed to be managed, it was your fault, right? So now this is the allegation which has been imposed, and now you have to provide the information, you have to provide the explanation, and after that you might get a clean report, or you might not get a clean report, right? So that is going to happen, right? So this is what is happening in the case of inquiry. So registrar informs about the allegation and asks to provide information and explanation, give opportunity of being heard, and carry out the inquiry. Now this again, inquiry can be carried out by the inspector. CG may also direct inquiry and appoint inspector, that the same manner as we have read in inspection. Okay, fine. So after order of inspection or after order of inquiry, registrar or inspector is appointed. They call for books of accounts and other books and papers, information, explanation, whatever is needed, and it is the duty of the directors or the officers, the employees, that they have to produce the documents which are asked for. They have to furnish all the information or explanation which is being asked for, right? And they have to give complete assistance. Okay, if the inspector comes and asks that where is this document, I need this document, so you have to provide that. Okay, you don't have to say I don't know, go to that table number, this table number, that, go to this cabin, go to that cabin. No, you're not going to do that. Okay, fine. If you don't follow what you have to, there is imprisonment and a fine. Otherwise, registrar or inspector, whoever the case be, is going to conduct inquiry or carry out inspection and give report on the same. In the process of conducting this inspection or inquiry, they will have the powers of a civil court, and they will also have the power to make copies of the documents or place identification marks, because they have to see, okay, there are thousands of documents which we are looking at, so they'll place this has been looked into, no error found, nothing found. So they will be needing to place identification marks. They're allowed to do that. Okay, fine. Now they carry out the inquiry or inspection in the manner provided, having those powers, and after that they are going to prepare a report, right? Okay, so the report that they prepare in writing, they give it to central government. Fine. In their report, they will actually recommend whether there is a need for further investigation or not. But why? If there is need for further investigation, they should have done everything. No. Every work has a certain scope. Right? Although these things have been presented in such a manner that nowadays tuition is a fashion and everyone is taking tuition. So if I'm talking about school students, but otherwise in general, if you try to understand the concept of tuition, what it actually was, it was like the school or the school teacher has a certain scope of work and limited time. So in this time, you have to teach this much, right? You cannot extend beyond. There are school hours which are limited. There is a scope of work which is limited, right? So if there are 50 students in the class and you're teaching wholeheartedly with complete dedication, and everyone is able to understand things. However, there are two students who are not able to get those things because maybe they are very weak, maybe they don't pay attention, maybe they don't focus. Now, can this teacher actually stop them that no, you haven't understood, you stay back, and I'm going to stay here all day, all night, and I'm going to teach you everything? No, that cannot be done. So that teacher may say that, okay, spend some more time with these children, make them practice more at home, right? If needed, get the tuition done. So the teacher is recommending that there is need for further studies at home also, maybe because that is the case. Here also, the inspector appointed or the registrar, they have limited time. The scope of work was only that. Now, if there is a serious fraud which they can sense or identify, then they will recommend that there is need to examine this. There is further investigation required. So, in detail, get someone appointed or pay us for the same, right? And let this be examined in detail. Okay, so they'll recommend investigation. Fine. Okay, now during this inspection or during this inquiry, right, if they have reasonable grounds to believe that the books and papers which belong to the company or in which something about KMP can be found out, or director or auditor or CS, because they all might be somewhere involved in fraud. Now, when the inspector is carrying out an inspection, he identifies a particular fraud. Now, everyone is going to be like, oh, now they'll ask for this document. And if I give this document, my name will be revealed. Oh, I have done this fraud. Let me hide this document. So what they can do is secret. They can hide that document. They can destroy that document, simply tearing it, right? Mutilate, somehow destroying it, right? Alter, change it, falsify. So changing it, like making it something else, right? So if there are chances that this could be done, the registrar or inspector, they'll seek special court's permission. They'll straight away enter and search those places. Search is what? Search is you are examining any document, or you're searching for those documents, right? Whatever you find, if you find that this is relevant to the inquiry, this is relevant to the inspection, and this could be mutilated, you can even seize it, right? Take it into your custody. So seize books and papers, place identification marks on them, make copies before returning, because you have to return it within 180 days. Okay, fine. Now, investigation. So there are two types of investigation basically that we read in this particular chapter. One is investigation into affairs of the company, and second is investigation about membership. So when we talk about investigation of affairs, investigation can be done under section 210, under section 213. Now, report under section 208, there was inspection going on or there was inquiry going on. Based on that, the report was furnished to central government, and based on that report, CG thinks that no, I should carry out investigation. So CG may, it is at the discretion of CG, it may carry out investigation. There might be cases when the members of a company think that, oh my God, there is some fraud which is going on in our company, and we pass a special resolution, and then thereby we are requesting central government that please order investigation of this particular company. There is some fraud in the management that we suspect. So CG may order investigation. In public interest, in general, CG may think and order investigation. These are the three cases where in central government must order investigation. When NCLT asks CG to order investigation, CG cannot deny and say, no, I don't think investigation is needed. No. In that case, CG has to order investigation. They will appoint, how CG is going to do that? CG will appoint inspector. Now, to investigate into the affairs of the company, an inspector is going to prepare a report in the directed manner. Very simple. Now, we have seen in a lot of movies, web series, or maybe real life, I don't ever want you to see that, but people come across such instances, so you may have seen it in real life also, that there is some crime which has happened. Now, police is investigating the same, right? But there are some serious crimes which take place, and now government somehow feels and thinks that no, this is not something which this particular police authority can do, and hence this particular case may be transferred to CBI, because they are expert in investigating such serious matters. In the same manner, there is a fraud which may have taken place in a company, or we suspect a fraud. There is some bigger fraud that we are looking at, or there is something serious which can be prima facie identified. In that situation, CG thinks that no, I should not give this case to a normal inspector, rather, I should give it to serious fraud investigating authority. Office, basically SFIO, when I say serious fraud investigating office, but that's an authority, or that's which is being created by central government for investigating frauds of the company only. Okay, so it is an entity which has a director, which has employees, right, which has experts, and they are experts at actually investigating such matters. So they may appoint inspector or may assign the case to SFIU if necessary or if need be, right? Okay. So now, ma'am, these three cases, or actually, let's have a look at this way. Tribunal is ordering investigation. Why will tribunal order investigation? CG could order investigation on those three grounds. Why is NCLT ordering investigation? And when NCLT orders investigation, it is the duty of CG that you have to carry out that investigation, right? So if eligible members, who are the eligible members? If the company has share capital, 100 members, or members with 10% voting power. If there is no share capital, 1/5 of members, they become the eligible members. With proper reasons, proper documents, they can make an application to tribunal. And if tribunal is satisfied that, okay, the business is being carried on in a fraudulent manner, or you have created the company for some unlawful purpose only, for selling of drugs, whatever it is, right? Or your management and promoter, they are doing some fraud, or the members have been suppressed with information, they are not being given they have not been given full information, they always have incomplete information, the management is not maintaining that transparency, not disclosing information appropriately. So if tribunal is satisfied of these reasons, they'll give an opportunity of being heard to the company, and thereafter decide about investigation. Once they say that investigation has to be done, CG is bound to order investigation. Okay, so CG will appoint an inspector or hand over the case to SFIO, and thereafter they will report to CG. If there is fraud, there will be consequences and all that. Apart from this, there are two more cases. Any person can make an application to tribunal, and if tribunal is satisfied of these grounds, they can further go ahead, or tribunal suo motu can also order investigation. Okay, so investigation may be carried out by the inspector or SFIO. Ma'am, what is SFIO? Central government establishes SFIO, which is going to have a director not below rank of Joint Secretary of Government of India. There will be expert in all these fields. There will be one director. There can be experts as many as required, and employees again as many as required. They'll be appointed on such terms and conditions as prescribed. Right? Okay. When will they investigate? If there was a report under section 208 and central government is of the opinion that investigation by SFIU is necessary, they'll assign the investigation to SFIU. On receipt of SR by company in public interest, or on request from CG or SG department, right? Central government department, state government department, or central government, state government, if they request. See, a lot of times it may so happen that, okay, there is a case which has suspected fraud, CG appoints an inspector, but then central government comes and say that no, this particular case, assign it to SFIU. So if there is such request, it may be assigned. Once the case is assigned to SFIU, all the existing inquiries or investigation, whatever was going on, will be suspended, and they will transfer all the papers to SFIU. So if the case has been assigned to SFIU, ROC, they will not initiate any investigation, nothing. If they've already initiated something, they'll stop and transfer all the records to SFIU. Okay, how SFIU works? Now, SFIU has got a case. We have got a case, right? So the director, what they are going to do is, they are going to look for an appropriate investigating officer in their team. So director calls that officer, okay, this is the case that we are assigning to you, and you have to conduct the investigation in the manner which is prescribed. You will get all the assistance from the directors, officers, employees of the company. You will have wonderful powers as given in section 217, which are given to an inspector. So you'll have the same powers, right? What you have to do is you have to prepare a report, you have to investigate the matter, go inquire, you'll get all the assistance, you'll have all the powers. Then you have to prepare a report, interim report and final report. You'll submit it to central government, right? That is what is your role. Now, there is one more thing which is there in section 212, which is about arrest. Only here you'll see such thing, because there are very high chances that when we are investigating into the matter, we get to know a suspected fraud, or we get to know, or we investigate some very serious fraud, and that person might want to be arrested. So we have the entire process of that. However, if the report states about fraud, central government is going to direct SFIO that, okay, start the prosecution against this particular, initiate prosecution, rather, the court will do that. Initiate prosecution against that particular officer or the company, whatever it is, right? And this disgorgement I'll discuss later. Then we have another section called as section 216, where we talk about investigation of membership of a company. I told you there are two types of investigation that we read in this particular chapter. Investigation of membership, what does it mean? We have read in a chapter of management and administration, we have read about registered owner, we have read about beneficial owner. What is it? Like if I tell you, if you hear about the company Reliance, what comes to your mind? Ambani's. If you go hear about Tata Group, Ratan Tata, right? That's what you hear, and that's what you know, that okay, the control belongs to this particular person. But then there could be some companies where you hear the company, you look at the shareholding pattern, you see that okay, it belongs to this person, but however, it is being controlled by someone else. Someone else is financially interested in that company, someone else is the beneficial owner, and that has not been disclosed. But that we need to discover, we need to know. So if there is a complaint which is made by some person or central government suo motu, they may order investigation of membership. But if NCLT tells CG, then it shall order, it must order, right? When they are ordering investigation of membership, they'll tell that, okay, you have to examine these parameters. This is going to be your scope and time of investigation. So you have to discover that who is the beneficial owner, or who is controlling the company's policies, who are financially interested in that particular company. Ma'am, who will do this investigation? CG will appoint an inspector and they will report to central government. Okay. Then we have section 222. What is 222? Imposition on restriction upon securities. Now, when we are supposedly investigating into membership of a company, investigating into membership of a company means what? Supposedly we have company and we find out that 40% shares are in the name of Mr. X, but we find this particular person as to be just the registered owner. There is someone else who is the beneficial owner, and somehow he's controlling all the policies and all that. So we want to discover the truth about that 40% shares that he's holding in the company. Now, if these shares are continuously being transferred from one person to another, we might not be able to discover the truth, and hence we approached the tribunal that please impose certain restrictions on this particular shares or securities, that they should not be transferred for a span of 6 months till the time we discover this. So in connection with investigation under section 216, this one, or on complaint by made person, tribunal has reason to find facts, and it can't be found out unless restrictions are imposed. And in such situation, tribunal can impose restrictions for a period not exceeding 3 years. This could be an MCQ which is being asked, right? For how long the restrictions may be imposed. Next is section 219, power of inspector to investigate affairs of related companies. Now, when you are carrying out the investigation, it may so happen that everything is connected. Fraud usually happens when a lot of people are involved. Fraud cannot take place with just one person, right? One person can do good in a company, but to do bad in a company, you need to have a lot of stages of people who are involved, right? So it may so happen that we're investigating into affairs of this particular company, but we get to know that, okay, this much money has gone to the subsidiary, and we need to check the affairs of that particular company also, right? So if the inspector appointed considers it necessary that I need to investigate subsidiary holding or subsidiary of holding manager or employee or any body corporate which is being managed by our MD, or the body corporate whose board of director acts according to our director's direction, right? Whatever it is. So they'll take approval of CG and investigate into those affairs also, into those companies also. However, they're not investigating into that particular company standalone. So whatever connection they find, so the report should be like whatever results are relevant to you this investigation. Okay. Then we have some section called as freezing of assets. Freezing of assets simply means again to put restrictions on transfer of assets. If CG makes a reference, or there is a complaint in case of oppression, we read that, right? Or there's a complaint by creditors or any other person. Now, what they're complaining, they're saying to tribunal that there are very high chances that this company might sell off this particular asset, and if they sell off this particular asset, there will be no money left with the company, and there is already so much fraud that they have done which you're investigating, and likely there will be winding up of the company, so please stop this transfer. Okay, so if tribunal has reasonable grounds to believe that yes, if this asset is removed or transferred or disposed of, then it is not going to be in the best interest of the company. It will be harmful for company or maybe the creditors or somebody else. Then tribunal can order that removal, transfer, disposal shall not take place again for a maximum period of 3 years. Okay. Then we have seizure of documents. Just like we read about search and seizure before, in the same manner during investigation also, if the inspector or SFIU, they have reasonable grounds to believe that books be mutilated, altered, falsified, etc., then inspector can enter into that particular place. They can search and seize documents. Okay. Inspector's report. Inspector is going to submit his report interim and final authenticated by seal and certificate of public officer and submit it to central government. If anyone wants, if any interested person want to see what report has been submitted, they can obtain a copy from the court. Okay. So if I think so far the things are clear. Now, where we started with? There was inspection or there was inquiry. Based on that, maybe investigation was ordered. Investigation was ordered, inspector was appointed. He prepared an interim report and a final report, and he submitted the report to central government. Now, this report has certain fraud. If it has fraud, maybe there is a director who has done that fraud and he has got a benefit of 10 lakh rupees. So central government will make an application to tribunal to pass an order of disgorgement. Disgorgement means what? Whatever wrongful gain you have got, paying it back. That is what disgorgement actually means. So here there is a director who has got 10 lakh rupees, which is an undue gain, right? You have done some fraud and you have made a money of 10 lakh, you must pay that back. So that is order of disgorgement. Legally you have to pay that back, right? And holding him personally liable. So this can be done if there is a fraud which is being reported. Apart from that, whoever is responsible, there will be prosecution against those persons. There might be winding up of the company. Winding up, there will be petition of winding up on the ground, simple last ground, just and equitable, right? Application under section 241 or both, you'll read this later, you'll be able to understand this, right? Or recovery of what? Recovery of damages, of property, or indemnification. Ma'am, damages, see, whenever there is a fraud which has been done by the company, there could be a lot of cases that the company's property has suffered or it has been misapplied. You have misapplied the funds of the company at some place, so that has to be recovered. There are certain damages which the company has incurred, right, because of this particular fraud, or somebody else has incurred, so indemnification, everything. Now, We also have section 225 because we read section 224. So let me tell you and go through section 225 also, which is about cost of investigation. So who pays the cost of investigation? The entire investigation is being carried out. Prima facie, it is going to be paid by central government, right? But what if all the investigation cost is going to be borne by central government? It will be very difficult for government to run, right? So it is later on going to be reimbursed. Reimbursed by whom? Reimbursed by person who has been found guilty, convict, or against whom prosecution is initiated. Now, there could be a case where no prosecution is initiated. In that case, will it be borne by central government? The answer is no. It will then be borne by the company, body corporate, managing director, or manager, whoever has been dealt by the report, and the applicants of investigation, whoever made an application for the investigation. Okay. And there is something more, that whoever name is being brought out in the proceedings, that particular person will also contribute, right? So there are in detail more things about that. Now we have section 217, which talks about the procedure powers of inspector. Inspector shall have what powers? Inspector can call information from present, past employees, will get the assistance, can keep the books in custody for 180 days, can examine on oath, right? They will have the powers of a civil court. They can take local assistance of officers, police authorities with CG approval, right? Even during search and seizure. They can also get information from foreign states through letter of request. See, usually countries have reciprocal agreements that, okay, if there is some crime which is taking place over here and you need some information, I'll provide you, I need information, you provide, and likewise, right? So through letter of request you can have that also. And lastly, we have protection of employees covered under section 218. Protection to employees means what? See, when the investigation is being carried out, investigation of affairs or investigation of membership, whatever it is, right? There are the employees or officers who provide a lot of information. Now, if I'm providing information against the company will straight away come and say that, okay, you are dismissed. You don't deserve to be the employee of this particular company. Well, I'm just saying the truth. So, just to encourage that and to discourage such practices, what is being said is that when the proceedings are being carried out, you cannot suspend any employee. You cannot punish any employee. Punishing any employee means removing him or reducing his rank, that is demoting him, or it changed the terms of employment. That means maybe earlier his salary was 2 lakhs, now it is 1 lakh. You cannot change the terms to his disadvantage. This is what is the general rule. Now, there might be genuine cases where actually the employee is not working and we want to suspend him. In that case, if the proceedings are pending, it's been carried out, you take the approval of tribunal. If tribunal does not reply within 30 days, it is deemed approval. Okay, you can take action against the employee. And if you're not happy with the decision, then of course you can make an application or you can make an appeal to NCLAT, right? Okay. Okay, now we are going to revise the chapter compromises, arrangements, and amalgamation, right? This ideally is chapter number 15 of Companies Act 2013 and contains section number 230 to section number 240, right? Now, this is a chapter which can very well be related to the practical world, and that's why the ones who understand the concepts will enjoy this. The ones who don't understand will somehow hover around and they'll not know what it is going on, right? It's also related and can be connected to some takeover part and all. You can relate. I have already explained you the meaning of the terms. I've already explained you the difference between merger and amalgamation as far as law is concerned, not in terms of accounting. So we'll not get into those details. This is a revision class and we'll quickly revise into the exam oriented concepts. But because the chapter itself talks about compromises, arrangements, and amalgamations, it's important that we first understand these three terms in very brief. When I talk about compromise, it's some kind of sacrifice that you're doing. And when do we sacrifice? When we don't agree to the same thing. If we both want the same thing, then there is no compromise. It's a win-win situation. But if there is a dispute and we want to settle down that dispute, or if we have certain rights, if we have certain claims, and if I have to pay you 100 and you have to take 100 from me, I'm paying you 100, you're taking 100, there's no compromise. But if you want 100 and I'm unable to pay 100, and I am willing you take 90 for 100, and we settle down, that somehow compromise means. Now when we talk about arrangement is basically a broader term, and it involves, or it includes, reorganization of share capital. As we have read before, that there is a share of 100 rupees, we want to divide it into 10 each, or we want to consolidate 10 each share of 100, maybe something like that, right? When we talk about amalgamation is basically where two or more companies become one company, right? So there are two companies which are merged into one, or maybe one company which acquires the other one, right? So that is how amalgamation is being done. If you go by Companies Act, the term amalgamation is not defined in the Companies Act, but otherwise I've explained you this and you know it well, right? And what is concerned or required in law, that also you know. Okay, so compromise, and if we look at the practical angle, whenever the company is entering into any scheme of compromise or arrangement with its creditors or with its members, or any class of creditors or any class of members, whatever it be, there is a combination of a lot of things. There could be merger, there could be compromise, there could be arrangement, all of that. So when there is a scheme, it may involve different things, right? It's not just that, okay, this is compromise that we're entering into. No, practically that doesn't happen basically. Now we have section 230, which is the most exhaustive section in the entire chapter, because section 230 talks about compromises or arrangements. Section 232 talks about merger and amalgamation, but it again redirects you to section number 230. So ultimately section 230 is one such section which has a lot of content. Okay, so what happens over here? The members, creditors, liquidator, or company, anyone can make an application and form NCLT to NCLT, because to carry out compromise or arrangement, you need NCLT's permission. Likewise, for carrying out merger or amalgamation, again, you need NCLT's permission, apart from the permission of course, members, creditors. So you need their approval. You also need NCLT's approval, right? So how it happens, what is the process? NCLT is also concerned that, okay, the creditors, the members, they all should agree to the scheme, right? So tribunal also gives you a lot of directions. Now what happens? They make an application to NCLT. NCLT may accept the application or it may reject the application. The application has to be accompanied with a lot of things, right? Here are certain things which are written. There are certain more things which you have to know. Firstly, what is the financial position of the company? So the latest financial position, the latest auditor's report, and if there is any investigation going on against the company, so that also has to be reported. Now, if it is a scheme of compromise or arrangement, it may include reduction of share capital. If there is any, you have to tell that. It may also include debt restructuring. So if there is any debt restructuring which is taking place, what is debt restructuring? There is a company, it has taken a loan from the secured creditors of 10 lakh. Now it is unable to pay that. It is asking for a debt restructuring. Maybe repayment has to be changed, or whatever it is. Now, whenever you are entering into or whenever there is any debt restructuring scheme which is being proposed, it has to be consented by at least 75% of secured creditors in value. Okay, so if that is there, it has to be agreed to. Plus, how you are safeguarding the interest of other creditors. Auditor also has to give a report that, okay, if the company enters into the scheme of corporate debt restructuring, there won't be any effect on its going concern. That means whatever the liquidity parameters are, it will fulfill those liquidity parameters. It is not that it will not have any funds to pay, right? So all the liquidity test it will approve, right? Thereafter, if you're entering into corporate debt restructuring, you have to follow the guidelines of RBI. Okay, so all those things plus the copy of scheme, fees, affidavit, which is going to contain disclosure, everything is going to be accompanied and NCLT accepts it. Once NCLT accepts the application, NCLT will order the company that call a meeting of whom? Meeting of the creditors or class of creditors, members or class of members, and the debenture holders. Okay. How will you call their meeting? By sending them the notice. Okay. What will be written in the notice? In the notice, there will be clearly written that what are the details of the compromise and arrangement, the valuation report, I think I told you this. Okay, I did not tell you. Valuation report means all the assets, movable, immovable, tangible, intangible, whatever is there has to be valued by the registered valuer, and that valuation report will be right here. Effect of compromise and arrangement and other matters. Okay, effect of compromise on and arrangement on KMPs, because it is very important. If you're entering into any compromise or arrangement, there may be that the KMP will change. It is very important because right now the company was being run by a certain person, and now if KMP changes, it may have a deep impact. So what is going to be the effect on the creditors, KMP, promoters, and what is going to be the effect on interest of the directors or likewise, right? So all these things will be included in the notice. The notice will also be issued by advertisement. It will also be placed on website. It will also be sent to SEBI and stock exchange where the securities are listed, and it will also be sent to certain authorities like government, income tax authorities, RBI, SEBI, official liquidator, CCI, that is Competition Commission of India, other sectoral regulator, if any. They all, if they have any objection, they can make their representation within 30 days of receipt of notice. Okay. After that, they cannot object. So if income tax authorities have an objection, no, don't allow this company this particular compromise and arrangement for different reasons, they can always raise objections. Okay, fine. Now, what happens next? The notice is being sent, meeting is being held. Thereafter, there will be passing of resolution. Now, passing of resolution or consent, what is it? Again, there has to be a dual consent. Dual consent means majority in number plus 3/4 in value. So it is a kind of dual condition compliance to approve. Okay. Plus the certificate of auditor that whatever accounting treatment we are going to undertake, that will be in accordance with the accounting standards. Okay. So that has to be certified by the auditor. And thereafter, tribunal will sanction the scheme considering the objections. Whatever scheme is sanctioned, it's going to bind the company, creditors, members, liquidators, everyone. The order will be sent to the company, and company has to file the order within 30 days to ROC. Fine. Right? These individual notices which are being sent to the creditors, members, debenture holders also have certain additional things. What are certain additional things? All these we have already read from the section. There are certain additional things. What are certain additional things? Let me tell you. Firstly, what is the interest of KMP, directors, promoters in this compromise or arrangement? If there is no interest, then you have to file a statement that there is no interest. What is the detail of shareholding of directors KMP? Okay. Then the details that the documents like financial statements, copy of compromise and arrangement scheme, right? Contracts, agreements, whatever are dealt in this scheme, they are available for inspection or for taking copies. So the details of availability has to be given in the notice that yes, you can come and you can check and you can inspect these, right? Then declaration that this particular compromise and arrangement, it is in the best interest of employees, creditors, members, and everyone. Fine. So this has to be additionally there, and once it is approved, this is passed, there are certain additional orders of tribunal. What are the additional orders of tribunal? Tribunal has sanctioned the scheme. In addition to it, it can also say certain additional matters, like what? Like it can talk about variation of rights, that if your compromise or arrangement is varying the rights of a particular class of shareholders, you have read a section 48, which talks about variation of rights of shareholders. So this has to be in accordance to that section only. If there is buyback, then it is going to be in accordance to section number 68 only. If there are convertible preference shares to whom dividend has not been paid, there may be an option that okay, you can take your dividend in cash, or you can get your dividend converted into equity shares. Okay. Then we have reduction of capital, if any. I have already told you that, right? If there could also be a case of exit offer to dissenting shareholders, right? So all these matters, tribunal may provide some additional orders with regard to these. Okay. Now we move to the next section, section 231. What is section 231? It talks about the power of tribunal. Now, tribunal has sanctioned the scheme of compromise and arrangement. Now it has to be implemented. But during implementation, there could be a lot of problems faced by the company, right? So, tribunal is going to supervise the implementation. Time and again, they can give directions. If need be, they can modify also. And if tribunal thinks that okay, I'm trying hard to get this implemented, it is not going to be implemented, I made modification, then also it's not working out, the company is not able to pay the debt, so let's order winding up. So it can make an order for winding up also. Then we have section 232. Section 232 talks about merger and amalgamation of companies, right? Now, when tribunal received an application under section 230, they found that okay, we're talking about some kind of compromise and arrangement, but this also contains or it relates to merger, amalgamation, or reconstruction, right? So in such a situation, they will order the meeting of creditors, members, or any class, whatever it relates to. They may also give directions for meeting. Same provisions of section 230 are going to apply over here. That means sending of notice in the same manner to eligible person, advertisement, website, notice to authorities, approval, everything is going to be the same. Everything is going to be the same over here also. So same provisions, mutatis mutandis, are going to apply, right? So why, ma'am, this additional section? To circulate some additional documents. Okay, so tribunal will order that you have to give certain additional documents. What are the additional documents? First of all, draft scheme. So whatever scheme you have prepared, the draft of it, right? Secondly, there is going to be a report. Report basically by the directors, right? That what is going to be the effect of this compromise on shareholders, on KMPs, on promoters, and likewise. Valuation report, then financial statement or accounting statement. Basically, if the last financials relate to more than 6 months, okay, then you have to have a supplementary accounting statement, you can say. Fine. So all these are going to be the extra documents which will be attached, which will be circulated. And if everything is complied with, there is going to be a certificate of auditor, AS compliance, as we read in section 230. The tribunal is going to sanction the scheme, will send the order to company. Company within 30 days is going to file with the registrar. Okay. Now the order of tribunal could contain a lot of more things. Why? Because now this is involving merger and amalgamations. Of course, there will be a transferor company and a transferee company, right? So the property of the transferor company will now be transferred to transferee company. So order regarding the transfer, order regarding allotment of shares or debentures, whatever has been agreed to, right? There are certain legal proceedings against this particular company. Now they will be transferred or they will be continued against this company. So the order regarding to that, this particular company, all the assets, properties, liabilities have been transferred, so it has nothing left, right? So, but it has a name, so it has to be dissolved without winding up. So order regarding dissolution without winding up. Okay. Now allotment of shares, acha, I have already told you. The transfer of employees of transferor company to transferee company, right? And other incidental matters, whatever it is, the order may contain all these additional things. Okay, fine. Then we come to, okay, I did not tell you this. There is going to be an, till the time, supposedly the scheme has been sanctioned, but the whole process is still going on. So until completion of the scheme, every year there is going to be an annual statement which will be certified by CA, CS or CMA, which is going to be filed with registrar every year. Okay. It only indicates that, okay, the scheme, you are complying with the orders of tribunal. In implementation of the scheme, you're complying with the orders of tribunal. That is it, right? Next, we move to section 232, which is actually merger and amalgamation of certain types of companies, or I should say fast track merger. This does not involve seeking permission of NCLT and all that. It is a simplified process where you seek permission of your creditors, of your shareholders, and thereafter CG, central government. That's it. Okay. What is the simplified process and on whom it is applicable? So it is applicable for merger of two or more small companies. You know what a small company is. You have read it in section 2 clause 85, right? So two or more small companies, then a holding and its wholly owned subsidiary, या फिर other class of companies. Okay, what are other class of companies as prescribed? So holding two or more startup companies, or one startup and one small company, these are some prescribed, right? So what is the process, ma'am? If this is a fast track process, so what is the process that has to be carried out? There is transferor company and transferee company. They are going to send notice inviting objections to registrar and official liquidator. They can make objection within 30 days. Now, apart from that, they will file a declaration of solvency to registrar, and they will also call general meetings. So in respective general meetings, they will call their general meetings, they will accord approval, right? So they'll consider objections, they'll take approval by shareholders with 90% of shares, and approval by creditors, two-way approval, majority in number representing 90% value. So once they get the approval, within 7 days, they're going to file the scheme. This scheme is going to be filed now by the transferee company to central government registrar and official liquidator. Now the whole process starts. If there was no objection which was raised, central government will register the scheme. It will confirm to the companies the transferor company will be dissolved. Other effects shall take place. There will be a confirmation order which is going to be filed with ROC. But if objection was raised and central government forms the opinion that in public interest, I should not proceed, then within 60 days, they will transfer the entire case to tribunal. They'll send the application to tribunal that you consider this. Now, tribunal may immediately confirm this, and thereafter order of confirmation will be filed with ROC, or they may consider the scheme under section 232 and they can pass orders accordingly. Okay. I hope this is clear. Fine. So, right. Then we have section 234. What is section 234? Company is merged into a foreign company is being merged into an Indian company. Now, in this case, we have read about the provisions of merger. What additional thing is that you need to have RBI's approval plus the consideration. It can be paid three ways: in cash, in depository receipts, or a mix of both. Then we have section number 235. 235 talks about dissenting shareholders and acquisition of their shares. What is it, ma'am? There is a transferee company which gave an offer to transferor company. Within 4 months, they will accept or they will reject. So far, I don't think there is any problem, right? There's a merger which is going to take place. The transferee company has given an offer to shareholders of transferor company to become their shareholders, right? They can accept, they can reject. If 9/10 value shareholders approve it, 9/10 value shareholders approve it, well, that is the approval that is needed, right? So if they approve it, there are some dissenting shareholders who disagree. Now, in such a situation, the transferee company will send a notice within 2 months to such dissenting shareholders. They do not have a choice but to surrender or to fight back. How do they fight? Such dissenting shareholders within 1 month they can apply to tribunal. If the appeal is in their favor, then fine. But if the appeal is dismissed or if they don't even appeal to tribunal, in such a case, transferee company will send a notice and transfer deed and consideration to the transferor company, because they are right now the shareholders of transferor company only. So they will register the transfer deed, right? So all the shares will now be in the name of transferee company. It has paid the consideration, registration of transferee as a holder. Within 1 month, they will inform the dissenting shareholders that, okay, your shares have been transferred to this transferee company, even though you did not agree, but this has to be done according to law. Please don't think that here the dissenting shareholders, it is very wrong for the dissenting shareholders and there should be some provision, they are being oppressed and like that. I have explained you the logic why law has been made like that in the regular class, right? Within 1 month, they'll inform the dissenting shareholders, deposit consideration in separate bank account, and within 60 days, it will be paid to the dissenting shareholders. So they are sorted. Okay. Now, purchase of minority shareholding, section 236. Now this basically you will have immense understanding when you read the SEBI regulations takeover code, because there you will actually know what an acquirer is, what a person acting in concert is, right? So there are a lot of concepts that you have to understand. But right now if we look at it, person have become holder of more than or equal to 90% of equity shareholder. So now maybe they are holding 92% shares in a company and the remaining 8% are with some minority persons, right? So they're making an offer at a predetermined price which is fixed by the registered valuer to those minority shareholders, which is very justified, which is very much you'll understand of course later. So they may offer to sell their shares. They're making just an offer. They may offer to sell their shares. If they offer to sell their shares, then the deposit is going to be in separate bank account. They will disperse it within 60 days. However, if there is some person who is holding more than equal to 75% of that minority shareholding, supposedly that minority shareholding is 1 lakh. So if somebody is holding 75,000 or more, he can even negotiate and reach an understanding for a higher price, right? Okay. Then we have section number 237, which we talk about amalgamation by central government in public interest. So at times, central government is satisfied that, okay, these two companies should actually amalgamate. So they will pass an order in official gazette for their amalgamation, right? But how it will happen? First of all, they'll draft an order of amalgamation and they will send it to the companies involved. Now, these two companies, the company creditor member, they may object within 2 months, right? If they feel that, okay, I'm going to get lesser rights in the transferee company, they may also be given some additional compensation, right? If you're aggrieved, you may make an appeal to tribunal within 30 days for increasing your compensation or whatever it be, right? Central government is going to consider the objections or suggestions, whatever is being made. They may also make certain modifications, and thereafter there will be final order which is going to be notified in official gazette and also laid in both houses of parliament, right? Okay.
Okay, now the revision of prevention of oppression and mismanagement. We have very few sections read with rules and some case laws in this particular chapter. This chapter comprises of not many sections, starting from section number 241 till section number 246. If we look at the chapter overview, if oppression and mismanagement is taking place in any company and if you're being oppressed in the capacity as a member, that is a continuous act of oppression that you're suffering from, then if you happen to be the eligible member, then you can make an application to tribunal for seeking relief from that oppression or mismanagement. This chapter intends to provide the preventive remedy and not the exact cure after an oppression has taken place. So oppression and mismanagement, these are the two terms which are not defined in the act, defined in this whole chapter. However, when we look at section number 241, we are being given two cases when an application may be made. So if you satisfy the criteria, if you fall into those cases and you meet the eligibility requirement, then you can make an application. So when we start with the chapter, we start with understanding the meaning of the two terms. There are two perspectives. One is the general meaning that we understand of the two terms, and second is the given intended meaning, the given intended precise meaning in the section which we have to present in our answers, right? So first thing, the very first thing, the chapter begins with a rule, that is majority rule, Foss versus Harbottle, which states that all the decisions will be taken by majority, which is fair enough. Because if we remove this particular rule, we will not have any proper procedure to take decisions in a company, in our lives, in anywhere, right? So obviously, if the decisions are to be taken by board of directors or the members, they are going to be taken by majority of people, which is the majority rule, which is nothing wrong at all. And the courts will not intervene in this internal management as long as the decisions are being taken in the manner they ought to be. However, this chapter says something as an exception to this Foss versus Harbottle majority rule, and it states that sometimes the decisions being taken by this majority could be oppressive, could be creating some atrocities to the minority group, to some group of members, to one member, two member, four member, five member. And in such a situation, courts will intervene. How the courts will intervene? NCLT gets the power under this chapter to entertain such applications and complaints, right? This is the slight background that I have given to you. Since just a revision class, we're not going to get into very much in-depth meaning of each and every term. Once again, if we come back to the chapter overview, someone is entitled to make an application under section 241. Who is entitled? The members' eligibility criteria or requirement is given under section 244. So before reading section 241, you need to have that understanding of section 244 and remember who is eligible to make an application. So someone who is eligible to make an application, if the circumstances prevail which are given in section 241. What are the circumstances? There are two cases which are given. One case is termed as oppression and one as mismanagement. Although section does not define the terms, section only states the circumstances we believe it to be the case of oppression or mismanagement, right? So if the members are eligible, they can make an application. If there are the circumstances prevalent, they can make an application to tribunal under section 241. Tribunal passes certain orders under section 242, and out of those orders, a few orders have certain consequences also, some after effects. That is given in section 243, and we have a separate segment, class action suits given under section 245 and 246 is absolutely nothing, right? You're not being asked any question. It is nothing. It's just about the applicability of some part. So that we are not concerned with. We start with the revision of first section 241, but before that, let's have a look at who is eligible to make an application. There might be a company with share capital, there might be a company without share capital. If it is a company without share capital, we don't have any share capital, we just have the number of members. So we can straight away say 1/5 of the total number of members. So if the company is without share capital, 1/5 of the total number of members. But if the company is with share capital, then ideally we have three things. And we can say lowest of all these three, or we can have a division that number wise also criteria could be met, or the value wise criteria could also be met. A company is having share capital. Who are the members who are eligible to make an application? Lowest of either 100 members or 1/10 of the total number of members, or the members who are holding at least 1/10 of the issued share capital. Here it means preference plus equity both. Point number one. Secondly, it's not paid up capital, it's issued capital. So you have to keep this thing in mind. So if you meet any of these three criteria, you become eligible to make an application. However, what is important is that you must have paid all the calls and sums due to the company. If you yourself have failed to pay the calls of the company, then your eligibility requirement also fails, and in that case you are not an eligible applicant. Moreover, sometimes it may so happen that although you fail to meet the eligibility requirement, yet your case is severe and your application is genuine, and you must make an application for seeking relief. In such a situation, tribunal can waive the requirements. Tribunal can say, fine, even if you're not 1/10 of members, you can still make an application. Even if you don't hold 1/10 of issued share capital, you still make an application and we will admit your petition. Right? So this is something which is possible. NCLT may permit the lesser number of members. That is something which is something that I have told you. Now, although these points are established through a lot of case laws as well, but two things I am telling you over here. One, I hold 100 shares and so I am eligible. After making an application, I sell my 50 shares. So my shareholding gets reduced. Later on, after making an application, will my application be still valid? The answer is yes. So I am supposed to hold the requisite number of shares only at the time of filing application and not thereafter. Secondly, I have given my consent, but subsequently I have withdrawn my consent. Will my application be still valid? The answer is yes. Right? So both these requirements, that is the shareholding as well as the consent, is needed only at the time of filing of application and not thereafter. Not thereafter. Thereafter, if it is subsequently reduced or withdrawn, it doesn't really matter. So one thing is clear, who is eligible to make an application? So we check whether the company is with share capital, without share capital, where do you fall, and do you meet the criteria as given or not. If you meet the criteria, then you may complain. If oppression takes place or if mismanagement takes place, are likely to take place, right? Because it is a preventive remedy. So one, if the affairs of the company are being conducted, have been conducted or are being conducted prejudicial to public interest. What do you mean by prejudicial? Prejudicial is harmful. So if it is harmful for public, it is harmful or oppressive to the members, it is harmful to the interest of the company. So if any of these things exist and you are eligible member, then you may complain. You may complain. You may complain. Secondly, there is some change in the management, or even without the change also this takes place. However, what is being given in the section, if there is change in the management and now it is expected that whatever actions they are going to do, it will prejudice us. Why change in the management is written over here? Because if there is no change, then affairs are being conducted in a harmful manner. So if there is no change, this point covers it all. But if recently some board of directors have changed, or maybe the two companies have come together, or maybe some shares have been acquired by a particular group, so that ownership in shares have been changed, so now whatever resolution will be passed, they will have the majority and they will be taking the decisions. So if there is some change, if there is no change, either the affairs will be running good or not good. Not good, you can use this ground and you can complain. If there is change in management, then you come to this particular point, right? So there is change in the management, you are expecting that it will be harmful to members, so you have proper circumstances and evidence which suggests the same, then you may also complain. And CG in public interest can also complain. So you can make an application to tribunal. And if tribunal is satisfied that yes, the allegation, the application is genuine and the above affairs exist, above state of affairs exist, and and the company is in such a condition that the company must be wound up. But if we go on to wind up the company, it will not be fair for the members who have made the application. Right? Something wrong has happened to me, and you're closing down the company. It doesn't rectify what wrong has happened to me. Right? So in such a situation, tribunal, instead of resorting to winding up, takes some other actions. What are the other actions? This part is given in section 242. So these are the orders of tribunal, what orders may be passed. Although tribunal can pass any order as they deem fit. However, there is some list of orders which are given which may be passed, right? So what orders can be passed? The tribunal can say that we are going to regulate the affairs. Fair enough. The tribunal could say regarding the purchase of shares by some group or by the company. The tribunal can instruct the company that, okay, fine, you buy the shares of these people at a fair price. And since you're buying back the shares, it should result in, or it should comply with all the provisions of reduction of share capital. Right? Sometimes it may so happen that some transfer of shares is constantly taking place which is not in the best interest of the company, and all the shares are being rerouted to a group of shareholders who are misusing their powers or something like that. So tribunal can restrict that transfer. Some further shares are being issued, and if these shares are issued to a particular group of people, they will become majority from minority. Tribunal can stop that allotment. Now, tribunal can terminate, set aside, modify the agreement between directors and company, or between company and some third party. If tribunal does this, it has consequences of 243. Only in this point. Only in this point we have consequences. For all other points, we don't have consequences. What do you mean by that, ma'am? Company has hired, or company has appointed Mr. X as the managing director for 5 years, but tribunal terminated their contract and said that you have to leave the company. Right? In such a situation, two consequences follow which are given in section 243. One, although if a managing director is removed before expiry of his term and he fulfills the conditions given in section 202, he is entitled to compensation. However, if he is removed under section 242 by tribunal, he will not be entitled to compensation. Moreover, because tribunal has found him guilty and that's why has removed him, so he will be disqualified for 5 years. If he wants to be appointed as a director before 5 years, then he has to go to tribunal, seek its permission, and then it can be appointed. Okay. Likewise, although third party and company, tribunal doesn't have the right to terminate a contract of third party and company, right? But still, here tribunal gets that power. Tribunal will discuss with the third party, will take permission from the third party, and then terminate, set aside, or modify the agreement with the third party. However, even in that situation, the third party also shall not be entitled to any compensation. So no matter if tribunal has terminated or set aside or modified the contract, then absolutely no compensation, and the concerned directors will be disqualified for 5 years of appointment until they seek the permission from tribunal. Next, setting aside a fraudulent preference. For this, you need to recall and understand what do you mean by fraudulent preference. Giving someone preference for a fraudulent motive or intention. That is fraudulent preference. Like what, ma'am? I have 10 creditors, and if I have to genuinely make payment of these 10 creditors, I will pay the creditor who has been waiting for the longest, right? But instead of making that particular payment, I paid to some creditor who I know is a good friend of mine. So this is giving fraudulent preference to that creditor just because I know that the company is running out of funds, and if I start in that sequence, my friend will not get money. But that's how it should happen. That's a fair play, right? But instead of going for that fair play, here we are involving some fraudulent motive and doing this. Tribunal has the power that in the past, if these type of transactions have taken place, they can set aside this transaction. Tribunal can remove MD, manager, director, appoint them who is going to report to NCLT. They can give instructions about the cost of this and recovery and other matters as they deem fit. So these are the orders which may be passed by tribunal. An application may be given by the eligible members to tribunal. Tribunal on receipt of application is satisfied that yes, it exists and winding up would be unfair. Then tribunal passes certain orders. Whatever order is passed, that has to be furnished to ROC within 30 days. Within 30 days. Okay. Now, we have another point over here on which we have not done a lot of questions because these are some recent amended sections which have been incorporated and a new thing which has been incorporated. But then this is important. Okay, so there is something more. What is it? Application to tribunal for relief in case of oppression, etc. And powers of tribunal and section 243. Ma'am, we have read section 241, we have read section 242, we have read even section 243. Then what is it? It is a combination of all three of them. It is an absolutely different topic, but it is not given in one section. Some part of it is given in section 241, some in 242, and some in 243. Okay, so let's begin from the very first part. See, if central government, on the basis of some circumstances, has a belief that there is a director in the company who is not fit enough to be the director. Fit enough means he is constantly negligent in his duties, he's not performing his duties well, or maybe he's constantly indulged in fraud, right? Some people are there who do mistakes, but some people are there who have a habit of doing mistakes, right? So if central government comes across any such person who is guilty of fraud or breach, or has not done the business according to the principles, or has been doing the business with the intent to defraud or cause injury, then CG wants to know, is he fit enough? CG wants to know, is he fit enough? So CG initiates a case and makes an application to tribunal. Now, tribunal should also have the confidence that do I really need to inquire about this person? So for that, CG gives a concise statement that why CG believes that yes, some inquiry should take place for this person. I don't find this person to be fit and proper. I don't find him to be fit enough to be the director, right? So central government gives the application to tribunal to inquire and record whether or not such person is fit and proper to hold office. Under section 242, tribunal records its decision. So tribunal will hear the case, will call him, will look for evidences and all that, and finally come to a conclusion that yes, he is fit or no, he is not fit, right? So whatever conclusion he comes across, he records that decision under section 242. And if he is fit, great enough. If he is not fit, then such person shall not hold office for 5 years from the said decision without the leave of tribunal. So if he wants to be appointed, he can take permission of tribunal, and such person shall not be entitled to compensation. Just the same thing that we have read before also. I have made another chart for you all in the same capacity so that you understand the whole for the same topic, so that you understand the whole concept well once again. Central government, if these circumstances suggest fraud, negligence, or default, not sound business principles, or serious injury to trade or industry, or intent to defraud, then it can make an application to NCLT to inquire along with concise statement. This part is given in section number 241. After hearing, NCLT shall pass order. This is given in section 242(4)(a). If he is fit, no further action needed. If he is not fit, then these three parts are given over here. Such person shall be removed, disqualified for 5 years in any company. If tribunal terminates or sets aside some agreement with the director, he is disqualified to be appointed for 5 years only in that company. But if tribunal finds that a person is not fit enough, then he is disqualified for 5 years to hold office in any company. That's the difference. And also entitled to compensation for that loss, right? So you get double clarity this way, right? So I think this is clear. Okay, now we probably have this last section that we need to discuss. Class action. Class action is a benefit which has been given, and this benefit is not just for the members but also for the depositors. I have made you a proper differentiate between section 241, section 245, that there are also some members are coming together and making an application. Here also members are coming together and making an application. So what is the difference? All that difference I've already told you. Right now we'll focus just on revising our concepts, right? So members can also go for class action, and depositors can also go for class action. If members, we are talking about members, the company may be with share capital, without share capital. If it is with share capital, the lowest of 100 members, 5% of number of members, or if it is a listed company, members holding 2% of share capital. If it is unlisted company, members holding 5% of share capital. Fine. If the company is without share capital, 1/5 of the number of members. You have to learn it. If you don't learn it, no, you will think and try to uh, focus that what is ma'am trying to tell us. I'm unable to gain this, I'm unable to retain this. So you will face a lot of problems if you don't learn. Wherever in law there is a limit, my dear, you have no choice but to learn, right? Other than these numbers and limits, all that concept building helps you to retain the concepts throughout, but this learning part has to happen. Okay. And if it is depositors, exactly the same thing. 100 depositors, 5% of depositors in terms of number, or the depositors who owes 5% of total deposits. So this is in terms of value and this is in terms of number. Fine. Now, if you are eligible, you can make an application. On what ground? That management of affairs are being conducted in a prejudicial manner. Tribunal will consider the factors. Tribunal might admit your application or it might reject the application, right? You are making an application to seek these specified remedies which may be granted to you. There is an option at the end, other remedy as well, which is a leftover option. Now, before this, what is the procedure of class action? In the procedure of class action, once tribunal receives an application, tribunal gives a public notice. Public notice as in, we have received a class action application. Now, all the members are being given a public notice. There might be some members who want to opt out from this, they can. But if they don't want to opt out, they are deemed to be a part of this class action application, right? Maybe there might be a situation that two class applications have been filed in the same regard, so they will be clubbed into one and one lead applicant will be selected. Now, it is the choice of the applicants only to select one lead applicant. However, if there is a conflict between these applicants, then tribunal can take a call and tribunal can decide about the lead applicant, which is going to be binding on everyone. Fine. So, what orders or what types of remedies can be obtained under this section? The company can be stopped from doing an ultra vires act, from committing some breach, and some resolution can be declared as void. A resolution for altering a particular regulation of articles of association was passed, but there was some problem which we have discussed in classes, so that can be rendered as void by the tribunal. Restraining company to act on above resolution. Since the above resolution has been rendered to be void, then obviously you will not even act on that resolution. If that resolution was valid, you will take its actions. But if it is not valid, then you will stop yourself. You will not go ahead. Right? Is stopping the company to act in contrary to the provisions. You can claim damages from the director, auditor, expert, others, and any other remedy which may be granted, right? So these are the different types of reliefs or remedies which may be given under a class action suit. Fine, so that was super quick revision of the chapter of prevention of oppression and mismanagement.
Hello everyone. This class is all about revision of IBC 2016. It's going to be in as fast manner as possible, of course, without compromising on the concept, so that you actually find it an effective revision. Without wasting any more time, let me begin with the revision. I have my handwritten charts of this chapter with me. If you want the same, they are available, of course, free of cost for all of you. Just to ease in your preparation, how can you get them? That you will find in the description, right? Okay, so let's start with the chapter. Insolvency and Bankruptcy Code 2016. First of all, it involves two terms, that is insolvency and bankruptcy. What do we mean by these two terms and why at all code is used? See, it has a wide application and it includes a lot of content, a lot of acts were repealed, a lot of acts were amended. Okay, and after that, this particular one unified law has been made with respect to insolvency and bankruptcy. Okay, so that's why the use of code instead of acts, as it involves a lot of aspects in one unified law. Now, what do we mean by these two terms, insolvency and bankruptcy? Right, because it is a code about the two terms involved over here. So, to understand that, insolvency is a state. Okay, insolvency is a state. We all know, we have been as commerce students preparing balance sheet for years, right? And every time we prepare balance sheet, we know that we have certain set of assets and certain set of liabilities. That is for any entity that we are making the financials of, as in a normal common parlance, that for each one of us, like if I talk about me as a person, I might have certain assets and I also might have certain liabilities. Say for example, I have a house and I have a bank loan. Okay, so supposedly I bought a house at 2 crore rupees and my loan is somewhere around 1 crore rupees. Now slowly what happened, that the house price, maybe for certain reasons, it declined and came up to 50 lakh. I have no bank balance and I have to repay a loan of 1 crore still. That means my assets can realize only 50 lakh, whereas I have to pay an amount of 1 crore to the bank. So my liabilities exceed my assets. So this is a state, this is a position where I am in right now. I am in a position where my liabilities are more, whereas my assets are less, right? So this is called as a state of insolvency. This may be for a company, for a non-company, for a partnership firm, for an individual, for any
entity, any person, right? So this is applicable in everyone. Now, I know this particular state of mind. Nobody else knows it. Supposedly, I defaulted in the repayment of my loan to bank. I had to make the payment of an EMI and I did not pay that. Now the bank knows that there is some issue why Shivangi is not paying our installments in time. So now the bank gets concerned and bank comes up to me. We have discussions like things. Now instead of constant repetition, reminders, I am still not being able to repay bank loan because I don't have money, right? So what bank can do now? What can bank do now? What can bank do now? Now bank can initiate some proceeding against me. So bank can go to some person and bank can say that Shivangi is not in a very well state. She is in a state of insolvency. What we should do is we should bring her out of this insolvency. How? Maybe there is some way, maybe her business is not going so well, so we can provide her ways, we can talk to her creditors, like to provide some credit, etc., and we can bring her out of that insolvency state so that she comes back in the normal position and repay my loan. And what if she cannot come out of that insolvency state? Then we should sell her house, whatever assets are available with her, and whatever loan amount can be repaid, I want my money back because I cannot take further risk. So bank wants someone to listen to this situation. Earlier also there were rules, there were authorities, there were laws, but not so uniform and not so well defined. IBC has made this process absolutely clear and utmost ease has been provided in this regard. So one by one we will try to understand that. Okay, so insolvency is a state, is a position, and now what happens is the person goes to some authority, the person tries to resolve my insolvency. If it cannot be resolved, then the court will declare me as bankrupt and all my assets will be sold and my liabilities will be paid off because I am an individual. I am an individual. Right? I have a chart over here which is going to help us realize. Please mark my words and keep this in mind. This is just a revision lecture, so I'm not going to explain you every step by step. This is just an introduction. I'm trying to give you the brief idea, not of course in the most in-depth manner that I take up in the classes. Okay, so this is just a revision class and you are only going to get an overview of the same. So insolvency, my dear, is a state where your assets are lesser than your liabilities. If you go ahead and treat the state of insolvency, that means you can resolve this insolvency, nothing better than that. And this particular code endeavors to do that only. Liquidation is a very trivial or a very small part of this particular code because its emphasis is to revive the person from the state of insolvency. Okay, so insolvency, if it is treated, nothing better than that. If it is untreated, then if you leave it like that or it cannot be treated for some reason, then it may lead to bankruptcy for non-corporates that I spoke to you about and for liquidation for corporates. Now, what do we mean by liquidation? Insolvency is a separate term, bankruptcy is a separate term, and what do you mean by liquidation? These three terms are separate, different terms. Liquidation is nothing but the process of winding up. And what is winding up? See, winding up, liquidation, dissolution, again, so many terms. So, dissolution and liquidation are different terms. Liquidation means winding up. And what is winding up? Winding up means sale of assets to pay off liabilities. Only that particular process is. Now, when you want to remove the existence of the company, say company was incorporated, then there is a register of companies in which the name of company is mentioned. That means company has a separate legal entity, company has its own existence. We dissolve this existence pursuant to liquidation. Clear? I hope you have got this basic idea. Now listen to me very carefully. Listen to me very carefully. Let's take an example. Let's take an example before I make you understand anything else. There is a company. A company means a corporate. Of course, I hope you all know what is corporate and what is non-corporate, right? So corporate, LLP, company, they all will come under corporates only. So there is a company that is a corporate. The company has taken a loan from a bank. The company has taken a loan from a bank. Now supposedly the company defaults in payment, in repayment of this loan. Company defaults in repayment of this loan. This bank will realize that there is something wrong, so bank can move an application to the appropriate authority, and appropriate authority will initiate the insolvency resolution process. That means they will try to resolve the state of insolvency of the company. If that cannot be done, then the relevant authority will pass the order of liquidation. That means they will say that sell off all the assets of the company and pay off its liabilities. So wind up this company. The company cannot no more function, cannot function anymore. Wind up this company and dissolve its name. You get my point? You get my point? So first endeavor is to resolve the state of insolvency. If that cannot be done, then liquidation happens. We have two set of people in this particular code. One is corporates and other is individuals, partnership firms and like, right? So we have to read about corporates only. So we will read corporate insolvency resolution process. Corporate insolvency resolution process, for which we need to know three basic terms: corporate debtor, financial creditor and operational creditor. Company or LLP, whatever the case may be, this is a corporate and it's a corporate debtor because it has taken some money. If it has taken a loan from a bank, that means bank has helped in its finances. The bank has helped the company in its finances. So of course it is a financial creditor. If a person has supplied goods to the company and the company is unable to make payment for that, company has taken some goods on credit, the company is unable to make payment for that, the person has helped in the company's operations. It is an operational credit. If the company is unable to pay the salary of employees are operational creditor or financial creditor. They will be considered as operational creditor. Why? Because they have helped in the operations of the company. Okay. If supposedly company has taken loan from some employee, now that employee has helped in the finances of the company, so that employee in that particular capacity will be treated as financial. You get my point, right? You should know all these. We are just revising. So these are basic parties that you must have an idea of. Okay. Now if we talk about this particular code, it has repealed 2 acts and amended many laws. It came into force on 28 May 2016. If you talk about it, was introduced in December 2015 in Lok Sabha. Then of course in May 2016 in Rajya Sabha. It was first passed in Lok Sabha, then passed in Rajya Sabha. It got assent on 28 May 2016 and was notified on the same day. Now, under this particular code, we have an authority. Or you can say we have a board, which is Insolvency and Bankruptcy Board of India. It is IBBI. which is commonly known as board. So throughout the act, wherever board is written, it does not mean your board of directors of a company. It means IBBI. Clear? Now, this IBBI, who has established IBBI? Central government has established IBBI to oversee the whole proceedings under IBC. So it is the authority which is governing everything under IBC. Okay, that means, ma'am, if supposedly a company has taken loan from a bank and the company is unable to repay the loan, the bank is going to move to IBBI and make an application? No, my dear. Under IBBI also we have authorities. We have read about National Company Law Tribunal under Companies Act, NCLT. That is going to be the adjudicating authority for the corporates under IBC. For the corporates under IBC, that is relevant for you. That is something that you must know. IBBI, of course, is a board which is going to oversee whole thing. Its head office is at New Delhi. But that is not the adjudicating authority. That is the supreme authority, you can say. Okay. So adjudicating authority is NCLT. So I might say NCLT, I might say adjudicating authority. Whatever I'm saying, they both mean the same for corporates under IBC. Okay. Now, this particular code is divided into 5 parts. It has 12 schedules and of course, all the chapters are divided, all the parts are divided into different sections. What is relevant for us? Listen to me very carefully. Part 2. Part 2 is for corporates. So part 2 talks about treating the insolvency state of corporates, and if it cannot be treated, then going for liquidation. That is what is covered under part 2 of the code. Okay, so part 2 has its own definitions also. It has the whole process. CIRP stands for Corporate Insolvency Resolution Process. Liquidation, fast track CIRP, voluntary liquidation. That means there is no one who has made an application. The corporate debtor himself wants to liquidate on certain grounds, so they can go for voluntary liquidation. Then about adjudicating authority, offences and penalties. So all this is covered under part 2. All this is covered under part 2. Clear? Part 1 is preliminary, which tells us about the title, application and certain definition. Now the definitions which are given under part 2 apply to the whole IBC, but the definitions which are given under part 2 will apply to only part 2. This is very obvious. I hope you all know that, right? Okay, so these are the basic structure, you can say. One important thing, the provisions for insolvency and liquidation of corporate debtors shall apply only when the minimum amount of default is 1 lakh. The government can go up and prescribe this amount up to 1 crore, and the government has actually prescribed the amount to 1 crore. So supposedly company has taken a loan of 20 lakh rupees and company has not repaid that loan. Can bank go and make an application under this code for recovery of money? No. The minimum default amount has to be 1 crore. The minimum default amount has to be 1 crore only then. Otherwise, IBC will be flooded with applications, right? And it will be very difficult for them to manage the same, right? So, the amount, earlier it was 1 lakh only. So, 1 lakh, what the authorities realized that they have a lot of applications flowing. So it became difficult for them to manage. So now the amount has been increased to 1 crore. Yeah. Now, let's talk about the whole overview of CIRP. A basic structure, idea we'll get, and then we will start one by one. So basic thing is commitment of default, and that too minimum amount default has to be 1 crore. If there is existence of default, then application may be filed with adjudicating authority. Who is the adjudicating authority? NCLT for corporates. So either our financial creditor can go and file the application, or the operational creditor can go and file the application, or the company itself, that is the corporate debtor itself, can go and file the application. So any of them can file an application with adjudicating authority that we want to resolve the state of insolvency. See, we cannot directly go for liquidation, because attempt will be not to suppress the business houses. The attempt will be to revive the business houses. If at all they cannot be revived, then to liquidate them, right? So existence of default, at least compliance with the minimum amount of default, and application with adjudicating authority. Now what happens? There has to be someone who is going to undertake the whole process of revival, who is going to try and resolve the state of insolvency. That person is selected from a panel of professionals who are qualified and registered, of course. So one such person will be selected from the list of insolvency professionals. Insolvency professionals, out of that, one person will be selected, and that person, if he gives his consent, just like we appoint auditors, we have so many members, so many chartered accountants who are in practice, who are eligible to carry out the audit. So we select one CA in practice. If he gives his consent that, okay, I'm ready to do your take up your audit work or assignment, so we appoint that person as an auditor. Likewise, the same is going to happen here also. Okay, who does it, who doesn't, I'm going to tell you everything. So in the same manner, out of that list of persons who are eligible, who are qualified, who are registered, that list of IPs, from that one person will be selected. He will be appointed as interim resolution professional for the time being, not the final one, but for the time being. Then what happens is a committee of creditors is formed. A committee of creditors, because if I'm talking about resolving the state of insolvency of a company, who are the persons I have to take care of? Of course, the creditor, because company has to make payment to the creditors. Supposedly there is a bank who has to take 2 crore from this company, and I, as some resolution professional, I am a professional who is going to resolve everything. I come and I say that, bank, I am going to pay you 50 paise in a rupee. The bank might get upset. The bank might not be happy with the decision. So do you think bank should have a say in the decisions that I make? Because it is the ultimate, who is the ultimate beneficiary? It is the creditors. So creditors must be involved in this decision making about how you are going to treat the insolvency of a company, right? So for that matter, a committee of creditors is being formed, and they appoint the final resolution professional. After that, who prepares information memorandum, then they invite plans from prospective resolution applicant, that how the state of insolvency can be resolved. The plan is submitted to committee of creditors. Do you agree? Do you disagree? If you agree, then we will submit the same plan to adjudicating authority, and if adjudicating authority also agrees, then we will implement the plan and we will resolve the state of insolvency. If you don't agree, then we don't have a choice. Or if you agree and we submit the plan to adjudicating authority and adjudicating authority doesn't exist, we don't have a choice. So in that situation, we will go for liquidation of the company, because ultimately, if anyone has made an application under this IBC code, he must get some resolution. He must get some relief. That is important, right? So these are some short forms that have been used in the charts, and they might help you. Okay.
So now we begin with the actual thing, why this particular code has been, or why this particular framework has been made, is to handle the conflicts between the creditors and the debtors in a more efficient manner, because earlier also you had disputes, there were court cases, one company has millions of court cases running, not millions, it's too high, hundreds of court cases maybe, against them. Now it becomes difficult for the judicial systems to handle as well as for the company to handle. So here what happens is, somebody has initiated CIRP, it's going to serve all the creditors. So it becomes better for them, right? It prevents a lot of business failure, because ultimately if this situation is not resolved, the company will run into liquidation. So if attempt can be made to resolve and revive the business, nothing better than that, right? So of course the code helps in a lot of manner, and wherever an enterprise defaults, the control of the enterprise is not going to stay with them. It is going to shift to basically the committee of creditors, who assess all the proposals and everything, and try to revive the enterprise. If it cannot be revived, they are going to take it for liquidation. Okay, so my dear, we begin with our code. It is applicable to all the entities, that is the company which is registered under Companies Act, LLP, then any other body corporate, even the guarantors to the corporate debtors, right? Partnership firms, proprietorship firms, individuals also I spoke about, right? But we have to read about the corporates, which is given under part 2. We have some important definitions which I'm not going to discuss in this revision class, but I have told you the basic meaning of the terms as and when needed. I have already told you about the financial creditor, operational creditor, insolvency professional, the person who is enrolled as a professional. Okay, so let's begin our CIRP. The first step is filing of an application. Of course, after the existence or commission of default, after that only application is going to be made. So if the corporate debtor has defaulted in payment, owed to applicant or owed to any other financial creditor. That means maybe company has taken loan from a bank and company has also taken loan from other people. The company has repaid this loan, has not repaid that loan. So collectively, if it has defaulted in the payment of amount to any financial creditor, then this application can be made either by itself or jointly with other financial creditors. See, one amazing thing I would say, which has been established under IBBI, or you can say under this particular code, is information utility. Information utility under IBC. Earlier there wasn't any information utility. Now we have India's first information utility, which is NESL. Okay, it is registered under IBBI. If you want to check out, you can check out its website. I was trying to quote that exact website for you. Yes, it is nesl.co.in. Okay, so if you want, you can check it. National E-Governance Services Limited. You will get that information utility. Now, what is information utility? Of course, it has some information which is stored. See, if you talk about income tax portal, whenever you have AIS, I hope you all know about AIS, Annual Information System. Just like we had 26 AS when we were filing returns previously, we now also have AIS. AIS is what it is doing. It is
tracing all the information from all the available sources and presenting it at one place, right? In the same manner, information utility is nothing but it stores information from different sources and brings it at one place, right? So a lot of people register their the banks are going to provide information, and that information is going to be stored. So financial creditors definitely have this information under IU, that is information utility. So if let me try to explain you with an example. Supposedly I tell you that my TDS for financial year 2021 has been deducted 20,000. The amount deducted as TDS is 20,000. Will you believe me? Well, the answer is you might believe me, you might not believe me. But if I present to you a copy of 26 AS wherein financial year 2021 is clearly mentioned and the TDS deducted comes out to be 20,000, you will definitely believe me. Why? Because it is an extract which has been made available from a government source. Likewise, if a financial creditor makes an application to IBBI stating that somebody has defaulted in repayment, the adjudicating authority might not believe it, but if they attach that extract from information utility, they have to believe it, right? So they file an application along with the record of default. They suggest the name of resolution professional. So out of that list, they can select one resolution professional and any other information which is specified by board. Board here means IBBI. Okay, so they file an application to adjudicating authority. What adjudicating authority is going to do is within 14 days, they are going to either admit the application if they are satisfied that yes, there is default, the application is complete, and the name of IP that they have suggested to act as RP is clean. That means there is no disciplinary proceeding which is pending against that particular person. There is no proceeding which is carrying out, right? So he has not been involved in any such thing, right? So if they are satisfied, they are going to admit the application, and the date of admission of application is going to be treated as the commencement of CIRP. Right? So this can be an objective question asked to you. What is the commencement of CIRP? Now, adjudicating authority can also reject application. When can it reject application? If it is satisfied that the default is not there, or the application is incomplete, or there is some disciplinary proceeding which is pending against the proposed RP. So they will give a notice to the applicant to rectify the defect within 7 days, and if rectified, then the application will again be admitted. If the application is admitted within 7 days, it is going to be communicated to the financial creditor as well as the corporate debtor. Corporate debtor might not even know that such application has been admitted by financial creditor, right? If it is rejected, then you don't need to intimate to corporate debtor, right? Financial creditor made an application. Directly you have rejected it, you intimate to financial creditor. But if you admit the application, now the process of insolvency is going to start. So you have to tell that company, you have to tell that corporate debtor that now we are going to start the insolvency resolution of your company. So you must inform them over here. Your information to them is not required. And if no order is passed within 14 days, you have to record reasons in writing for the same, that why is there a delay? Why is there a delay? Here, right? So shall we move further? Okay. Now this was about financial creditor. See, the important section numbers to remember. Financial creditor can initiate CIRP under section 7. Operational creditor can initiate CIRP under section 9. However, section 8 and section 9 both are for operational creditor. We are going to read them now. And corporate debtor himself can initiate CIRP under section 10. Okay, so these are three you can say, important sections. And then we have under section 11 certain persons who are not entitled to make an application for CIRP. That means in certain cases you cannot go for CIRP. Okay, so about financial creditor we have already read. Now we are going to read about the operational creditor. Now operational creditor record will not be there in information utility, and I am a company, I have taken some goods from a supplier, from a vendor. I have not repaid their amount. In these operational transactions, there can be existence of dispute a lot of times. I wanted certain goods, you provided the goods of a lower quality, so I have not made your payment. You're not ready to take back the goods. You have provided me defective goods. You have provided me delayed goods for which I suffered losses. So a lot of problems can exist in such type of cases. And that's why maybe delay in the payment. So supposedly the vendor gave me goods which are not up to the mark or of the quality that I agreed to, and that's why I'm not making payment. Now the operational creditor goes to the adjudicating authority and tells that he's not making my payment. You initiate CIRP against him. It will be a waste of time. It will be a waste of time, because it's not so that I'm not ready to make the payment, that I'm not making payment because there is existence of dispute, right? So in such situation, the case is slightly different. What happens is the code requires operational creditor to send a notice, a demand notice plus the invoice, demanding payment from the corporate debtor, and corporate debtor within 10 days has to either pay the amount or intimate about dispute, has to do either of the two things. If it does not do any of the things, then application for initiating CIRP can be filed. If there is a dispute which is in existence, that dispute has to be resolved. Payment, you cannot initiate CIRP over here, right? If the person has already made payment, you cannot initiate CIRP. If the person is not doing any of these, then you can initiate CIRP, and you can file an application. You will attach the copy of invoice, demand notice, affidavit that there is no dispute, proposed IRP. Here it is not mandatory to propose the name of IRP. The financial creditors know about IRP, they are in touch of IRP, but a vendor, we cannot expect him to propose some IRP or knows the name of any IRP. So here it is optional. You may propose. If you don't propose, the board, the IBBI is going to appoint one for you. Record with IU, if available, certificate from financial institution that the debt is not, that is your bank records, other proof or any prescribed information. So you file an application for initiating CIRP against corporate debtor, and within 14 days, if the adjudicating authority is satisfied that the application is complete, you gave the demand notice. These are prerequisites. Under section 8, you read about the prerequisites. That means an operational creditor has to satisfy these things. Only then he can make an application under section 9 for CIRP against the corporate debt. So if adjudicating authority is satisfied that yes, demand notice has been given to corporate debtor, because that is a prerequisite which is given under section 8, so it has to be given first. And what will be the effect of the demand notice? That either the debt will be paid or the dispute will be given, or none of that happens, right? So if debt is not paid, then only you can make an application, and there should be no dispute of notice. So if AA, that is the NCLT, is satisfied of that, and of course the proceedings, if any proposed IRP is there, there should be no pending proceedings against him, only then the application will be admitted. And the date of admission of application is the date of commencement of CIRP. However, if NCLT thinks that maybe application is not complete, or maybe you have not complied with the prerequisite under section 8, that means you have not served the demand notice to corporate debtor, or if you have served the demand notice, maybe the debt has already been paid off, or there is some notice of dispute which has been received, or there are some pending disciplinary proceedings against the proposed IRP. In that case, NCLT will provide an opportunity to rectify the default within 7 days, and if rectified, application will be admitted. If not rectified, the application will be rejected. Clear? Now comes section number 10, initiation of CIRP by corporate applicant. The corporate applicant himself can also make an application for CIRP. Supposedly it thinks that maybe if we don't treat our insolvency now, we might run into liquidation or we might incur some heavy losses. So it's better to revive our situation, and that a professional can do certainly better. So we want some professional to take over the management and try to resolve with a beautiful resolution plan. So corporate debtor himself makes an application to adjudicating authority. The same thing happens within 14 days if the adjudicating authority is satisfied that whatever name of IRP you have proposed, there is no pending proceedings against that person, the application will be admitted. If there are pending proceedings, you will be given an opportunity to rectify the default or defect within 7 days and resubmit your application. If rectified, application will be admitted. If not, application will be rejected. Clear? Okay. Once you have made an application under section 7, 9 or 10, 7 by financial creditor, 9 by operational creditor and 10 by corporate debtor himself, corporate applicant. If you have made an application, can that application be withdrawn? See, if you make an application and the application is not yet accepted by the adjudicating authority, so you give the permission, no, I want to take back my, request for the permission, I want to take back my application, you can. If it has already been accepted, that means somehow the proceedings have moved to a next stage. Quite possible, till now you have not constituted the committee of creditors, so you don't need their approval. Only IRP can make an application and do it. If you have constituted COC or thereafter you have invited plans or all, then you require approval from COC of at least 90%. Okay, so then once you obtain the approval, within 3 days you will make an application to adjudicating authority, and adjudicating authority is going to pass an order for approval that yes, you may withdraw your application. So this can be a question which may be asked to you, that whether an application once submitted for CIRP can be withdrawn or it cannot be withdrawn, right? So it can be withdrawn. There are certain cases where an application cannot be made for CIRP, which is given in this section number 11. See, some corporate debtor is already undergoing CIRP, some operational creditor again wants to make an application. Arey Baba, the CIRP process is already going against that corporate debtor, so how another application? That will be multiplicity, na? How can we initiate CIRP against one corporate debtor by two different people? No. So that is not allowed. If supposedly CIRP was completed 6 months before only, and again you want to initiate CIRP, no. That is not possible. So give it some time, right? So if it was completed within preceding 12 months, if there was some CIRP plan which was approved, but the company could not implement and execute the same and violated it within preceding 12 months, then again you cannot initiate CIRP. And lastly, if already liquidation order is being passed for the corporate debtor, so you cannot initiate CIRP, right? So my dear, what is the flow? Application is being filed by either financial creditor, operational creditor or the corporate debtor himself. Once an application is filed, it is either admitted or rejected. If it is admitted, If it is admitted, that comes out to be the admission, or that comes out to be the commencement date, and from that commencement date within 180 days CIRP has to be completed. CIRP has to be completed. A one-time extension of 90 days may be granted subject to approval. So COC is going to by 66% votes in value, they are going to approve that yes, we want extension. Then RP will apply for extension to adjudicating authority, and adjudicating authority will grant an extension, but that extension cannot be granted more than once, and that too of 90 days only. Clear? Now, once your application is admitted, it marks the date of initiation of CIRP, and that has to be completed within 180 days. As soon as the application is admitted, there are three things which happen. Firstly, declaration of moratorium. Secondly, appointment of IRP. And thirdly, public announcement. What do we mean by moratorium? Moratorium means suspension of certain things. Supposedly, I am trying to resolve certain things, and at the same time, more issues are popping up. It will be difficult to resolve. Likewise, if I'm trying to settle down the disputes between the creditors and the debtors, but some creditors are again filing cases against these people, it will be difficult, it will be impossible to resolve. So that is suspension of these things, which is moratorium covered under section 14, which tells us that on insolvency commencement date, AA, that is adjudicating authority, or NCLT, is going to prohibit that no new suit is going to be filed, no old suit is going to be continued for hearing during moratorium. So these all things or activities are going to be suspended. You cannot transfer any asset, you cannot dispose of any asset, you cannot create any new charge on that assets, you cannot let someone else recover the property which is in your possession at right now. Supposedly, the company is functioning in a building. That building is taken on lease from someone else. So he cannot take back the property right now, which is in possession of corporate debtor. Of course, if lease has expired, other terms are prevalent, right? So that cannot be recovered during moratorium. You cannot execute any order of court, and you cannot even enforce the action under SURFACI Act. But there are two things which will not be affected. One is supply of essential goods and services. So like electricity and all. So supply of essential goods and services will not be affected. And if the company had a telecom license, that license will not be revoked, because if that license is revoked, the company will not be able to function anymore. Right, and when the company is not able to function anymore, how will the insolvency be revived? Right, so that will be become difficult. So the license will not be revoked or suspended, and the supply of essential goods will not be terminated. Moratorium comes to the end once CIRP comes to the end. So during whole process of CIRP, there will be moratorium. Supposedly CIRP could not happen properly, and the company had to turn into liquidation. So when it starts the liquidation, then also moratorium will come to end. Clear? So what is happening? Applications are being filed, application is admitted, then moratorium is declared, then IRP will be appointed, and after IRP is appointed, within 3 days, IRP will make a public announcement. So first of all, I'm going to deal with IRP. Who do you think should be appointed as IRP? When applications for CIRP were filed by financial creditor or the corporate debtor, they proposed a name. And when the application was filed by operational creditor, they also could propose a name. It was not mandatory for them to propose a name, but they can propose a name, right? So if they had proposed the name and no disciplinary proceeding is pending against that person, he will be appointed as IRP. Supposedly, operational creditor files an application and does not propose any name, then the matter will be referred to the IBVI. to IBBI, and IBBI within 10 days will suggest a name who will be appointed as IR, right? So likewise, the appointment of IRP is going to take place. Once IRP is appointed, within 3 days, I hope it's clear, right? So within 3 days, he is going to he is going to make a public announcement. What will be written in public announcement? In public announcement, he is going to invite the claims. He is going to tell about the corporate debtor, that what is the name, what is the address, under which authority it is registered. I am the IRP. What is the last date by when you can submit the claims? If you submit a false claim, there will be a penalty, and by when CIRP will end. Okay. So he makes a public announcement with respect to that. Now, IRP is appointed, he has certain powers and he also has certain duties. What type of powers? He is going to take all the powers of board. He is going to supersede the board. All the officers, all the employees will now report to IRP. So he is going to take over the whole management of corporate debtor. He can execute deeds and documents, he can sign, he can take actions, he will have access to all the books of accounts, to all the records, all the, of course he has to comply with law, right, and protect all the property of the company. At the same time, he also has certain duties. What are the duties? He has to collect information about the asset. And as I told you, when he makes a public announcement, he is making public announcement for invitation of claims. So he also collects and collates all the claims. He verifies all the claims. The most important function is to constitute the committee of creditors. See, IRP has a very short tenure. From the insolvency commencement date till the appointment of RP, he might be appointed as RP also, and somebody else can also be appointed as RP. So in the capacity of IRP, he has a very short tenure. In that tenure, he has to perform these duties. He has to take care of the assets. He has to file the information with the utility so that it's updated. He has to monitor the assets and he has to perform the duties as specified. Manner of submission of claims, not so important, but you can remember the forms, that if you're a financial creditor, you have submitted in form C. If operational creditors, submit in form B, and the employees and workmen have to submit in form D, right? So they submit all the claims, IRP verifies the claims, makes a report and provides it to adjudicating authority, right? Now, application is filed, application is admitted, moratorium is declared, IRP is appointed, public announcement is made, then claims are collected and committee of creditors is formed. Committee of creditors, my dear, under section number 21. So, after collation of claims, before collation of claims, you cannot constitute a committee of creditors. Why? Because you need to know who are the financial creditors. In the committee of creditors, we have financial creditors. We don't have operational creditors. Okay, but if supposedly there are no financial creditors, then we might have to include operational creditors only. Now listen to me. If you have these doubts that ma'am, their interest will be hampered, no such their interest will be hampered. I'm telling you. If financial creditors exist, then all the financial creditors will be the part of that committee of creditors. But if there are any related party, they will not have a right to say, they will not have a right to vote. Okay. If all the financial creditors are related party, then operational creditors will be the part of committee of creditors. And if there is no financial creditor, then also operational creditors will be the part of committee of creditors. In both these situations, the 18 largest operational creditors by value, one representative of workmen and one representative of employee, they are going to be They are going to be the financial creditors. Supposedly we don't have 18 operational creditors, we only have 10 operational creditors, then all the 10 operational creditors will be the part of committee of creditors. So IRP constitutes a committee of creditors. If there are 2 or more financial creditors as a part of consortium, that means they have collectively advanced the money, then they both are going to be part of COC, and their voting will be in proportion to the amount that they have advanced. If a person is financial as well as an operational creditor, then his voting share will be determined accordingly in proportion to his debt as a financial creditor, right? And if he assigns his debt to a financial creditor, then again the voting will be accordingly proportionate. Now, once the committee of creditors has been constituted, within 7 days you have to conduct the first meeting of COC. Just like we have read about general meetings of shareholders or the board meetings, like that we also have the meetings of the committee of creditors, wherein a notice has to be sent. 5 days notice to every participant. 5 days notice to every participant. It may be reduced by COC to not less than 24 or 48 hours. Quorum has to be 33% in value. Then voting, all the votes have to be approved by 66% in value. If the quorum is not present, the meeting is going to be adjourned to just the next day, right? If it's a holiday, the succeeding day, right? If the quorum is not present even in the adjourned meeting, the members present shall constitute the quorum, right? In board meeting, if you remember, in general meeting, if you remember, you have read about that the board may decide about the adjournment. Here nobody decides about the adjournment because everything has to be quick. The process cannot wait, right? Okay. This point I have dealt in later also, so I'm going to tell you later. Now, what happened is, application was filed, application was admitted, then public announcement, moratorium was declared, IRP was appointed, public announcement was made, claims were collected, they were verified, they were collated. Committee of creditors was formed by the financial creditor, comprising of the financial creditor or operational creditor, whatever the case be. After committee of creditors is formed, the first meeting takes place within 7 days, and after that, in the first meeting of COC, RP is appointed. Resolution professional is appointed, that is by 66% votes. Either you appoint the same IRP as RP if his consent is obtained, or you can also replace IRP. If you do that, you are going to send this application to adjudicating authority, who is going to forward to the board, and board confirms within 10 days whether to appoint or not to appoint, right? So RP is appointed. Now what IRP does? What IRP does? Okay. IRP has to conduct the whole CIRP process, that RP has to conduct the whole CIRP process. Whatever documents were available with IRP is going to hand over the documents to RP. RP also has the same rights and duties and powers as IRP. It has to manage the operations till CIRP ends or the liquidation order is passed. He has to conduct the meetings of COC. In the first meeting he is appointed, so subsequent meetings he of course conducts in the manner specified by board, and he also has certain duties as are given in section number 25, and he also prepares information memorandum. See, information memorandum contains that relevant information. What happens is, we have certain eligible resolution applicants. What is the main motive? We are conducting CIRP. So we want someone to come up with a beautiful resolution plan how this company can resolve. But unless we have the details we require to formulate a plan, we cannot provide a plan. So information memorandum basically contains the relevant information which is needed by every resolution applicant to make a plan, which also contains the details about the compliance of law and like things, right? So these are their duties. During CIRP, if at any point of time COC finds that no, we don't want to continue with this RP, they can by 66% votes resolve and propose a new RP, obtain its consent, forward the name to AA. It is going to forward the name to IBBI, and IBBI is going to confirm that no disciplinary proceeding is pending, so he shall be appointed. If it is pending, then board recommends a name. Okay, and he shall be appointed. There are certain duties or actions which are subject to approval also under section 28. Certain actions which are subject to approval. But I'll not deal in detail, but once you just go with the flow. See, resolution professional undertakes all the duties, it has all the powers, but there are certain things for which it requires the approval of committee of creditors. Just like when we read about a company, the board has powers, but the powers of board, section 179, they're also restricted. Certain powers require approval of shareholders, right? So the same happens over here also. If you want to raise any, I don't think I have included that section 28 in the chart. So you read it on your own. Anyways, if you want to raise any interim finance, that means already you have so much of loan, now you want more loan. You want to raise some interim finance, you cannot raise it on your own, you need to go and take the permission from committee of creditors. If you want to create any security interest, if you want to delegate any authority, if you want to undertake any related party transactions, right, if you want to make some changes in some contracts, so there are certain things which are given in section number 28 for which you require approval. Otherwise, you have to protect the assets, you have to take control of the assets, you have to exercise right for corporate debtors, you have to file application for avoidance of transactions, chapter 3. You have to maintain an updated list of claims. If you are unable to understand this, I'm going to tell you later, don't worry. You can appoint if any professional you need. You have to represent in corporate debtor in third party dealings, and you have to perform other actions as specified by board. So these are all theoretical things, right? Now, what happens? The next important step is that inviting resolution plans. You have prepared information memorandum, right? And that includes all the details that are needed to formulate a plan. So there are certain resolution applicants who are the persons who are not eligible are given under section 29A. Of course, it doesn't have to be someone who is related or someone who is not competent. A person who is disqualified to become a director cannot be a resolution applicant. Someone who has been prohibited that you cannot trade, he cannot be a resolution applicant. Someone who is convicted on offense, or someone who is disabled under some foreign law, or some connected person, or someone who is insolvent, right, or promoter. So all these people are not going to be eligible to be the resolution applicant. Other than that, if you are eligible, then you can submit a plan. You can prepare, you can formulate a resolution plan, and you can submit the same. So resolution applicant, on the basis of information memorandum, they submit a resolution plan plus affidavit of eligibility that yes, I'm not disqualified to be a resolution applicant. They submit the plan to resolution professional who examines the plan, because all the plans has to conform to section number 31. They have to conform to certain standards. Same, the whole CIRP process involves a lot of cost. Maybe you have to spend 5 lakh rupees in this cost, paying the fees of RP, paying the fees of IRP, other administrative type of expenses. So whatever plan you are formulating, that should ensure that these costs are also met. It should ensure that you are not contravening any law, right? Now, so resolution process cost should be provided. How you are going to manage the affairs of the company after this plan is approved? How are you going to implement the plan? There should be no contravention of law and it should conform to the guidelines of IBBA. Now, this point will clear a lot of air. Ma'am, when we were constituting committee of creditors who is going to be involved in all the decision making, you said that the operational creditors will not be included unless we have to necessarily include them in the absence of financial creditors. Otherwise, financial creditors will be the part of committee of creditors. So, supposedly 5 financial creditors form the part of committee of creditors. Now, a resolution plan is presented before them which says that all their debts will be paid off, but the operational creditors will have to make compromises. They will immediately sanction the plan. They will say, yes, let them compromise and we are going to get our money. So wouldn't it be harsh on part of operational creditors? Yes. Why operational creditors are not included in the committee of creditors is because they do not have that adequate sense and knowledge about the finances. Point number 1. But that doesn't mean that their rights will be compromised. So whenever a plan is being made, resolution professional at its first place ensures that that plan should provide for their debts first. Ma'am, if all their debts will be provided, it will again be very difficult, right? So their debts have to be provided for. Supposedly I say that, okay, their debts have to be provided for. So maybe the financial creditor will say that, okay, if we have to pay them 10 crore of rupees, let's pay them 1 crore only. And the resolution plan conforms to the standard that we have also provided for operational debts. You get my point? So this is also not going to be work and this might also be harsh on them. So what the code says, what IBC tells us is that it is mandatory, it is necessary that whatever resolution plan is being presented, it should provide for the debts of operational creditor at least to that amount that they would get if the company goes into liquidation. So today if we wind up the company, we sell all the assets and we pay off the liabilities, what will they get? At least they will get 4 crores. So at least 4 crores should be there in that resolution plan, so that there should not be any injustice to operational creditors also. So if all these things exist in the plan, then that plan is going to be presented before the committee of creditors. They can either approve the plan or they can reject the plan. Supposedly they approve the plan, then just a second. This does not happen. There is adjudicating authority. Supposedly they approve the plan, then it is submitted to then it is submitted to adjudicating authority. Submitted to adjudicating authority. Adjudicating authority might approve or reject the plan. Okay, it might reject the plan or it might approve the plan. If it approves the plan, right, now it's good to go. So the plan is presented to committee of creditors. Committee of creditors can approve the plan or they can reject the plan, right? If they approve the plan is going to be approved by at least 66% in value vote. So if they approve it, then the plan is submitted to adjudicating authority, and if they also approve it, then the moratorium comes to the end. You have to now implement the plan, and the plan is going to be applicable to the company, to government, everyone. You cannot say that the plan is not going to be applicable to this person or that person, right? Yes, of course, the person who is not satisfied can appeal on certain grounds to the adjudicating authority. Now, if supposedly COC rejects the plan, then we don't have a choice. It is going to run into liquidation. If supposedly COC approves the plan but AA rejects the plan, then also it's going to run into liquidation, right? So we don't have time. What can be the other grounds on which liquidation may start? If the plan is not submitted within the time limit, if the COC resolved that no, COC at any point of time found out that it is futile that we are undertaking the CIRP process, nothing is going to happen, it's better that we wind up the company. So CIRP passed a resolution by 66% votes that let's liquidate the company. So it will go for liquidation. If corporate debtor contravenes the plans and someone appeals that they are not following the plan, then it will come to an end and the liquidation order will be passed if the resolution plan is rejected, as I already told you, right? Rejection of resolution plan, that is something that I've already told you. So in all these cases, the process of liquidation, my dear, starts. The process of liquidation starts. So the plan, if approved, is going to be applicable to the corporate debtor, its employees, the members, creditors, guarantors, all the stakeholders, and even government or any local authority which is involved. The moratorium comes to the end, and the resolution plan is going to be implemented. Clear? Clear? I think so far the things are clear. If anyone wants to appeal, they can appeal if the approved plan is in contravention of law, or RP has not been regular in his exercise of powers or has misused his powers, the operational creditor's debts has not been provided for, CIRP cost has not been provided for, or the plan doesn't comply with any criteria which is mentioned by IBPI. So on these grounds, appeal can be made. Then comes the process of liquidation. The process of liquidation. See, the main motive of the code is to resolve. That is why it is known as CIRP, that is Corporate Insolvency Resolution Process. However, if the attempt to resolve the insolvency of a corporate debtor fails, then only the liquidation process is triggered, and as soon as the liquidation process is triggered, you have to first appoint the liquidator. Right? So far the proceedings were being conducted by the resolution professional. Now the proceedings will be conducted by the liquidator. So, who is going to be appointed as the liquidator? IRP. RP can be appointed as liquidator also, provided he gives the consent. If he does not give the consent, then someone else will be appointed as liquidator. See, as soon as the order of liquidation is passed, that means now the company is going to be dissolved. All the assets will be sold, the liabilities will be paid off. That means it is a deemed notice to all the employees that you are no more needed. It is your termination, right? So it is a deemed notice of discharge to all the employees, etc. Liquidator is appointed. Resolution professional will act as liquidator if he gives his written consent, and he shall have all the powers of board of director or KMP, and personnel, that is the employees, they have to extend the assistance to liquidator. If, however, the plan was rejected because it could not meet the requirements as given under section 31, then if RP was proved to be incompetent in the CIRP process, how can you expect him to be competent in the liquidation process? So in that case, he will not be appointed. If the board recommends that we want some RP to be replaced for reasons in writing, then he will not be appointed. Or if IRP doesn't give his written consent, not request but consent, so he will not be appointed as liquidator. Okay. So in these cases, how the liquidator will be appointed? Adjudicating authority will direct the board to propose a name, and within 10 days, the board IBBI proposes a name with his written consent, and such person will be appointed as liquidator. What is liquidator going to do? He is going to verify the claims, invite the claims, settle the claims. He shall take into custody all the assets, protect those assets, carry on business if needed until when needed, sell the property by auction, transfer, or any other manner. He can make negotiable instruments. He can take out in official name letter of administration to deceased contributory. I've explained this particular point in the class in detail. Obtain professional assistance if needed. He can institute suits just to file, to recover money and everything. He has to investigate affairs with respect to undervalued and professional transactions, which I'm going to tell you right now, to take all the actions, to sign the documents, apply to adjudicating authority for necessary orders or other specified functions. Now, liquidator will have the access to all information from information utility, books of accounts and everything. And if the creditor asks for information from the liquidator, then liquidator also has to provide financial information to them within 7 days. Now, liquidation estate. What do we mean by liquidation estate? See, there is a company. What are the assets will be treated, what are the assets which are going to be included in that consortium, and what are the assets which will not be included? So of course, the assets which corporate debtor has ownership rights, any encumbered assets also, all types of assets, whether tangible, intangible. If there are some decisions, there was some suit pending for which court has declared that yes, this asset belongs to the company, so that asset will also be of the company. If there is some asset which has been recovered through proceedings during CIRP proceedings, that assets also. Assets which are collateral. See, whenever there is a creditor, secured creditor, supposedly, he has two choices. He is a secured creditor, he has some asset. He might enforce his security interest or he might let it go. If he enforces his security interest, supposedly he has a loan of 10 crores and he has an asset as a collateral security of say 8 crores. So he has two choices. He can give this asset back, right? And or he can enforce that security interest and realize his money. In both the cases, if company has more money, it will be paid. Supposedly the creditor chooses to sell that asset and realize his money. Now he will be paid the differential amount of 2 crores at a very later stage. The order of preferential payments, that unpaid portion of the secured creditor comes at a later stage. But supposedly he lets go of his security interest. Now he will be paid here. All that 10 crore rupees. If the company has 100 crore, he will definitely get his 10 crores. But if he chooses to sell off the security interest, he might be get the unpaid portion, or he might not get the unpaid portion, unrealized portion, right? So he has a choice to make. If he lets go of his security interest, then that asset will also be included. The proceeds of liquidation, of course, and all the property that belonged to the company at the commencement. What will not be included? Supposedly I have a building which is on lease, so it does not belong to corporate debtor, it is just in the corporate debtor's possession, so it will not be included. Collateral which is held by the financial service providers, that will not be taken. As I told you, as I gave you the example, if it is relinquished, then that will be taken. Personal assets of shareholders, assets of Indian or foreign subsidiary, or other as may be specified by the board. So once the liquidation proceedings start, within 30 days, liquidator will collect all the claims with the supporting documents, verify the claims, and can admit the claims or maybe reject some claims. If you reject, then the person has the power to appeal also, that why you have rejected their claim. One person has submitted the claim, they can change their claim within 14 days of submission, or they can withdraw also. Now, after the liquidator has collected all the claims, it is going to check for preferential transactions, undervalued transactions, extortionate credit transactions, and apply to adjudicating authority accordingly. After that, liquidator will sell off the assets and pay off the claims. In what order you have to distribute the assets or pay off the claims? First of all, you will provide for the cost. And secondly, you will provide for these two things: debts of secured creditor, if they have relinquished their security interest, of course, as well as the workman's dues for past 2 years, 24 months. Okay, so if the money is not sufficient to cover both, they will be paid proportionately. The third stage is wages other than workmen for past 12 months. Then financial debts to unsecured creditors. See, the unpaid portion, if a secured creditor enforces a security interest, then the unpaid portion comes even after the unsecured creditor. So it's sometimes better to let go of the security interest, so you will be paid here, otherwise you will get the unpaid portion at a later stage. So it depends what amount of asset you have as collateral. If it is sufficient to cover your dues, then you should enforce your security interest, otherwise you should let it go, right? So amount due to central government, state government, and this remaining debts and dues, then preference shareholders, and at the last equity shareholders as well as the partners. So liquidator is going to distribute the proceeds. When all the assets are liquidated, liquidator is going to make an application to adjudicating authority for dissolution.
Okay, so after we have discussed about the liquidation process, that is, all the assets are distributed, thereafter liquidator distributes the proceeds within 90 days to all the stakeholders, and when the assets are liquidated, he makes an application for dissolution, right? Makes an application to adjudicating authority for dissolution. Now we have to discuss about the bankruptcy process for individuals. As I've already discussed with you that we don't have to read the entire personal insolvency process. As we read for corporates, in corporates what we read is first CIRP, then liquidation. If CIRP fails, then the company is liquidated, the assets are being sold off and the liabilities are paid off. However, for individuals, what is personal insolvency? What parts are covered? The individuals, partnership firms, personal guarantors. Now, if they do not pay, That means they are in a state of insolvency, but we're not discussing how to treat this insolvency. Of course, an application by creditor or the debtor himself is made to debt recovery tribunal, and thereafter insolvency resolution process is being undertaken. If that repayment plan is rejected or the repayment plan turns out to be non-satisfying your debts, or it is a case of fraud, then you can also make an application for bankruptcy. We have to read the process of bankruptcy and not of insolvency. That is not in our syllabus, right? So what happens in case of bankruptcy? First, we make an application of bankruptcy in the eligible cases. Thereafter, interim moratorium is declared. During interim moratorium, there will be no legal proceedings, right? No suits and all, anything you can file and everything. After that, bankruptcy trustee is appointed. Who is appointed as bankruptcy trustee? Someone whose name is being suggested, right? If no name is being proposed, then an application will be made to IBBI. IBBI will recommend the name, and that person will be appointed as bankruptcy trustee. Okay. Thereafter, when the confirmation is being received that okay, fine, bankruptcy trustee is appointed, then bankruptcy order is passed by DRT. DRT is the adjudicating authority in this case. Now, after passing of bankruptcy order, which is also the commencement of bankruptcy proceedings, so bankruptcy commencement date is also this date, all the property that belongs to the individual now lies in the hands of bankruptcy trustee. So he has now all the property. The adjudicating authority also issues a notice, gives a notice to the creditors, and issues a public notice where people are being informed that such individual is being, against such individual, bankruptcy order is being passed. So if you have to recover anything from this individual, submit your claims. So the claims are being invited, and bankruptcy trustee is expected to register those claims. Once he compiles all the claims, he has to call the meeting of creditors and thereafter constitute committee of creditors. Okay. And after constituting committee of creditors, of course, he makes the payment in accordance to the chapter. He administers the state. He makes the payment. After he has made all the payment that he had, like that he could recover, then he prepares a report on the same and presents it in front of the creditors. Then they give him a release. They release him. Fine, you have discharged all your duties, so now you are released. After he is released, he applies to adjudicating authority. Adjudicating authority passes an order, and the bankruptcy trustee is discharged, and so is the bankrupt, the individual against whom order was passed. Right? I had made you prepare another chart which contains the details. I would say the detailed timelines and everything, that when application can be made, within how many days you have to apply, like within how many days the order is passed, within how many time you have to register the claims, within what time period you have to constitute COC. So everything is a little more detailed in this chart that I made you write. For all those who haven't, who don't know this, I'm showing it to you, just a glimpse. Okay, so that's it.